American Indian Treaties. The History of a Political Anomaly. Francis Paul Prucha. Contents. List of illustrations. 11. Preface. 13. Abbreviations used in footnotes. 15. Introduction, The Anomaly of Indian Treaties. 1. Part 1. A Treaty System. 21. 1. The Revolutionary War Years. 23. 2. Treaties of Peace after the Revolution. 41. 3. Treaty-making procedures under the Constitution. 67. 4. Confirming the procedures, other treaties in the 1790s. 85. Page 8. Part 2. Instruments of Federal Policy. 103. 5. Testing the Treaty System, 1800 to the War of 1812. 105. 6. A Position of Dominance, the War of 1812 and after. 129. 7. Indian removal and the debate about treaty making. 156. 8. The removal period in the North. 183. 9. Patterns in treaty making. 208. 10. Treaties in the expanding West. 235. 11. The Civil War decade. 261. Part 3. Deterioration. 287. 12. The end of treaty making. 289. 13. Treaty substitutes. 311. 14. The collapse of the treaty system. 334. Page 9. Part 4. Renewal, the 20th century. 359. 15. Treaties in the new century. 361. 16. Treaties before the Supreme Court. 385. 17. Treaty rights activism. 409. Appendix A treaty documents and their promulgation. 429. Appendix B ratified Indian treaties. 446. Appendix C ratified agreements with Indian tribes, 1872-1911. 506. Appendix D unratified treaties. 517. Sources for the study of American Indian treaties. 521. Index. 539. Picture credits. 561. Preface. I have long been interested in American Indian treaties, for they were one of the principal instruments by which the United States government dealt with the Indian nations. For the Indians, too, the treaties were of tremendous importance historically, and they continue today as the basis, in large measure, for the Indians' land claims, hunting and fishing rights, and distinct political status. Although much attention has been paid to the treaties in histories of Indian policy and in legal studies, I felt a need for a substantial volume that would deal specifically with the treaties and with what might be called the treaty system to discuss how and why the treaties were negotiated, to uncover the historical arguments for and against their use, and to look at the vicissitudes in the continuing history of the treaties that had been ratified before that date. It is my hope that such a volume will help toward a fuller understanding of a part of United States history about which there is still much misunderstanding, emotional disturbance, and wishful thinking. The account of 2 centuries of treaty history should at least make clear the complexity of the historical record and promote an appreciation that goes deeper than popular stereotypes and slogans. This is primarily a chronological account of treaty making and of the subsequent history of the treaties. Yet as I wrote the narrative I was plagued by 2 problems that were hard to shake. One was the urge to, page 14, write a treaty-by-treaty account, because nearly every treaty had unique features, and accurate generalizations, even narrowly defined ones, proved difficult to construct. The other was the danger of launching once again into a general history of American Indian policy, because the treaties played a large role in giving flesh to that policy. I am not sure that I have solved the problems. Scholars who have studied a particular treaty intensively will no doubt be disappointed that I did not treat that one more fully. As for Indian policy, I have tried to keep my eye on the treaty process, with reference to the formulation of policy only as needed to give the treaties a historical context. Although treaties are thought of as contracts between independent states, in the case of the treaties of the United States with the Indian nations it is necessary to remember that formal written treaties were an Anglo-American, not an Indian, device. And as the decades passed, the United States played an increasingly dominant role, making use of the treaty process for its own purposes. These two facts make it appropriate and even necessary to consider American Indian treaties largely from the white perspective. Such a course, I know, slights Indian views of the treaties, stories that remain to be told in some detail as more scholars turn their attention to them and as more materials become available. Here I work, as in previous studies, on the national level, leaving for others to supply the detailed knowledge and corrected impressions that can come only from tribal or other particular investigations. In the appendixes the book has reference materials that may be used independently of the narrative, especially the complete and careful lists of ratified treaties and ratified agreements, which contain basic information about each document. I owe a debt to many people for assistance, to librarians and archivists for locating, retrieving, and helping to assemble the necessary documents, to scholars and other friends who have listened to my problems and have offered information and advice, and to my colleagues at Marquette University and my fellow Jesuits there, who have been generous and patient as I concentrated on this project. I thank, also, the University of Nebraska Press for permission to copy some brief sections from my book The Great Father. Francis Paul Prucha, S.J. Marquette University. Page 15. Abbreviations used in footnotes. ASPIA. American State Papers, Indian Affairs. 2 volumes. Washington, Gales and Seaton, 183,234. CIAAR. Annual Report of the Commissioner of Indian Affairs. For the period 1824-1920, the edition in the Congressional Serial Set is used, and the serial number is given. Documents. Documents relating to the negotiation of ratified and unratified treaties with various Indian tribes, 180116869. National Archives Record Group 75. GPO. United States Government Printing Office. JCC. Journals of the Continental Congress. 34 volumes. Washington, United States Government Printing Office, 190,437. Kapler. Charles J. Kapler, Comp. Indian Affairs, Laws and Treaties. 5 volumes. Washington, United States Government Printing Office, 190,441. OIALS. Office of Indian Affairs, Letters Sent. National Archives Record Group 75. Ratified Treaties. Ratified Indian Treaties, 17221869. General Records of the United States Government. National Archives Record Group 11. Royce, Sessions. Charles C. Royce, Indian Land Sessions in the United States. 18th Annual Report of the Bureau of American Ethnology, 1896-1897, Part 2. Washington, United States Government Printing Office, 1899. Page 16. Senate X. PROC. Journal of the Executive Proceedings of the Senate of the United States of America. Volumes 13, Washington, Duff Green, 1828, Volumes 4, Washington, United States Government Printing Office, 1887. Reprint, New York, Johnson Reprint Corporation, 1969. Senate. Records of Executive Proceedings, President's Messages, Indian Relations. Records of the United States Senate. National Archives Record Group 46. Ter. Papers. Clarence E. Carter, ed., The Territorial Papers of the United States. 26 volumes. Washington, United States Government Printing Office, 193,456, National Archives, 195,862. WDLS. Letters sent by the Secretary of War relating to Indian Affairs, 18001824. National Archives Record Group 75. 4 documents in the Congressional Serial Set. The numbers of the Congress and session are given in this abbreviated form, 46-2. The abbreviations used in the citations to some legal sources follow the forms given in the Blue Book, A Uniform System of Citation, 15th ed. Page 1. Introduction. The anomaly of Indian treaties. The formal treaties made by the United States government and various Indian tribes and bands have a complex history. They served many purposes for both the United States and the tribes, and they were negotiated by a great array of federal commissioners and Indian chiefs and warriors. Between 1778, when the first treaty was signed with the Delawares, and 1868, when the final one was completed with the Nez Perces, there were 367 ratified Indian treaties and 6 more whose status is questionable. In addition, a considerable number of treaties that were signed by the Indian chiefs and the federal commissioners were never ratified by the Senate and the President. 1 For both sides, conditions at the time of treaty signing called for pragmatic decisions, and it is dangerous to approach the treaties and their history with a priori patterns into which the actual events are squeezed to fit. Nor has the understanding of the old treaties in newer times followed a single pattern. Indian treaties, when all is said and done, were a political anomaly. Chief Justice John Marshall hit it right when he wrote in Cherokee Nation v. Georgia, the condition of the Indians in relation to the United States is perhaps unlike that of any other 2 people in existence. The relation of the Indians to the United States is marked by peculiar and cardinal distinctions which exist nowhere else. More than half a century later, the Supreme Court in United States v. Kagama echoed Marshall's sentiment, the relation of the Indian tribes living within the borders of the United States to the people of the United States has always been an anomalous one and of a complex character too. What was true about Indian-white relations in general was especially true about the Indian treaties. The general rule is that a treaty is a formal agreement between 2 or more fully sovereign and recognized states operating in an international forum, negotiated by officially designated commissioners and ratified by the governments of the signatory powers. But American Indian treaties have departed from that norm in numerous ways, as their history shows. They exhibited irregular, incongruous, or even contradictory elements and did not follow the general rule of international treaties. It will not do to insist on univocal definitions while ignoring the multifaceted historical reality of the use of treaties in the relationships between the United States and the Indian communities. Only a detailed historical account will display the nature of the treaties and the many changes through which the understanding and use of the treaties passed in the course of American history. Sovereignty. Indian treaties had certain characteristics or elements that, although appearing paradoxical or even incompatible, did not cancel each other out but existed together in an anomalous whole. The United States, from the beginning of its political existence, recognized a measure of autonomy in the Indian bands and tribes. Treaties rested upon a concept of Indian sovereignty or quasi-sovereignty and in turn greatly contributed to that concept. Treaties, as it was repeatedly pointed out in discourse about the relations between the United States and the Indians, made no sense unless based on recognition of some kind of special legal status of the Indians. In their actions, whites frequently enough disregarded Indian rights, but both theoretically and in practice the treaties gave the Indians a protected existence. Often this recognition of independence meant more to Indian groups than did their lands, and tribes eagerly sought treaties in order to gain. Page 3. Political recognition, and not just to acquire the economic benefits that came from presents and from annuities paid for land. The autonomous status was seen in the early treaties of peace and friendship, for declaring war and peace were functions of sovereign nations. The first United States treaty, that with the Delawares in 1778 while the Revolutionary War was still raging, declared that a perpetual peace and friendship shall henceforth take place, and subsist between the contracting parties. Through all succeeding generations, and at the end of the war, treaties with all the one-time hostile Indians were designed to establish peace. The preambles to the treaties spoke of the United States giving peace to the Indians and receiving them into its favor and protection, but it was to be a mutual understanding of peace, the formula used in 178,586 with the Cherokees and other southern tribes at Hopewell, in South Carolina, made this evident. The hatchet shall be forever buried, and the peace given by the United States, and friendship re-established between the said states on the one part, and all the Cherokees on the other, shall be universal, and the contracting parties shall use their utmost endeavors to maintain the peace as aforesaid, and friendship re-established. 3. Similarly, after the War of 1812, the treaties at Portage de Sioux with the western tribes declared, there shall be perpetual peace and friendship between all the citizens of the United States of America, and all the individuals composing. And the post-Civil War treaties made with the 5 civilized tribes, who had aligned themselves with the Confederacy, re-established permanent peace and friendship between the United States and each tribe. Some of the tribes agreed, as the Creek Treaty read, to remain firm allies and friends of the United States, and never to take up arms against the United States, but always faithfully to aid in putting down its enemies. 4. In between such times of return to peace after a war, countless treaties issued or renewed declarations of peace between the United States and the Indian tribes. Treaties also dealt with other aspects of the quasi-international status of the Indian tribes. Boundaries were established between the tribes and the United States, and in some cases, notably in the Treaty of Prairie du Chien of 1825 and the Treaty of Fort Laramie of 1851, between the various tribes as well. The lands of the Indian groups, although within the territorial limits of the United States recognized by European nations, were considered to be apart from the lands of the whites. This was a carryover from the concept of Indian country that was found in the Proclamation of 1763 with its line dividing Indian lands from areas of white settlement, a concept more sharply institutionalized by the federal trade and intercourse laws between 1790 and 1834. Treaties reinforced and amplified this principle of the separateness of tribal territory, especially in the initial years of treaty making. Early treaties with the Creeks and with the Cherokees, for example, required passports for United States citizens to enter Indian lands. There were, in addition, provisions in the treaties for the extradition of criminals, requiring the Indian tribes to deliver up Indians or other persons who committed crimes against United States citizens, so that they could be duly punished by the federal government. The cession of Indian lands, a prominent feature of Indian treaties, was an indication of Indian sovereignty over those lands, and the recognition by the United States of Indian ownership to the lands remaining strengthened the concept. 5. Combined with the idea of separate Indian lands was the recognition of Indian autonomy within those lands. The language of the treaties is unmistakable in this regard. The first treaty was made with the Delaware Nation, and subsequent treaties followed that terminology, although little by little, especially with the Indians north of the Ohio River, the term tribe replaced nation or was used alternately with it. Even when tribe became common, the Creeks, Cherokees, and others of the southern tribes were still usually denominated nations. 6. John Marshall in the Cherokee cases of 1831 and 1832 argued the point at some length. In Cherokee Nation v. Georgia he declared that there was no doubt that the Cherokees were a state, a distinct political society, separated from others, capable of managing its own affairs and governing itself. They had always been considered a state, he said, and the numerous treaties made with them by the United States had recognized them as a people capable of maintaining the relations of peace and war, of being responsible in their political character for any violation of their engagements, or for any aggression committed on the citizens of the United States by any individual of their community. 7. Though Marshall balked at defining Indian tribes as foreign nations, able to bring suit before the Supreme Court, calling them instead domestic dependent nations, in Worcester v. Georgia he repeated and amplified his argument that the Indian nations were distinct, independent political communities. He concluded, "The words treaty and nation are words of our own language, selected in our diplomatic and legislative proceedings, by ourselves, having each a definite and well understood meaning. We have applied them to Indians as we have applied them to the other nations of the earth. They are applied to all in the same sense." 8. Erosion of sovereignty. If the matter had stopped there with the Platonic notions of Indian sovereignty that guided Chief Justice Marshall, to which the United States Supreme Court recently referred, all might be simple enough. 9. The anomaly in treaty making, however, soon appeared. Indian tribal sovereignty had gradually eroded, until the tribes became the dependent nations Marshall also spoke of. The treaties both reflected and contributed to the inequality and dependency with which the Indian negotiators faced the federal treaty commissioners. They rested on the assumption that the Indian tribes were not independent nations on the international scene. The treaties of peace after the Revolutionary War not only spoke of the United States as giving peace to the Indians, but also included some such phrases as the following: "The said Indian nations do acknowledge themselves and all their tribes to be under the protection of the United States and of no other sovereign whatsoever." 10. The same formula was used by the United States in treaties with the Western tribes who signed treaties at Portage de Sioux after the War of 1812, the Missouri River tribes encountered by General Henry Atkinson and Indian agent Benjamin O'Fallon in 1825, the tribes of the Pacific Northwest met by Governor Isaac I. Stevens in the mid-1850s, and the Northern Plains tribes with whom the Edmunds Commission dealt at Fort Sully in 1865. In such treaties the Indians agreed to submission to the United States in their external political affairs. John Marshall called such submission the single exception to tribal independence, imposed by irresistible power, which excluded them from intercourse with any other European potentate than the first discoverer of the coast of the particular region claimed. In declaring that the Indians were not foreign nations, Marshall spoke bluntly. "They look to our government for protection, rely upon its kindness and its power, appeal to it for relief of their wants, and address the President as their great father. They and their country are considered by foreign nations, as well as by ourselves, as being so completely under the sovereignty and dominion of the United States, that any attempt to acquire their lands, or to form a political connection with them, would be considered by all as an invasion of our territory, and an act of hostility." 11. In fact, even though in the beginning the treaties were of a diplomatic nature, being negotiated by separate political powers dealing with each other on grounds of rough equality, very soon the United States came to negotiate the treaties from a position of overwhelming strength. Thomas Jefferson wrote to William Henry Harrison as early as 1803 regarding the Indians: "We presume that our strength and their weakness is now so visible that they must see we have only to shut our hand to crush them." Secretary of War John C. Calhoun, less than 2 decades later, could say of the Indians, "They are not, in fact, an independent people, nor ought they to be so considered. They should be taken under our guardianship, and our opinion, and not theirs, ought to prevail, in measures intended for their civilization and happiness." William Clark, Indian Superintendent at St. Louis, spoke in 1826 of the Indians as once a formidable and terrible enemy, whose power has been broken, their warlike spirit subdued, and themselves sunk into objects of pity and commiseration. 12. The practical inequality of the parties, the legal scholar Felix Cohen once warned, must be borne in mind in reading Indian treaties. 13. The political dependence of the tribes was matched by economic dependence. In fact, Economic dependence was in large part the reason that the Indians were forced to accept United States suzerainty. Since the Indians were dependent upon the whites for trade goods, control of that trade was a primary means for putting political pressure upon the tribes, and elimination of abuses in the trade was a means for preserving peace on the frontiers. The details of trading relations were worked out in a series of trade and intercourse laws, stretching from 1790 to 1834, and between 1795 and 1822 the federal government itself managed trading houses in the Indian country to satisfy the Indians' wants and tie them to the United States. But the treaties were another means, for in them the Indians themselves agreed to give Congress the exclusive right to regulate trade with them. Some treaties repeated the provisions of the trade and intercourse laws requiring a license from a United States official for citizens or others trading in the Indian country, and the Treaty of Greenville in 1795, for example, specified in considerable detail the measures to control the trade. 14. The treaties signed by tribes along the Missouri River in 1825 contained this clause: the said bands also admit the right of the United States to regulate all trade and intercourse with them. And as the United States domain expanded west to the Pacific, the Indians newly encountered agreed by treaty to the extension of the trade and intercourse laws over their territories. 15. The Indians' continuing, increasing, and in many cases nearly absolute dependence upon white citizens for necessary goods was an important factor in the growing conviction that Indians were wards of the government, not members of independent sovereignties with whom the United States should deal by means of formal treaties. Moreover, the sovereignty of the tribes was seriously compromised by repeated provisions in the treaties that left many stipulations to be carried out at the discretion of Congress, the Senate, or the executive. In a number of cases, when articles in the treaties specified payments or grants to individuals, the treaties themselves provided that if these articles were not ratified, the rest of the treaty would not be affected. The treaties at Fort Sully in 1865 with the Northern Plains tribes carried this principle to an extreme, for each of those 9 treaties provided. Any amendment or modification of this treaty by the Senate of the United States shall be considered final and binding upon the said band, represented in council, as a part of this treaty, in the same manner as if it had been subsequently presented and agreed to by the chiefs and headmen of said band. 16. The 1842 treaty with the Chippewas allowed the Indians to hunt on the territory ceded by the treaty until required to remove by the President of the United States, and stipulated that the trade and intercourse laws would continue to be in force with respect to Indian intercourse with whites until otherwise ordered by Congress. The treaties with the Eastern Sioux in 1851 declared that rules and regulations to protect the rights and persons and property among the Indians, parties to this treaty, and adapted to their condition and wants, may be prescribed and enforced in such manner as the President or the Congress of the United States, from time to time, shall direct. 17. When a treaty was signed with the Delawares in 1854, a practically open provision for federal action was included in these words. A primary object of this instrument being to advance the interests and welfare of the Delaware people, it is agreed, that if it prove insufficient to effect these ends, from causes which cannot now be foreseen, Congress may hereafter make such further provision, by law, not inconsistent herewith, as experience may prove to be necessary to promote the interests, peace, and happiness of the Delaware people. 18. The President, again and again, was given discretionary authority in treaties to establish trading posts and military posts at locations of his choice, designate places in the Indian country at which trade could be conducted, appoint agents to advise and direct the Indians, arbitrate claims between whites and Indians, decide territorial claims between Indian tribes and arbitrate other such claims, determine the time at which a tribe should remove from ceded lands, fix the size of annuity payments and the nature of such payments, determine lands for the Indians in exchange for cessions, convey parts of Indian lands to individual Indians as private reserves, approve sale of reserves by the Indians, dispose of lands held within reservations by missionary groups, decrease annuities as tribal population decreased, approve attorneys chosen by Indian chiefs, invest tribal monies, and extend benefits to Indian tribes. as he might think just and proper. 19. Such authority placed in the hands of the President indicated not only the respect that the Indians had for the Great Father but also the ability of the federal government by means of treaties to set its will as the determining factor in many elements of Indian life. Civilization. Many grants of authority given to the President or Congress in the treaties were business or administrative matters, which by a stretch of the imagination might be seen as proper in the relations between a sovereign and a dependent protectorate. Much more powerful in contributing to the anomalous character of the Indian treaties was the persistent drive of white society and its government to change, indeed, to revolutionize Indian societies by the promotion of white civilization. The treaties themselves, to a remarkable degree, were instruments intended to transform the cultures of the tribes. Building upon a long history of colonial precedents, federal leaders beginning with George Washington sought to change the Indians from hunters and gatherers to agriculturalists and herdsmen. It is not surprising that the treaties were full of provisions designed explicitly to enhance this process. The treaty with the Creeks in 1790 declared that the Creek nation may be led to a greater degree of civilization, and to become herdsmen and cultivators, instead of remaining in a state of hunters. The United States will from time to time furnish gratuitously the said nation with useful domestic animals and implements of husbandry. 20. Such items would weaken communal ties, or so Secretary of War Henry Knox hoped when he spoke in 1789 of instilling in the Indians a love of exclusive property and recommended that gifts of sheep and other domestic animals be presented to the chiefs and their wives. Knox instructed General Rufus Putnam, who was sent in 1792 to treat with the Indians near Lake Erie, to make clear the desire of the United States to impart to the Indians the blessings of civilization, as the only mean of perpetuating them on the earth, and that the government was willing to teach them to read and write and to practice the agricultural arts of the whites. 21. It became common in the treaties for the United States to promise clothing, implements of husbandry, domestic animals, spinning wheels, and looms, to provide blacksmiths to repair agricultural implements as well as guns, and to build mills, all designed to promote the movement toward white ways of subsistence. It is easy to concentrate on the land cession provisions of the treaties and see the treaties simply as a means of territorial aggrandizement, as a license for empire, and thus to miss the overwhelming obsession of the United States with changing the cultures of the Indians from communally to individually based systems of property ownership and from hunting or mixed economies to yeomanry. 22. When treaties were made in the 1850s with the tribes in the newly acquired territories in the West, the same concern for civilization was evident, even though many of the Indians were not ready for it and hardly understood what it meant. The Treaty of Fort Laramie of 1851, for example, provided annuities in provisions, merchandise, animals, and agricultural implements. In justifying the payment of $50,000 a year for 50 years, one of the commissioners of the treaty remarked, "Humanity calls loudly for some interposition on the part of the American government to save, if possible, some portion of these ill-fated tribes, and this, it is thought, can only be done by furnishing them the means, and gradually turning their attention to agricultural pursuits." 23. The much criticized treaties signed with the Eastern Sioux in 1851, in which the band ceded large sections of land in Minnesota and adjacent regions of Dakota and Iowa in order to make room for expectant settlers and to acquire funds to wipe out large debts to traders, were also seen as a means to acculturate the Indians to agricultural life. Unknown to most Dakota, a recent historian of those Indians writes, the treaties of 1851 were tools of reform rather than examples of reciprocity. Even the abortive treaties with the Apaches, Navajos, and Utes in New Mexico Territory embodied civilizing principles, for the Indians agreed to cultivate the soil and raise flocks and herds, and they accepted gradually reduced annuities, which the President, at his discretion, could use in part for the Indians' moral improvement and civilization. 24. The treaties in the same decade signed by Commissioner of Indian Affairs George W. Manypenny with the eastern tribes that had been moved west of the Mississippi in earlier decades. Indians who, for the most part, had long been in contact with whites adopted the ultimate provision for changing the Indians into yeoman farmers, allotment of reservation lands in separate agricultural parcels to individual families. The treaties with the Pacific Northwest tribes in the same years spoke specifically of civilization and contained stipulations toward that end. The treaties signed in 1867 and 1868 by the United States Indian Peace Commission at the very end of the treaty-making era were civilizing documents. One needs only to read the treaties with their extensive provision for arable land for farming, construction of warehouses, mechanics shops and other buildings, a land book to record individual allotments, domestic clothing, compulsory education, seeds, and agricultural implements, and farmers, blacksmiths, and physicians to see the strong thrust towards civilization that dominated them. By then the treaties had long since ceased to be simple political agreements between equal sovereigns, as some present-day Indian writers still see them. Aside from the change to an agricultural mode of subsistence, formal schooling was the principal vehicle for modifying Indian cultures. The United States encouraged the educational efforts of missionary groups among the Indians and in 1819 formalized its support of these groups by providing an annual civilization fund to support their schools. It is understandable, then, that the treaties, too, made provision for schools and teachers. It was another element in the contract. The United States promised to furnish the means, and the Indians, explicitly or implicitly, agreed to send their children to school. The Treaty of Doak Stand with the Choctaws in 1820 provided that 54 sections of good land out of the ceded territory should be sold for the purpose of raising a fund, to be applied to the support of the Choctaw schools, on both sides of the Mississippi, and a subsequent treaty in 1825 added an annuity of $6,000, to be applied for 20 years to the support of schools in said nation, and extending to it the benefits of instruction in the mechanic and ordinary arts of life. Between 1817 and 1852 Congress appropriated more than $500,000 for Choctaw education under treaty provisions. 25. Other tribes, too, benefited from education provisions in the treaties, for the treaty commissioners repeatedly entered such stipulations into the treaties. 26 By 1834 14 treaties provided an annual total of $35,500 for schools, with payments to run for limited periods of time or at the pleasure of Congress. By 1845 the annual sum reached $68,195.27. Farther west, the story was the same. The treaties made by Manypenny in the 1850s included stipulations for schools and education, and in Governor Stevens's Treaty of Medicine Creek of 1854 with Puget Sound Indians, the government agreed to furnish an agricultural and industrial school for 20 years. 28 The Indian Peace Commission treaties of 186,768, of course, made sure that education was attended to. All its treaties included this article. In order to ensure the civilization of the Indians entering into this treaty, the necessity of education is admitted, especially of such of them as are or may be settled on said agricultural reservations, and they therefore pledge themselves to compel their children, male and female, between the ages of 6 and 16 years, to attend school, and it is hereby made the duty of the agent for said Indians to see that this stipulation is strictly complied with, and the United States agrees that for every 30 children between said ages who can be induced or compelled to attend school, a house shall be provided and a teacher competent to teach the elementary branches of an English education shall be furnished, who will reside among said Indians, and faithfully discharge his or her duties as a teacher. The provisions of this article to continue for not less than 20 years. 29. It must be noted that these and other educational provisions were not always carried out to the letter. The United States was remiss in fulfilling its promises for schools and teachers and the Indians in sending their children to school. Still, the presence of such provisions in the political treaties enhanced their anomalous character. Another thrust toward bettering the condition of the Indians came in treaty provisions to prohibit or restrict the use of spirit-use liquors by the Indians. Control of the liquor trade, with its deleterious effects on Indian society, was a fundamental element of American Indian policy. The trade and intercourse laws became increasingly severe in the matter, and those statutes were augmented by specific treaty provisions. Many chiefs recognized the evil of the liquor traffic and easily acquiesced in restrictive articles entered in the treaties. Thus, in some of the many penny treaties of the 1850s, the Indians promised to use their best efforts to prevent the introduction and use of ardent spirits in their country, to encourage industry, thrift, and morality, and by every possible means to promote their advancement in civilization. The Chippewa Treaty of 1854 said bluntly, "No spirit-use liquors shall be made, sold, or used on any of the lands herein set apart for the residence of the Indians, and the sale of the same shall be prohibited in the territory hereby ceded, until otherwise ordered by the President." In some cases, as a motivation for enforcement, the treaties provided for withholding annuities from Indians who drank liquor or brought it into the reservations. 30. The desire to direct the Indians into the path of peaceable white civilization was well summed up in an article inserted in Menipeni's treaty with the Winnebagos signed in Washington in 1855. The said tribe of Indians, jointly and severally, obligate and bind themselves, not to commit any depredation or wrong upon other Indians, or upon citizens of the United States, to conduct themselves at all times in a peaceable and orderly manner, to submit all difficulties between them and other Indians to the President, and to abide by his decision, to respect and observe the laws of the United States, so far as the same are to them applicable, to settle down in the peaceful pursuits of life, to commence the cultivation of the soil, to educate their children, and to abstain from the use of intoxicating drinks and other vices to which many of them have been addicted. And the President may withhold from such of the Winnebagos as abandon their homes, and refuse to labor, and from the idle, intemperate, and vicious, the benefits they may be entitled to under these articles of agreement and convention, or under articles of former treaties, until they give evidences of amendment and become settled, and conform to, and comply with, the stipulations herein provided. 31. Such provisions, of course, cut deeply into the lives of the Indians and subjected them almost completely to the will of the dominant partner in the treaties. The treaties, in fact, became social documents as well as political ones, a catch-all for legislating a good life for the reservation Indians. Domestic policy. Running through the anomaly of Indian treaties and going directly counter to the notion that a treaty is an international agreement between independent sovereign states was the hard fact that the Indians were ultimately a domestic issue for the United States. This was evident from the start, as Indian affairs were made the responsibility of the War Department rather than the State Department. When interference in Indian affairs by the separate states of the Union was condemned as a violation of the Articles of Confederation, it was because it went against the sole and exclusive right and power of Congress to regulate trade and manage all affairs with Indians rather than because it violated the prohibition upon the states against entering into any conference, agreement, or alliance or treaty with any king, prince, or state. It is instructive to note, too, that Lewis and Clark, who met many Indian tribes on their cross-continental journey Indiana 18046 and freely distributed peace medals to the chiefs, did not enter into treaty negotiations with them. President Jefferson, who was an aggressive treaty maker with Indians within the territorial boundaries of the United States, thought of dealing with the distant tribes only through trade, not through the political arrangements of formal treaties. This may have been because, when he planned the voyage of discovery, the Louisiana Purchase had not yet been consummated and the Indians were not yet within United States territory. 32. Even John Marshall, for all his talk about autonomous political entities and the meaning of the words treaty and nation, said that the relation of the Indians and the United States resembles that of a ward to his guardian. The bold act of the Southern tribes in throwing off their allegiance to the Union in the Civil War and joining the South has the appearance of an international act, but the Confederate States themselves, in their treaties with the Indian tribes, adopted Marshall's usage and spoke of recognizing the Indians as their wards. By the time the treaties were being used to regulate Indian trade, provide for Indian education, and transform the Indians from hunters to full-time agriculturalists, the domestic nature of Indian affairs was fully confirmed. The post-Civil War drive to detribalize the Indians and assimilate them as individuals into the dominant white society was a culmination of a movement that had long been underway. Resolution of disputes between the tribes and the United States has always been the business of federal courts, not international tribunals. It is true that some Indians in the 20th century have demanded international status and have sought recognition by the League of Nations or the United Nations, but they have been little heeded. 33. Faith and honor. What kept the anomaly of the treaties alive was the enduring quality in the American character that upheld the faith and honor of the nation. Government officials, in the early years of the Republic especially, were conscious that the United States was an experiment in Republican government, watched by the whole world. If the treaty contracts were not lived up to by the federal government, there would be an indelible stain on the honor of the country and its citizens. Moreover, there was a deep consciousness that the United States was a Christian nation and that not only would it lose its religious innocence by dealing unfairly with the Indians, but that God in His justice would punish the nation if it left the path of righteousness by violating sacred treaties. Evangelical leaders tried hard to prevent the commission of such a national sin by arousing the conscience of the citizenry. Many Indians relied on this concept of national honor in dealing with the United States, asserting their belief in honorable treatment by the federal government, and they pleaded with the government not to violate its plighted faith and the national honor. Such tactics had considerable influence, for they touched a sympathetic chord among many white citizens and their official leaders. The cry for living up to treaty stipulations made by the articulate opponents of Indian removal in the 1820s and 1830s, for example, softened the blow of removal and left the southern Indian nations intact. The reliance on the honor of the nation in respect to treaty rights prevented the organization of territorial government in the Indian Territory in the decades immediately following the Civil War, for the sanctity of property rights acquired by contract was a principle that neither the legislators nor the courts could openly reject. After powerful arguments against signing any more treaties with Indian groups because they had lost the attributes of sovereignty, Congress in 1871 declared an end to such treaty making. But it could not disregard arguments about the sanctity of the treaties already signed and ratified, and confirmation of those treaties appeared side by side with the prohibition against making any more. On one hand, the sovereign political character of Indian communities was denied, on the other, the tribes continued to exist as subjects of the rights the old treaties promised. In the 20th century, a renewed popular movement in support of treaty rights, although not uniformly successful, brought forward the strong sense of conscience relative to contractual obligations that imbued the American ethos. Some observers saw its strength or virulence resting upon a guilt complex over the treatment accorded the Indians in the past. The Supreme Court in upholding Indian treaty rights in modern times has reflected anew the noble ideal of living up to the obligations of formal contracts with the Indians. The statement of Justice Hugo Black in dissenting in a case in which it seemed to him the majority of the court had temporarily lost its way, has become an oft-repeated motif for Indians and their advocates. Great nations, like great men, should keep their word. 34. This reliance on faith and honor has been mocked by the broken treaty syndrome that has become a pervasive part of pro-Indian rhetoric in the later 20th century. There is a widely held sentiment that the federal government has consciously and intentionally broken all the treaties it signed with the Indian tribes. Such a view was dramatically expressed and widely circulated in the 1969 book by Vine Deloria, Jr., Custer Died for Your Sins. America has yet to keep one Indian treaty or agreement, Deloria said, despite the fact that the United States government signed over 400 such treaties and agreements with Indian tribes. And he concluded that it is doubtful that any nation will ever exceed the record of the United States for perfidy. He added, in looking back at the centuries of broken treaties, it is clear that the United States never intended to keep any of its promises. 35. The refrain has been a common one, repeated so often that scholars as well as the man in the street accept it as conventional wisdom. 36. The matter is not that simple, as the historical narrative below will demonstrate. There certainly are well-confirmed cases in which the federal government failed to live up to the stipulations of the treaties, just as there are cases in which the Indian signatories broke the treaties. Neither the United States nor the Indian tribes were able to control the actions of their subjects, as aggressive white settlers moved illegally into lands reserved for the Indians and as young Indian warriors continued their raids on white settlements after the chiefs had agreed to permanent peace. On the side of the whites, the governmental system contributed to the problem. 4 treaties negotiated and signed in good faith by the executive branch were delayed, amended, or rejected by the Senate, and Congress was often slow or negligent in appropriating the funds needed to implement the treaties. But it is not proper to maintain, as some Indian groups have done, that an initial treaty is absolute and that any subsequent treaty, agreement, or statute that changes its provisions is an illegal abrogation of the original treaty. The anomaly of Indian treaties would be ended if the treaties could be wiped out, totally abrogated, because of the historical changes that time has brought. Some Americans think that would be the answer, and their representatives in Congress have introduced bills to that effect, but the demand for an absolute end to Indian treaty rights on the basis of equal rights for all citizens has made little headway, and it is not likely to. Treaties are on the books, and the courts have supported them. In mulling over the reasons why the Supreme Court has refused to allow American Indian tribes to be engulfed by the passage of time, the legal historian Charles F. Wilkinson offers a thoughtful conclusion. Macmillan Company, 1969, reprint, with a new preface, Norman, University of Oklahoma Press, 1988, 28, 48. These old laws emanate a kind of morality profoundly rare in our jurisprudence. It is far more complicated than a sense of guilt or obligation, emotions frequently associated with Indian policy. Somehow, those old negotiations typically conducted in but a few days on hot, dry plains between mid-level federal bureaucrats and seemingly ragtag Indian leaders are tremendously evocative. Real promises were made on those plains, and the Senate of the United States approved them, making them real laws. My sense is that most judges cannot shake that. Their training, experience, and, finally, their humanity, all of the things that blend into the rule of law, brought them up short when it came to signing opinions that would have obliterated those promises. 37. The judges are not alone. Many Americans would be brought up short if asked to support unilateral obliteration of Indian treaty rights. So the anomaly continues in the final decade of our century, for as Indian tribes have renewed the exercise of their inherent sovereignty in limited forms and speak much about self-determination, they simultaneously demand the continuation and amplification of the trust responsibility of the federal government for education, health services, and social welfare, both demands based on their reading of the old treaties. 38. To ignore the political anomaly that has arisen during 2 centuries of Indian treaty making is to ignore the actual history of Indian-white relations and to destroy any realistic foundation for future programs and development based on that history. Part 1. A treaty system. The Indian treaty system of the United States did not spring forth full-blown from some statesman's brow. No federal commission or task force proposed a blueprint for relations with the Indians who inhabited aboriginal lands within the territorial boundaries of the United States. To be sure, there were precedents of colonial and British imperial policy, and the idea of formal treaties with Indian tribes had roots in European practice. But the United States worked out a set of procedures on its own, reacting to the crisis on its frontiers and mindful of the high republican principles it was testing under the eyes of the rest of the world. Practical decisions were made by the federal legislature and its committees, then by the president, his advisors, and the treaty commissioners, and finally, after the Constitution was adopted, by the Senate. State governments, too, sought to protect their interests touched by treaty making, and the Indian leaders, astute and resourceful, fought to preserve their lands and their autonomy within a context of intertribal and intratribal divisions. The decisions made were not inevitable. Many of them could have gone some other way, but by the end of the 18th century certain patterns became accepted and the procedures standardized. Thus, management of Indian affairs fell to the federal government, not to the states. The general stipulations on treaty making embed. Page 22. in the Constitution were specified in practice by George Washington and the Senate. Indian protocol and ceremonies, at first adopted by United States commissioners, were cast aside as the power of the new nation increased in comparison with that of the Indians, and it was no longer necessary to defer to Indian customs. And the treaties began to serve as vehicles for reforming the cultures of the Indians to bring them into conformity with white society. Though not yet perfected, a treaty system was in place by the time Thomas Jefferson assumed the presidency. 1. Page 23. Chapter 1. The Revolutionary War years. During the Revolutionary War, as the Continental Congress groped its way toward a satisfactory procedure for dealing with the Indian tribes within the boundaries of the nation, the United States got its first taste of treaty making with the Indians. The Congress hoped to gain the friendship or at least the neutrality of the tribes in the war with Great Britain, to ease the continuing pressure of white settlement on Indian lands, and withal to maintain a posture of justice and humanity that would win the support and admiration of the whole civilized world. It was not an easy task for the weakly united colonies, which were intent first of all on vindicating by military force the independence from Great Britain that they had so eloquently proclaimed in the Declaration of Independence. The colonies, of course, did not lack precedents on which to base their actions. The mother country, against whom they were now rebelling, had dealt with the American Indians for almost 2 centuries. The two cultures, marked by distinct race, had worked out patterns of accommodation for coexistence. Colonial governors, assemblies, and other agencies spent a good deal of time on problems concerning the struggle for control of America's lands. The Indians, on their side, followed diplomatic and economic interests of their own and were not merely passive recipients of European initiatives. Out of the joint. Page 24. Concerns, as a means of diplomatic engagement, came numerous treaties and treaty councils. 1. The role of Indian treaties. Confusion about the initial dealings of the Congress with the Indians arises from reading back into the past our modern understandings of the word treaty. The current prevailing sense is a contract between 2 or more states, relating to peace, alliance, commerce, or other international relations, and also, the document embodying such a contract, formally signed by plenipotentiaries appointed by the government of each state. But in the colonial and early national periods of United States history, the term also had an alternate meaning, now considered rare or obsolete, that was widely used. A treaty in that sense was the act of negotiating, the discussion aimed at adjustment of difference or the reaching of an agreement, and by extension the 1. Alden T. Vaughan, ed., Early American Indian Documents, Treaties and Laws, 1607-1789, 20 volumes projected, 1, 13. This series, when completed, will be an invaluable source for the colonial period, presenting reliable texts of key documents, including treaties and reports of treaty councils. There is a small corpus of scholarly works on colonial treaties, mostly British treaties. See references in Francis Paul Prucha, A Bibliographical Guide to the History of Indian-White Relations in the United States, 119, and its supplement, Indian-White Relations in the United States, A Bibliography of Works published 1975-1980, 30. Recent studies include Dorothy V. Jones, License for Empire, Colonialism by Treaty in Early America, which discusses a treaty system of accommodation between Great Britain and the Indians, 176,368, the transformation of that system, 176,886, and the emergence of a colonial treaty system, 178,796, Francis Jennings, ed., The History and Culture of Iroquois Diplomacy, an interdisciplinary guide to the treaties of the Six Nations and their League, which accompanies an extensive microfilm edition of Iroquois Treaty Documents, Iroquois Indians, A Documentary History of the Diplomacy of the Six Nations and their League, ed. Francis Jennings, for which there is a printed guide, and Dorothy V. Jones, British Colonial Indian Treaties, in Handbook of North American Indians, Volume 4, History of Indian-White Relations, ed. Wilcome E. Washburn, 18590, which appends a table of Indian treaties with Britain and British colonies, 16071775, prepared by George Collot. Page 25. Meeting itself at which such negotiations took place. Point 2. The language of the Continental Congress and its contemporaries makes it clear enough from the context which sense of the word is meant. The documents are full of such terminology as holding a treaty with the Indians, inviting Indians to a treaty, providing military support and purchasing presents for a treaty, or greeting Indians as they arrived at a treaty. These gatherings or councils, following British colonial custom, had a number of purposes. The open discussion itself was of primary importance, for it was a vehicle for expressing or developing mutual friendship. In an exchange of views, usually expressed according to the style, rubrics, and protocol of the Indians, the commissioners of the Congress made known their concerns and demands, while in turn the Indian spokesmen voiced their complaints, grievances, and desires. There could be a beneficial clearing of the air, and such parleying was an end in itself, as each side expressed its friendship for the other, past wrongs were forgiven, and promises of one sort or another were firmly made. Especially among the Iroquois and the northwestern tribes, speeches were confirmed by exchange of strings or belts of wampum. The meetings sometimes brought to light divisions between the tribes, a diplomatic fact that the United States commissioners learned to appreciate and even to encourage. Point 3. A second purpose or function of the councils was the presentation of gifts to the assembled Indians. The exchange of presents was a part of Indian protocol, but in many cases it became a one-way street, as the Congress provided presents, often goods badly needed by the Indians to win or keep the friendship of the tribes. The Indians depended upon the articles provided, and the United States early learned the importance of finding appropriate goods to supply the Indians in order to keep their loyalty. Attempts were made to gain the support of influential chiefs by special presents and by marks of authority and esteem, such as silver medals, ornamental gorgets, and wristbands, which had also been the custom among the European nations in their dealings with the Indians. Meetings, moreover, were an opportunity to overawe hesitant tribes by a display of military force. Many of the councils, sometimes to the dismay of the Indians, were held at established forts, and for some, additional troops or state militia were at hand or in readiness for any overt hostility on the part of the Indians. In the beginning, the production of a written agreement signed by the negotiators and ratified by the governments, a treaty in the modern sense, was not a primary consideration. The meeting itself was the significant event, and for the Indians the exchange and acceptance of wampum strings and belts confirmed the decisions at the council. The belts with their designs were memory aids in recalling the contents of the conferences, and such oral tradition was considered a suitable substitute for paper documents. Of the numerous treaties held with Indians by commissioners of the Continental Congress during the Revolutionary War, only one, a treaty with the Delawares at Fort Pitt in 1778, resulted in a formal document, the first in the standard collections of United States Indian treaties. The United Colonies faced a severe challenge from the Indians in the north, where the powerful League of the Iroquois leaned toward its old friends, the British; in the south, where Cherokees, Creeks, Choctaws, and Chickasaws adhered to the British cause or engaged in friendly intercourse with the Spanish; and in the west, where tribes across the Appalachians in the Kentucky District of Virginia and in the region northwest of the Ohio River resisted the encroachment of white settlers with open hostility. Point 4. Individual colonies sent commissioners to the tribes, but relations with the Indians could not be handled adequately by disparate provincial actions. On July 12, 1775, therefore, the Continental Congress established 3 departments for Indian affairs: Northern, for the 6 nations of the Iroquois and Indians to the north of them; Southern, for the Cherokees and all others to the south of them; and Middle, for the tribes living in between. For each department Congress appointed commissioners of Indian affairs, who were to treat with the Indians in the name, and on behalf of the United Colonies. The commissioners were to work to preserve peace and friendship with the Indians and, in a quaint understatement, to prevent their taking any part in the present commotions. The appointment of Benjamin Franklin, Patrick Henry, and James Wilson for the Middle Department indicates the importance attached to the matter. 5. The commissioners, aided or substituted for by military commanders on the frontiers, called numerous councils with the Indian nations. Given the slowness in communications between Philadelphia and the frontiers and the involvement of the Continental Congress in the complexities of carrying on a war, engaging in diplomatic negotiations with European nations, and attempting to solve or prevent domestic problems, the commissioners were allowed considerable discretion in their handling of Indian matters. They tested the attitude of the Indians, picked suitable spots for the meetings, called the chiefs and warriors to the councils, arranged for presents for the Indians and for military presence at the councils, and reported regularly to the lawmakers in Philadelphia. Indian Affairs in the North. Major General Philip Schuyler was the dominant commissioner in the Northern Department. Together with other commissioners appointed by Congress and those appointed by the government of New York to represent that state's interests, Schuyler held conferences with the various tribes of the Iroquois at Albany in 1775, at German Flats in 1776, at Albany again in 1777, and at Johnstown, New York, in 1778.6. The Northern Councils represented the changing character of the war as both the British and the Americans deserted the policy of Indian neutrality and actively sought and gained military support from the tribes. For the Johnstown Council, Congress instructed the commissioners to speak to the Indians in language becoming the representatives of free, sovereign, and independent states, and in such a tone as will convince them that we feel ourselves to be so, but the commissioners were granted discretion about whether to insist upon active aid from the Indians or merely neutrality. Governor George Clinton of New York was empowered to select a suitable commissioner to attend the meeting. A report of the council, held on March 7, 1778, with a number of sachems and warriors of the Six Nations, was referred to the Board of War, but no formal treaty document came out of the meeting. 7. Another series of treaty councils was held at Pittsburgh, under the auspices of the commissioners of the Middle Department. These were for the Western tribes, although on occasion Indians from the Six Nations also attended. In September and October 1775 the first of 5 councils was held, with some Indians from the Six Nations, Delawares, Shawnees, and Wyandots in attendance. Virginia sent 5 commissioners, 2 more came from Philadelphia to represent the United Colonies. The commissioners reassured the Indians that the boundary lines established at the Treaty of Fort Stanwix in 1768 would hold, and they sought to convince them that the Patriots' cause would succeed. 8. As various Indian delegations arrived at the meeting place, they were formally greeted by the commissioners with prepared speeches, to which they responded with similar ceremonial talk, the usual fare of treaty councils carried over from British practice. 9 Condolence ceremonies were performed for the Wyandots and others, who had never been. Councils at German Flats and Albany are printed in E. B. O'Callaghan, ed., Documents Relative to the Colonial History of the State of New York, 15 volumes, 8:60531. For other actions, see JCC, 5:651, 7:166. Condoled with, agreeable to their custom since the last war, for the loss of their friends who fell in battle. Strings of wampum were presented and goods were delivered as a present of condolence, comprising 4 black strouds, 4 ruffled shirts, 4 pairs of leggings, 4 matchcoats, and a blanket. Then came more speeches, which went in part. It is from that council we are sent to renew and more perfectly establish the antient friendship that has subsisted between you and us. We therefore, brethren, bid you welcome to this council fire, and with these strings we wipe the dust and sweat occasioned by the fatigue of your journey. We likewise wipe off from your memories and clear your ears from any wicked reports which may have tended to interrupt you and our peace and the peace of our wives and child, Aaron, that you may plainly hear and understand what we say to you, a string to each nation. Brethren, with these strings we dry up your tears for the loss of your friends who have died since your last assembly at this place. We remove all grief from your hearts on this account, that your minds may be at ease whilst we deliver our embassy to you from our great united council of wise men now assembled at Philadelphia, which we hope you will hear with as much pleasure as we shall deliver it. And we collect the bones of your deceased friends and bury them deep in the earth, and transplant the tree of peace over them, that our friendship may not be interrupted nor our minds disturbed at the sight of them. A large string to each nation. With these strings we clear our council house, and desire no discontent may be allowed to enter therein, but that we may consult together with honest hearts for your and our mutual peace and happiness. A string to each nation. 10. Such speeches of goodwill, interspersed with similar orations from the Indian leaders, occupied a good many days. On October 10, the United Colonies Commissioners withdrew so that those from Virginia could conduct their business, which dealt in large measure with the return of white captives, blacks, and horses that the Indians had not yet searched out and given up. In the end, on October 19, agents were appointed to make sure that the agreements about return of prisoners and property would be carried out. There was no signed treaty, and none of the participants seemed to have expected 1.11. News from the west of continuing Indian unrest, often exaggerated, as it spread eastward, moved the Continental Congress to provide for a second council at Pittsburgh in 1776. George Morgan, the Pennsylvania land speculator and trader who had been appointed agent for the Indians of the Middle Department, spread the alarm, and Congress responded with a series of resolutions providing funds for a new gathering of the tribes. Congress directed on April 10 that so soon as conveniently may be, a treaty be held between the Commissioners for Indian Affairs in the Middle Department, and the nations of Indians to the westward, and that the said Commissioners be desired to appoint the time and place of meeting for that purpose, and give the Indians information thereof. A month later, on May 6, it extended its plan to all the departments and urged that treaties be held with the Indians as soon as practicable, and it appropriated $10,000 to the commissioners of each department for presents to the Indians and other expenses. It instructed the Standing Committee on Indian Affairs to carry into execution the resolution of May 6, and it specified that July 20 be set as the date for holding a treaty at Pittsburgh with the Indians of the Middle Department. As might be expected, affairs did not move very quickly, and on July 4, new commissioners for the Middle Department were appointed. 12. There was continuing fear that the Indians were forming a confederacy to resist the Americans, but new information from the frontier dissipated to a large extent the panic of the spring. On August 19, after a report on the state of Indian affairs on the western frontier from the Standing Committee on Indian Affairs, Congress granted discretion to the commissioners about when to hold the new treaty and where, and instructed them to make the treaty as general as possible. Representatives of only the Senecas, Delawares, and Shawnees appeared at Pittsburgh, but Morgan was able to report to Congress on November 8 that the cloud that had threatened from the west appears now to be nearly dispersed. 13. The Third Council at Pittsburgh in 1777 was intended as a similar event. On the urging of Morgan, who had invited the Delawares, Shawnees, and the Six Nations to assemble again at Fort Pitt in July, Congress appropriated funds for the meeting. The Delawares were on hand, and on Morgan's urging some Senecas, too, appeared. But frontiersmen at Pittsburgh, holding the Senecas accountable for recent murders and captures, killed several of the Indians when they arrived. For the council, thus destroying any good that might have been expected from the meeting. 14. In 1778 a fourth council at Pittsburgh with the Western Indians was prepared. On June 4 Congress authorized 3 commissioners and agreed to the necessary expenses. On June 20 it appropriated $10,000 for procuring goods and presents for the Indians and set July 23 as the date for the treaty. The commissioners were directed to dispose of the goods among the Indians in such manner as they shall judge will best conduce to conciliate their affection and secure them in the interest of these states. 15. The plan did not work out quite as intended, for the meeting did not commence until September 12. Only the 2 Virginia commissioners appeared, General Andrew Lewis and his brother Thomas Lewis, and only the Delaware Indians, but it was a significant parley nonetheless, for it resulted in the only written agreement made with the Indians during the Revolutionary War. In 1778 preparations had begun for an attack on Detroit, and Delaware friendship was essential for its success, since the expedition was to proceed through Delaware territory. That friendship was successfully sought at Pittsburgh, for some Delawares had been strongly influenced toward friendship with the Americans by the Moravian missionaries, especially David Zeisberger and John Heckewelder, who worked among them. In the ceremonial language demanded by the occasion, the Delawares at the council were told by the commissioners, "You alone of all the Western Indians seem inclined to hold fast the chain of friendship, and even in this instance it has contracted some rust, of a very dangerous nature. The paths between us are grown up with bushes, so that they can scarce be seen. They are bloody, your and our people's bones are scattered through the woods, our people stumble over them. Black heavy clouds hang over our heads. We present you with this belt of wampum, by which we open the path between us, once more, and wash away the blood that has been spilt on it. We bury the scattered bones of our deceased relations, and dispel the black clouds, and wipe the tears from your eyes. We remove all sorrow from your hearts, that joy and the bright sun of friendship may shine on you with greater luster than ever. 16. Then, with a belt of white wampum showing in black the 13 United States and the Delaware nation holding to the same chain of friendship, the commissioners presented their arguments to the Indian delegates. They offered friendship, wishing to consider the Delawares as their own people. They noted the American alliance with France, which would soon enable the United States to trample all our enemies under our feet. They promised no obligations to the Indians except such as would be for mutual good and happiness, and that would secure future peace whilst the sun or the earth endures, but they clearly intended the Delawares to be active allies against the British. After the Indians agreed to their presentation, the United States commissioners drew up a document, which was read and explained to the Indians on September 14. 3 days later these Articles of Confederation and Union were read and interpreted again, and the Indians gave their assent. The document was then signed in triplicate. 17. The signing was witnessed by a number of military men, including General Lachlan McIntosh, the commandant at Fort Pitt, who entertained the Indians with a parade of his troops in celebration and delivered a speech to the assembly, in which he told the Delawares it was time to show their friendship by taking up this hatchet like men determined to be free with us, against all our enemies and your enemies. And this belt to confirm it, expecting when I go over this river your warriors will join me, that we may grow great together, and be one people whilst the sun and moon shines or the waters run. 18. The Treaty of Fort Pitt was a treaty of formal alliance, a fact which perhaps explains why it was produced in written form. After asserting perpetual peace and friendship, the document said, and if either of the parties are engaged in a just and necessary war with any other nation or nations, that then each shall assist the other in due proportion to their abilities, till their enemies are brought to reasonable terms of accommodation. The Delawares agreed to allow free passage of United States troops through their country and to ally their warriors with the aimer. And Biography 24, 16,879. The quotation is on 17,071. A similar version of the negotiations is printed in Louise Phelps Kellogg, ed., Frontier Advance on the Upper Ohio, 1778-1779, 13,845. Icon troops. The United States agreed to build a fort in Delaware country for the better security of the old men, women, and children, whilst their warriors are engaged against the common enemy. 19. In the final article the United States agreed to guarantee the territorial rights of the Delawares. Then it provided for other friendly tribes to join with the Delawares and to form a state whereof the Delaware nation shall be the head, and have a representation in Congress. The origin of this extraordinary provision is unknown, and the extant treaty proceedings make no mention of it. 20. Nothing in the treaty was to be considered conclusive until Congress approved. The treaty was received by Congress with a letter from the commissioners on October 6 and referred to a committee, but there is no indication of any action taken. 21. The treaty on the surface seemed to be a great success, but in the end it accomplished little, and it left a bad taste in the mouths of the Delawares. John Kilbuck, one of the 3 Delaware signers, on January 20, 1779, wrote to George Morgan that he had been deceived because he had not understood the interpreter. He asserted that he had been determined to continue in that what I was so often told to do by you, which was to sit quite still and let you and the English make out the matter together, but was very much surprised when I found after my return from the treaty, that I was looked upon as a warrior. He claimed that when the tomahawk was handed to him at Fort Pitt it was done not in a warlike manner and that he had contracted only to lead the United States troops through his country as they sought the enemy. Colonel Morgan, himself, said later, there never was a conference with the Indians so improperly or villainously conducted as the last one at Pittsburgh. I am only surprised it has not had worse effects. 22. Morgan, in the spring of 1779, arranged for a Delaware delegation to Philadelphia, where the Indians could explain to the Continental Congress their dissatisfaction with the Treaty of Fort Pitt, but it availed nothing, and peace and friendship between the United States and the Delawares collapsed. The best friend of the United States among the tribe, Chief White Eyes, was murdered by frontiersmen, and eventually the tribe's council decided to join the British in fighting the United States. 23. Before that eventuality, however, still another council was held at Pittsburgh in September 1779, this time with the Wyandots, who, unlike the Delawares in 1778, were unwilling to let American troops pass through their lands in the projected attack on Detroit. There was a good deal of wampum exchanged in pledges of friendship and condolences for past enmities in speeches by Daniel Brodhead, who had replaced McIntosh in command of Fort Pitt, and Half King, the Wyandot chief, but nothing else was accomplished. 24. Indian affairs in the South. Meanwhile, a comparable series of councils was held on the southern frontiers, where conditions were as unsettled as those in the north but where more initiative was left in the hands of the states of Virginia, North Carolina, South Carolina, and Georgia. 25. The states appointed commissioners, including well-established Indian traders, to deal with the tribes, and the Continental Congress in the beginning authorized 5 commissioners for the Southern Department. Congress appointed John Walker of Virginia and Willie Jones of North Carolina, to whom were added George Galphin and Edward Wilkinson of South Carolina and Robert Ray of Georgia. 26. The plans for parleys with the Indians to maintain their neutrality, however, were aggressively countered by the British Indian Superintendent John Stuart, and in 1776 the Cherokees took up arms against the colonists. The resounding defeat of the Cherokees in this Cherokee War of 1776 by Patriot forces from Virginia, the Carolinas, and Georgia had a lasting effect and substantially removed the threat of major Indian uprisings in the South. Negotiations for a formal treaty of peace after the Patriot victory were initiated by Virginia, which appointed special commissioners to meet with Cherokee delegates to draw up a preliminary agreement. The initial discussions in April 1777 with the Overhill Cherokees dealt with declarations of peace, the return of prisoners, and the protection of the Indians' lands from white incursions. Meanwhile, South Carolina and Georgia negotiated with other groups of Cherokees at DeWitt's Corner, South Carolina. In the treaty drawn up there with the Lower Cherokees on May 20, 1777, the Indians admitted their defeat, ceded their lands east of the Unicoi Mountains, and agreed to deliver up prisoners, both white and black. The states promised to provide trade goods and to keep whites east of the new boundary line. The hatchet was to be forever buried. 27. Then, 2 months later, a formal council at Long Island of the Halston began between the Overhill Cherokees and 4 commissioners from North Carolina and 3 from Virginia. After some days of speeches from both sides, confirmed by strings of wampum, separate articles of a treaty of peace were signed on July. Treaties provided for the cessation of hostilities, return of prisoners, and cessions of land with new boundary lines. No whites were to be allowed to settle or graze cattle on the Indian lands, and whites residing in or passing through the Overhill towns were required to have a license. 28. At the same time, George Galphin conferred with potentially hostile Creeks, hoping to maintain peace by promises of trade. 29. But during much of the Revolutionary War, southern Indian affairs were in control of the British, who maintained their influence with the tribes, upon whose loyalty they depended. Indians were stirred up against the Patriots, and sporadic raids and counter-raids continued, including an invasion of Cherokee lands from Virginia in 1780. Then, as the Patriot military cause succeeded in the area, the Indians lost their British support. By 1782 the Cherokees and Chickasaws sought to make peace with the Americans. Only the Creeks stood by the British, bolstered by the emergence of Alexander McGillivray as leader of the Creek Confederation, but some dissident Creeks, importuned by Georgia, ceded lands in a treaty with the state at Augusta in 1783.30. The Continental Congress, acting for the United Colonies, appeared to take little or no part in these southern affairs. No formal treaties negotiated and signed by special commissioners of the Congress appeared until after the Treaty of Paris in 1783.31. The Articles of Confederation. The action of the Southern states in dealing with the Cherokees and Creeks during the Revolutionary War pointed up a persistent problem in treaty making in the early years of the new nation. Should treaties be made by the separate states, who inherited the sovereignty of the British Crown and who were intimately concerned with the Indians on their borders, or was treaty making an exclusive power of the Continental Congress, representing the Confederated States? It was a question of states' rights versus the central government, and it was not easily settled either in theory or in practice, although from the beginning the decision moved toward central control of Indian affairs. Benjamin Franklin's Albany Plan of Union of 1754 had provided that the President General with the advice of the Grand Council should hold or order all Indian treaties, regulate all Indian trade, make peace and declare war with Indian nations, make all Indian purchases of lands not within the bounds of particular colonies. 32. When Franklin in the Continental Congress drew up a draft for a confederation on July 21, 1775, he relied upon the Albany ideas. He offered two articles. First, no colony could engage in offensive war against the Indians without the consent of Congress, which would be the judge of the justice and necessity of the war. Second, a perpetual alliance, both offensive and defensive, should be made with the Six Nations. For them, as well as for all other tribes, boundaries should be drawn, their land protected against encroachments, and no purchases of land made except by contract drawn between the Great Council of the Indians and the Congress. Agents residing among the tribes would prevent injustices in the trade and provide for the personal wants and distresses of the Indians by occasional presents. The purchase of land from the Indians was to be by Congress for the general advantage and benefit of the United Colonies. 33. The committee appointed to draft the Articles of Confederation put the task into the hands of the able writer John Dickinson, a Pennsylvanian like Franklin and an advocate of congressional control of the western lands. His draft, submitted on July 12, 1776, elaborated Franklin's plan. In the general enumeration of powers granted the central government, Dickinson included regulating the trade, and managing all affairs with the Indians. 34. This centralized control of Indian affairs did not appeal to all the states. South Carolina, for example, wanted to handle Indian affairs herself. But the overall necessities of controlling the Indians prevailed, for, as James Wilson pointed out, the Indians refused to recognize any superior authority, and only the United States in Congress assembled could hope to deal with them effectively. Above all else, rivalries between colonies in treating with the Indians had to be avoided. 35. When Congress accepted an amended draft on August 20, the Franklin-Dickinson articles about alliance, maintaining boundaries, and purchase of the lands were omitted. Only a simple statement appeared: the United States assembled shall have the sole and exclusive right and power of regulating the trade, and managing all affairs with the Indians, not members of any of the states. 36. Even this did not satisfy the advocates of state control, who were jealous of individual state authority within their own territories, and corrective amendments were offered. Congress rejected two alternative amendments before agreeing to the provision that appeared in the ratified document. In its long enumeration of the powers of Congress, the Articles of Confederation declared, "The United States in Congress assembled shall also have the sole and exclusive right and power of regulating the trade and managing all affairs with the Indians, not members of any of the states, provided that the legislative right of any state within its own limits be not infringed or violated." 37. The document was approved by Congress on November 15, 1777, but not ratified until March 1, 1781, because Maryland held out until the landed states agreed to transfer their western lands to the national government. Thus the principle was enunciated that the management of Indian affairs and the regulation of Indian trade belonged to the federal government, but it was far from clear what was meant in practice by Indians, not members of any of the states, or what would infringe or violate the legislative right of any state within its own boundaries. New York continued to deal with the Iroquois and the southern states with the Indians on their frontiers, each interpreting the articles according to its own interests. A second question, closely tied to state versus federal control of Indian affairs, was whether the Indian tribes were to be considered the same as foreign nations or whether they were primarily a domestic issue. If they were members of any of the states, they could hardly be considered foreign states, and treaties signed with them would be domestic conventions. If, however, the tribes transcended state authority and could be dealt with only by the National Congress, their status as international bodies would be considerably advanced. There was little consistency in the actions of European nations during the colonial period or of the states and the Continental Congress during the Revolutionary War. In some cases the Indians were described as dependent or subjects, at other times they were addressed in councils as allies. 38. The situation becomes clearer, however, when one considers the sections of the Articles of Confederation and the practice of the Continental Congress concerning treaties with European nations. Procedures for dealing with established foreign nations were quite different from those for dealing with the Indian nations, although eventually the patterns of the former crept into those of the latter. Article 6 of the Articles of Confederation declared, "No state without the consent of the United States in Congress assembled, shall send any embassy to, or receive any embassy from, or enter into any conference, agreement, or alliance or treaty with any king, prince, or state." Article 9 provided, "The United States in Congress assembled, shall have the sole and exclusive right and power of determining on peace and war. Of sending and receiving ambassadors, entering into treaties and alliances. In the case of imminent danger of an Indian invasion, however, war could be engaged in by a state." The provision in Article 9 about the sole and exclusive right and power of the Congress to regulate trade and manage all affairs with the Indians was tucked away in a list of exclusive powers that included regulating the value of coins, fixing weights and measures, establishing post offices, and appointing officers of the Army and Navy. Domestic questions all. The Continental Congress during the Revolutionary War made elaborate preparations for treaties of alliance or commerce with European nations. A detailed plan of a treaty was drawn up, discussed, and amended in Congress, and specific instructions were issued to specially appointed agents. 39 For Indian councils, however, the commissioners for the several Indian departments were usually granted wide discretion for inviting Indians to council and negotiating with them, and, except for the case of the Delawares in 1778, no formal documents resulted. During the Revolutionary War, Indian affairs were considered and treated as a domestic matter, not a foreign question, and most of the documents refer to Indian tribes within the limits of the United States. The Indian tribes were treated to some extent as independent but at the same time in some way subject to the United States because they were within its boundaries. Treaties with the Indians fell under the jurisdiction of the Board of War, those with foreign nations under that of the Committee on Foreign Affairs. At Indian treaties, presents for distribution to the chiefs and warriors were a major concern, and it was the practice to provide military troops at or near the council grounds to overawe the Indians and to protect the commissioners of the United States, if necessary, from Indian attack. Expenses of the treaty, often considerable because of the large numbers of Indians attending, were borne solely by the United States or by the individual state. When the war ended, the United States, still uncertain about the responsibilities of its new independent status, continued to rely upon this legacy of Indian relations from the colonial and revolutionary periods. Page 41. Chapter 2. Treaties of Peace after the Revolution. The Treaty of Paris of 1783, by which Great Britain recognized the independence of the colonies and their sovereignty over the western lands reaching to the Mississippi, made no mention of the Indians, who for the most part had sided with the British. The tribes, in effect, were deserted by their ally in war, and in their discouragement and disarray had to make peace separately with the new nation. The Indians did not think that they had been militarily defeated, but the United States looked upon itself as a conqueror and counted the Indians among the conquered. 1. Plans for peace. The Congress under the Articles of Confederation acted quickly and responsibly to ensure peace. On May 1, 1783, it directed the Secretary of War to inform the Indian nations that preliminary articles of peace had been agreed on and that hostilities had ceased with Great Britain. He was to tell the Indians that the British forts would soon be evacuated and to intimate to the Indians that the United States were disposed to enter into friendly treaty with the different tribes. But unless hostile Indians stopped their attacks upon citizens of the states and accepted the offers of peace, Congress would take strong measures to compel them. Congress was concerned also about the steady encroachment onto Indian land by whites. A proclamation of September 22 forbade settlement on lands inhabited or claimed by the Indians outside of state jurisdiction and purchase or other receipt of such lands without the express authority and direction of Congress. It declared, moreover, that any such purchases or cessions were null and void. 2. A report submitted on October 15 by a committee headed by James Duane of New York proposed a policy for dealing with the Indians of the northern and middle departments. The committee argued strongly against any action that would result in war, but it nevertheless proposed drawing proper boundary lines that would restrict the Indians enough so that lands would be available to fulfill pledges of land bounties made to soldiers during the war and to provide for expanding population. The committee spoke of the Indians as conquered nations, whose lands could be taken by right of conquest. And even if the right of conquest were waived, it said, the destruction wrought by Indians and the outrages and atrocities they had committed required atonement and a reasonable compensation for the expenses incurred by the United States. 3. The committee proposed a general conference with the tribes in order to receive them back into the favor and friendship of the United States and to determine the boundary lines that would divide the white settlements from the villages and hunting grounds of the Indians. The government commissioners, the committee said, should demand hostages for the return of all prisoners but should indicate at the same time the nation's preference for clemency instead of rigor in dealing with the defeated Indians. And the importance of the Indian trade was not forgotten. To prevent violence, fraud, and injustice toward the Indians, the trade must be regulated and the traders required to give security that they would follow the regulations. The question of whether there should be just one general convention with the Indians or whether separate treaties should be sought from the different tribes was answered first one way and then another. Duane's committee favored a general treaty and would yield to separate conventions only in case of inevitable necessity. But Congress on occasion had to fall back on separate councils and in fact signed 2 treaties with the 6 nations, 3 with western tribes, and 3 more with southern Indians. The Treaty of Fort Stanwix. Congress began first in the north, hoping for a settlement with the Iroquois and the western tribes together. In February 1784 it directed General Philip Schuyler to send notice to the Indians that Congress was seeking a comprehensive treaty with them as soon as the season and other necessary circumstances will permit, and that in the meantime, if they maintained peace, they could depend on the protection of the United States. On March 4 it elected 5 commissioners to negotiate with the Western Indians as far south as the Cherokees. In what amounted to prior ratification of whatever treaties might be signed, Congress gave authority to any 3 of the commissioners to treat with the Indians and promised to hold valid and to carry out whatever might be agreed upon. 4. Meanwhile, a good deal of activity was taking place on the frontiers. 5 On January 11, 1784, General Schuyler met with tribal leaders at Schenectady and spoke strongly to them. He reminded them that they had not kept their promises of peace in 1776, but he added, and yet Congress, with a magnanimity and a generosity peculiar to a free people, are willing to forget the injuries and give peace to the Indians. He gave the Indians a copy of the peace treaty with Great Britain to convince them that the treaty contained no stipulations for the Indians. They are not even so much as mentioned, he said of the Indians, they are therefore left to settle matters with Congress. He added that the conditions will be doubtless such as Congress have a right to insist upon and as the Indians out of regard to their future welfare ought to accept. 6. The state of New York was making its own plans for treating with the Indians. In this regard, Governor Clinton in the summer of 1784 received advice from James Duane about interpreting the rights of Congress in Indian affairs under the Articles of Confederation. If the tribes are to be considered as independent nations, detached from the state, and absolutely unconnected with it, Duane wrote, the claim of Congress would be uncontrovertible. On the other hand, the state could treat them as antedependents of New York. On this ground, Duane argued, the tribes in question may fall under the character of members of the state with the management of whom Congress hath no concern. He thought the Indians should be reconciled to that idea, and he urged careful consideration to the style as well as the substance of the state's communications with them. To that end, Clark, Oliver Wolcott, Nathaniel Greene, Richard Butler, and Stephen Higginson, late in April, Benjamin Lincoln and Arthur Lee were chosen to replace Greene and Higginson, who declined to serve. Ibid, 27,374, 282. A vivid, candid picture of the interstate rivalries that plagued the dealings with the Indians is given in a letter of Charles Thomson, Secretary of Congress, to his wife, October 21, 1783, Congress at Princeton, being the letters of Charles Thomson to Hannah Thompson, June-October 1783, ed. Eugene R. Sheridan and John M. Murrin, 8283. He advised that the Indians should not be addressed as nations, and he objected to the use of the word treaty, which seems too much to imply equality. 7. At the end of August and in the early part of September 1784, the New York governor and 3 state commissioners met with representatives of the 6 nations at Fort Stanwix. The Indians listened to the commissioners, but in the end, influenced by the Mohawk leader Joseph Brant, they refused to deal with the state until they had met first with the commissioners of the 13 states. 8 The Western Indians, insisting that the negotiations be at Niagara, refused to go to Fort Stanwix to treat with Governor Clinton, and it was impossible to assemble them for a council with the United States so late in the season. The negotiations of the commissioners of Congress at Fort Stanwix were thus limited to the 6 nations, with only a few Shawnees as spectators. 9. The council at Fort Stanwix in October was a dramatic encounter, with forceful statements on each side accompanied by the exchange of wampum strings and belts. The United States Commissioners Oliver Wolcott, Richard Butler, and Arthur Lee issued a formal statement, which set forth their authority and asserted that the Indians should treat only with them. They recalled the error the tribes had made in going to war on the side of Great Britain and how they had in the end been abandoned. Peace, they noted, was necessary for the Indians and that it could be obtained by giving up their prisoners and by making an appropriate cession of land. 10. The Indian reply was made by the Mohawk chief Aaron Hill, who adopted a strong and arrogant tone, speaking, he said, not only for the 6 nations but also in the names of all the other tribes. He declared, we are free and independent and at present under no influence. We have hitherto been bound by the great king, but he having broke the chain, and left us to ourselves, we are again free, and independent. In regard to the prisoners, he suggested that the commissioners themselves send a delegation back to the tribes to pick them up. The next day the Seneca half-blood corn planter spoke. He excused the actions of the Indians in the war and then, with some hesitation, set forth a proposed boundary line, which, however, was about the same as that fixed at Fort Stanwix by the treaty in 1768.11. On October 20 the commissioners replied in a dictatorial speech, probably delivered by General Butler. Butler found it extraordinary that the Six Nations should speak for the Western Indians, because only the Six Nations had been summoned to treat, and he asked for some authority, either in writing or in wampum belts, without which your words will pass away like the winds of yesterday that are heard no more. He dismissed the claim that the Indians had merely been fulfilling their covenants with Great Britain in warring against the colonists. Where was your sense of covenants, he asked, when after solemnly covenanting with us in 1775, and again as solemnly in 1776, receiving our presents to cover you, to comfort, and to strengthen you, immediately you took up the hatchet against us, and struck us with all your might. Then he rejected the claim to independence made by Hill. It is not so. You are a subdued people, you have been overcome in a war which you entered into with us, not only without provocation, but in violation of most sacred obligations. 12. On the questions of prisoners and of the boundary line, Butler declared that the Indians had not given the smallest satisfaction. He asserted that only the Indians could collect and deliver up the prisoners and that they were obliged to do so. And he rejected the boundary line proposed by the Indians. We shall now therefore, he concluded, declare to you the condition, on which alone you can be received into the peace and protection of the United States. He then read to the Indians the 4 articles the commissioners had drawn up and commented briefly on each one. Special claims of Pennsylvania were handled at Fort Stanwix immediately after the treaty with the United States. On October 23 Pennsylvania commissioners, who had attended the General Treaty Councils, got the agreement of the Six Nations to relinquish all their claims to land in Pennsylvania except for 800 acres on the Allegheny River reserved for Cornplanter and his heirs. In return Pennsylvania provided a large quantity of trade goods for the Indians. 16. The Treaty of Fort Stanwix was not an auspicious beginning of treaty making by the independent United States. The United States used the procedural forms of treaty negotiations to force unilaterally upon the Indians the demands of the United States, in this case return of prisoners and, most important, land cessions. It did this under an umbrella of magnanimity. It spoke of giving peace to the tribes and of receiving them into the protection of the United States, and it delivered goods to the Indians in consideration of their present circumstances and to carry out its humane and liberal views. But the blatant reliance on the principle of conquest set a bad tone, and in fact the claim of conquest later had to be abandoned. The failure to include Western Indians in the treaty gave substance to the Indians' claim that the treaty was invalid since it provided for land cessions without the approval of all the tribes. Nor did the preliminary action of New York in meeting with the Indians and the subsequent agreement of Pennsylvania with the Six Nations do anything to dispel the cloud of confusion about the precise line of jurisdiction between the United States and the individual states in treating with the Indians. After Fort Stanwix, the state of New York, by numerous state treaties with the Six Nations, managed to acquire most of the Indian lands within New York. 17. Treaties with the Western Indians. The United States commissioners turned next to deal with the Wyandots and Delawares and with attending Ottawas, Chippewas, Munsees, and Senecas. At Fort McIntosh a treaty was signed on January 21, 1785, by Commissioners Plenipotentiary of the United States George Rogers Clark, Richard Butler, and Arthur Lee, and by tribal representatives, including the Wyandot half-king and the Delaware Captain Pipe. 18. The council and the treaty followed closely those at Fort Stanwix, exacting from the Indian signers present a cession of land that should have had the approval of the Confederated Northwest tribes. At the opening of the conference on January 8, 1785, the commissioners made it clear to the Indians present that they stood alone against the United States. They read the Treaty of Alliance with France, in which the French king had renounced all claims to lands within the United States, and the Treaty of Peace with Great Britain. The King of Great Britain in his treaty with the States, they told the Indians, has not stipulated anything in favor of you and of the other Indian nations who joined him in the war against us. You are therefore left to obtain peace from the States, and to be received under their government and protection, upon such conditions as seem proper to Congress, the Great Council of the States 19. The Indians pleaded to retain the lands on which they lived and which had been handed down to them by their fathers, but their pleas were brushed aside by the commissioners, who replied, "You have been particular in describing to us the claim and title of each particular tribe. The detail of these claims and title may appear to be of consequence among yourselves. But to us and to the business of the council fire to which we have called you, they have no relation, because we claim the country by conquest, and are to give not to receive. It is of this that it behooves you to have a clear and distinct comprehension. Point 20. The treaty document, signed on January 21, 1785, described a boundary line between the Wyandot and Delaware Indians and the United States. Within the lines, the United States allotted the lands to those tribes and to Ottawas who lived there. Outside the lines, the lands belonged to the United States, and the Indians were forbidden to settle on them. The first article of the treaty provided for hostage-zone Wyandot chief and 2 Delaware chiefs to be retained until prisoners were given up. In the second article, the Indians acknowledged themselves and all their tribes to be under the protection of the United States and of no other sovereign whatsoever. Other sections reserved lands for United States trading posts and military forts, withdrew American protection from whites who might settle on the Indian lands, and directed the handing over of Indians who committed robbery or murder against citizens of the United States. As at Fort Stanwix, the treaty provided for the distribution of goods to the Indians upon its being signed. Point 21. The Treaty of Fort McIntosh reinforced the blustering attitudes that the United States had displayed at Fort Stanwix. Instead of assuring peace, the treaty increased the Indians' discontent and resentment and strengthened their desire to unite in defense of the Ohio River boundary. The British agent Alexander Mackay wrote to Sir John Johnson on May 29, 1785, "The impolicy of exacting or enforcing such terms upon the Indians was visible by the disgust shown upon this occasion by all nations." 22. Congress still needed to deal with the more western tribes: Shawnees, Miamis, Wees, Piankashaws, Potawatomis, Kickapoos, and others. To provide for them, it adopted a formal resolution for holding a treaty conference at Vincennes on the Wabash, gave specific authority to the commissioners, and instructed them to make the contemplated cession of land as extensive and liberal as possible. The continuing hostility of the tribes, however, made it impossible for the commissioners to hold negotiations as far in the interior as Vincennes, and recognizing the obstacles, Congress directed that the council be held on the western bank of the Ohio, at the rapids or at the mouth of the Great Miami, and it provided for troops to be present at the negotiations. Point 23. Again, the United States failed in its hope of making a general treaty with the Western Confederacy, for many Indians opposed the partial treaties signed at Fort Stanwix and Fort McIntosh and rejected the invitations of the United States commissioners. Only the Shawnees arrived to treat at Fort Finney, which had been established at the mouth of the Miami. When the council began at the end of January 1786, the commissioners presented the usual terms: recognition of United States sovereignty over the land ceded by Great Britain, acceptance of the protection of the United States, surrender of hostages for the return of prisoners, relinquishment of claims to their lands east of the Miami River, and agreement to punish, under American law, crimes against whites in the Shawnee country. These exorbitant demands the Shawnee chief Kakupaleth rejected outright. "By what you have said to us yesterday, we expected everything past would be forgotten, that our proposals for collecting the prisoners were satisfactory, and that we would have been placed on the same footing as before the war. Today you demand hostages till your prisoners are returned. You next say you will divide the lands. I now tell you it is not the custom of the Shawnees to give hostages. Our words are to be believed. When we say a thing we stand to it. We are Shawnee, and as to the lands, God gave us this country. We do not understand measuring out the lands, it is all ours. You say you have goods for our women and children. You may keep your goods, and give them to the other nations. We will have none of them. Brothers, you seem to grow proud, because you have thrown down the King of England, and as we feel sorry for our past faults, you rise in your demands on us. This we think hard. Point 24. Such a tone only irritated the American commissioners. General Butler answered the Indians belligerently, "You have addressed us with great warmth. We think the answer unwise and ungrateful, and in return for just and generous proposals, you have not only given us improper language, but asserted the greatest falsehoods." He warned that the United States intended to hold firm to its conditions and that refusal of the terms would mean war. "The destruction of your women and children or their future happiness," he said, "depends on your present choice. Peace or war is in your power, make your choice like men, and judge for yourselves." The Indians were chastened and meekly agreed. "Brethren," Kukupilev said, "you have everything in your power, you are great, and we see you own all the country, we therefore hope, as you have everything in your power, that you will take pity on our women and children. And we agree to all you have proposed, and hope, in future, we shall both enjoy peace, and be secure." 25. The treaty signed by Kukupilev and the other Shawnee chiefs on January 31, 1786, was more like a dictated peace treaty than the result of negotiations between two sovereign powers. It called for 3 hostages. The Shawnees acknowledged the United States to be the sole and absolute sovereigns of all the territory ceded to it by Great Britain. The United States granted peace to the Shawnee Nation and received the Indians into its friendship and protection and allotted lands to them within specified boundaries. Indian criminals against whites were to be delivered up for punishment, and whites illegally settling on the Indians' lands forfeited their government's protection. Point 26. The treaty at the mouth of the Great Miami did no more to assure peace than had that at Fort McIntosh. The Shawnees had been intimidated into agreeing to its terms and felt justified in repudiating the treaty. Attacks and reprisals continued to mark the relations between the Shawnees and the Kentucky frontiersmen. Even though the United States had failed to achieve its goals in the 3 treaties signed between October 1784 and January 1786 in the North, the nation acted as though the Indian cessions of much of Ohio. Journal, published in olden time, 2:51825, 52931. Kukupilev's speech is on page 522. Were an accomplished fact and passed ordinances for surveying, selling, and governing the land. Yet the national government could not restrain the eager speculators and settlers who sought the lands still in Indian hands. After a tour of the West in 1784, George Washington had reported the extent of the menace. Such is the rage for speculating in, and forestalling of lands on the west side of the Ohio, he said, that scarce a valuable spot within any tolerable distance of it, is left without a claimant. Men in these times talk with as much facility of 50, 100, and even 500,000 acres as a gentleman formerly would do of 1,000 acres. In defiance of the proclamation of Congress, they roam over the country on the Indian side of the Ohio, mark out lands, survey, and even settle them. This gives great discontent to the Indians, and will, unless measures are taken in time to prevent it, inevitably produce a war with the western tribes. 27. The United States, however, was not yet ready to go to war, and it began to soften the arrogant position of conquerors that had been behind the dictated treaties and which, it became increasingly clear, had not solved the problem of Indian hostility on the frontier nor guaranteed the peaceful expansion of white settlers. As an alternative to war, it sought to better organize its trade and other relations with the Indians. In fact, on May 17, 1786, Congress disbanded the treaty commissions established in the previous year because the future connection and intercourse with the several Indian nations may, at less expense, be maintained by a proper organization of the Indian Department. 28. Such action indicated that the Congress thought of treaties with the Indians as only one way of proceeding, gone an expensive way. Its belief that it would be better to rely on a well-organized Indian Department pointed up the fact that the Indians were considered chiefly a domestic matter. After considerable attention to alternatives, Congress on August 7, 1786, enacted an ordinance for the regulation of Indian affairs, which reasserted the sole and exclusive right of Congress to deal with Indian affairs. The ordinance provided for southern and northern districts with a superintendent in each to carry out the instructions of Congress and to report, through the Secretary of War, to Congress. Special regulations requiring licenses and bonds were established to govern the trade with the Indians. In a set of instructions issued to the superintendents in February 1787, Congress recalled the Republican principles of the new nation and sought to allay Indian resentment and hostility. The United States are fixed in their determination, the instructions read in part, that justice and public faith shall be the basis of all their transactions with the Indians. They will reject every temporary advantage obtained at the expense of these important national principles. Congress directed the superintendents to seek out the causes of Indian unrest and correct them as far as possible. Abuses irritating to the Indians could be checked by controlling the traders, and military commanders on the frontier were to be called upon to help enforce the ordinance. 29. The treaties of Fort Harmar. Although there still were cries from many for military action against the Indians, Secretary of War Henry Knox in July 1787 urged new treaties instead of military action. He spoke of the strong principles of humanity which ever forbid a war for an object which may be obtained by peaceable and honorable means, and he argued that the nation was utterly unable to maintain an Indian war with any dignity or prospect of success. Even if a war were successful, he noted, peace must ultimately be accomplished by a treaty with the Indians. Knox did not want the United States to seem to prefer war to peace and thus arouse the verdict of mankind against it, for, he shrewdly noted, men are ever ready to espouse the cause of those who appear to be oppressed provided their interference may cost them nothing. A warlike attitude on the part of the United States would stain its reputation, and Knox wanted to follow the British custom of paying for the lands ceded by the Indians rather than take them by right of conquest. The British, he said, thought a treaty and purchase money for land, was the most prudent measure and in no degree dishonorable to the nation. He realized that in a new treaty with the northern tribes the boundaries fixed in the original treaties might have to be discussed again and payment made for the cessions. On July 21 Congress officially resolved to pursue a treaty with the Indians to be held at Vincennes. 30. Gress's views about Indian relations. The committee saw that either a war or a treaty to adjust difficulties had to occur soon. It opted for a treaty, but it recommended a change in treaty practice. Instead of holding frequent and separate treaties with the various tribes which can have no permanent effect upon the temper of the Indians, or tendency to produce a general acquiescence in them to the cessions made of any of their lands, the committee wanted general treaties with chiefs of many tribes at the same treaty, for such treaties would not only be able to adjust all issues relative to the same subject but would be less frequent and less expensive. It wanted to give durable gifts to the chiefs instead of lavishing presents upon all kinds of Indians, and it admonished, instead of a language of superiority and command, may it not be politic and just to treat with the Indians more on a footing of equality, convince them of the justice and humanity as well as power of the United States and of their disposition to promote the happiness of the Indians. Finally, it recommended the principle of fairly purchasing the Indian lands. 31. In October 1787 Congress directed the Governor of the Northwest Territory, Arthur St. Clair, to hold a general treaty with the Indians north of the Ohio. But the instructions drawn up on October 26 showed the ambivalence of the lawmakers. 32 The governor was to remove all causes of controversy, so that peace and harmony may continue between the United States and the Indian tribes, to regulate trade, and to settle boundaries. The boundary line to be proposed was an extension to the Mississippi of the east-west line stipulated in the Land Ordinance of 1785, a line that began where the Ohio crossed the western boundary of Pennsylvania and considerably north of the rest of the Ohio River, which the Indians wanted to be the boundary. 33 These were incompatible ends, for the boundary line specified was precisely what was rejected by the Indians, still supported in their claims by the British, who retained the Northwest forts on United States soil. So the matter dragged on. Congress appropriated considerable sums of money for the treaty and modified some of its instructions to St. Clair, directing him on July 2 to fix the boundary even farther to the north at the 41st parallel rather than at the line stipulated in his original instructions. 34 St. Clair, to his credit, objected to the boundary lines proposed by Congress. Even the first line, he wrote to Secretary Knox in July 1788, would not be agreed to without much difficulty, for the land to be thus acquired contained the principal hunting grounds of the Indians and was the home of some tribes not well disposed toward the United States. To extend the boundary to the 41st parallel he thought completely out of the question. The Indians would not give up the lands for any sum that the United States could afford to offer. If, by chance, the Indians did sign a treaty with such boundary stipulations, they would never consider themselves bound by it, so that instead of establishing a solid and permanent peace, a foundation may probably be laid for irreconcilable hatred and wasting wars, and the money be thrown away into the bargain. 35. St. Clair was unable to get any Indians to appear for a treaty until the final days of 1788, when Iroquois, Wyandots, Delawares, Ottawas, Chippewas, Potawatomis, and Sacs came to Fort Harmar, a fort that had been established in 1785 at the mouth of the Muskingum River. Despite Knox's strong advice and the changed tone in Congress's deliberations about dealing with the Northwest Indians, the council at Fort Harmar was little more than a repetition of those of the earlier treaties. St. Clair discovered that the Indians were not united, and he brushed aside their renewed proposal of the Ohio boundary, the Indians' willingness to settle for the Muskingum River as the western line of white settlement was ignored. Irritated by Indian resistance, St. Clair on January 6 assumed some of the air of superiority that had marked the earlier treaty negotiations. The United States would have been justified to all the world to have marched their armies into your country and punished you in an exemplary manner, but they chose to give an example of clemency. They considered that the war had spread misery enough over many countries and were desirous to prevent its spreading wider. They offered you peace upon the condition of surrendering a part of your country. You accepted it upon that condition, and a boundary was established. If there were ever engagements that should be binding upon mankind, they were these, for the you states, not only buried the remembrance of past injuries but made a generous division of the ceded country, with you, and made you very valuable presents of goods besides. St. Clair told the Indians they could have either peace or war. If they would renew and confirm the boundary set at Fort McIntosh, he would insert in the treaty a provision allowing them to hunt on the land they had ceded and make a payment in goods. He did not have the nerve to propose the boundary line set forth in his instructions from Congress. 36. The Indians were not prepared to stand up to St. Clair, and two treaties were signed at Fort Harmar on January 9, 1789. The first, with the Wyandots and other western tribes present, reconfirmed the Fort McIntosh boundary line, and for the ceded lands the United States now agreed to pay goods worth $6,000. The new treaty was considerably longer than the one it confirmed. There were renewed provisions for hostages, for trading posts and military forts, and a renewal of peace and friendship, but there was in addition an amplification of provisions to ease the contacts between the Indians and the whites. The treaty specified punishment for crimes committed, established punishment for stealing horses and demanded return of the stolen animals, set up regulations for opening trade with the Indians, sought to forestall Indian hostilities, and restricted white settlements. 37. The second treaty was with the representatives of the Six Nations. It repeated the Treaty of Fort Stanwix of 1784 and confirmed the boundary line in consideration of the peace then granted to them, the presents they then received, as well as in consideration of a quantity of goods, to the value of $3,000, now delivered to them by Arthur St. Clair. 38. Not until May 2 did Governor St. Clair forward the treaties to President Washington. Pleading in justification of the long delay, his own indisposition, and the severity of the winter, which had made communication impracticable, he explained the impossibility of setting the northern boundary at the 41st parallel, for any efforts to extend the limits of the previous cession would have been very ill received and might have defeated entirely the treaty of peace. The negotiation, he told Washington, was both tedious and troublesome, and, for a long time, had an unpromising aspect, but it came, at last, to as favorable an issue as could have been expected. But he noted that several Indian tribes along the Wabash, who had not come to Fort Harmar, were still ill-disposed and likely to make trouble. The two separate treaties, with the Six Nations and the more western Indians, he explained, had been signed because there was a jealousy that subsisted between them, which I was not willing to lessen by appearing to consider them as one people. St. Clair was persuaded that the Indians' general confederacy was entirely broken, and he thought it would not be very difficult, if circumstances required it, to set them at deadly variance. 39. On January 18, shortly after the signing of the treaties, St. Clair had written to Knox that the Indians seem to be very well satisfied, and if they are not sincere in their professions, they know very well how to put on the appearance of it, but in fact the treaties accomplished no more than had the previous ones. St. Clair had not carried out his instructions, for there was no general treaty, and he had not even been able to broach the subject of extending the earlier cessions. Although he had spoken boldly to the Indians, he had not overly impressed them. They resented all the treaties, including the ones just signed at Fort Harmar, and Indian hostilities along the western frontiers of settlement continued. Not until the Ohio Indians were roundly defeated by Anthony Wayne in 1794 did they give up claim to the ceded lands. 40. The treaties at Hopewell. In the South, the difficulties in dealing with the Indians after the Revolutionary War were, if anything, even greater than in the North. It was not clear how far the authority of Congress extended, because the states of Virginia, North Carolina, South Carolina, and Georgia aggressively pushed their own interests. They strove to satisfy the demands of their citizens for more land and were imbued with a strong sense of their state sovereignty. This continual clash between the states and Congress seriously weakened the possibilities for firm action on the part of the national government. In the South, moreover, the four principal Indian nations Cherokee, Creek, Choctaw, and Chickasaw had organized governments and astute leaders, who put forth their rights to land and who could field sizable military forces. Added to these complications was the presence of the Spanish, who had regained Florida in the Peace of 1783 and who sought to promote their interests by diplomatic connections with the Indian nations. The Spanish signed treaties with the Creeks, Choctaws, and Chickasaws in the summer of 1784, and these Indians submitted to Spanish protection and trading dominance. The Indians, especially the Creeks, continued to play the Spanish against the Americans in their diplomatic game. 41. Congress moved slowly in extending its treaty policy to the South. A committee appointed to consider Southern Indian affairs returned a report in May 1784, which argued that Congress should have exclusive control of Indian affairs, and which otherwise offered proposals about the same as those put forth in October 1783 for the Northern and Middle departments. Opposition to centralized control from Southern delegates and the fear that excessive land cessions from the Southern Indians would benefit land speculators caused continuing delay, and on his detailed maps of land cessions, Royce, Cessions, 649, 651. See also White, Middle Ground, Chapter 10. White describes the politics of the Indians' confederations and shows why the Indians did not present a united front to the Americans. Congress adjourned in June 1784 without attending to the Southern problems. 42. The delegates met again in November, but it was not until March 15, 1785, that Congress adopted a report about dealing with the Southern Indians. The report asked for the appointment of commissioners to form a treaty or treaties with the Indians in the Southern Department, for the purpose of making peace with them, receiving them into the favor of the United States, and ascertaining the boundary lines by which the settlements of the citizens of the United States are or ought to be separated and divided from the Indian villages and hunting grounds, and thereby if possible extinguishing animosity, and preventing in future any contention or disquiet. It contained a number of specific instructions for commissioners concerning prisoners, notice to the Indians that they were now at the mercy of the United States, investigation of the boundaries of lands already ceded, notice to the states of times and places of meetings, restriction of settlement on Indian lands, and agents for the tribes. 43. Congress chose 5 commissioners, any 3 of whom were empowered to treat: Benjamin Hawkins, Andrew Pickens, Joseph Martin, Lachlan McIntosh, and William Peary. Negotiations with the Creeks were scheduled for Galphinton on the Ogeechee River in Georgia, but when the commissioners arrived there on October 24, they found Indians from only 2 of the 100 towns and refused to treat with such a small number, suspecting that others had not appeared because of the intrigues of the Spanish and the influence of Alexander McGillivray, the shrewd mixed blood who had risen to top leadership among the Creeks. They explained their mission and gave presents to those on hand and then departed. Commissioners of Georgia, who visited the United States commissioners, protested the projected treaty, and after the latter had left, signed a treaty of their own with the Indians for a cession of land. 44. The 4 federal commissioners arrived at Hopewell on November 17 and on November 21 began negotiations with the Cherokees. North Carolina and Georgia had representatives on hand, but they took no active part. In an opening statement, the commissioners reminded the Indians that they had sided with Great Britain in the war, that the king had been defeated and compelled to withdraw, and that Congress was now the sovereign of the whole country. But the tone was conciliatory, and the commissioners, noting the humane and generous policy of the United States, expressed a desire to promote the happiness of the Indians, regardless of any distinction of color, or of any difference in our customs, our manners, or particular situation. There was no mistaking the reply of the Indians, who insisted on the boundary line established in 1777 and who wanted the whites removed who had settled across that line. Our Congress, who conquered the King of Great Britain, asked the tassel, unable to remove these people. The commissioners countered that many of the intruders had been there a long time, that they were numerous, and that it was impossible to remove them. After some days of forthright give and take, the commissioners drew up the treaty with the boundary lines stipulated. The treaty was read, and interpreted to them with great attention, so that they agreed that they perfectly understood every article, and would with pleasure unanimously sign the same. On November 28, 1785, 2 copies were signed, one for the Cherokees, the other for the United States. The next day presents worth $1,200 were delivered for the 918 Indians at the council. 45. This treaty, like those in the North, contained more than provisions for boundary lines. It spoke of the United States giving peace to the Cherokees and receiving them under its protection, and the Indians acknowledged themselves to be under the protection of the United States of America, and of no other sovereign whosoever. The boundary line was allotted to the Cherokees for their hunting grounds. Both sides agreed to restore prisoners, and whites intruding on Indian lands would forfeit the protection of the United States if they did not leave within 6 months of the ratification of the treaty. 2 articles dealt with trade. 1 read, "For the benefit and comfort of the Indians, and for the prevention of injuries or oppression on the part of the citizens or Indians, the United States in Congress assembled shall have the sole and exclusive right of regulating the trade with the Indians, and managing all their affairs in such manner as they think proper." In the other, all citizens of the United States were authorized to trade with the Cherokees until Congress decided otherwise. Another article, about which there was no indication in the minutes of the council and which was never acted upon, gave the Indians the right to send a deputy of their choice, whenever they think fit, to Congress. This was an indication that, whatever the language in the negotiations, the tribe was considered a domestic, not a foreign nation. The land provisions of the treaty were in general accord with the existing situation and by no means satisfied white speculators and eager settlers. Nor was the sole and exclusive right of Congress in Indian affairs clearly vindicated. Before the treaty document was presented for the Indians' agreement, William Blount issued a formal protest to the commissioners against the treaty, as containing several stipulations which infringe and violate the legislative rights of the state. The commissioners replied bluntly, "We are certain that a steady adherence to the treaty alone, can ensure confidence in the justice of Congress, and remove all causes of future contention or quarrels. The local policy of some states is certainly much opposed to federal measures, which can only, in our opinion, make us respectable abroad and happy at home. 46. The United States Commissioners, not expecting to see the Choctaws or Chickasaws, were preparing to adjourn when word came that the Choctaws were on their way, having been delayed by Creek attempts to prevent them and by the theft of their horses. They arrived without needed clothing and provisions, the whole of them almost naked, and had to be cared for before the negotiations could begin. The council got underway at the end of December, and a treaty was signed on January 3, 1786, which set the boundary of Choctaw lands where it had been on November 29, 1782, the day before the signing of the preliminary peace with Great Britain. Otherwise the treaty was very similar to that with the Cherokees, although no mention was made of a delegate to Congress. 47. Meanwhile the Chickasaw delegation arrived, and negotiations began at once with them. The commissioners, who reported that in the negotiations they paid particular attention to the rights and interests of the United States, regardless of the protests of the adjoining states against us, gave their set speech about the change in sovereignty that came with Great Britain's defeat and about the humanity and generosity of the United States. They presented a draft of a treaty, and the Indians examined and discussed it. On January 10 the treaty was then read over again, and every article explained with great attention, and the Indians acquiesced with them, and the treaty was signed. It was very much like those with the Cherokees and with the Choctaws. 2 days later presents were given to the Indians. As before, William Blount submitted a protest against the treaty for North Carolina. 48. On April 17 the treaties were entered into the Journals of Congress, an act that was intended to signify ratification. 49. The three treaties themselves referred to commissioners plenipotentiary of the United States, and at the end of each was the statement that the commissioners, by virtue of our full powers, have signed the definitive treaty, and have caused our seals to be herewith affixed. The matter of settlement with the obstreperous Creeks was left hanging. The years 1786 to 1790 were full of trouble between the Creeks and Georgia, which wanted no federal interference in its interests but at the same time looked to the federal Congress for protection. Georgia signed a new treaty at Shoulderbone in November 1786 with a few Creek chiefs, confirming the cessions made to the state earlier, and McGillivray insisted again that the Indian signers did not represent the Creek nation. 50. Congress was aware that the treaties were not well received by North Carolina and Georgia and that the boundary provisions were not observed by white citizens. Henry Knox in July 1787 reported to John Hancock, January 4, 1786, Ibid. 1:4950. McIntosh had departed Hopewell before word of the approach of the Choctaws and could not be recalled in time for the treaty. The minutes of the council are in Draper Manuscripts 14U 5692. The treaty is in Kapler, 2:1114. Congress on the Southern situation and pointed to the weakness of Article 9, wondering about Congress's power to deal with the Creeks within Georgia. The article, he thought, was perhaps too inexplicit to be applied as a remedy, because the Indians seemed to be members of the state, and the same held true for North Carolina. He recommended that the state cede their western territories to the United States, so that Congress could then manage the land and its Indian inhabitants. 51. A special committee, on August 3, 1787, delivered a ringing rebuke to the Southern states and demanded that Congress give serious attention to the repeated complaints of the Indians about encroachments upon their lands, as well because they may be unjustifiable as on account of their tendency to produce all the evils of a general Indian war on the frontiers. Its strongest statement came in support of federal control of Indian affairs. The committee conceived that it has been long the opinion of the country, supported by justice and humanity, that the Indians have just claims to all lands occupied by and not fairly purchased from them, and that in managing affairs with them, the principal objects have been those of making war and peace, purchasing certain tracts of their lands, fixing the boundaries between them and our people, and preventing the latter settling on lands left in possession of the former. The powers necessary to these objects appear to the committee to be indivisible, and that the parties to the Confederation must have intended to give them entire to the Union, or to have given them entire to the state. These powers before the Revolution were possessed by the king, and exercised by him, nor did they interfere with the legislative right of the colony within its limits. It cannot be supposed, the state has the power mentioned without making the recited clause useless, and without absurdity in theory as well as in practice. Point 52. Still the encroachments continued. Knox reported to Congress in July 1788 the unprovoked and direct outrages against the Cherokee Indians by the inhabitants on the frontiers of North Carolina in open violation of the Treaty of Hopewell. The outrages were of such extent, Knox declared, as to amount to an actual although informal war, and he urged Congress to take action to uphold the treaty provisions and thus the reputation and dignity of the Union. Congress, at Knox's behest, issued a proclamation on September 1, which cited the provisions of the Treaty of Hopewell and the boundary lines it provided, and which ordered the intrusions and outrages to cease. It directed the Secretary of War to have troops ready to disperse the intruders. Point 53. That Knox and Congress were not sure of their ground is shown by the deference they both paid to the state of North Carolina. Knox stated in his report his assumption that North Carolina would place no obstruction in the way of federal action, but he recommended nevertheless that a special request of concurrence be made of the state. Congress sent special copies of the proclamation to the executives of North Carolina and Virginia, asking their cooperation. As the days of the Confederation came to a close, it was clear that Congress in its treaty making with the Indians had not had substantial success. The treaties made with the Indians in the North had been largely repudiated by the Indians, and those in the South Congress found impossible to enforce against citizens of the states. It was not a good foundation for subsequent treaty making, but at least the problems had been pointed up and some patterns developed that persisted for good or for bad into the new era. For one thing, there was no turning back from the policy of dealing with the Indian tribes through formal treaties. Consideration of the Indians as nations, not as members of the states, seemed essential if congressional authority was to prevail over that of states like New York, North Carolina, and Georgia. Knox made the position clear in a report shortly after the inauguration of the new government under the Constitution. The independent nations and tribes of Indians ought to be considered as foreign nations, not as subjects of any particular state. Each individual state, indeed, will retain the right of preemption of all lands within its limits, which will not be abridged, but the general sovereignty must possess the right of making all treaties, on the execution or violation of which depend peace and war. 54. Yet, despite the expediency of considering the Indians foreign nations, treaty making was the white man's device, not the Indians'. Indians were called or invited to a treaty council by white government officials or agents. Even though the whites adopted Indian protocol at the early councils, as time passed the procedures became more clearly white-driven. The white agents started the proceedings, drew up the treaty drafts, explained them to the Indians. They also provided food for the Indians attending and clothing when it was required, and they presented gifts at the conclusion of the deliberations. There were exchanges of strings and belts of wampum in the early treaties, but the giving of gifts and goods was not reciprocal. And the Indians agreed to a considerable diminution of their autonomy when they accepted peace given by the United States, agreed to be under its protection, and acquiesced in the treaty provisions that Congress would have the sole and exclusive right of regulating the trade with the Indians, and managing all their affairs in such manner as they think proper. Page 67. Chapter 3. Treaty-making procedures under the Constitution. The rough edges in treaty-making with the Indians were smoothed out when the Constitution replaced the Articles of Confederation. The uncertainty about which Indians would attend the councils and whom they represented, the indecision between treaties as councils for discussion and treaties as formal written covenants, the lack of clarity about how far the powers of the Continental Congress reached, and the opportunity that such confusion gave to states to act independently of Congress in Indian affairs disappeared to a large extent. The provisions in the Constitution about trade and about treaty making vindicated centralized control, and the new government, with its stronger executive, could hope to make the provisions effective. George Washington worked out in practice what the constitutional provisions for senatorial advice and consent meant, and his decision to consider Indian treaties on a par with foreign treaties formalized Indian treaty making and provided an important means for the United States to manage Indian relations. Not all the problems were resolved, of course, and the basic anomaly of dealing by treaty with groups of limited autonomy within the territorial jurisdiction of the United States never went away, but in the first decade under the Constitution, regularization of the process and continuing dependence upon treaties to carry out federal Indian policy set a pattern for future decades. Page 68. The Constitutional Convention. In spite of the ambiguity in the Articles of Confederation about federal or state management of Indian affairs, very little attention was paid to the issue in the Constitutional Convention, and there was no extensive statement about Indians in the Constitution itself. The lack of prolonged debate on the question was a sign of agreement within the convention that Indian affairs should be left in the hands of the federal government. Since the Constitutional Convention had been called to consider weaknesses in the Articles, the question of federal authority over Indian affairs, of course, did find some place in the discussion. James Madison well understood the problem, and when the Committee of the Whole discussed the Patterson Plan on June 19, he asked, "Will it prevent encroachments on the federal authority?" A tendency to such encroachments has been sufficiently exemplified among ourselves, as well in every other confederated republic antient and modern. His first example was the following: by the federal articles, transactions with the Indians appertain to Kongs. Yet in several instances, the states have entered into treaties and wars with them. 1. When the draft of the Committee on Detail submitted on August 6 said nothing about Indians in its listing of the powers of the legislature, Madison on August 18 proposed adding to the list of such powers, to regulate affairs with the Indians as well within as without the limits of the United States. The proposal was referred to the Committee on Detail. Point 2. This broad grant, touching internal state affairs as well as affairs beyond the territory of the states, was cut down by the committee, which merely added to the clause granting Congress the power to regulate commerce with foreign nations, and among the several states the words "and with Indians," within the limits of any state, not subject to the laws thereof. Then on September 4 the Committee of 11 reduced the clause still further to the simple 5-word phrase "and with the Indian tribes." The convention agreed to this wording on the same day without debate. Point 3. The convention in its long deliberations over the treaty-making power did not mention Indian treaties specifically, but the power of states to make any treaties was repeatedly denied. As a further protection against state usurpation, the convention declared federal laws and treaties superior to those of the states. The Patterson Plan on June 15 offered a detailed proposal to make federal laws and treaties superior to state laws and to authorize the central government to use force to compel obedience. There was considerable discussion on the matter. Madison considered the negative on the laws of the states as essential to the efficacy and security of the general government, because the necessity of a general government proceeds from the propensity of the states to pursue their particular interests in opposition to the general interest. He insisted that the power to overrule laws of the states was the most mild and certain means of preserving the harmony of the system. The Committee on Detail on August 6 reported the provision from the Patterson Plan as it stood, except that it omitted the section authorizing forceful execution of the laws or treaties. A small amendment was made on August 23, and on August 25 action was taken to obviate all doubt concerning the force of treaties pre-existing, by inserting after all treaties made the words "or which shall be made," so that the first phrase would refer to past treaties and the inserted words to future treaties. In the final version, the Constitution included the statement in Article 6, "This Constitution, and the laws of the United States which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. 4. There was considerable debate about which branch of the government should have the responsibility for making treaties and the power to do so. Was treaty making an executive function, a legislative function, or a joint function? The convention opted for the third choice, and the Constitution in Article 2 provided, "He shall have power, by and with the advice and consent of the Senate, to make treaties, provided 2/3 of the senators present concur." 5. But how this was to be carried out in practice was not clear from the Constitution itself. Two questions arose: how precisely did the Senate advise and consent in regard to treaties, and were agreements with Indian tribes to follow regular treaty procedures? Washington and the Senate. Both questions were answered in 1789 and 1790, as President Washington and Secretary of War Henry Knox dealt with the Senate concerning the treaties signed at Fort Harmar in 1789 and the treaty made with the Creeks in New York in August 1790. The answers worked out at that time set the procedures for future Indian treaties. 6. Misinterpreted the Supremacy Clause and wrongly asserted that treaties are on a par with the Constitution and above federal statutes. 5. Recent scholars have been concerned about the growth of executive power in treaty making and have sought to show that treaty making as a joint function of the President and the Senate was the intent of the framers. An excellent discussion of the issue is found in Jack N. Rakove, Solving a Constitutional Puzzle, the Treaty Making Clause as a Case Study, Perspectives in American History, NS. 1, 23381. See also two long articles by Arthur Bester, Separation of Powers in the Domain of Foreign Affairs, The Intent of the Constitution Historically Examined, Seton Hall Law Review 5, 527,665, and Respective Roles of Senate and President in the Making and Abrogation of Treaties. The Original Intent of the Framers of the Constitution Historically Examined, Washington Law Review 55, 1135. There is useful discussion, also, in Abraham D. Sofar, War, Foreign Affairs and Constitutional Power, The Origins, but the book does not deal specifically with Indian treaties. Although negotiated and signed before the new government under the Constitution was set up, the Fort Harmar treaties were submitted by President Washington to the Senate on May 25, 1789. The treaties and related documents were delivered to the Senate and placed in the hands of the Vice President by Henry Knox, under whose official superintendence the business was transacted, as Washington noted, and who will be ready to communicate to you any information on such points as may appear to require it. With the treaties, the President sent a report by Knox, dated May 23, which explained the nature of the treaties and their authorization by the Continental Congress, and which recommended, if the Senate should concur in their approbation of the said treaties, their ratification and publication, with a proclamation enjoining their observance. To his report Knox appended a statement of Indian opposition to the earlier treaties of Fort Stanwix and Fort McIntosh, and he included the treaty instructions sent by Congress to Governor Arthur St. Clair. 7. The Senate was in no hurry. It put the material aside for future consideration, and not until June 12 did it appoint a committee of 3 to deal with the treaties. The committee made its report on August 12, and the Senate considered it on August 26. The committee noted that the Fort Harmar treaties contained a more formal and regular conveyance to the United States of the Indian claims to the lands yielded by the treaties of Fort Stanwix and Fort McIntosh, and submitted a resolution to the effect that the Senate accept the treaties and advise the President to execute and enjoin the observance of the same. The committee apparently felt that its duty was to see that the treaty had been negotiated according to the instructions given, and its formulation of its recommendation followed the suggestion of Knox's report. On September 8, the Senate again considered the report and duly resolved that the President be advised to execute and enjoin an observance of the Fort Harmar Treaty with the Wyandots and other Western Indians. 8. This rather vaguely worded approval of the treaty did not satisfy. Related documents. It is skillfully edited and includes a considerable number of related documents. I have cited this work whenever possible rather than the earlier printings of the same materials in JCC, Annals of Congress, Aspaya, and James D. Richardson's A Compilation of the Messages and Papers of the Presidents. Washington, who on September 17 sent Henry Knox again to the Senate with another message, which elaborated the President's views on Indian treaties. 9. First of all, Washington stated his general opinion about procedures in handling Indian treaties. It is said to be the general understanding and practice of nations, as a check on the mistakes and indiscretions of ministers or commissioners, not to consider any treaty, negotiated, and signed by such officers, as final and conclusive until ratified by the sovereign or government from whom they derive their powers. This practice has been adopted by the United States, respecting their treaties with European nations, and I am inclined to think it would be advisable to observe it in the conduct of our treaties with the Indians, for though such treaties, being on their part, made by their chiefs or rulers, need not be ratified by them, yet being formed on our part by the agency of subordinate officers, it seems to be both prudent and reasonable, that their acts should not be binding on the nation until approved and ratified by the government. It strikes me that this point should be well considered and settled, so that our national proceedings in this respect may become uniform, and be directed by fixed and stable principles. He noted that he had forwarded the Fort-Harmar treaties with two questions for the Senate to resolve. First, whether those treaties were to be considered as perfected, and consequently as obligatory, without being ratified; if not, then to ndly. Whether both, or either, and which of them ought to be ratified. He was not satisfied with the Senate's action of September 8, with its advice to execute and enjoin an observance of the Wyandotte Treaty, for it seemed ambiguous. To execute could mean either that the treaty was to be ratified by the President as a new act of government, that it was already perfected and obligatory and that he was only to carry it out, or that the treaty would derive its completion and obligation from the silent approbation and ratification which my proclamation may be construed to imply. He thought that all doubts about the Senate's intention ought to be removed. He asked, also, for some action on the treaty with the Six Nations. The committee of the Senate to whom Washington's letter was referred reported the following day, that the signature of treaties with the Indian nations has ever been considered as a full completion thereof, and that such treaties have never been solemnly ratified by either of the contracting parties as hath been commonly practiced among the civilized nations of Europe. The committee, therefore, did not consider formal ratification of the treaty either expedient or necessary, and it thought that the Senate's resolution of September 8 was sufficient. As to the Six Nations Treaty, no action had been recommended because of particular circumstances affecting a part of the ceded lands. This report, however, was rejected by the full Senate, which on September 22 resolved that the Senate do advise and consent that the President of the United States ratify the Wyandotte Treaty. It postponed action on the Six Nations Treaty because the treaty might be construed to prejudice the claims of the states of Massachusetts and New York and of the grantees under the said states. 10. Washington was satisfied, and on September 29 he issued an instrument of ratification for the treaty with the Wyandottes and other Western Indians, in which he noted that the treaty had been made in proper form by Governor St. Clair, who had been duly authorized. He added, "Now know ye that I, having seen and considered the said treaty, do by and with the advice and consent of the Senate, accept, ratify, and confirm the same, and every article and clause thereof." On the same day, he issued a public proclamation of like effect, in which he enjoined and required all officers of the United States civil and military and all other citizens and inhabitants thereof faithfully to observe and fulfill the same. 11. Thus the precedent was established, in accordance with Washington's views, that Indian treaties like those with foreign nations be formally approved by the Senate before they took effect. The Senate advised and consented that the President ratify the treaty, which he did in a formal instrument of ratification. The standard construction of treaties was that ratification was retroactive, a treaty took effect from the date of the signing. 12. The Second Fort-Harmar Treaty indicated that not all the confusion about the ratification of treaties had been dissipated. Although the Senate and the President failed to ratify the agreement, and although the treaty was not forwarded to the Department of State to become part of its official treaty archives until 1797, officials of the federal government acted as though the treaty were valid. Washington himself, writing to Seneca chiefs in January 1791, referred to the boundary set at Fort Stanwix and confirmed by the Treaty of Fort Harmar upon the Muskingum, so late as the 9th of January 1789, and he asserted that the lines fixed at Fort Stanwix and Fort Harmar must therefore remain established. Peace commissioners to the Confederated Indians in the Northwest on July 31, 1793, noted that the Six Nations had renewed and confirmed the Treaty of Fort Stanwix at the Fort Harmar Council. 13. The Fort Harmar treaties had been signed before the inauguration of the new government under the Constitution. The Senate did not, therefore, have any part in the negotiations of the treaties, but was presented with them as a fait accompli. It could only judge whether they had been completed in due form and according to the instructions drawn up by the Congress under the Articles of Confederation. It was quite otherwise with negotiations for a treaty with the Creeks initiated by President Washington in 1789, for the new president took seriously the prescription to act with the advice and consent of the Senate, which he at first took to mean using the Senate as a sort of council with whom to discuss the negotiations. He expected to talk with the senators in person, to get their advice about proposed strategies, and to receive prior approval and confirmation of his actions. Even before the Fort Harmar treaties were disposed of, the Senate and the President began to work out procedures for treaty making. On August 6 the Senate appointed a committee to wait on the President of the United States, and confer with him on the mode of communication proper to be pursued between him and the Senate, in the formation of treaties, and making appointments to offices. 14. The committee members and the President met on August 8 and again on August 10. The matter of confirming nominations was easily disposed of. Washington believed that in these cases written communications alone would serve, and that the presence of the President when the Senate considered his nominations would be improper and unpleasant for both parties, as the President has a right to nominate without assigning his reasons, so has the Senate a right to dissent without giving theirs. In the matter of treaties, however, Washington thought that oral communications seem indispensably necessary, because in these a variety of matters are contained, all of which not only require consideration, but some of them may undergo much discussion, to do which by written communications would be tedious without being satisfactory. He was also concerned about the proper protocol. Where should the oral communications take place, and if in the Senate chamber, how would the President and the Vice President be positioned? These are matters, he said, which require previous consideration and adjustment for meetings in the Senate chamber or elsewhere. 15. At the second meeting, Washington was more forceful in asserting his prerogatives. The time and place of consultation, he thought, should rest with the President, who could summon the Senate to his house, but he was willing to make a distinction between confirmation of nominations and treaty business. Washington did not want any hard and fast rules, however, for the manner of consultation may also vary according to the nature of the business and the inclinations or dispositions of the two parties. And experience might well suggest modifications. The Senate, he thought, should provide for the reception of either oral written propositions, and for giving their consent and advice in either the presence or absence of the President. In a letter to James Madison on August 9, Washington said the committee had informed him that the Senate wanted to accommodate the wishes of the President, but that he sensed oral communications was the point they aimed at. The President's views met approval in the Senate, and on August 21 it set up the protocol to be followed. 16. The theory was soon tested in practice, for on August 21 Washington sent a message to the Senate that he would meet with them the next morning at 11:30 to advise with them on the terms of the treaty to be negotiated with the Southern Indians. 17. The Senate was then a small body, since Rhode Island and North Carolina were late in ratifying the Constitution. It had only 22 members. Washington went to the Senate in good faith. 2 weeks earlier he had sent the Senate information about the critical state of affairs existing between Georgia and the Indians, which seemed to require the immediate interposition of the general government. He was looking for action that would be fair to both sides. While measures of government ought to be calculated to protect its citizens from all injury and violence, he told the Senate, a due regard should be extended to those Indian tribes whose happiness, in the course of events, so materially depends on the national justice and humanity of the United States. The President asked for authority, to appoint a three-man commission to arrange for a treaty with the Indians. Congress appropriated $20,000 for such a treaty and provided pay for commissioners to carry out the negotiations. Washington nominated Benjamin Lincoln, Cyrus Griffin, and David Humphreys, and the Senate quickly confirmed the nominations. 18. On August 22, accompanied by Henry Knox, Washington went to the Senate chamber, where he took his place in the vice president's seat, while John Adams, who presided over the Senate, sat with the rest of the senators. In a written statement, the president summarized the state of affairs respecting the Southern Indians. He noted the military power of the tribes and asserted that the fate of the Southern states may principally depend on the present measures of the Union towards the Southern Indians. He called attention to the violations of the Treaty of Hopewell with the Cherokees by citizens of North Carolina, but thought no solution could be proposed until that state had ratified the Constitution and joined the Union. For the Cherokees and the more distant Choctaws and Chickasaws he advocated no more than messages of assurance and friendship and plans for trade. 19. That left the powerful Creeks, on whom Washington then centered his attention. Their case, he said, was of the highest importance and required an immediate decision, and he referred to the fundamental cause of conflict between the tribe and the state of Georgia, the difference of judgment about the Georgia treaties of Augusta, Galphinton, and Shoulderbone, with their land cessions to Georgia. The only solution was to have United States commissioners investigate the problem and seek some agreement with Georgia and the Creeks. But what should the commissioners be instructed to do? It was on this point that Washington sought the senators' advice, and he proposed 7 specific questions to which he wanted their answers. The first 2 questions concerned the Cherokees and the Choctaws and Chickasaws and were quickly passed over. The remaining 5 questions set forth a series of either/or proposals for the Senate's judgment. Question 3. If the commissioners judged that the Creek Nation had been fully represented at the 3 Georgia treaties and that the treaties were just and equitable, should the commissioners insist on a confirmation of their provisions, and if the Creeks refused, should military force be used to compel them? Question 4. If, on the other hand, the commissioners judged that the 3 treaties had not been proper, should they attempt to obtain a cession of the lands, offering compensation in goods and money up to an amount to be specified, a secure port on the Altahama or St. Mary's rivers through which the Creeks could obtain trade goods, payment and honorary military distinctions to Creek chiefs, solemn guarantee of remaining Creek lands with a line of military posts if necessary. Question 5. If such offers did not induce the Creeks to make the desired cession to Georgia, should the commissioners issue an ultimatum? Question 6. Or should a treaty be made with the Creeks, with the disputed lands retained by them? Or should a temporary boundary be drawn at the Oconee River, and should other provisions of the treaty conform to those in the treaties of Hopewell with the Cherokees, Choctaws, and Chickasaws? Question 7. Could all of the $20,000 appropriated for treaties be spent on a treaty with the Creeks? If not, what proportion of it? 2 days later, August 24, on Washington's second visit, the Senate replied to these questions. Question 3 was answered in the affirmative, as was question 4, with the sum of money to be determined by the President. Question 5, about issuing an ultimatum to the Creeks, was answered in the negative. The first part of question 6 was likewise answered negatively, while the rest was confirmed. On question 7 the Senate approved use of the full $20,000 for a Creek treaty, at the discretion of the President. 20. If one relies solely on the Senate Journal, the conclusion must be that the conferences progressed smoothly, with the questions proposed by Washington answered quickly, precisely, and amicably by the senators. The idea of the Senate as a council to advise the executive about specific proposals for treaty negotiations seemed to be off to a good start. The reality, however, was quite the opposite, and Washington never again went to confer with the Senate in person. What happened during those 2 days in the Senate chamber? The answer appears in the detailed private journal of the Senate proceedings kept by William Maclay, a senator from Pennsylvania. It is obvious from Maclay's account that the meetings were not pleasant for either the president or the senators. Washington's 7 questions were read by the vice president from his chair on the floor, but carriages passing by outside made so much noise that the senators could not understand what was being read. The president was fretful and the senators seemed overawed and reluctant at first to speak. The Senate asked for the reading of the earlier treaties and other documents alluded to in Washington's statement. "I cast an eye at the President of the United States," Maclay recorded. "I saw he wore an aspect of stern displeasure. When a proposal was made to commit all the papers to a committee for further study," Maclay noted, "the President of the U.S. started up in a violent fret. 'This defeats every purpose of my coming here,' were the first words that he said. He then went on that he had brought his secretary at war with him to give every necessary information, that the secretary knew all about the Bucina sand, yet he was delayed and could not go on with the matter. Washington cooled however by degrees and agreed to postponement of further discussion until Monday, 2 days hence. At the reconvening of the Senate, Maclay reported, the president wore a different aspect from what he did Saturday. He was placid and serene, and manifested a spirit of accommodation. There was tedious debate, but in the end all the questions were answered, and the president withdrew. 21. The president had wanted a full and immediate discussion, with problems in the senators' minds answered at once by the knowledgeable Knox. The senators, however, wanted more time to study the supporting documents and were irked when they were rushed ahead without time to examine the evidence. The beautiful theory of a Senate council advising the president in a face-to-face discussion fell apart. The story circulated in the Capitol that on leaving the Senate Washington declared that he would be damned if he ever went there again. Washington, nevertheless, continued to keep the Senate informed in writing about the negotiations with the Creeks. 22. The Creek Treaty of 1790. With the advice of the Senate in his pocket, Washington undertook negotiations with the Creeks. The 3 commissioners were given instructions that closely paralleled the agreement reached between the President and the Senate. "The first great object of your commission," they were told, "is to negotiate and establish peace between the state of Georgia and the Creek Nation. The whole nation must be represented and solemnly acknowledged to be so by the Creeks themselves." They were instructed to meet the Indians at Rock Landing of the Oconee River in Georgia on September 15, where the Indians were expected to assemble. 23. The commissioners, when they arrived in Georgia, sent messages of friendship to the Cherokees, Choctaws, and Chickasaws, dealt extensively with the governor of Georgia, and notified Creek Chief Alexander. Of the First Federal Congress of the United States of America, Volume 9, The Diary of William Maclay and Other Notes on Senate Debates, ed. Kenneth R. Bowling and Helen E. Veit. It supersedes earlier editions of the manuscript, which are not as accurate, complete, or well documented. Maclay's account of Washington's visits to the Senate on August 22 and 24 appears on pages 12,832. McGillivray of their coming and their hopes for peace. On September 20 they arrived at Rock Landing, and the negotiations began. The spokesman for the Creeks was, of course, McGillivray, but some 2,000 Indians were on hand. 24. Despite all the preparations and the desire of the Washington administration to find some means to assure peace on the Georgia frontier, the council came to nothing. The commissioners presented a draft of a treaty, but the boundary line it stipulated did not satisfy McGillivray. He abruptly departed the conference on September 25 without submitting his own position on the boundary nor discussing fully with the commissioners his objections to the former treaties. In reply to the entreaties of the commissioners, he wrote on September 27, we expected ample and full justice should be given us in restoring to us the encroachments we complained of, in which the Oconee lands are included, but finding that there was no such intention and that a restitution of territory hunting grounds was not to be the basis of a treaty of peace between us, I resolved to return to the nation. We sincerely desire a peace, but we cannot sacrifice much to obtain it. The next day the commissioners ruefully wrote to the Secretary of War, "We have the mortification to inform you that the parties have separated without forming a treaty. The terms which were offered by us at the commencement of the negotiation were not agreeable to Mr. McGillivray, but neither would he come forward with written objections or propose any conditions of his own. 25. In early 1790 Washington tried again. He sent a special emissary to McGillivray, Colonel Marinus Willett, a Revolutionary War veteran. Willett carried a letter from Benjamin Hawkins, then a senator from North Carolina, who candidly chided the Creek leader for having rejected the peaceful overtures of the United States and warned him of the calamities that would follow a war with the United States. 26 Willett persuaded the Creek chief to reconsider his rejection of the proposed treaty and to come to New York to deal directly with Washington and Henry Knox. Escorted by Willett, McGillivray and some 30 Creeks made a celebrated journey through the Carolinas, Virginia, and Pennsylvania and a dramatic entry into New York for treaty negotiations. 27. The Creeks in New York were attended by federal officials, and they made a good impression. But they were not all as acculturated to white ways as McGillivray was. The Revolutionary War soldier and artist John Trumbull told how Washington was interested to see in what manner Trumbull's recently completed portrait of the president would be received by the Indians. He therefore directed me to place the picture in an advantageous light, facing the door of entrance of the room where it was, and having invited several of the principal chiefs to dine with him, he, after dinner, proposed to them a walk. He was dressed in full uniform, and led the way to the painting room, and when the door was thrown open, they started at seeing another great father standing in the room. One was certainly with them, and they were for a time mute with astonishment. At length one of the chiefs advanced towards the picture, and slowly stretched out his hand to touch it, and was still more astonished to feel, instead of a round object, a flat surface, cold to the touch. He started back with an exclamation of astonishment. Ugh! Another then approached, and placing one hand on the surface and the other behind, was still more astounded to perceive that his hands almost met. I had been desirous of obtaining portraits of some of these principal men, who possessed a dignity of manner, form, countenance and expression, worthy of Roman senators, but after this I found it impracticable. They had received the impression, that there must be magic in an art which could render a smooth flat surface so like to a real man. I however succeeded in obtaining drawings of several by stealth. 28. It was the first treaty negotiations set, not in the Indian country, but in the capital of the United States, and Secretary of War Knox himself was designated the official commissioner for the United States. Washington informed the Senate on August 4 that the treaty negotiations were far advanced, but that trade arrangements were causing embarrassment. He noted that the Creeks got their trade goods from British merchants operating in Spanish ports, and he declared, as the trade of the Indians is a main means of their political management, it is therefore obvious, that the United States cannot possess any security for the performance of treaties with the Creeks, while their trade is liable to be interrupted or withheld, at the caprice of two foreign powers. He therefore asked the Senate to approve a secret article for the treaty that authorized trade goods for the Creeks to pass through United States ports free of duty if their regular channels of trade became obstructed, consent that the Senate immediately gave. By August 6 Washington, who indicated that the negotiations to that point had been informal, was ready to draw up the treaty in proper form, and on August 7 the treaty was signed by Knox and 24 Creek representatives. The President laid the completed treaty before the Senate on the same day. The Senate gave its consent by a vote of 15-4 on August 12, and on August 13 Washington formally ratified it. 29. A ratification ceremony took place in Federal Hall before a large assembly, including the Vice President, the Governor of New York, and several members of Congress. Washington addressed the Creeks, declaring the treaty just and equal, and presented a string of beads and a paper of tobacco to McGillivray as tokens of peace. McGillivray made a short reply, the Creeks sang a song of peace, and the parties exchanged handshakes, ending the highly interesting, solemn, and dignified transaction. 30. The treaty was similar to those signed in 178,586 with the Cherokees, Choctaws, and Chickasaws. 31 It spoke of perpetual peace and friendship between the citizens of the United States and the Creeks, and it stipulated that the Creek Nation was under the protection of the United States and that it would not hold any treaty with a state or with individuals of a state. Provisions were made for return of prisoners, for punishment of crimes, and for discouraging white settlement on Creek lands. In a foreshadowing of later and persistent use of treaties as vehicles for promoting the civilization of the Indians, Article 12 stipulated that the Creek Nation may be led to a greater degree of civilization and to become herdsmen and cultivators, instead of remaining in a state of hunters. The United States will from time to time furnish gratuitously the said nation with useful domestic animals and implements of husbandry. And further to assist the said nation in so desirable a pursuit, and at the same time to establish a certain mode of communication, the United States will send such and so many persons to reside in said nation as they may judge proper, and not exceeding 4 in number, who shall qualify themselves to act as interpreters. The key item, of course, was the boundary line specified, which validated some, but not all, of the earlier cessions made to Georgia that McGillivray had so adamantly opposed. In return, trade goods were delivered to the Creeks and a $1,500 annuity was provided. The United States solemnly guaranteed the remaining Creek lands. Instituting a practice that became common in subsequent treaties, the treaty stipulated that it would take effect and be obligatory on the contracting parties, as soon as the same shall have been ratified by the President of the United States, with the advice and consent of the Senate of the United States. According to secret articles, McGillivray got control of the trade for the Creeks through United States ports, and he was made an agent of the United States in the Creek Nation with the rank of Brigadier General and pay of $1,200 a year. Commissions, large medals, and $100 a year were allowed for 6 great medal chiefs. There is no doubt that these perquisites helped incline McGillivray to sign, especially the placing of a trade monopoly in his hands, for his status among the Creeks rested largely on his ability to control the influx of essential goods, and he had begun to question the ability of his agreements with Spain to maintain that flow. But there were other factors as well. His connections with the Spanish were weakening, and the danger of a British-Spanish war arising out of a conflict involving Nootka Sound in the Pacific Northwest made reliance on Spain even more problematic. The Yazoo land grants, made by Georgia to speculators, threatened Indian claims, and McGillivray saw that it was in his interest as well as that of the federal government to thwart those schemes. 32. Both sides seemed pleased. The United States had publicly won the loyalty of the Creek leader, confirmed its authority to deal with the Indians, and provided for Georgia citizens who had settled on lands claimed by the Creeks. McGillivray won United States acceptance of his office as head chief of the Creeks and gained control of trade, to say nothing of his commission and annual stipend. But in fact the treaty never took full effect. Georgia was dissatisfied because not all her claims were met, dissident Creeks who disputed McGillivray's leadership were not appeased, and Spain threatened to replace McGillivray as its agent if he did not repudiate the concessions he had made and the ties to the United States he had agreed to in New York. The boundary line was not surveyed and marked because the Indians would not join the American surveyors. Restlessness and hostility persisted on the Creek-Georgia frontier. Yet this first foray of President Washington into treaty-making was a significant beginning. He had felt his way toward a fixed procedure for sharing his responsibility with the Senate, and he had persuaded the powerful Creek Nation to come to his seat of government for treaty negotiations. He was now more confident in dealing with other tribes that called for his attention. Article analyzes the influence of the Nootka Sound controversy between England and Spain and the Yazoo land grants in McGillivray's decision to go to New York to treat with the United States, and it traces the activities of Spanish and British agents in New York during the time of the treaty negotiations. Chapter 4. Confirming the procedures. Other treaties in the 1790s. After negotiating with the Creeks in 1790, Washington turned to the Cherokees, whose complaints about violations of the Treaty of Hopewell by citizens of North Carolina he had forwarded to the Senate in 1789.1. At the time, he had noted the impossibility of taking firm action because North Carolina had not yet joined the Union, but that state ratified the Constitution on November 21, 1789, and its cession of Western lands was accepted on April 2, 1790. The President now felt empowered to act, and in August 1790 he sent a written message to the Senate, asserting, "I shall conceive myself bound to exert the powers entrusted to me by the Constitution in order to carry into faithful execution the Treaty of Hopewell, unless it shall be thought proper to attempt to arrange a new boundary with the Cherokees, embracing the settlements, and compensating the Cherokees for the cessions they shall make on the occasion." He therefore proposed 3 questions to the Senate. 1. Documentary History of the First Federal Congress of the United States of America, ed. Linda Grant DePauw, Volume 2, Senate Executive Journal and Related Documents, 31. The documents are printed 18,588, 100, and 99,201. There is an account of the dealings with the Cherokees in Ralston-Hayden, the Senate, and treaties, 1789-1817, the development of the treaty-making functions of the United States Senate during their formative period, 3034. 1. Should an attempt be made to arrange a new boundary with the Cherokees, to include the white settlements made since the Treaty of Hopewell? 2. Should payment be made to the Cherokees an annuity or a gross sum for land relinquished, with the settlers held liable for the value of the land? 3. Should the United States solemnly guarantee any new boundary arranged? 2. The Senate immediately considered the message and resolved to advise and consent that the President, at his discretion, should either enforce the Treaty of Hopewell or undertake to gain a new cession from the Cherokees as the tranquility and interest of the United States may require. It authorized in payment an annuity not to exceed $1,000 and agreed to solemnly guarantee any new boundary that might be drawn. Washington in this case avoided the awkward face-to-face confrontation with the Senate that he had found so unsatisfactory in the case of the Creek Treaty, and he asked the Senate's advice in very general terms, unlike the specific either/or proposals he had sent about Creek negotiations. The Senate, on its part, moved quickly, and it seemed not to hesitate in giving prior consent to guarantee a new boundary without knowing precisely what the provisions might be. Congress had already voted funds for a treaty on July 22, 1790.3. New treaties with the Cherokees. William Blount, the newly appointed governor of the territory southwest of the Ohio, who was instructed to conduct the treaty, met some 1,200 Cherokees on the banks of the Halston River at the present site of Knoxville in June 1791. Blount had a flair for ceremony, and the assembly was a colorful event. The governor sat under a marquee in full uniform, with civil and military officers at his side, and the Indians in ranks faced the marquee. Blount, looking out for his own land interests as well as the interests of the United States, wanted to expand his instructions and acquire greater cessions, but Secretary of War Knox objected, and the Indians insisted on cutting back his proposals for the boundary point 4. The treaty, signed on July 2, 1791, contained an affirmation of peace and friendship, the acknowledgement by the Cherokees of the protection of the United States, and provisions dealing with prisoners and prohibition of settlement on Indian lands similar to those in the Treaty of Hopewell. It added an article on promoting the acculturation of the Cherokees like that in the Creek Treaty of 1790. The boundary line, over which Blount and the Indians had argued, was set to include in the cession the lands on which the whites had settled in force. After Washington submitted the document to the Senate, a committee that studied the treaty reported that it considered the treaty to be in accord with the President's instructions and the Senate's advice given on August 11, 1790, and it recommended approval. whereupon the Senate gave its advice and consent. Washington issued a statement of ratification and a separate proclamation on November 11, 1791.5. The Cherokees were dissatisfied with the treaty and sent a delegation to Philadelphia, which arrived in the capital on December 28, 1791. The delegates met with the President and made known their complaints to the Secretary of War. Their spokesman, Bloody Fellow, related the arguments with Blount about the boundary and how the Cherokees had finally given in. At the time of the treaty, he said, we objected to giving up so much land, but, for the sake of peace and quietness, we did it. But we object to the little money given for so much land. It was not enough, he lamented, even to buy a breech clout for each one in the nation. He asked that the $1,000 annuity be raised to $1,500. Knox signed an agreement with the Indians to that effect on January 17, 1792, and the next day Washington sent the agreement to the Senate as an additional article to the original treaty, which the Senate approved. 6. The Treaty of Halston still did not bring satisfaction to the Cherokees and even less to the white citizens who had continued to encroach upon Cherokee lands despite threats from the federal government, and actual hostilities broke out. Another treaty was negotiated in Philadelphia on June 26, 1794, by Knox and a delegation of Cherokees. The Senate was in recess at the time, and Washington did not submit it to the Senate, as certain additional articles to the Treaty of Halston, until December 30, almost 2 months after the opening of the second session of the Third Congress. After referring the message to a committee and hearing its report, the Senate gave its approval on January 8, 1795.7. The treaty was primarily a renewal of the Treaty of Halston. Both parties declared that the former treaty was to all intents and purposes in full force and binding upon the said parties as well in respect to the boundaries therein mentioned as in all other respects whatever, and it prescribed that the boundaries be marked. The compensations set forth in the Hopewell and Halston treaties were replaced by a more generous annuity of goods valued at $5,000. To deal with the serious problem of horse stealing, the Cherokees agreed in the treaty to a deduction of $50 from the annuity for every horse stolen from whites by Cherokees. 8. The ineffectiveness of treaties can be seen in the fact that these agreements with the Cherokees in 1791, 1792, and 1794 did not end the encroachment upon Indian lands that had been guaranteed by the United States in the treaties. The boundary line specified in the Treaty of Halston and reconfirmed in 1794 was not finally marked until late in 1797, with the result that numerous whites were found across the line. They were removed, but to correct that inconvenience George Walton of Georgia and Lieutenant Colonel Thomas Butler, commanding United States troops in Tennessee, were appointed commissioners to negotiate yet another treaty. Secretary of War James McHenry sent detailed instructions, and he told the commissioners, should the Indians not incline to sell the whole quantity of land therein specified, you will endeavor to obtain as much of it as you possibly can. President Adams sent a talk to the Cherokees about the negotiations, full of reminders of the goodwill of the United States toward their nation, but noting too that he had to look out for the interests of my white children, the citizens of the United States. 9. A treaty was signed at Tellico in eastern Tennessee on October 2, 1798. It renewed the previous treaties, but it also stipulated new land cessions by the Cherokees, for which $5,000 worth of goods was delivered at once, and an annuity of $1,000 added to the annuities already promised. 10. The Northwest Territory. The decade of the 1790s was a time of troubles in the Northwest Territory, where there were continuing hostilities. Washington and Knox wanted to avoid war, not only because war was so expensive but also because the blood and injustice which would stain the character of the nation, would be beyond all pecuniary calculation. But the Americans were intent on settling north of the Ohio, and the Indians were equally resolved that the Ohio was to be a permanent and irrevocable boundary between the whites and themselves. Pressure for war became too strong for Knox to resist as reports of Indian incursions and atrocities poured in from the West Point. 11. In September 1790, General Josiah Harmar launched an attack from Fort Washington against the Miami towns, only to be roundly defeated by the Indians. The next year Arthur St. Clair, the territorial governor, tried in turn to pacify the Indians. His command was attacked on November 4, 1791, and destroyed. Washington next appointed General Anthony Wayne to command a new expedition, but while the general trained and disciplined his troops, one more attempt was made for peace. 12. In May 1792, Secretary of War Knox instructed General Rufus Putnam to call a general council with the hostile tribes in order to bring them to understand the peaceful intentions of the United States. As the basis of your negotiation, Knox said, you will, in the strongest and most explicit terms, renounce on the part of the United States, all claims to any Indian land which shall not have been ceded by fair treaties, made with the Indian nations. Putnam was to inform the Wabash Indians, with whom no treaty had yet been made, about the new and stronger government under the Constitution, and that now all the Indians could rest with great confidence upon the justice, the humanity, and the liberality of the United States, and that the United States wanted to advance their well-being. He was to convince the Indians that the United States wanted not a foot of their land, and that they had the right to sell and the right to refuse to sell. 13. In mid-September, Putnam met the Indians at Vincennes and persuaded them to agree to a peace. He read the treaty articles to them and confirmed the agreement with wampum belts, telling the Indians, the white people commit to writing what they transact, that the paper may speak when they are dead. Your custom is to record by belts. We shall do it both ways. 14. The treaty, signed on September 27, 1792, reflected Knox's instructions to Putnam, from which the fourth article was taken almost verbatim. The United States solemnly guarantee to the Wabash and Illinois nations, or tribes of Indians, all the lands to which they have a just claim, and no part shall ever be taken from them, but by a fair purchase, and to their satisfaction. That the lands originally belonged to the Indians, it is theirs, and theirs only. That they have a right to sell and a right to refuse to sell. And that the United States will protect them in their set just rights. 15. This article proved to be the undoing of the treaty, for when Washington submitted it to the Senate in February 1793, he suggested approval, but with an amendment that would guard, in the ratification, the exclusive preemption of the United States to the lands of the said Indians. A Senate committee, later in the month, recommended postponement of further consideration of the treaty until the next session of Congress, and that in the meantime the executive should negotiate a new article with the Indians that would provide for United States preemption rights, as Washington had suggested. Such action proved impossible, however, because many of the principal Wabash chiefs had died of smallpox. 16. On January 9, 1794, almost a year after the treaty had been submitted, the Senate considered it again, and an attempt was made to accept the treaty with an amendment providing for preemption, but when the vote was finally taken on the simple question of approving the treaty as it stood, the Senate voted it down, 21 to 417. It was the first instance in which the Senate refused to agree to an Indian treaty or even to amend it according to the President's recommendation. But by that time the signatory Indians had renewed hostilities, and the treaty was a dead issue. Meanwhile, a new peace initiative had been undertaken in 1793, and commissioners appointed to treat with the Northwest Indians went to Detroit. The Indians, however, refused to deal with them, and the peace movement fell apart. 18. A new military expedition was the result. General Wayne moved north against the Indians the next summer, and on August 20, 1794, the American troops decisively defeated the Indians at the Battle of Fallen Timbers on the Maumee. The British at Fort Miami, not willing to risk an open conflict with the United States, closed their gates in the face of the retreating Indians, and the hope of British aid collapsed. The following summer the Indians gathered at Fort Greenville to accept the terms of the victor. Wayne received a draft of a treaty to be presented to the Indians and instructions for his negotiations. Point 19. The various Indian delegates arrived over a period of days in June. They were greeted by Wayne with brief speeches and gifts of wampum, but it was not until July 13 that the formal council with all the assembled tribes got underway. A good bit of time was spent explaining the earlier treaties and their land cessions, and Wayne remarked about the ceded lands, "Younger brothers, notwithstanding that these lands have been twice paid for, by the 15 fires, at the places I have mentioned, yet, such is the justice and liberality of the United States, that they will now, a third time, make compensation for them." And he continued the Indian protocol. "We have nothing to do but to bury the hatchet, and draw a veil over past misfortunes. As you have buried our dead with the concern of brothers, so I now collect the bones of your slain warriors, put them into a deep pit, which I have dug, and cover them carefully over with this large belt, there to remain undisturbed. I also dry the tears from your eyes, and wipe the blood from your bodies, with this soft, white linen. No bloody traces will ever lead to the graves of your departed heroes, with this, I wipe all such entirely away. I deliver it to your uncle the Wyandot, who will send it round amongst you. I now take the hatchet out of your heads, and with a strong arm throw it into the center of the great ocean, where no mortal can ever find it, and I now deliver to you the wide and straight path to the 15 fires, to be used by you and your posterity forever. So long as you continue to follow this road, so long will you continue to be a happy people. You see it is straight and wide, and they will be blind indeed, who deviate from it. I place it also in your uncle's hands, that he may preserve it for you. I will, the day after tomorrow, shew you the cessions you have made to the United States, and point out to you the lines which may, for the future, divide your lands from theirs, and, as you will have tomorrow to rest, I will order you a double allowance of drink, because we have now buried the hatchet, and performed every necessary ceremony, to render propitious our renovated friendship. Point 20. Later he pointed out the cessions that were to be confirmed and read the articles of the treaty to the Indians. Indian spokesmen replied, some with suggestions for changes, but Wayne was unmoved. In the end the Indians indicated their assent and on August 3 signed the treaty. Presents and medals were distributed, and the council adjourned on August 10. The treaty established the well-known Treaty of Greenville Line, by which the Indians relinquished claim to the southern two-thirds of Ohio and a slim triangle of land in what is now Indiana. It was similar to the Fort Harmar Line but with considerable extension to the west, and it enclosed more land than Wayne's instructions had prescribed. In addition, the Indians approved a number of parcels of land for military or trading posts beyond the line. Remaining lands were guaranteed to the Indians, but there was a clear statement that when the tribes disposed of any of them the lands were to be sold only to the United States. In return for the cessions the United States delivered to the Indians $20,000 worth of goods and promised a $9,500 perpetual annuity of like useful goods, suited to the circumstances of the Indians. A tribe could ask that a part of the annuity be commuted to domestic animals, implements of husbandry, and other utensils convenient for them, and in compensation for useful artificers who may reside with or near them, and be employed for their benefit. The Indians got the right to hunt in the ceded territory without hindrance or molestation, so long as they demean themselves peaceably, and offer no injury to the people of the United States. The treaty contained the usual statements about peace and friendship and acceptance by the Indians of the protection of the United States and included provisions for a licensed trade. Point 21. The Treaty of Greenville was a good example of independent executive action in Indian treaty making. When considering a new treaty with the Western Indians in early 1793, Washington had proposed questions to his cabinet about such a treaty, especially about retrosting lands to the Indians already acquired by treaty, and he asked whether the Senate shall be previously consulted on this point. Jefferson, then Secretary of State, reported that the unanimous opinion was that it would be better not to consult the Senate, giving as a reason that news of it might leak out to the British. 22 The Senate apparently was not asked to approve Wayne as commissioner, and it received no communications from Washington about the Treaty of Greenville until December 9, 1795, 2 days after the opening of the Fourth Congress, when the President submitted the treaty, the instructions given Wayne, and the Council proceedings. On December 22 the Senators unanimously approved the treaty without any apparent concern that they had not been consulted ahead of time. Washington proclaimed the treaty on the same day. 23. Treating with the Six Nations. The hostility of the Wabash River tribes and the military expeditions against them in 1790, 1791, and 1794 created serious worry about the Indians of the Six Nations. How could their neutrality be assured, so that they did not militarily aid the Western Indians in their struggle against the United States? And was there even a possibility that some of the Iroquois might be recruited to assist the American forces? These concerns led to a number of councils with the Six Nations and ultimately to the Treaty of Canandaigua in 1794, which were the work primarily of Timothy Pickering as United States Commissioner. 24. Pickering had been active in the Revolutionary War as Adjutant General, Quartermaster General, and member of the Board of War, but he had had no direct experience with Indians until Washington in September 1790 appointed him commissioner to treat with the Seneca Indians, who were incensed by the recent murder of 2 of their number by white brigands. It was essential to United States policy to keep the Indians at peace, and Pickering met with the Senecas at Tioga Point, a frontier post on the Susquehanna River above Wilkes-Barre near the northern boundary of Pennsylvania. Here, in November 1790, he successfully redressed the Indians' grievances with mourning belts of wampum, an array of presents, and promises to investigate problems in the land purchases that had been made from the Senecas. 25. In 1791, after General Harmar's defeat, Washington sent Pickering to deal with the combined Six Nations to hold them to the line of peace. In late June and early July, the commissioner met the Indians at Newtown Point on the Chemung River in southern New York State, some 40 miles west of Tioga Point. A large gathering of Indians assembled, and Pickering sparred with the Seneca orator Red Jacket. Ignoring his instructions to attempt to recruit warriors to aid the United States in its campaign against the Western Indians, Pickering managed to quiet the Indians' fears and misgivings. He promised, to promote their adoption of the arts of husbandry, a policy that became increasingly important in his mind. After distribution of generous gifts, Pickering closed the conference on July 17, with the neutrality of the Six Nations assured. 26. After the unsuccessful peace attempts in the West in 1792 and 1793, the Six Nations again became a center of attention, especially as they challenged the development of white settlements at Presque Isle, and Pickering once more was delegated to treat with them. He met with the Indians in October 1794 at Canandaigua, the home of General Israel Chapin at the northern point of Lake Canandaigua. As usual, the Indians were slow to assemble, but eventually about 1,600 appeared, and the conference opened on October 18. Amid delays caused by Indian drunkenness, Pickering conducted the negotiations with reliance on Indian protocol, andated by the news of Wayne's victory at Fallen Timbers, which arrived on October 27. He was able, after considerable haggling, to get agreement of the Indians to a formal treaty on November 11.27. It was the last treaty with the Iroquois in which the American commissioners followed the ancient forms of the native protocol. After that the United States no longer felt bound to observe the Indian customs. 28. The treaty settled a long-standing Seneca complaint about the boundary established at Fort Stanwix in 1784 and reconfirmed at Fort Harmar, for Pickering redrew the line, returning to the Senecas more than 1,000,000 acres, and the treaty acknowledged the land of the Oneidas, Onondagas, and Cayugas reserved in their treaties with New York. The United States agreed not to claim any of the Indian lands until the Indians themselves chose to sell them to the United States, and the Indians gave up claims to any other lands. The United States won the right to build a road from Lake Ontario to Buffalo Creek on Lake Erie and free passage of American citizens through Indian lands. The Indians received goods valued at $10,000, and their annuity was raised to $4,500, to be spent yearly forever, in purchasing clothing, domestic animals, implements of husbandry, and other utensils suited to their circumstances, and in compensating useful artificers, who shall reside with or near them, and be employed for their benefit. The treaty reaffirmed perpetual peace and friendship and condemned private revenge or retaliation for injuries. 29. In addition, Pickering concluded a treaty on December 2 with the Oneida, Tuscarora, and Stockbridge Indians. It provided compensation to those loyal Indians for property lost during the Revolutionary War in the form of $5,000 to be distributed to individuals, grist mills, and sawmills with persons to run them for 3 years, and $1,000 to build a church. In return, the Indians relinquished all claims for losses and services during the war. 30. The Creeks. In the summer of 1795, President Washington turned his attention again to the Creeks and at the request of Georgia planned another treaty with them, seeking to discover and to settle the reasons for Creek dissatisfaction with the Treaty of New York. To that end he appointed Benjamin Hawkins, Andrew Pickens, and George Clymer commissioners to hold a treaty with the nation. Washington wanted the treaty to follow the general terms of the Treaty of New York, and he expected Georgia to bear half the cost of the provisions for the Indians who assembled for the council. 31. Almost a year passed before the commissioners met the Indians in May and June 1796 at Colerain, on Georgia's southern boundary, on land held by the Creeks but vehemently claimed by Georgia. 32. 3 commissioners from Georgia were on hand, but the federal commissioners refused to let them land the militia they brought up the river and in other ways put obstacles in their path. Fending off rumors that the Georgia militia intended to force a land cession from the Creeks, the federal commissioners established stringent regulations for the council grounds. The commissioners for holding a treaty with the Creek Nation of Indians, in order to prevent quarrels, improper behavior, or malpractices, during the negotiation, have judged proper, in virtue of the powers and authorities vested in them, to make the following regulations. 1. The Indians are to encamp on the river bank, above the garrison, convenient to the spring and the river. 2. The superintendent is to fix his residence within the Indian encampment. 3. No citizen of the United States is to be permitted to encamp with, or near to, the Indians, except such as are under the direction of the superintendent. 4. No citizen is to be permitted to enter the Indian camp in arms. 5. No citizen is to visit the Indians, or hold conversation with them, except with a permit from the commissioners of the United States, or either of them. 6. No citizen is to be in arms in the garrison, or neighborhood of it, and, on the arrival of any visitors, who may travel with arms, they are to be informed of this order, and required to conform thereto. 7. No citizen is to be permitted to furnish, by sale or gift, any spirit-use liquors to the Indians, or to have any commercial traffic with them. 8. These regulations are to be posted up at the 2 gates of the garrison, and at the residence of the superintendent. 33. The Georgia commissioners were outraged, for they believed that the actions of Hawkins and his colleagues were an unconstitutional assumption of power. The ground they encamp on, and the ground the treaty is to be held on, is within the limits, and under the actual jurisdiction of the state of Georgia. They complained. We know of no power on earth, competent to hinder a citizen of Georgia, observing the laws of his country, from exercising the locomotive faculty, within the limits of the state, in the most liberal extent. But the federal commissioners would not budge, and in the end the Georgians acquiesced. 34 The federal government under Washington was concerned to protect Indian rights against aggressive state citizens, and it would not be cowed by Georgia. When the Creeks rejected a cession to Georgia, the commissioners upheld them, and the Georgians were frustrated. The Treaty of Colerain, signed on June 29, 1796, reaffirmed the Treaty of New York and provided for the running of the boundary under the eyes of the Indians, and the Creeks relinquished any claims they had to land ceded by the Cherokees, Choctaws, and Chickasaws at Hopewell. Articles 3 and 4 allowed the United States to establish trading posts and military posts in the Creek country and authorized annexing to each post a tract of land 5 miles square for use of the United States, which land was to revert to the Indians when it was no longer needed by the federal government. The Indians received goods valued at $6,000 and were promised 2 blacksmiths. 35. The Georgia commissioners issued a long and strongly worded protest against the treaty the day before the signing. They objected to the restrictions on their freedom in dealing with the Indians, to the place and manner of the negotiations, to the commissioners' open rejection of the treaties of Augusta, Galphinton, and Shoulderbone, to the grant of land to the United States for posts without the consent of Georgia, and to being liable for half the provisions supplied at the council. They claimed that the United States commissioners knew before the treaty council met that the Creeks had adamantly decided against any land cessions and that sticking the state with payment for the council was a fraud on the state, and a trick, unworthy of the dignity and honor of the United States, for the treaty was to serve federal purposes and the state would reap no benefits from it. 36. These complaints were considered by the Senate, for Washington, on January 4, 1797, laid the treaty before the Senate with the bulky correspondence and other papers relating to it. The Senate spent a good deal of time on the matter, showing special concern for Georgia's protest against the grant of land around the posts without its consent. In the end, the Senate agreed to the treaty with the following proviso, that nothing shall be construed to affect any claim of the state of Georgia to the right of preemption in the land therein set apart for military or trading posts, or to give to the United States, without the consent of the said state, any right to the soil, or to the exclusive legislation over the same, or any other right than that of establishing, maintaining, and exclusively governing, military and trading posts within the Indian Territory, as long as the frontier of Georgia may require these establishments. Thus the Senate, mindful of Georgia's claims, amended the treaty, although there is no evidence that the executive was not in accord with the changes. 37. Despite the conflicts between the federal government and Georgia, the Treaty of Coleraine, unlike that of New York, was effective, and peace was finally established on the southern frontiers, the result of changed circumstances between 1790 and 1796 that strengthened the federal government's position. Alexander McGillivray had died in February 1793. Defeat of the Indians in the Northwest Territory by Anthony Wayne in 1794 removed one obstacle to forceful United States action in the South, and the Treaty of San Lorenzo with Spain in 1794 ended American-Spanish rivalry in the Southwest. The firm resolve of Washington's administration to protect the Indians from avaricious whites strengthened its hand in dealing with the Indians. That the executive was more confident in its treaty-making was shown 2. By its proceedings in the Second Creek Treaty. Whereas the Treaty of New York had been preceded by extensive collaborative discussion with the Senate, that of Coleraine was simply presented to the Senate as an established fact. Provisions for trade. Treaties by themselves were not sufficient for managing relations with the Indians. The constant complaints from the Indians of violation of the boundaries set by the treaties and the simultaneous cries from settlers about Indian depredations convinced Washington and Knox that something more was needed if the promises made to the Indians about guaranteeing their lands were to be kept and the honor of the Republic thus preserved. The President's insistent call upon Congress to take some action was met by a series of laws to regulate trade and intercourse with the Indian tribes. These laws, which were originally designed to implement the treaties and enforce them against obstreperous whites, gradually came to embody the basic features of federal policy and became a means parallel to treaties for governing Indian affairs. The first of the laws continued the pattern set by the Ordinance of 1786 by establishing a licensing system for trade with the Indians. But it also struck directly at the frontier difficulties. To prevent the steady eating away at the Indian lands by individual or by state acquisitions, the law explicitly stated in Section 4. No sale of lands made by any Indians, or any nation or tribe of Indians within the United States, shall be valid to any person or persons, or to any state, whether having the right of preemption to such lands or not, unless the same shall be made and duly executed at some public treaty, held under the authority of the United States. And to put a stop to the outrages committed on the Indians by whites who aggressively invaded the Indian country, the law provided punishment for murder and other crimes committed by whites against the Indians. 38. The law did not prove strong enough to restrain the whites and defend the Indians, and Washington continued his campaign to provide a rule of law and justice in dealing with the Indians. In his annual message to Congress on October 25, 1791, he outlined his basic principles for advancing the happiness of the Indians and attaching them firmly to the United States. He had a 6-point program. 1. An impartial dispensation of justice toward the Indians. 2. A carefully defined and regulated method of purchasing lands from the Indians, in order to avoid imposition on the Indians and controversy about the reality and extent of the purchases. 3. Promotion of commerce with the Indians, under regulations tending to secure an equitable deportment toward them. 4. Rational experiments for imparting to the Indians the blessings of civilization. 5. Authority for the President to give presents to the Indians. 6. An efficacious provision for punishing those who infringed Indian rights, violated treaties, and thus endangered the peace of the nation. 39. In 1793 Congress replaced the first trade and intercourse law with a second and stronger measure, and 3 years later still another law was enacted. The 1796 Act provided the first designation of the boundaries of the Indian country in statute law. This delineation was meant to indicate with added clarity the government's intention to uphold the treaties. There was opposition in Congress to this provision and to the strong measures to prevent encroachment on the Indian lands, but the law emerged unscathed. In 1799 the law was reenacted with only minor changes. 40. Much of Washington's program for Indian affairs was contained in these intercourse laws, and the statutory measures were continued into the 19th century with important new laws in 1802 and in 1834. But Washington had another plan as well. Next to a rigorous execution of justice on the violators of peace, he told Congress on December 3, 1793, the establishment of commerce with the Indian nations in behalf of the United States is most likely to conciliate their attachment. And the President proposed a system of government trading houses to offer competition to the profit-seeking private traders and thus eliminate fraud and extortion in the trade. Congress heeded the President's advice and in 1795 provided a tentative system of trading houses and in 1796 established the program firmly as an essential element in American Indian policy that lasted until 1822, when it was crushed by the power of private fur traders. 41. Treaties were covenants with the Indians that bound the tribes and the United States government to carry out the stipulations set forth. The trade and intercourse laws were aimed not at the Indians but at white citizens of the United States, but they had many of the same ends as the treaties. The factory system sought to benefit the Indians and promote peaceful relations with the white society by eliminating abuses in the trade and ultimately advancing the civilization programs already enunciated in the treaties and in the intercourse laws. The century ended with this tripartite policy in place. The intercourse laws and those establishing the trading houses were unilateral actions on the part of the United States in regulating the relations between its citizens and the Indians. The treaties, on the other hand, were bilateral agreements, ostensibly based on negotiations between the two parties, and an honest diplomatic give and take can be found from time to time in future decades of treaty making. But in the new century, treaties to a large extent became merely another means for the United States government to carry out the domestic Indian policy it had adopted, not unmindful, to be sure, of the Indians' welfare but primarily concerned with the interests of the rapidly expanding white population of the United States. Part 2. Instruments of Federal Policy. Between the beginning of Thomas Jefferson's administration and the end of the 1860s, the United States engaged in 6 decades of active, and in some cases almost frenetic, treaty making with the Indians. The bulk of the ratified Indian treaties, 348 of them, were negotiated in that period, and they exhibited a great variety in purpose and scope. Along with the series of trade and intercourse laws, which regulated by statute the relations between white citizens and the Indians, treaties became primary instruments for carrying out federal Indian policy. As that policy developed in complexity, so too did the intercourse laws and the treaty system. It is not true that the treaties were simply imposed upon the Indians, although there were examples of such action, for the Indians, too, saw benefits in the system. But the treaties were European instruments, and their history is heavy with white designs. Of signal importance were the massive land transfers by which the Indians lost title to most of the continental United States. By 1860, cessions of land made by the Indians in the treaties had cleared the eastern half of the nation of Indian title, and the Indians had lost as well most of the Pacific slope. In the next decade much of the remaining Trans-Mississippi West passed into white hands. 1. A good deal of the land transfer occurred during the period of Indian removal in the 1830s, when eastern lands of the Indians were exchanged for lands beyond the Mississippi, with the fatuous hope among federal officials that west of the Great Lakes and west of Arkansas and Missouri the Indians would be secure from white pressures and white vices. Then the great territorial acquisitions of the 1840s Texas, Oregon, and the Mexican Cession upset that vision, and the United States suddenly had to deal with new communities of Indians on the plains, in the mountains, and beyond the Sierras and Cascades. Although these Western Indians differed in marked respects from those who had originally lived east of the Mississippi, the old treaty patterns were used to deal with them. As westering white citizens moved to Oregon and California and onto the plains, they aroused Indian resentment and resistance that led to 2.5 decades of Indian wars. The Civil War, too, in which the Southern Indians in what is now Oklahoma joined the Confederacy, brought new problems. The convenient solution for all the Western problems was to extend the trade and intercourse laws to the new regions and to sign treaties with the newly encountered Indian inhabitants. The treaties in the New West recapitulated in their reformist and civilizing tendencies the old treaties, which were in fact consciously adopted as patterns. There was occasional criticism of the treaty system from United States officials and voicing of doubts by them and other Americans about whether treaties were a legitimate form of agreement between an increasingly dominant white society and the increasingly weakened and dependent Indian tribes. During the debate over Indian removal, especially, were the pros and cons of treaty making vigorously debated, but there was no concerted drive yet to end the system. Chapter 5. Testing the Treaty System. 1800 to the War of 1812. Jefferson's administration continued the process of treaty making, accepting without question what by then had become the traditional method of dealing with the Indian tribes. Between 1800 and the War of 1812 the treaty system was well tested, as treaties were negotiated with the Southern Indians, with the Six Nations in New York, and with the tribes in the Old Northwest, altogether some 30 treaties. These documents specified and confirmed the uses to which treaties were put by the United States government. Treaties with the Southern Indians. The treaties with the Southern tribes before the War of 1812 were generally well ordered. The commissioners had clear instructions, and they dealt with established chiefs of tribes that already had been recognized as nations in treaties concluded at the end of the Revolutionary War. And except for some overlapping of claims, the different tribes had clearly defined territories. The Indians, of course, were not easily swayed to part with lands they did not want to sell, so the goals of the United States were only partially obtained. Nevertheless, the continual pressure from white settlers, the decrease in game on Indian hunting lands, the heavy debts the Indians owed to merchants and traders, and some judicious attention to pliant chiefs enabled the United States to acquire extensive new lands. 1. The treaties were short documents and primarily land cession instruments, and the chief American motive for the cessions was to satisfy the expanding white population seeking new lands. Our 17 states compose a great and growing nation, Jefferson told visiting Choctaws in Washington at the end of 1803, their children are as the leaves of the trees, which the winds are spreading over the forest too. But Jefferson had other concerns, as well. Out of fear of foreign invasion up the Mississippi Valley, he was determined to obtain possession of lands bordering the river on the east. In addition, roads through the Indian country were needed to tie the sections of the nation together. The Indians, especially the Creeks and the Cherokees, strongly resisted selling more land, though little by little they gave in. The Choctaws and to some extent the Chickasaws, burdened by debts owed to the British trading firm of Panton, Leslie and Company, were more willing to cede lands so that they could obtain funds to pay their creditors. Jefferson's remarks about encouraging the Indians to run up debts at United States factories because they would then be willing to lop them off by cessions of land have been frequently quoted as an indication of the president's cynicism. 3 But in fact the Indians needed little encouragement to run into debt. As hunting for furs and pelts declined, cession of lands was the only way at hand to pay for trade goods that had become necessary for their well-being. In May 1800 Congress authorized $15,000 to defray the expense of such treaty or treaties, as the President of the United States shall deem it expedient to hold with the Indians south of the river Ohio. Jefferson acted quickly, and through Secretary of War Henry Dearborn he made preparations to deal with those tribes. Postponing action with the Creeks for the time being, Dearborn in mid-June 1801 called the Cherokees to a conference at Southwest Point in eastern Tennessee on August 1, the Chickasaws at Chickasaw Bluffs on September 1, and the Choctaws at Natchez on October 1, urging them to send their principal men as representatives of the whole tribe. 4. In instructions of June 24 to William R. Davie, James Wilkinson, and Benjamin Hawkins, the United States Commissioners, Dearborn outlined what they were to seek from each of the tribes and what compensation might be paid. Above all, the commissioners were cautioned to proceed diplomatically. They were told to pay careful attention to the disposition of the Indians and to introduce the wishes of the government in such a way that they could drop them quietly in the face of Indian objections without giving the Indians an opportunity to reply with a decided negative, or raising in them unfriendly and inimical dispositions. None of the propositions were to be stated in a tone of demands, and the commissioners were to proceed according to their judgment of the prospects of success of the various items they proposed. 5. Less than a month later, Dearborn sent the commissioners special instructions for dealing with the Creeks, whom they were to meet at Fort Wilkinson in Georgia after dealing with the other tribes. He charged them to obtain the area known as Tallahassee County and to investigate the possibility of gaining land also between the Oconee and the Ocmulgee rivers. The Creeks being a powerful and proud nation, and great jealousies having at different times arisen between them and the frontier inhabitants, Dearborn told the commissioners, all prudent means in your power should be exerted to reconcile them, and to remove every obstacle to their mutual friendship. 6. The results of this first round of 19th-century treaties were mixed. Our applications to the Cherokees failed altogether, Jefferson admitted. Though our overtures to them were moderate, and respectful of their rights, their determination was, to yield no accommodation. The commissioners' request for a road through Cherokee country and for sites for houses of entertainment and ferries was met curtly by the Indians. The roads you propose, we do not wish to have made through our country. 7. The Chickasaws and the Choctaws were more obliging and allowed roads through their lands. The Choctaws pleased the commissioners by indicating a willingness to consider agriculture and domestic manufactures and by rejecting the whiskey that was intended as presents for them. 8. The Creeks, in delayed negotiations, in June 1802 ceded 2 narrow strips of land in exchange for sizable annuities, goods, and payment of debts and allowed the United States to establish military posts within their country. 9. The first round of treaties with these southern tribes was quickly followed by another stretching from 1802 to 1806 that provided a series of land cessions. The initial treaties, with the Choctaws, were simple conventions formally specifying boundaries for lands previously ceded by the Indians to Great Britain. These were routine matters, hardly calling for formal treaty procedures, but there seemed to be no other way to accomplish the business. 10. More complicated was a treaty of limits negotiated with the Choctaws by Silas Dinsmore, a New Hampshire Yankee who was their agent, and James Robertson, a Tennessee soldier and land speculator. President Jefferson, eager to build up settlements along the Mississippi, wanted land for that purpose held by the Choctaws, and the Choctaws, heavily in debt to Panton, Leslie and Company, were willing to sell. At the instigation of the company, the Indians in 1803 and 1804, knowing that they could not alienate their land to the company directly, petitioned the president to buy enough land to provide money to cancel the debts. 11. A preliminary meeting with the Choctaws at Fort St. Stephen's in the summer of 1805 produced no results. 12. Then, in November 1805, a treaty was signed at Mount Dexter in the Choctaw country. The Indians were unwilling to cede the lands along the Mississippi, but with the heavy debt resting upon them and Panton, Leslie and Company more insistent on payment, they made a large cession of lands in southern Mississippi Territory. In compensation, the United States agreed to pay $50,000, of which $48,000 was to enable the Mingos to discharge the debt due to their merchants and traders, and also, to pay for the depredations committed on stock and other property by evil-disposed persons of the said Choctaw Nation. 13. Jefferson still clung to his desire to gain lands along the Mississippi and lamented the fact that the Choctaws had won out at Mount Dexter, and ceded alternate lands instead to cover their debts. He stubbornly refused to send the treaty to the Senate. As he later told that body, against express instructions, and not according with the object then in view, I was disinclined to its ratification, and therefore did not, at the last session of Congress, lay it before the Senate for their advice, but have suffered it to lie unacted on. But conditions changed, as tension arose between the United States and Spain over West Florida, and Jefferson reconsidered. It is now, perhaps, he said at the beginning of 1808, become as interesting to obtain footing for a strong settlement of militia along our southern frontier, eastward of the Mississippi, as on the west of that river, and more so than higher up the river itself. The consolidation of the Mississippi Territory, and the establishing a barrier of separation between the Indians and our southern neighbors, are also important objects. So he finally submitted the treaty to the Senate on January 15, 1808, and the Senate approved it unanimously on January 27.14. The Chickasaws, too, were indebted to Panton, Leslie and Company and agreed to a land cession in 1805. The treaty provided $20,000 for the use of the nation at large, and for the payment of the debts due to their merchants and traders. As was common in the treaties, the United States provided special payments for the chiefs. 15. The United States, pressed by Georgia, did not give up its intention to gain from the Creeks the lands in Georgia between the Oconee and the Ocmulgee rivers, but it was a long process, for the Indians did not want to give up the lands. A conference in 1803 failed to gain Indian assent, and Dearborn informed Governor John Millage of Georgia that the boundary would be marked in conformity with the stipulations of the 1802 Treaty of Fort Wilkinson. But soon new negotiations were undertaken, and in November 1804 the Indians granted land west to the Ocmulgee and were promised payment of $200,000 to be held in trust by the Secretary of War, with 6% interest paid to the Indians semi-annually. 16. It was a high price, but a necessary one, as the President explained to the Senate when he submitted the treaty for its approval in December 1804.17. The Senate refused its sanction. On February 2, 1805, after an unsuccessful attempt to send the treaty back to the President for such modification of the terms contemplated by said treaty, as well relative to price, as to the mode of payment, as may be more conformable to the policy and interest of the United States, it rejected the treaty by a vote of 19 to 12. When the Senate returned the treaty, however, it sent along a special resolution requesting the President to cause a further and immediate negotiation to be entered into, for the procuring of the lands between the Oconee and Ocmulgee rivers, not already obtained, together with such other lands as the said Creeks may be disposed to relinquish. 18. Finally, in Washington, on November 14, 1805, Dearborn signed the desired treaty with the Creeks, in which the Ocmulgee became the boundary and a horse path was authorized from the Ocmulgee to Mobile through the Creek country. The Creeks accepted an annuity of money or goods, and implements of husbandry, at the option of the Creek Nation $12,000 worth for 8 years and then $11,000 worth for 10 succeeding years, a little more than half as much as the original treaty had provided. The Senate approved the treaty 28-1 on December 23, 1805.19. Although they were urged to do so, the Creeks refused to specify in the treaty any use of the money to pay their debts to Panton, Leslie and Company. 20. At length the Cherokees, who had refused to consider the proposals of the United States Commissioners in 1801, signed a series of 4 treaties in 18,046.21. In the first of these, on October 24, 1804, the Cherokees agreed to no more than the relinquishment of a small tract in Georgia known as Wofford Settlement, for a payment of $5,000 in goods and an additional annuity of $1,000.22. The subsequent history of this treaty is a good indication of the less than sacrosanct character with which the documents were endowed. 4. The treaty was lost in the War Department files for 20 years. It was not received by President Jefferson and thus not sent to the Senate for its action. The Indians received the $5,000 payment on the spot and relinquished the land, but the promised annuity was not forthcoming. Then, in January 1824, a Cherokee delegation in Washington brought up the question of the treaty, but the War Department, after a search of its files, could find no record of it. At that point the Cherokees produced their copy of the treaty and asked that it be sent to the Senate to complete the process of ratification. John McKee, one of the witnesses of the signing of the treaty in 1804 and then a member of the House of Representatives from Alabama, attested to the genuineness of the treaty, and Secretary of War John C. Calhoun sought information as well from Thomas Jefferson, who called the document genuine and asserted that his careful records of correspondence indicated that he had never received the treaty or laid it before the Senate. He apologized deeply for this slip of the executive functionaries. The Cherokees' copy of the treaty was sent to the Senate, which gave its consent to ratification on May 13, 1824.23. Since the ill-fated Treaty of 1804 had not obtained cession of all the lands that the federal government had instructed the treaty commissioners to acquire, 3 additional treaties were negotiated, one at Tellico, another in Washington, and a third at Chickamauga. In the first 2 the Cherokees ceded land, the successful negotiations being aided by gifts to the chiefs who signed the treaties. Return J. Meigs, the Cherokee agent, who was one of the commissioners, later wrote to the Secretary of War, "With respect to the chiefs who have transacted the business with us, they will have their hands full to satisfy the ignorant, the obstinate, and the cunning of some of their own people, for which they well deserve this silent consideration." 24. On December 2, 1807, Meigs negotiated another treaty with Cherokees, this time at Chickamauga on the Tennessee River, to purchase from the Indians a tract of land 6 miles square as a site for iron works, although the Indians agreed as well that if the ore should give out in the ceded tract, the United States shall have full liberty to get ore off their land in the most suitable place. Jefferson, in transmitting the brief treaty to the Senate, spoke strongly of the advantages of the measure, not least because the iron works would create a demand for corn and other provisions and would immediately draw around it a close settlement of the Cherokees, would encourage them to enter on a regular life of agriculture, familiarize them with the practice and value of the arts, attach them to property, lead them, of necessity, and without delay, to the establishment of laws and government, and thus make a great and important advance towards assimilating their condition to ours. The Senate, apparently not moved by this prospective utopia and not convinced by the advantages Jefferson pointed out of producing cast and wrought iron in close proximity to the Indians, after considerable delay rejected the treaty unanimously on January 10, 1812.25. Land transfers in New York. Land transfers accomplished in New York in the first years of the new century illustrate the wide latitude of Indian treaty procedures under the Constitution, for some documents in the official collection of Indian treaties are a far cry indeed from conventions between sovereign nations. The sale of Indian lands to the state of New York or to individuals or land companies within the state had begun at the end of the 18th century. A notable example was the sale on September 15, 1797, by the Senecas to the land speculator Robert Morris of all the country in western New York assigned to the Indians by the Treaty of Canandaigua in 1794, except for certain reserved parcels. This was done by an indenture. Although the document described the sale as done at a treaty held under the authority of the United States, this transaction was not treated as an official treaty. 26. Then, in order to exchange tracts of land and to cede some of the reserved lands, new negotiations were undertaken in 1802 at the instigation of Governor George Clinton of New York. To handle them on the part of the United States, Thomas Jefferson appointed John Taylor of New York. 27 Secretary of War Dearborn sent instructions to Taylor on March 17, which made clear the commissioner's subordinate role to Governor Clinton. Governor Clinton will notify you of the time and place of holding any such conventions. You will act in some measure in the character of an umpire between the state and the said Indians in any bargains which may be made between the parties, and you will of course pay due attention to the interests of the Indians, and see that all transactions relative to our bargains are explicit and fair. Taylor's compensation was to come from New York, or, in case of cessions to the Holland Land Company, from the company. At the same time Dearborn wrote to Clinton about the proposed negotiations. It has been considered, he said, that all such bargains, between individuals and any of the Indian nations should be made under the direction of the governor of the state in which such Indians reside. Mr. Taylor will therefore attend to the negotiations between the aforesaid agent and the Senecas, by instructions from your Excellency when convenient for the parties. 28. Out of the negotiations came 4 documents, which President Jefferson on December 28, 1802, laid before the Senate as treaties, asking whether you will advise and consent to their respective ratifications. 29. One between the State of New York and the Oneida Indians, dated June 4, 1802, by which the tribe ceded tracts of land to the state for an immediate sum plus a perpetual annuity to be paid by the state. 2 between the State of New York and the Seneca Indians, dated August 20, 1802, by which the Indians sold to the state lands along the Niagara River. 3 between the Holland Land Company and the Seneca Nation, dated June 30, 1802, in which an exchange of parcels of land was negotiated. The heading of this document calls it an indenture, but the body of the document speaks of a treaty, held under the authority of the United States. The document was signed by only the Senecas and the Holland agents, but Taylor attested that it was done at a full and general treaty. Under the authority of the United States. 30. 4 between the Seneca Indians and Oliver Phelps and his associates Isaac Bronson and Horatio Jones, dated June 30, 1802, by which the Indians sold the men a tract of land along the Genesee River known as Little Beard's Reservation. The document speaks of a treaty held under the authority of the United States. In the presence of John Taylor, Esquire, Commissioner, appointed by the President of the United States for holding said treaty. Actually, Taylor had some doubts about whether his commission included this action, but apparently those doubts were resolved positively. 31. The Senate on receipt of the 4 treaties from the President considered them over a period of days from December 28, 1802, to February 4, 1803, referring some of them to a committee for study. In the end it advised and consented to them all and so informed the President. 32. But of the 4 documents only 2 oaths with Oliver Phelps and with the Holland Land Company were finally ratified by the President, the first on January 12 and the second on February 7, 1803. They were incorporated into the State Department's official collection of treaties, printed in the United States Statutes at Large, and entered into Charles J. Kapler's official compilation. 33. The treaties between the Oneidas and the Senecas and the State of New York were dropped for reasons that cannot now be ascertained. 34. William Henry Harrison. Treaty making in the Old Northwest was more complicated and confused than that with the established tribes in the South and in New York. The Treaty of Greenville in 1795, with its effective land grants north of the Ohio, had not settled affairs as firmly as General Wayne had imagined. The line established by the treaty was not immediately marked, and the press of settlers to the north and west created new troubles with the resident Indians. Parcels of land granted to the United States at Greenville beyond the principal boundary, especially that at Vincennes, needed specification. Some tribes in the area, like the Sacs and Foxes, moreover, had not signed treaties with the United States, and others, like the Kaskaskias, had wasted away until their land claims seemed out of proportion to their small numbers. To add to the difficulties, in the first decade of the new century, the Indian tribes of the region showed a restlessness, aggravated by British intrigue, that could easily have led to war. Responsibility for Indian affairs in this cauldron rested largely on William Henry Harrison, who on May 13, 1800, at the age of 27, was appointed governor of the newly created Indiana Territory. 35 Harrison, when he arrived at Vincennes in January 1801 to assume his new duties, faced the difficulties realistically. He noted the near impossibility of bringing white murderers of Indians to justice, the need to remove white settlers who had settled beyond the treaty lines, the illegal destruction of game on the Indian lands by whites, the necessity to conciliate the Indians lest the abuses lead them to war against the United States, the immense and destructive problem of drunkenness among the Indians, and the difficulty of dealing effectively with Indian groups that had not yet entered into any treaty relationship with the United States. 36. For the next 2 years a heavy correspondence about Indian affairs passed between Harrison at Vincennes and the Secretary of War and the President. The governor made clear the needs and offered his suggestions for action. He depended closely on the directions he received from his superiors in Washington, but they in turn gave him almost total discretion in handling specific affairs with the Indians. 3 particular elements in the relations with the Indians in the Old Northwest called for new treaties with the tribes. Foremost was the matter of land. The United States wanted new cessions to satisfy the pressure of white settlers and to consolidate the settlements already begun, as, for example, between the Greenville cession and the growing settlement at Vincennes. And when news reached the United States of the transfer of Spanish Louisiana to France, Jefferson and others became alarmed about American security and sought land cessions from the Indians that would give the United States control of land along the upper Mississippi. Jefferson in February 1803 remarked on the importance of gaining the whole eastern border of the Mississippi. "The crisis is pressing," he wrote. "Whatever can now be obtained must be obtained quickly. The occupation of New Orleans, hourly expected, by the French, is already felt like a light breeze by the Indians. You know the sentiments they entertain of that nation. Under the hope of their protection, they will immediately stiffen against cessions of land to us. We had better therefore do at once what can now be done." 37. Before new cessions could be negotiated, however, precise boundaries needed to be established and marked for lands already ceded, and the continual and often bitter controversies among the different tribes about joint or independent ownership of particular areas had to be resolved. Such resolution of disputed boundaries and disputed ownership was needed not only to maintain peace but to facilitate new cessions of land for white occupancy. As Harrison candidly reported to the Secretary of War near the end of his tenure as governor, it was at once determined, that the community of interests in the land amongst the Indian tribes, which seemed to be recognized by the Treaty of Greenville, should be objected to, and that each individual tribe should be protected in every claim that should appear to be founded in reason and justice. Harrison also wanted to provide compensation to Indians who lived on lands to be ceded, even though they did not have claim to the land, and he admitted such Indians as parties to the treaties. In addition, he sought to get recognition of particular tribal claims by the other tribes, so that there would be no grounds for complaint when the lands were transferred. 38. A second strong element of Jeffersonian policy to be incorporated into treaties was the program of civilization that sought to turn the Indians from hunters into farmers. 39. Secretary of War Dearborn reminded Harrison that the intention of Congress in establishing trading houses was to promote the introduction of civilization, by encouraging and gradually introducing the arts of husbandry and domestic manufactures among them. And Jefferson himself repeatedly preached this doctrine to Indian groups who visited Washington. The President told Harrison, the decrease of game rendering their subsistence by hunting insufficient, we wish to draw them to agriculture, to spinning and weaving 40. Harrison in turn harangued the Indians on the same point when he met them in council. He told a group of Kaskaskias, Kickapoos, Wees, Eel River Miamis, Piankashaws and Potawatomis whom he met at Vincennes in August 1802 that the President wanted them to assemble your scattered warriors, and to form towns and villages, in situations best adapted to cultivation. He will cause you to be furnished with horses, cattle, hogs, and implements of husbandry, and will have persons provided to instruct you in the management of them. Harrison told the Indians of God's command for men to increase and multiply, and that divine command could not be obeyed if we were all to depend upon the chase for our subsistence. In the minds of the Jeffersonians, adoption of white civilization and the cession of lands went hand in hand, for as Jefferson told Harrison, when they withdraw themselves to the culture of a small piece of land, they will perceive how useless to them are their extensive forests, and will be willing to pare them off from time to time in exchange for necessaries for their farms and families. 41. A third factor that led to treaties with the Indians under Harrison's jurisdiction was the patent needs of the Indians. Their dependence upon white goods, like that of Indian groups in other regions of the United States, became increasingly manifest, as advancing white settlement and a decrease in fur-bearing animals made reliance on the fur trade insufficient for their needs. Many Indians were eager enough for presents and annuity goods to be willing to cede lands, again and again, to the Americans. As Harrison noted when he explained to the Secretary of War why he had included the Potawatomis in the Treaty of Fort Wayne, the poverty and wretchedness of the Potawatomis made them extremely desirous of a treaty at which they expected to have their most pressing wants relieved. 42. For these reasons treaty making proceeded rapidly under Harrison's direction. On February 8, 1803, Jefferson sent the governor a special commission, with full power to conclude and sign any treaty or treaties, which may be found necessary with any Indian tribes northwest of the Ohio, and within the territory of the United States, on the subject of their boundaries or lands. 43. Between that date and the conclusion of treaties at the end of 1809, Harrison negotiated 11 treaties with the Indians. 44. Harrison succeeded in his mission, cajoling the tribes and playing upon their dependency for goods. He specified boundary lines for the tract at Vincennes ceded by the 4th article of the Treaty of Greenville, and acquired a valuable salt spring in southern Indiana and sites for houses of entertainment along roads through Indian lands. The cessions made by the Indians stretched west to the Mississippi. By the end of 1805, in fact, he had gained for the United States a margin of land north of the Ohio above the mouth of the Wabash in present-day Indiana, roughly 50 miles in width. And in what is now Illinois he gained a large central area from the Kaskaskias and a connecting link with the Indiana lands from the Piankashaws, to say nothing of a huge cession made at St. Louis in 1804 by the Sacs and Foxes, who gave up their claims to the territory between the Mississippi and Illinois rivers, running north as far as Wisconsin and including a segment of land across the Mississippi in what is now Missouri. To make these cessions more secure, the governor obtained a release from other tribal claimants to some of these lands. 45. In return the United States paid small sums in accordance with what it was accustomed to pay for Indian title. These were in the form of goods or money, paid on the spot or provided as annuities. Payments were intended to ease the hardships and suffering of the Indians, but the treaties also vigorously pushed a civilization program for the Indians. A good example is the treaty with the Delawares at Vincennes in 1804, in which the official rationale was explicitly set forth in the preamble. The Delaware tribe of Indians, finding that the annuity which they receive from the United States is not sufficient to supply them with the articles which are necessary for their comfort and convenience, and afford the means of introducing amongst them the arts of civilized life, and being convinced that the extensiveness of the country they possess, by giving an opportunity to their hunting parties to ramble to a great distance from their towns, is the principal means of retarding this desirable event, and the United States being desirous to connect their settlements on the Wabash with the state of Kentucky. The tribe ceded the land along the Ohio that the United States wanted, and the United States promised on its side to increase the tribe's annuity by $300, to be exclusively appropriated to the purpose of ameliorating their condition and promoting their civilization. In addition, the United States agreed to employ persons for 5 years to teach the Indians how to build fences, cultivate the earth, and perform such of the domestic arts as are adapted to their situation, and $400 worth of draft horses, cattle, hogs, and implements of husbandry were to be delivered in the course of the next spring. All of this, plus $800 worth of goods delivered at once, was the payment for the ceded tract. 46. After Harrison's treaties of 1803, 1804, and 1805, conditions in the Old Northwest were not conducive to treaty making. Increasing hostility of the tribes, many of whom supported the Prophet and his brother Tecumseh, and the continuing British agitation convinced Harrison to lie low for the time being. But by the summer of 1809, the governor noted more peaceful circumstances, and he wrote to the Secretary of War from Vincennes, "I have for several years considered a further extinguishment of Indian title as a most desirable object. And it appears to me that the time has arrived when the purchase may be attempted with a considerable prospect of success." 47. President Madison's Secretary of War, William Eustis, quickly gave his approval. "The President of the United States," he wrote in mid-July, "authorizes and instructs you to take advantage of the most favorable moment for extinguishing the Indian title to lands lying east of the Wabash and adjoining south on the lines of the treaties of Fort Wayne and Gru's Eland. The compensation to be paid for this extinguishment should not exceed the rate heretofore given for the Indian title to lands in that quarter, to prevent any future dissatisfaction. Chiefs of all the nations who have or pretend right to these lands, should be present at the treaty, and, if practicable, the cession should be obtained without leaving any reservations." It was left to the governor to decide the method of payment: a gross sum at the signing of the treaty, installment payments, an annuity for a set number or years, or in perpetuity, or a combination of these modes. 48. Harrison decided to hold the treaty at Fort Wayne, rather than at Vincennes, where the facility of procuring spirits and the constant intrusion of bad men amongst them would probably render them unmanageable. He met the various groups as they arrived, explained his purposes, and tried to calm the jealousies between tribes. In general meetings he pressed the Indians for a new cession, pointing to the vast benefit which they derived from their annuities, without which they would not be able to clothe their women and children, and that the proposed addition to these annuities would enable them to acquire domestic animals and begin raising them on a large scale. But he held firm against Indian demands for a higher price for their lands. He spoke to them, also, of the purposes and importance of treaties. No other power but the United States had ever treated with them. Other civilized nations considered the lands of the Indians as their own and appropriated them to their own use whenever they pleased. A treaty was considered by white people as a most solemn thing, and those which were made by the United States with the Indian tribes were considered as binding as those which were made with the most powerful kings on the other side of the big water. They were all concluded with the same forms and printed in the same book, so that all the world might see them and brand with infamy the party which violated them. The United States would always adhere to their engagements. To do otherwise would be offensive to the Great Spirit, and all the world would look upon them as a faithless people. 49. The Miamis were the hardest to convince, but at length, after a private conference with Harrison, they too joined in signing the treaty, which took place on September. The narrow triangle in the territory ceded at the Treaty of Greenville, a sizable area north of the Vincennes Tract, and two smaller tracts west of the Wabash along the border of Indiana and Illinois. Money and goods were presented at the treaty grounds, and the permanent annuities of the tribes were increased. Harrison rejoiced that the cessions would contain upwards of 2.5 millions of acres and will cost less than 2 cents per acre. 51. Then, in order to complete the negotiations and get approval from Indians who were not at Fort Wayne, Harrison signed separate treaties at Vincennes with the Whees on October 26 and with the Kickapoos on December 9. These were the last of Harrison's treaty-making before the outbreak of the War of 1812.52. Harrison had had his way in arranging cessions of land from separate tribes, vindicating his opinion that joint ownership by all the tribes did not obtain. Formal treaties had proved an effective vehicle for his policies, and the governor had had full support from the President, Secretary of War, and the Senate, which ratified all the treaties with little trouble. But the Treaty of Fort Wayne in 1809 severely aggravated the increasing Indian hostility to white advance in the Old Northwest. Tecumseh, seeking to build a confederacy of tribes against the whites, bitterly denounced the treaty. He claimed that the chiefs who sold the land had no right to do so and that they would be killed unless the land was restored to the Indians. 53 Harrison's encounters with Tecumseh only widened the difference between them, and Harrison's victory over the Prophet at Tippecanoe in 1811 accomplished nothing toward pacifying the Indians, who for the most part sided with the British in the war that was rapidly approaching. Other treaties in the North and West. While Governor Harrison carried on negotiations with Indians in his territory, other commissioners dealt with tribes outside his purview. One of these was Indian agent Charles Jahut, appointed a treaty commissioner by Secretary of War Dearborn in the spring of 1805. Dearborn instructed him to hold a treaty with Wyandot, Ottawa, Chippewa, and other Indians at which the tribes could sell to two land companies their claims within the Western Reserve of Connecticut. Connecticut had reserved these lands lying south of Lake Erie when it transferred its western lands to the federal government, and the preemption rights to the western part of this reserve had fallen to the Connecticut Land Company and a company incorporated under the name of the proprietors of the 500,000 acres of land, lying south of Lake Erie, called Suffer's Land 54. Jahut's task was to call the interested Indians to a council, over which he would preside, so that they could cede the lands to the land companies at terms that would be fair and just. Dearborn hoped to keep the cession price at from 1 to 2 cents an acre, in line with what the United States was paying at the time. He told Jahut, in addition, to attempt to purchase for the United States the tract of land lying between the 41st parallel and the Treaty of Greenville line, at not more than 2 cents an acre. Dearborn estimated the tract at 1 million to 1,250,000 acres. 55. On July 4, 1805, Jahut signed two treaties with the Wyandot, Ottawa, Chippewa, Munsee, and Delaware, Shawnee, and Potawatomi Indians at Fort Industry near the mouth of the Maumee. In one, the Indians sold to the land companies the desired tract for the sum of $18,916.67. In the other, the tribes ceded to the United States the land between the 41st parallel and the Treaty of Greenville line as far west as the meridian 120 miles west of Pennsylvania, for which a perpetual annuity of $1,000 was agreed upon. 56 Jahut's presence at the agreement between the Indians and the land companies, like that of John Taylor at the Seneca treaties, fulfilled the stipulations of the trade and intercourse laws that forbade sale of lands by Indians without the concurrence of the federal government. It was a strange use of a formal treaty, but it protected the interests of the United States and of the Indians, too. The problematic nature of treaty making on the western frontier is well illustrated by a treaty signed by Lieutenant Zebulon M. Pike with the Sioux at the mouth of the Minnesota River on September 23, 1805. In the treaty, the Indians relinquished, for military and trading posts, a 9-mile square at the mouth of the St. Croix River and a strip 9 miles wide on each side of the Mississippi from the mouth of the Minnesota up to and including the Falls of St. Anthony. The treaty itself left blank the amount of payment, which the Senate filled in with the sum of $2,000. The treaty was slow in getting to Washington, but once received, Jefferson submitted it to the Senate on March 29, 1808, even though he said the United States had no immediate plan to establish a post in the area. The Senate approved it unanimously with the $2,000 insertion on April 16, but the treaty was never proclaimed by the President. 57. The United States negotiated treaties also with Indians in Michigan Territory, which had been cut off from Indiana Territory in 1805. Dearborn sent a commission and instructions to Governor William Hull on July 22, 1806, directing him to negotiate with the chiefs of such Indian tribes or nations, as are actually interested in a large section of land lying in southeastern Michigan, and, if possible, another tract in northwestern Ohio. Dearborn was solicitous that the number of Indians invited be kept to a minimum. No greater number of Indians should attend the treaty, he told Hull, than what will be necessary to include all the chiefs of any note of the respective nations. You will find it necessary, for you to be particularly attentive to this object, otherwise you will have such a concourse, as will be not only troublesome but very expensive. From 50 to 100, is as great a number, as ought to be allowed to attend. He instructed Hull, further, not to entertain at public expense a concourse of white people, who may have the curiosity to attend the treaty, and very little liquor was to be furnished the Indians. As to prices for the land, Dearborn suggested that it should not be more than 1 cent an acre and not on any condition to exceed 2 cents per acre 58. On November 17, 1807, Hull signed a treaty with the chiefs and warriors of the Ottawa, Chippewa, Wyandot, and Potawatomi nations, in which the cession of the Michigan lands was accomplished. Hull warned the Indians of impending war with Great Britain and urged them not to join the British, and in the treaty the Indians acknowledged themselves to be under the protection of the United States and that they would prove by their conduct that they are worthy of so great a blessing. A number of small reservations for the Indians were specified in the treaty. 59. The next year at Brownstown, south of Detroit, Hull treated with the same tribes plus the Shawnees for the additional cession, in which the United States acquired roadways through the Indian lands in northwestern Ohio. 60 President Jefferson had addressed a special message to these Indians, confirming their ownership of their lands and their freedom to sell or not sell as they chose, but he also pointed to the need of the United States to connect its settlements and made an eloquent plea for the Indians to settle down on individual family farms. He, like Hull, called attention to the increasing tension with Great Britain and warned the Indians of the disaster that would strike them if they forsook their friendship with the Americans and joined the British in war. 61. The irregularities in making treaties with Western tribes, the high-handed treatment of unfriendly Indians, and the control of tribes by withholding trade are all evident in the treaty signed in 1808 with the Great and Little Osage Indians. These Indians had a history of hostility toward other tribes and toward the Americans. Militant Osage warriors stole horses and plundered the frontier, and the chiefs could not control them. At the direction of the Secretary of War, William Clark, Superintendent of Indian Affairs and Brigadier General of Militia in Louisiana Territory, went up the Missouri some 300 miles from its mouth to establish a trading factory and a military post. The Osages were pleased with the plans for a factory and a post and, Clark said, expressed much anxiety to become more closely under the protection of the United States than they had been. Clark, thereupon, drew up a conditional treaty by which the Indians on September 14, 1808, agreed to cede their lands between the Arkansas and the Missouri east of the fort. Clark took the treaty to St. Louis and delivered it to Meriwether Lewis, the governor, who changed the document to satisfy some Osage objections and then sent the new treaty, in the hands of the Indian agent and trader Pierre Choteau, to the main Osage encampment in the West. 62. In his instructions, Lewis urged Choteau to use that extensive influence, which you have long possessed over those nations, and he set forth the advantages that would be gained. This draft of a treaty, you will observe, contemplates something more than the restoration of peace. It gives to the Great and Little Osage, the most efficient security, in our power to bestow. It assures to them, for their exclusive use, the lands west of the boundary line. It separates those who sanction it, from the vicious and the profligate, whom no treaties can bind, whom no menaces can intimidate, and by whose ungovernable conduct, the peace of both nations is perpetually endangered. It enables us also, to reduce to submission, without bloodshed, those who persevere in hostility, by withholding from them the merchandise necessary for their support. By these arrangements, we shall also obtain a tract of country west of our present settlements, and east of the hunting boundary of the Osage, sufficient for the purposes of our white hunters, and for such Indian nations, as have long been on terms of intimate friendship with us. Thus, will our frontier be strengthened and secured, with the least possible expense to the government. The governor was blunt. He insisted that those Osages who wanted to be friends of the United States must sign the treaty. They would be given certificates which would allow them to trade at the factory or fort. Those who did not were not to be supplied with goods, either from the factory or from private traders, under any pretext whatever. 63. By the treaty the Osages were received into the exclusive friendship and protection of the United States, and they agreed not to sell lands to any foreign power or to citizens of the United States without the approval of the federal government. The United States, in return for the cession of lands, confirmed its commitment to establish a factory and a fort, to furnish a blacksmith and a horse mill, and to reimburse its citizens for goods stolen by the Osages. Goods worth $1,200 were delivered at the signing of the treaty, and an annuity of $1,500 was stipulated. 64. Thus did the United States use the treaty-making power in the first decade of the century to further its interests and to some extent those of the Indians as well. The United States got land for expanding settlement and to provide for the perceived needs for security on its frontiers. And the treaties repeatedly established the dominant position of the United States, as the tribes acknowledged the friendship and the protection of the federal government. But the tribes, too, profited. Though they parted reluctantly with their lands, they faced the hard fact that land was a commodity that could be exchanged for goods they needed and could not produce for themselves. As Thomas Jefferson observed in 1803, while they are learning to do better on less land, our increasing numbers will be calling for more land, and thus a coincidence of interests will be produced between those who have lands to spare, and want other necessaries, and those who have such necessaries to spare, and want lands. 65. The Indian tribes also got something more. The treaties were a form of political recognition, the attesting by the United States government that the Indian tribes with whom they signed formal treaties were separate political entities. Even though the disparity of power between the United States and the tribes was clearly evident, none of the federal officials before the War of 1812 suggested that the treaty system was a farce or that it should be ended. Chapter 6. A Position of Dominance. The War of 1812 and after. The War of 1812 was a watershed in the history of treaty making with the Indians. The defeat of the British and their Indian allies by William Henry Harrison at the Battle of the Thames in October 1813 and the resounding defeat of hostile Creeks by Andrew Jackson at Horseshoe Bend in March 1814 removed all serious threat of Indian military resistance east of the Mississippi River. Whereas the United States, despite its frequent display of braggadocio, previously had to keep in mind the danger of Indian wars and was often forced to deal cautiously with the Indian tribes both north and south of the Ohio. After the War of 1812 the nation acted from a position of assured dominance. The long-held Republican principles of the government prevented any crushing destruction of the Indian communities, yet, even though the treaty procedures were retained, the councils became less and less a matter of sovereign nations negotiating on terms of rough equality. Treaties simply continued to be a convenient means for carrying out the complicated and burdensome task of fulfilling the federal government's constitutional task of managing Indian affairs. They served in some measure to protect the Indians and nudge them along the path toward assimilation. But at the same time responsible men began to suggest publicly that treaties were an unrealistic and obsolete method for pursuing the goals of Indian policy. Treaties arising from the War of 1812. The rising tensions with Great Britain that led ultimately to the outbreak of war in 1812 had already stopped negotiations with the tribes in the Old Northwest after the Treaty of Fort Wayne in 1809, and the elucidation of a Cherokee treaty signed near the end of 1807 was the final pre-war treaty in the South. The next treaties grew out of the war itself. In the summer after the American victory at the Thames, Secretary of War John Armstrong appointed General Harrison, Governor Isaac Shelby of Kentucky, and Governor Lewis Cass of Michigan Territory to treat with the Wyandots, Shawnees, Delawares, and other tribes that had been loyal to the United States. His original purposes were to cement the friendship in a solemn treaty, to win active support from the Indians in the continuing war with Great Britain, and to obtain a cession of lands in northwestern Ohio. But on more mature deliberation Armstrong dropped the request for lands and specified only two articles, one, stipulating peace and friendship, the other, military aid to the United States, on the part of the Indians, if required. 1. Harrison and Cass met with 3,000 Indians at Greenville between July 1 and July 22, 1814, smoked the pipe of peace, explained the purposes of the United States, and denigrated the British. Harrison told the Indians that our people, and the Red people, were the only nations on earth who were really free, and governed by men of their own choice, and that this ought to induce them to be on terms of friendship with each other. The chiefs, except for a few Miamis, whom the commissioners reported were in British pay, signed the treaty on July 22, 1814, with great apparent willingness and satisfaction too. The treaty proclaimed peace between the United States and the Indians and among the tribes themselves, and the signatory Indians agreed to give aid to the United States in its war against the British and the tribes who were still hostile, and to make no peace with either without the consent of the United States. 3. Of considerably more importance was the Treaty of Fort Jackson signed with the Creeks in August 1814, for it exacted an immense cession of Creek land in Alabama and Georgia and marked the end of any immediate Indian resistance south of the Ohio. Andrew Jackson, who had led the forces against the Creeks as commander of the Tennessee militia, was appointed to the regular army as a brigadier general in command of the 7th Military District, and was directed to proceed to Fort Jackson to make peace with the Indians. 4. He assembled the Creeks, mostly friendly ones, for the hostiles had fled into Florida, and dictated a treaty, which the Indians over strong objections were forced to sign on August 9. The treaty was a punitive one, with a long preamble referring to the unprovoked, inhuman, and sanguinary war waged by the Creeks despite the provisions of peace in the Treaty of 1790 and the kind actions of the United States toward the nation. As an equivalent for all expenses incurred in prosecuting the war to its termination, it demanded the cession of more than 20 million acres running through what is now central Alabama and southern Georgia, and it required the Creeks to abandon all communication with British or Spanish posts and not admit as traders any persons not licensed by the United States. The United States was given the right to establish military and trading posts and roads in Creek lands and free navigation of all their waters. Prophets and instigators of the war were to be surrendered. In return, the United States guaranteed to the Creeks their remaining land, and provided reservations for friendly chiefs from motives of humanity. It promised to provide the means of subsistence for the destitute Creeks until new crops could furnish an adequate supply. 5. The friendly Creeks at Fort Jackson loudly and repeatedly complained that they were being punished by loss of their lands for the sins of the hostiles, but Jackson paid no heed. He was determined that the Indians be crushed, that national security be assured by cessions of land along the Florida/Spanish border, and that lands be opened from Tennessee to the Gulf. 6. The Treaty of Ghent with Great Britain, signed on December 24, 1814, provided for a return to the state of affairs before the war, and in Article 9 stipulated that the United States end hostilities with the Indians and restore to the tribes all the possessions, rights, and privileges which they may have enjoyed or been entitled to in 1811 previous to such hostilities. This would seem to have nullified the cessions made at the Treaty of Fort Jackson, and British advisers of the Creeks assured them that the Treaty of Ghent meant the return of their lands. Jackson adamantly refused to concede the point, and the administration in Washington did not or could not shake him from that purpose, nor did the British insist on compliance with Article 9. The cession stood. 7. In the North, the Indian aspects of the war wound down in somewhat different fashion. Although the Battle of the Thames had meant the end of the Tecumseh-driven Confederacy and its hostility to the United States, when the Treaty of Ghent was received, a good many tribes in the upper Mississippi Valley were still hostile. It was necessary to inform them that Great Britain and the United States had signed terms of peace and that they too should cease hostilities. Secretary of War James Monroe appointed Governor William Clark of Missouri Territory, Governor Ninian Edwards of Illinois Territory, and Augusta Choteau, the prominent St. Louis trader, to carry out the terms of the Treaty of Ghent and to invite the tribes to send delegations of chiefs to a council to sign a treaty with the United States. It is thought proper, Monroe told them, to confine this treaty to the sole object of peace. Other arrangements between the United States and the Indian tribes adapted to their mutual interests may be entered into hereafter. Goods worth $20,000 were purchased as presents for the Indians, and Monroe sent solid silver medals for presentation to chiefs who had delivered up their British medals to Lieutenant Pike and had been promised American medals in their stead. 8. The commissioners set the site for the treaty at Portage de Sioux, on the west bank of the Mississippi a short distance above its confluence with the Missouri, and then pursued the difficult task of finding competent and acceptable messengers to send to the various tribes whose hostility or friendship was largely unknown. Some of the tribes were slow to respond, the Sacs and Foxes especially remained hostile, and regular army troops, augmented by 2 large gunboats on the river, were stationed at the council site. Little by little in early July, however, representative delegations came in, turning the council grounds into a colorful and interesting spectacle. 9. Between July 18 and September 16 the commissioners signed 13 separate peace treaties with the following tribes or bands: Potawatomi residing on the Illinois River, Piankashow, Teton Sioux, Sioux of the Lakes, Sioux of St. Peter's River, Yankton Sioux, Maha, Kickapoo, Osage, Sac of the Missouri, Fox Iowa, and Kansa. These treaties were short and for the most part identical. They asserted perpetual peace and friendship and a mutual forgiving of injuries. For tribes with whom the United States was already tied by treaty, the previous commitments were acknowledged and confirmed. For tribes with whom the United States had not yet made treaties, the Indians, using the traditional formula, acknowledged themselves to be under the protection of the United States, and of no other nation, power, or sovereign, whatsoever. 10. While Clark, Edwards, and Choteau were dealing with the tribes of the upper Mississippi Valley, 3 other commissioners, William Henry Harrison, Duncan MacArthur, and John Graham, were treating with the Indians of Ohio and Indiana and Michigan territories. The objects of the proposed treaty, Acting Secretary of War A.J. Dallas wrote, are to remind the tribes of their existing relations with the United States, to explain to them the nature of the reciprocal stipulations in the Treaty of Peace and Amity lately concluded between the United States and Great Britain, so far as they concern the Indians, to inform them of the measures that have been taken to carry the Treaty of Peace into effect, by a mutual surrender of the military posts which the American and the British forces had taken from each other during the war, to warn them against any improper practices that might involve them in hostilities with the United States, to promise a punctual performance of all our engagements with them, and to insist upon the observance of good faith on their part. The United States expected no new cessions of land but only to manifest its disposition to cultivate peace and goodwill, and to secure the advantages of the treaties which already exist. 11. The commissioners met with the tribes at Spring Wells, near Detroit, dealing not only with the Chippewa, Ottawa, and Potawatomi Indians, who had been hostile to the United States during the war and thus fell under the prescriptions of Article 9 of the Treaty of Ghent, but also with Wyandot, Delaware, Shawnee, Seneca, and Miami Indians, most of whom had been friendly, as the commissioners explained. Many individual Indians belonging to the friendly tribes had taken up arms in support of Great Britain, and the friendly tribes wished and expected to be included in the treaty. There was no difficulty in getting the tribes to sign on September 8, 1814, confirming previous treaties and acknowledging that they were under the protection of the United States. 12. A multiplicity of treaties. Very quickly the pressure on the Indian land holdings was renewed with a vengeance. That the extinguishment of so many parcels of the Indians' landed estate proceeded so inexorably was due to the inordinate demand for lands that came after the defeat of the Indians in the War of 1812, fueled by an explosive spirit of nationalism that marked the period. And the subjugated Indians were in no position to forcefully resist the new onslaught. Treaties poured into Washington and were sent in batches to the Senate for what was almost always unanimous approval of their ratification. After the treaties of peace, numerous new treaties were made with varied groups of Indians north of the Ohio and in the Trans-Mississippi regions. Between the end of the War of 1812 and the inauguration of President Andrew Jackson in 1829, there were 39 treaties with 24 tribes in these regions. Some of the treaties were signed by more than one tribe, so that there were 67 separate signatory groups. 13. Many of these treaties were negotiated by Lewis Cass, Governor of Michigan Territory from 1813 to 1831, and William Clark, who was Governor of Missouri Territory and then appointed Superintendent of Indian Affairs at St. Louis when Missouri became a state in 1821. They were the two officials most knowledgeable about northern and western Indian affairs, and together, individually, or with other commissioners. They had a hand in 26 of the 39 treaties. Their views and policies were as important as those of War Department officials in Washington, for these men were generally given wide discretion in dealing with the tribes. As Secretary of War, Calhoun wrote to Cass and his fellow commissioners in May 1818, "The terms to be offered depend so much on the whims and tempers of the tribes interested in the land, that no particular instructions can be given to you, but the President, reposing full confidence in your judgment and discretion, expects that you will acquire it on terms as advantageous to the United States as practicable." 14. Although most of these treaties dealt with determination of boundaries and cessions to the United States, a number of special elements in them can be noted, some of them new to the treaty-making process. Of singular importance was the matter of reserves or reservations retained by the tribe or by individuals when tribal lands were ceded. The United States wanted to consolidate white settlement in Ohio, Indiana, and Illinois, and the War Department informed Cass in 1818 that the great object was to remove, altogether, these tribes beyond the Mississippi. 15. But generally the tribes were unwilling to remove entirely. Cass noted of his negotiations with the Chippewa Indians, "Although I am firmly persuaded that it would be better for us and for these Indians that they should migrate to the country west of the Mississippi, or, at any rate, west of Lake Michigan, yet it was impossible to give effect to that part of your instructions which relates to this subject, without hazarding the success of the negotiation." 16. It was necessary to allow reduced tracts of land to be retained by the tribes and in addition to set aside reserves for special individuals. Cass and MacArthur, who negotiated a treaty with Wyandots and other Indians at the rapids of the Miami on September 29, 1817, justified the practice. The treaty exhibits the result of mutual demands and of mutual compromises. We considered our instructions as rather advisatory than imperative, rather intending that we should comply with the general principles than with the minutiae details. Any other course would have been fatal to our exertions and to the expectations of the government. We have been compelled to admit the claims of a number of individuals, and to stipulate that patents shall be granted to them. In every case, it was the urgent wish of the Indians that land should be granted to these persons. To have refused these requests would have embodied against us an interest, and created obstacles, which no efforts of ours would have defeated or surmounted. 17. A difficulty arose, however, because this treaty with the Wyandots specified that the reserves were to be granted by patent, in fee simple, and that the owners could convey them to anyone they chose. Although the Senate approved most Indian treaties routinely, in this case it objected to what it considered a violation of the preemptive right of the United States government to Indian lands. The Senate Committee on the Public Lands, to whom the treaty had been referred, asserted that the provision was unprecedented by any former treaty, and at variance with the general principles on which intercourse with the Indians tribes has been conducted. It feared that the treaty would set a bad precedent and would encourage the spread of the practice, to the detriment of both the Indians and the United States. The Senate attempted to amend the treaty, but in the end it decided to postpone action and requested the president to reopen negotiations with the tribes so that the feasible grants could be omitted and the reserves held in like manner as has been practiced in other and similar cases. 18. Calhoun, accordingly, sent Cass and MacArthur the Senate's resolution and directed them to renegotiate the treaty with the Indians, but he added, "I am fearful that the change of tenure proposed by the Senate will indispose the Indians to renew the negotiations, and that they will expect not only a great increase of their annuity, but a great increase of lands to be reserved for their use." He left it up to the commissioners to accomplish whatever they could. The commissioners signed a supplementary treaty with the Indians on September 17, 1818, which specified that the reserved tracts would be held in the same manner as Indian reservations have been heretofore held. Enlarged tracts of land were reserved for the Wyandots and Senecas, and additional perpetual annuities ranging from $500 to $1,000 were provided for the Wyandots, Shawnees, Senecas, and Ottawas. 19. The War Department had learned its lesson, and Calhoun wrote to Clark and Choteau as he sent them a commission to treat with the Quapaws. The lands reserved for the Quapaws must be held by the tenure by which the Indians usually hold their lands, as the Senate would probably ratify no treaty which recognizes in the Indians the right of acquiring individual property, with the power of selling, except to the United States. Subsequent treaties allowing reservations within the cessions provided that the reserves could not be conveyed without the consent of the President of the United States or that the Indians would hold title in the accustomed manner. 20. An important part of the treaty negotiations and treaty stipulations were presents and annuities. Treaties in the years immediately following the War of 1812 were made in the West, not in Washington, and the large groups of Indians that customarily attended the councils taxed the government's ability to dispense sufficient provisions and rations to satisfy the assembled throngs at the treaty grounds. At the treaty with the Potawatomis in 1826, for example, the commissioners distributed goods worth $30,547.71 and promised an additional $900 worth. Without this provision, they reported, no treaty could have been formed. The Indians always arrive at our treaty grounds poor and naked. They expect to receive some part of the consideration at the moment of signing the treaty. This expectation, in fact, furnishes the only motive for their attendance, and much the most powerful motive for their assent to the measures proposed to them. The Chippewas of Lake Superior were especially destitute when Cass and Thomas L. McKenney met with them for the Treaty of Fond du Lac in 1826, and the commissioners wrote into the treaty special provisions for goods that were not authorized by their instructions. The presents, too, they believed, would afford some control over these northern Indians and draw them away from British influence. 21. Many of the treaties, at the urgent request of the Indians, stipulated that annuities and other payments be made in silver. There were some advantages to this practice, for silver could easily be divided and distributed to tribal members, and the United States saved the heavy costs of transportation of bulky merchandise. Although Cass worried that with the habitual improvidence of savages, they were anxious to receive what they could speedily dissipate in childish and useless purchases, at the expense of stipulations that would be permanently useful to them, he thought the advantages outweighed the disadvantages. The payments had to be in specie, not in paper money. Paper is almost valueless to the Indians, Cass thought, it is a representation of wealth, with which they are little acquainted. They require something whose amount is more palpable and obvious. 22. There was a movement away from perpetual annuities, although they were by no means eliminated altogether. William Clark was especially strong on this point. After dealing with the Osages and the Kansa Indians in 1825, he wrote, "An annuity forever. More harm than good." In the treaties concluded with the Kansas and Osages, the annuities are limited to 20 years, in the course of which time, the humane experiment now making by government, to teach them to subsist themselves by the arts of civilized life, will have had a fair trial, and, if it succeeds, they will need no further aid from the federal government. 23. Promotion of white civilization remained a strong force in treaty negotiations. Clark's treaty with the Osages in 1825, for example, stipulated, "The United States shall, immediately, upon the ratification of this convention, or as soon thereafter as may be, cause to be furnished to the tribes or nations, aforesaid, 600 head of cattle, 600 hogs, 1,000 domestic fowls, 10 yoke of oxen, and 6 carts, with such farming utensils as the Superintendent of Indian Affairs may think necessary, and shall employ such persons, to aid them in their agricultural pursuits, as to the President of the United States may seem expedient, and shall, also, provide, furnish, and support for them, one blacksmith, that their farming utensils, tools, and arms, may be seasonably repaired, and shall build, for each of the 4 principal chiefs, at their respective villages, a comfortable and commodious dwelling house. 24. Money for education of Indian youth was another element in some of the treaties. A typical provision in the 1826 treaty with the Potawatomis read, to appropriate, for the purposes of education, the annual sum of $2,000, as long as the Congress of the United States may think proper, to be expended as the President may direct. In some treaties the education article could be struck out without affecting the rest of the treaty. 25. The treaties in this period often stipulated that the United States would pay claims against the tribes by United States citizens for loss of property or other damage, and in 1825 the government began a practice among the northern and western tribes that was to cause trouble and concern later, providing in the treaty for the payment of specific debts owed by the tribe or by individual tribal members. Clark argued for the practice on the grounds that a treaty with Indians should always be a complete settlement, and leave no cause for future complaint or negotiation, nor any difference unadjusted. In the Osage Treaty of 1825, therefore, he paid a debt of $4,500 of sundry individuals of the Osage tribes or nations due to the then defunct government factory at Fort Clark, in return for which the Osages freed the United States from the obligation to maintain a military post there as promised in an earlier treaty. The treaty, as well, provided payment to United States citizens for horses and other property stolen by the Indians, a $1,000 debt owed the Delawares by the Osages, and Osage debts owed to 3 individuals, including Shoto. 26. One of the serious problems facing the United States on the northwest frontiers was the almost continuous intertribal warfare, especially between the Sioux and the Chippewas and between the Sioux and the Sacs and Foxes. It had been the federal government's practice not to be involved in conflicts between tribes, but maintenance of peace on the frontiers soon demanded some attention to the problem. Accordingly, the government invited Chippewas, Sacs, and Foxes, Menominees, Iowas, Sioux, Winnebagos, and a portion of Ottawa, Chippewa, and Potawatomi tribes on the Illinois River to meet with Cass and Clark at Prairie du Chien, at the mouth of the Wisconsin River, in a spirit of mutual conciliation. Besides attestations of peace and friendship among the various tribes, the treaty specified the territorial boundaries of each tribe in order to remove all causes of future difficulty. At a spectacular gathering of some 1,000 members of the different tribes, the experienced commissioners drew what boundary lines they could and postponed for future negotiations problems that could not be solved on the spot. The treaty was signed on August 19, 1825.27. The treaty specified that because the Chippewas were widely dispersed, the government in the following year should convene them on Lake Superior in order to explain fully to them the objects and advantages of the treaty, with the hope that it might be observed by the warriors. Thus, in July and August 1826, Cass and McKinney met with the Chippewas at Fond du Lac and signed a treaty with them on August 5, which confirmed the Treaty of Prairie du Chien. 28. A similar extension of the Treaty of Prairie du Chien was contained in a treaty with Chippewas, Menominees, and Winnebagos signed by the same commissioners on August 11, 1827, at Butte de Morts, near Green Bay. Boundaries between the tribes were drawn, but special problems concerning boundaries with the New York Indians who had recently emigrated to the region were referred to the President for decision. 29. The negotiations at Butte des Morts highlighted a problem faced by the federal commissioners at treaties with the Indians in the northwestern regions, who were the tribal chiefs with whom the negotiations should be conducted. The tribes did not have governments as formally organized as the commissioners wanted, and the federal officers sought to remedy the situation by designating or making chiefs. At Butte des Morts, on the first day of the council, Cass told the Menominees that they were in a bad situation with respect to their chiefs. There is no one to whom we can talk as head of the nation. If anything happens, we want some person who has authority in the nation to whom we can look. He said the tribe looked like a flock of geese without a leader, and he indicated that the commissioners would make inquiries and select a proper person to be chief. The next day McKinney reiterated the point, even more forcefully. Point 30 The highest dignity fell on Oshkosh, the second highest on Karen, and these two chiefs' names appear first on the list of signers for the Menominees. Most of the treaties of cession, sometimes following explicitly the Treaty of Greenville of 1795, permitted the tribes to continue to hunt on the ceded lands, often with the notation as long as the shall remain the property of the United States. In the treaty with the Chippewas at Sault Ste. Marie in 1820, the United States promised the Indians a perpetual right of fishing at the Falls of St. Mary's, and also a place of encampment upon the tract hereby ceded, convenient to the fishing ground. 31. A few treaties dealt with very specific single issues. Thus treaties with the Osages and with the Sacs and Foxes in 1822 absolved the United States from maintaining trading houses promised in earlier treaties with the tribes. Treaties with the Osage and Kansa Indians in August 1825 gave tribal consent for the president to mark out a road between Missouri and New Mexico, with the road considered to extend to a reasonable distance on either side, so that travelers thereon may, at any time, leave the marked tract, for the purpose of finding subsistence and proper camping places. 32. A separate series of treaties, this time merely of trade and friendship, were signed with the tribes along the Missouri River in 1825. The fur traders expanding operations out of St. Louis aroused Indian hostility, and death and destruction soon occurred. An attempt in 1823 to punish the Indians, using United States troops from Fort Atkinson at Council Bluffs, was not vigorously pursued, and the fur traders demanded stronger military action to prevent continued Indian outrages. Congress balked at a proposal to establish a military post on the upper Missouri, in order to prevent the rich Rocky Mountain fur trade from falling into British hands, but it did authorize the president to appoint commissioners to treat with the Indians along the Missouri and authorized $10,000 for a competent military escort to the commissioners. 33. President Adams appointed General Henry Atkinson and the Indian agent Benjamin O'Fallon as commissioners, and the two men left Council Bluffs on May 16, 1825, with a military escort of 476 men. As they moved by stages up the river, the commissioners met in council with the Indians and between June 9 and August 4 concluded 9 treaties with Poncas, Teton, Yankton and Yanktonais bands of Sioux, Oglala Sioux, Cheyennes, Hunkpapa Sioux, Arikaras, Minitaries, Mandans, and Crows. The various councils were much alike. First came a review of the troops drawn up in parade, intended to awe the Indians. There followed a formal council at which the treaty was approved and presents distributed. In the evening, shells were fired from a howitzer to further impress the Indians. 34. The tribes asserted perpetual friendship, acknowledged that they lived within the territorial limits of the United States, recognized its supremacy, claimed its protection, and admitted its right to regulate trade. The United States for its part agreed to receive the Indians into their friendship, and under their protection, and to extend to them, from time to time, such benefits and acts of kindness as may be convenient, and seem just and proper to the President of the United States. The United States would license traders to supply the Indians, and the Indians in turn promised to seize and turn over to the federal authorities any unlicensed persons who sought to trade with them. The treaties prohibited private retaliation for injuries done to individuals and stipulated the return of or indemnification for stolen horses and other property. After an unsuccessful attempt to make contact with the Blackfeet and the Assiniboines, Atkinson and O'Fallon headed downriver and arrived at Council Bluffs in mid-September. They sent messages to the Otos, Pawnees, and Omahas, and when these tribes arrived at Fort Atkinson, councils were held and treaties signed between September 26 and October 6.35. These treaties were a straightforward use of the treaty-making power to regularize relations with frontier tribes, to bring them formally into the political orbit of the United States, and thus force them to cut ties with the British and turn their trade to American, not British, traders. Conventions with New York Indians. Quite different were the two conventions signed at the same time by the Seneca Indians of New York, in which they sold land to individuals who had preemption rights. In the first of these, signed on September 3, 1823, the Senecas conveyed to John Grieg and Henry B. Gibson a parcel of land known as the Gordo Reservation. The treaty was concluded under the authority of the United States, represented by Charles Carroll, who had been appointed commissioner, and in the presence of Nathaniel Gorham, who represented the state of Massachusetts. Both these men attested to the treaty. The treaty, however, was not submitted to the Senate. According to Thomas L. M.C. Kenny, head of the Indian Office, it was esteemed to be a useless ceremony, the President approving it only 36. The Second Seneca Treaty was signed at Buffalo Creek, New York, on August 31, 1826. In it the Senecas sold several tracts of land to Robert Trupp, Thomas L. Ogden, and Benjamin W. Rogers, in the presence of Oliver Forward, Commissioner of the United States, and Nathaniel Gorham, agent for Massachusetts. The treaty was submitted to the Senate for its approval by President John Quincy Adams on February 24, 1827. The Senate formally considered the treaty but on February 29, by a vote of 20 to 20, failed to agree to its ratification. On April 4, by formal resolution, it stated its reasons, that by the refusal of the Senate to ratify the treaty with the Seneca Indians, it is not intended to express any disapprobation of the terms of the contract entered into by the individuals who are parties to that contract, but merely to disclaim the necessity of an interference by the Senate with the subject matter. 37. The federal government in these cases was torn between two provisions of the Trade and Intercourse Act of 1802. One stipulated that no purchase of Indian land was valid unless the same be made by treaty or convention, entered into pursuant to the Constitution, while the other authorized state agents, with the approval of the United States Commissioners, to be present at an Indian Treaty Council and to deal with the Indians regarding compensation for claims to land extinguished by the treaty. 38. The Southern Tribes. The Southern tribes in the period after the War of 1812 differed markedly from those in the North. As Cass and Clark astutely remarked in their report on Indian Affairs in 1829, their political organization differs materially from that of the Northern and Western tribes. With the former, power is in the hands of few, with the latter, of many. 39. This difference was manifested in treaty making. While some of the treaties with the Cherokees, Creeks, Choctaws, Chickasaws, and Seminoles were negotiated with large assemblies of tribesmen, others were conducted by a few leaders of each tribe, delegated for the purpose, and a third of the treaties were signed not in the Indian country but in Washington, D.C., where the Secretary of War dealt with selected chiefs. Following the practice of the United States in appointing commissioners to negotiate and sign a treaty, with later ratification by the nation, some of the tribes specified that the treaty had to be approved by the whole tribe in Council. 40 But most of the treaties obviated any tribal ratification by specifying that the contract was concluded by kings, chiefs, headmen, and warriors of the Indian nation, in council assembled, on behalf of the nation. Between 1816 and 1828, 17 treaties were signed with the 5 southern tribes dealing with cessions of land or adjustment of boundaries. The United States was concerned in the South as it was in the North about the orderly advance of white settlement. It wanted to open lands adjacent to the established settlements and to discourage wide scattering of the whites to areas far distant, and the extinguishment of Indian titles by treaty proceeded pretty much in this fashion. 41. Significant, too, was the development of the idea of Indian removal with an exchange of lands. The Indians would relinquish their traditional eastern holdings and accept instead equal or comparable lands west of the Mississippi. President Jefferson had broached the idea as early as 1803, and the policy was urged upon the Cherokees, Indiana, 18089. Not until after the War of 1812, however, were there treaty provisions for such action. In a treaty of July 8, 1817, the Cherokees agreed to give up 2 sizable tracts in Georgia and North Carolina for one of equal size on the Arkansas and White Rivers. The treaty authorized the proportional division of annuities between the eastern Cherokees and those who chose to migrate westward, and provided 640 acres to individual Indians who chose to remain where they were and become citizens. A large part of the Cherokee Nation adamantly opposed removal, but the treaty was signed by a considerable number of chiefs and headmen sympathetic to such removal. The War Department feared that there would be opposition to the treaty in the Senate by members who disliked the policy of removing the Indians to west of the Mississippi and those who felt that too few chiefs had signed the treaty, but in the end the Senate approved the treaty with no dissenting votes. 42. This Cherokee removal treaty of 1817 severely divided the Indians, and those who decided to emigrate charged persecution from the other faction, but large numbers of Cherokees, nevertheless, moved west. In 1819, in Washington, D.C., Secretary of War John C. Calhoun and a delegation of Cherokees made adjustments in the 1817 treaty, and set the division of the annuities at 2/3 for the eastern Indians and 1/3 for the western. 43. The western Cherokees eventually came to deal with the federal government as a separate unit, and by a treaty of May 6, 1828, Western Cherokees and Secretary of War James Barber agreed to a new grant of land, which moved the Cherokees beyond a newly declared western boundary of Arkansas Territory. This treaty provided to the Cherokees, in addition, a perpetual outlet, west, as far as the sovereignty of the United States extended, and it was notable for the strong statement on the political autonomy of the tribe. It being the anxious desire of the government of the United States to secure to the Cherokee Nation of Indians a permanent home, and which shall, under the most solemn guarantee of the United States, be, and remain, theirs for vera home that shall never, in all future time, be embarrassed by having extended around it the lines, or placed over it the jurisdiction of a territory or state, nor be pressed upon by the extension, in any way, of any of the limits of any existing territory or state. 44. Choctaws, too, made progressive cessions of land, and they, like the Cherokees, moved in considerable numbers across the Mississippi into Arkansas Territory, where land was granted them in a treaty of October 18, 1820. This Treaty of Doak's Stand, negotiated by Andrew Jackson and Thomas Hines, was an indication of the government's growing determination to remove the Indians from the states east of the Mississippi to lands west of the river. Jackson reluctantly accepted the appointment as commissioner, but then, by skillful use of subsistence supplies, bribes, and threats, got the agreement of the Indians to exchange 5 million acres of their lands in Mississippi for some 13 million acres in Arkansas Territory. As was the case with the Cherokees, the citizens of Arkansas raised a great fuss over the movement of eastern Indians into lands coveted by whites and to a large extent already settled by them. In answer to these problems, Choctaw delegates met with Calhoun in Washington in 1825, and the Indians' land in Arkansas was reduced in exchange for annuities and more money for the education of Choctaw youth. 45. With the Creek Indians, treaty negotiations ran into special difficulties when the federal negotiators attempted to bring that tribe, too, under the removal policy umbrella. When the majority of the Creeks and their leaders adamantly resisted a removal agreement, the United States Commissioners, Duncan Campbell and James Meriwether, began a series of scandalous maneuvers that involved a removal-minded faction of the nation led by William McIntosh, the Indian agent, and officials of the state of Georgia, which desperately sought to remove the remaining Creeks from within its territorial boundaries. The National Council firmly insisted that no more land be ceded, and it relied on an earlier law declaring death to any leader who agreed to sell land to give weight to its decision. 46. At a meeting with the National Council in December 1824, Campbell and Meriwether tried vainly to convince the Creek leaders, but the Indians rebutted them at every turn of their argument and ended with a firm rejection of the federal proposals. Then the commissioners began to confer secretly with McIntosh. At Indian Springs on February 12, 1825, they signed a treaty of cession and removal with McIntosh and his faction, which cleared Georgia of Creeks and gave up Creek lands in Alabama. $200,000 were provided for the removal expenses of the McIntosh group. To the National Council and the majority of the Creek people, the treaty was an iniquitous document grounded in fraud and chicanery and acted out in treason, but the United States commissioners rushed to Washington with the treaty, declaring it had been made with the Creek Nation. 47. President Monroe laid the document before the Senate, and although the Creek agent and chief big warrior, as representative of the National Council, followed the commissioners to the Capitol and argued against the validity of the treaty, the Senate on March 3, 1825, at the very end of the Monroe administration, approved the treaty without having had time to study it. John Quincy Adams, in one of his first acts as president, proclaimed the treaty on March 7.48. William McIntosh soon received his reward. The Creek National Council voted his execution as a traitor who had violated the laws of the nation, and on the night of April 30 McIntosh was killed at his plantation by a force of Creek warriors. While Governor Trupp of Georgia moved to support the McIntosh faction, President Adams hoped to persuade the Creek Nation to accept the treaty, and he sent General Edmund P. Gaines to press for peace and adjustment between the factions. Adams authorized Gaines to use force to prevent an early survey of the ceded grounds by Georgia, but the general could not get the Creek Council to accept the Treaty of Indian Springs. In the end, a Creek delegation went to Washington to confer with Secretary of War James Barber about correcting the evils of the McIntosh Treaty. After much argument and disagreement, a new treaty was signed on January 24, 1826.49. When President Adams submitted the new treaty to the Senate, he explained how he had hoped to reconcile the two sides, prevent civil war among the Creeks, and protect the interests of the McIntosh faction. But his expectations had been disappointed. In this state of things, he told the Senate, "The question is not whether the treaty of the 12th of February last shall or shall not be executed. So far as the United States were or could be bound by it, I have been anxiously desirous of carrying it into execution, but, like other treaties, its fulfillment depends upon the will not of one, but of both the parties to it. The parties on the face of the treaty are the United States and the Creek Nation, and however desirous one of them may be to give it effect, this wish must prove abortive while the other party refuses to perform its stipulations, and disavows its obligations. By the refusal of the Creek Nation to perform their part of the treaty, the United States are absolved from all its engagements on their part, and the alternative left them is, either to resort to measures of war, to secure by force the advantages stipulated to them in the treaty, or to attempt the adjustment of the interest by a new compact. 50. Adams, of course, had chosen the latter course, and he urged the Senate to accept the revised compact. In an unprecedented move, the new treaty in its first article declared the Treaty of Indian Springs to be null and void, to every interest and purpose whatsoever. The Creek delegates, faced with no real alternative, now agreed to part with most of the lands in Georgia. The treaty provided a sum of $217,600 to be divided among the chiefs and warriors and an additional perpetual annuity of $20,000. The treaty protected the interests of the McIntosh group, restoring them to good standing within the Creek Nation and authorizing funds for those of them who wished to remove to the West. 51. The Senate refused to accede to the new treaty as it was submitted because the Georgians insisted that all the Creek lands in Georgia be given up, and a supplementary article was signed by the Creek delegates on March 31 to extinguish their title to Georgia lands. With this in hand, the Senate ratified the treaty by a vote of 30-7 on April 21.52. The Chickasaw Indians in treaties of 1816 and 1818 were similarly pressured to cede lands wanted by advancing white settlers, although the exchange of lands and removal to west of the Mississippi was not part of the negotiations. The tribe parted with lands in Alabama and Tennessee in return for cash annuities for specified terms of years. In both treaties, provisions of land and money were made for particular individuals. 53. The last of the 5 civilized tribes, the Seminoles in Florida, underwent a similar reduction of lands, but their condition was considerably different from that of the better established southern tribes already considered. Made up of descendants of aboriginal peoples and of Creeks migrating from Georgia and Alabama, they lacked the cohesion or the power to deal forcefully with the United States government. The United States, for its part, after the acquisition of Florida in 1821, sought to move the Indians from the territory or concentrate them in some restricted spot, opening lands for white settlers and removing the Indians from contact with the coast. At Moultrie Creek, south of St. Augustine, United States Commissioners met with the Indians, and the treaty signed there concentrated the Indians in central Florida and paid them $6,000 worth of goods and an annuity of $5,000 for 20 years. In addition, the United States provided rations for 12 months, paid for improvements that had to be abandoned, supplied funds for removal costs, and established separate reservations of land for 6 of the chiefs. 54. Although the Indians succeeded in changing the boundaries of the reservation to include better land, they were in no position to challenge the general thrust of United States policy in their regard. The treaty declared that the chiefs and their tribes have appealed to the humanity, and thrown themselves on, and have promised to continue under, the protection of the United States. James Gadsden, one of the negotiators, later wrote privately to Calhoun, "It is not necessary to disguise the fact to you, that the treaty effected was in a degree a treaty of imposition. The Indians would never have voluntarily assented to the terms had they not believed that we had both the power and disposition to compel obedience." 55. Criticism of treaty making. The treaty-making process went forward without a great deal of reflection, for it served the expansionist purposes of the United States. The pattern was set and the constitutional provisions were adhered to. But ultimately, perhaps inevitably, a question arose about the propriety of considering the Indian tribes, no matter what their power, political organization, and sophistication, as sovereign nations, with whom the only means of dealing was by formal treaty. Not surprisingly, Andrew Jackson was the first national figure to bring the matter up. In March 1817, while military commander in the southern states, he told President Monroe that he had long viewed treaties with the Indians an absurdity not to be reconciled with the principles of our government. By that time he had served as official commissioner in signing treaties with Creeks, Cherokees, and Chickasaws, and he was about to resume that role. His long frontier experience, moreover, led him to consider himself an expert on Indian affairs. Jackson considered the Indians subjects of the United States, inhabiting its territory and acknowledging its sovereignty, and he considered it absurd for a sovereign to negotiate by treaty with subjects. Congress, he maintained, had as much right to legislate for the Indians as for the citizens of the territories, and he urged that Congress make use of this right to prescribe their bounds at pleasure, and provide for their wants, and whenever the safety, interest, or defense of the country should render it necessary for the government of the United States to occupy and possess any part of the territory, used by them for hunting, that they have the right to take it and dispose of it. Due compensation was to be given, or course, just as in any exercise of eminent domain. 56. The Indians, in Jackson's view, had been thrown on the liberality and humanity of the government after the Revolution and after their defeat in subsequent Indian wars. Treaties would be all very well if the Indians were in fact independent nations, possessing the rights of sovereignty, but Jackson flatly denied that this was the case. The Indians, he said, have only a possessory right to the soil, for the purpose of hunting, and not the right of domain. Hence I conclude that Congress has full power, by law, to regulate all the concerns of the Indians. Jackson rejected the argument that the United States, following the example of Great Britain, had always treated the Indians as independent nations. To his mind, the policy of making treaties with the Indians grew up out of necessity at a time when the government was not strong enough to enforce its regulations among the Indians or to keep peace in any other way. Now, under changed circumstances, a more just procedure would be the forceful reduction of the Indian lands, so that the natives, confined to closer limits, would adopt the civilized existence of the whites. Jackson condemned the farce which has been introduced of holding treaties with them, and he spoke of the susceptibility of the chiefs to bribery. Money, he said, is the weapon, in the hand of the commissioner, wielded to corrupt a few of their leaders, and induce them to adopt the plans embraced by the views of the government, when the poor of the nation receive but little, and are, by the influence of their chiefs, induced to assent to their wills. Honor, justice and humanity, he concluded, certainly require that a change of policy should take place. Monroe replied, "The view which you have taken of the Indian title to lands is new but very deserving of attention." He asserted that the hunter or savage state requires a greater extent of territory to sustain it than is compatible with the progress and just claims of civilized life, and must yield to it. But he noted that, where the Indian title had not been extinguished, the United States title to land was good only against European nations, that it was by treaties that American limits were determined, and that it was customary to purchase title from the Indians. Yet he admitted that if the Indians did not voluntarily submit to the civilizing programs, compulsion would have to be resorted to. 57. Jackson did not let up. When asked in June 1820 to serve again as a treaty commissioner, he wrote to Secretary of War Calhoun that he had determined never to have anything to do again in Indian treaties, but that he would accept simply to please the President. On September 2 of that year he repeated to Calhoun what he had written earlier to Monroe, and on September 17 he amplified his statement. "I do think it not only useless but absurd. When Congress has the power to regulate all Indian concerns, by act of Congress, and the arm of the government is sufficiently strong to carry such regulations into effect, more general justice can be done to the Indians, in this way than by treaty. When the policy of treating with the Indians was first adopted, it was at a time when we found them thrown upon our hands by the Treaty of 1783, without any provision being made for them, and at that time they were numerous and hostile, while the arm of the government was too weak to enforce such regulations as justice and good policy required, hence the necessity of managing them by treaties. But this has passed away. The arm of government is sufficient to protect them and to carry into execution any measures called for by justice to them, or by the safety of our borders. Hence the absurdity of holding treaties with Indian tribes within our territorial limits, subject to our sovereignty and municipal regulations, and to whom, by legislation, every justice can be done, and the safety of our southern frontier perfectly secured. 58. The Secretary of War, even more than the President, received Jackson's opinions favorably. He replied that Jackson's views appear very correct. "I entirely concur with you," he wrote, "that it is perfectly absurd to hold treaties with those within our limits, as they neither are or can be independent of our government. This opinion has been frequently communicated to Congress, and although they have not yet adopted it, I still hope that they will ultimately. By its adoption both ours and their interest would be advanced, and all of the objections, which may be urged against almost every Indian treaty which has been made, be thereby avoided." 59. Yet neither Jackson nor Calhoun at the time could change the traditional procedures. During the 7½ years that Calhoun conducted Indian affairs as Secretary of War, 40 treaties were signed with the Indians. While Jackson was President, 67 Indian treaties were ratified. Tradition was hard to overcome, and treaties were a convenient and generally effective way to carry out American Indian policy. The ideas that Jackson expressed, however, would not die. They surfaced again and again, without full effect, until some 50 years later Congress finally ended treaty making with the Indians. Chapter 7. Indian Removal and the Debate about Treaty Making. In the late 1820s and the 1830s, a full-scale debate on Indian treaties renewed the criticisms of treaty making that Andrew Jackson had brought forth a decade earlier. There was a powerful onslaught against the treaties and the Indian nationhood on which they rested, and an equally vigorous and eloquent defense of both, set in a framework of preservation of national faith and honor. The debate centered on the Cherokees in Georgia, but it had broader applicability. The Georgia-Cherokee controversy. The initial focus of debate was Georgia's demand that the United States remove the Cherokees within the state. If that were not done, Georgia threatened to extend its jurisdiction over the Cherokee lands. There were deep historical roots for the controversy, for in 1802 the state and the federal government had signed a compact by which Georgia relinquished her western lands in return for a promise by the United States that it would extinguish the Indian title to lands in Georgia as early as the same can be peaceably obtained on reasonable terms. 1. As the demand for the Indian lands increased, Georgia accused the federal government of bad faith in failing to live up to its part of the bargain. Although Monroe and John Quincy Adams listened to the complaints of Georgia and urged the Indians to leave the state, the presidents would not budge from their position that the Indians would have to act voluntarily and that the federal government would not force them. The fire was further fueled by the Cherokee adoption of a formal constitution in 1827, which declared the tribe to be a sovereign nation under the protection of the United States and in no way subject to Georgia's jurisdiction. The Georgians cried that this unconstitutionally established an imperium in imperio, a separate nation within the boundaries of the sovereign state. The federal government refused to act, and the state took the law into its own hands. Its line of action was to extend the authority of the state and its laws over the Cherokee lands, in effect withdrawing the Cherokee territory from the status of Indian country, bringing the lands under Georgia's control and, by overt as well as subtle pressure, forcing the Indians out. 2. To justify such action, Georgia struck at the heart of the treaty system, for it denied the Indians title to the land, their sovereign jurisdiction over the territory they claimed, and the validity of the treaties with the Indians. From 1827 until the final removal of the Cherokees in 1838, the arguments echoed through the halls of Congress and the public press. The Georgia legislature asserted an absolute title of Georgia to the Indian lands. Before the Revolutionary War, it argued, Great Britain had had full sovereignty over the lands, and with American independence Georgia had succeeded to that sovereignty. The possession of the Indians was permissive. They were mere tenants at will, the legislature said, and that tenancy could be ended at any time by Georgia. 3. In 1827, to be sure, the Georgia legislature had urged the people of the state to accept any treaty that the United States might make providing for Cherokee removal, but when supporters of Cherokee rights pointed to the Cherokee treaties to support the Indians against Georgia, the argument moved beyond the question of land title to the more fundamental ones of Indian sovereignty and the consequent power to enter into formal treaties with the United States. Georgia and its friends denied both. Andrew Jackson was in accord with Georgia's position on Indian titles and Indian sovereignty, and his election to the presidency emboldened Georgia. In 1828 the state added Cherokee lands to certain northwestern counties of Georgia and in 1829 extended its laws over these lands, effective June 1, 1830, after which date Cherokee laws and customs would be null and void. 4 Jackson, through Secretary of War John Eaton, replied to Cherokee complaints on April 18, 1829, he told the Indians flatly that he could not support them against Georgia's claim to sovereignty and urged them to move west of the Mississippi. 5. To the Cherokees and their friends the action of Georgia and the President's support of the state's position were a call to battle. Unable to conceive that historical practice with its promises and guarantees could be forgotten and the honor and good faith of the United States disregarded by its elected officials, these men began a concerted attack on the anti-Cherokee forces. In so doing, they brought forth all possible legal and moral arguments to uphold the rights of the Cherokees to their ancestral lands, the sovereignty of the nation within those lands, and the sanctity of the treaties in which the sovereignty and landed rights had been guaranteed. It was a full-dress discussion of Indian treaties and the treaty-making power that was unequaled in American history. The leader in the campaign was Jeremiah Evarts, a New England lawyer who served in Boston as secretary of the American Board of Commissioners for Foreign Missions, a Congregational/Presbyterian missionary society with active missions and schools among the Southern Indians. Touched by the plight of the Cherokees, many of whose leaders he knew personally through mission contacts, Evarts set to work to awaken the conscience of the nation and warn Jackson and his friends of the divine retribution they could expect if they did not turn from their evil path. 6. Evarts's most important work was a series of 24 essays that he published in the National Intelligencer between August 5 and December 19, 1829, under the pseudonym William Penn. The articles, with their detailed legal analysis of the Cherokee treaties and their recognition of the Cherokees as a nation, were the fullest and best statement of the Cherokee case. Numerous newspapers and periodicals reprinted them, and they circulated widely in pamphlet form. Churchmen and congressmen alike drew their arguments from this source. 7. After a detailed account of the Treaty of Hopewell and the Treaty of Halston, Evarts asked, "What is a treaty?" His answer indicates his commitment to the Indian cause. Is a compact between independent communities, each party acting through the medium of its government. No instrument, which does not come within this definition, can be sent to the Senate of the United States, to be acted upon as within the scope of the treaty-making power. The Indian tribes and nations have made treaties with the United States during the last 40 years, till the whole number of treaties thus made far exceeds 100, every one of which was ratified by the Senate before it became obligatory. Every instance of this kind implies that the Indian communities had governments of their own, that the Indians, thus living in communities, were not subject to the laws of the United States, and that they had rights and interests distinct from the rights and interests of the people of the United States, and, in the fullest sense, public and national. All this is in accordance with facts, and the whole is implied in the single word treaty. 8. Evarts recounted the Cherokees' relations with the United States, treaty by treaty, pointing out the provisions that clearly recognized the national sovereignty of the Indians, and he emphasized again and again that these compacts were called treaties with a meaning that no ingenuity can distort, pervert, or evade. He laughed at the argument of Georgia that treaties could not be made with Indian communities because they were not nations. Unfortunately for this theory, he wrote, it was notoriously invented to answer a particular purpose. It is not, and cannot be, entitled to the least degree of credit. Communities of Indians have been called nations, in every book of travels, geography, and history, in which they have been mentioned at all, from the discovery of America to the present day. Treaties have been made with them, during this whole period. The colony of Georgia, he noted, had always spoken of Creek and Cherokee nations, and it called the compacts that it made with them treaties. 9. Evarts was answered belatedly by another benevolent spokesman, the Reverend Isaac McCoy, a Baptist missionary to the Indians, who had a long career of seeking to establish a separate Indian territory west of the Mississippi. In a series of 6 articles in the United States Telegraph in August and early September 1830, McCoy spoke out sharply against his opponents. He followed the Jacksonian position on the necessity and wisdom of removal of Indians from the eastern states, and he had an extremely negative position on Indian sovereignty and the treaties that rested on it. He flatly denied that the Indian had any rights in the land they occupied and asserted that no civilized nation had ever admitted any. Whatever has been understood by the word treaty, he wrote, as employed in our intercourse with the Indian tribes, it is evident that it did not imply that they were the sovereign owners of the countries they inhabit. He considered the treaties made with Indians fundamentally fraudulent. We cannot consider the Indians really a party to a contract in the conveyance of land, he argued, when they are assembled at the pleasure of the whites, when the latter give the terms, and when the latter are as fully determined to have the land in question, or, rather, to hold the land in question, to which they already consider themselves entitled, if the terms offered to the Indians should not be agreed to, as if they should. It was clear to McCoy that the United States had not pretended to pay for the land at its full value. Treaties with the Indian tribes are, in fact, merely matters of convenience to us, and of humanity towards them. He concluded. In treaty we were merely purchasing their consent to leave the lands, or their consent to our occupying it. 10. McCoy's views on treaties, however, gained little support and did not much weaken the powerful theoretical case for the treaties advanced by Evarts. Debate on the Indian Removal Bill. In his first State of the Union address, on December 8, 1829, President Jackson discussed the issue of removal and recommended emigration beyond the Mississippi as the solution to the impasse between Georgia and the Cherokees. The Committee on Indian Affairs in the House and in the Senate, to whom this section of the message was referred, each reported a removal bill. The Senate with little discussion, the House with strong arguments in support of Georgia. The long debate on these bills gave voice to the cases of both Georgia and the Cherokee sympathizers. In April and May 1830 congressional debate centered on the issue, long harangues filled the air until no phase of the question of Cherokee rights and treaty procedures remained untouched. 11. Senators and representatives from Georgia had their say, ridiculing the cant and fanaticism of the northern supporters of the Cherokee cause, with increasing insistence that treaties with the Indians had been a big mistake. A key advocate of Georgia's position was Wilson Lumpkin, who served successively as representative in Congress, governor of Georgia, and senator. During this long public career he fought for Georgia's rights against the Indians and against the federal government. To him the purchase of Indian lands by treaty was nothing more than the substitute of humanity and benevolence and had been resorted to in preference to the sword, as the best means for agricultural and civilized communities entering into the enjoyment of their natural and just right to the benefits of the earth, evidently designed by him who formed it for purposes more useful than Indian hunting grounds. He noted that all the old states had abandoned treaty legislation and had substituted for it direct legislation for the control and government of the Indians. 12. In the Senate at the end of the decade, as he looked back over his career of dealing with Indian matters, Lumpkin exclaimed, "I have long since been disgusted, and with shame and confusion of face looked at the policy pursued by this government towards the Indians. Look at your large volume of Indian treaties. What do you there see? One recorded farce after another, couched in language of high official and formal mockery. One continued tissue of deception and deceit. How can any senator," Lumpkin asked, "expect to put the negotiations of Indian treaties upon the principle and footing of similar transactions with civilized, foreign, enlightened nations? Are not these Indians in a state of dependence and pupillage? Are we not in the place of parents and guardians to them? Shall we, then, overlook all the facts connected with the subject under consideration? Shall we imagine a state of things which we know has no existence?" 13. Lumpkin's Georgia colleagues in Congress echoed and reinforced his sentiments in their debates on the removal bills. Those who did not condemn outright the ancient practice of making treaties with the Indians spoke of changed circumstances, and a good deal of attention was given to the clauses in the Cherokee treaties in which the Indians admitted dependence upon the United States. Throughout, much ridicule was heaped on the Northerners who upheld the Cherokee cause and on their memorials to Congress. 14. The anti-Jackson forces in Congress, feeling themselves on the defensive against the president's influence and the growing party sentiment that gave support to his and Georgia's views, occupied long hours on the floor of the Senate and the House in condemnation of what they feared the removal bill would mean. They drew their argument largely from Evarts's writings, and he corresponded with them regularly to bolster their resolve. They argued passionately for Indian title to the land, the long-recognized nationhood of the tribes, and the sanctity of treaties. In the Senate, Theodore Frelinghuysen of New Jersey, known as the Christian statesman because of his adherence to Christian reform movements, was the principal advocate of Cherokee rights. On April 7, 8, and 9 he spoke for 6 hours on the issue. 15 He was seconded by Senator Peleg Sprague of Maine, who insisted that the treaties with the Cherokees had been made with all the forms and solemnities which could give them force and efficacy, by commissioners, duly appointed with full power, and that they had been ratified by the Senate, confirmed by the President, and announced to the world, by his proclamation, as the binding compact of the nation, and the supreme law of the land. 16. More support came from Senator Asher Robbins of Rhode Island, who asserted, the turning question, then, of this whole debate, I repeat, is whether the Indian nations within our territorial boundaries are competent to make treaties. He was surprised that the question had been raised at all, for treaties upon treaties, and almost without number, have been made with Indians thus situated, without a doubt, in a single instance, of their competency to make them. To be competent to make a treaty, he said, a tribe must be a sovereign, but he distinguished, as his friends did, between independent sovereignty and dependent sovereignty and declared that it was immaterial which kind the Indians had. 17. When the major debates shifted to the House in May, representatives from New York, New England, and other northern states repeated the time-worn arguments with renewed enthusiasm. Representative William L. Storrs of Connecticut, especially, discussed at length the treaty-making power, noting that the Constitution made it a function, not of the President alone, but of the executive and two-thirds of the Senate, and that both the President and individual states were bound to support this supreme law of the land. Representative Isaac C. Bates of Massachusetts said that it has been intimated, to get rid of the effect of our Indian treaties, that they are not treaties, but he ridiculed such a position. The treaties between the United States and the Cherokees were negotiated as treaties, and treaties between nations competent to make treaties. They were ratified as treaties. They were called treaties, not only by us, but by the French, Spanish, and English, before our time. They were admitted to be treaties by Georgia. How, then, can we say to the Indian nations, that what we called treaties, and ratified as treaties, were not in fact treaties? 18. One fear that cropped up again and again in the speeches of the Cherokee defenders was that the removal bill would put power to arrange Indian affairs solely in the hands of the President. Thus, Representative John Test of Indiana complained about the novelty of the removal bill, which, he said, throws into the hands of the President some $20 million to disperse exactly as he pleases. It throws into his hands the lives and liberties of 400,000 human beings, for such is about the number of Indians on both sides of the Mississippi, besides 100 millions of acres of land, without check or control over him, no power to revise his acts, and his compacts are without the revising power of the Senate. It is a discretion which I can never consent to grant to any man. Test wanted the treaty system to continue. Here, he said, is safety. If the treaty is fraudulent, it can be set aside. If it is improvident, it can be rectified. If the President should drive the project too fast, or extend his operations too wide, he can be checked. 19. Frelinghuysen wanted to amend the removal bill so that it would explicitly protect the independence of the tribes and their treaty-making power, but he was able to obtain no more than an innocuous statement that the bill would not be so construed as to cancel existing treaties or agreements between the United States and the Cherokees. 20. Large argued at length for treaty rights from a legal and constitutional standpoint. But what drove them so passionately against Jackson and the Georgians was their deep Christian commitment to morality, to the honor and good faith of the nation. Evarts's fear that the nation was about to commit a serious sin by throwing aside its solemn commitments to the Cherokees was echoed strongly in the chambers of Congress. Representative George Evans of Maine on May 18 called attention to one of Lumpkin's remarks, namely, that the time would come when it would be odious to be known as an advocate of Indian rights, and he rejoined, before that period shall arrive, you must burn all the records of the government, destroy the history of the country, pervert the moral sense of the community, make injustice and oppression virtue and breach of national faith honorable, and then, but not till then, will the visions of the gentlemen assume the form of realities. Senator Frelinghuysen asked, do the obligations of justice change with the color of the skin? Is it one of the prerogatives of the white man, that he may disregard the dictates of moral principle, when an Indian shall be concerned? He told the Senate, the question has ceased to be what are our duties. An inquiry much more embarrassing is forced upon us, How shall we most plausibly, and with the least possible violence, break our faith? Sir, we repel the inquiry, we reject such an issue and point the guardians of public honor to the broad, plain path of faithful performance, to which they are equally urged by duty and by interest. Representative Test could not believe, he said, that the nation would forfeit her solemn pledges, her sacred honor. 21. Frelinghuysen and the other Cherokee supporters, despite their vigorous arguments, lost the battle in Congress. The House bill was dropped in favor of the Senate bill, and the Senate approved the measure on April 24, by a vote of 28 to 19, the House on May 26, by a vote of 103 to 97.22. Jackson signed the bill on May 28. John Marshall and the Cherokee cases. The Cherokees, rejected by the President and Congress, turned next to the Supreme Court. With William Wirt as their advisor, the Cherokees brought suit against Georgia, seeking an injunction against Georgia's encroachment on Indian lands in violation of the tribe's treaty rights. 23. Chief Justice Marshall was sympathetic to the Cherokees' cause and to their reliance on treaties to uphold it. In Cherokee Nation v. Georgia, decided on March 18, 1831, Marshall wrote about the Cherokees as a state. They have been uniformly treated as a state from the settlement of our country. The numerous treaties made with them by the United States recognize them as a people capable of maintaining the relations of peace and war, of being responsible in their political character for any violation of their engagements, or for any aggression committed on the citizens of the United States by any individual of their community. Laws have been enacted in the spirit of these treaties. The acts of our government plainly recognize the Cherokee Nation as a state, and the courts are bound by those acts. 24. But Marshall would not accept the Cherokee Nation as a foreign nation, entitled to sue the state of Georgia under the Constitution, so he rejected the suit as outside the jurisdiction of the court. He asserted that the Indian tribes were, instead, domestic dependent nations and that their relation to the United States resembles that of a ward to his guardian. 25. Two dissenting justices, however, believed that the Cherokees were a foreign state, and their opinion renewed hope for the Indian cause. A law of Georgia that took effect on March 1, 1831, forbade whites to reside in the Cherokee country without a license. Two missionaries among the Indians, Samuel A. Worcester and Elizur Butler, refused to heed the law and were arrested and imprisoned. Wirt now brought suit against Georgia on Worcester's behalf, a case in which the Supreme Court clearly had jurisdiction. Marshall's decision in Worcester v. Georgia, delivered on March 3, 1832, was a forthright vindication of the Cherokee position. The Indian nations had always been considered as distinct, independent political communities, retaining their original natural rights, as the undisputed possessors of the soil from time immemorial, with the single exception of that imposed by irresistible power, which excluded them from intercourse with any other European potentate than the first discoverer of the coast of the particular region claimed, and this was a restriction which those European potentates imposed on themselves, as well as on the Indians. The very term nation, so generally applied to them, means a people distinct from others. The Constitution, by declaring treaties already made, as well as those to be made, to be the supreme law of the land, has adopted and sanctioned the previous treaties with the Indian nations, and consequently admits their rank among those powers who are capable of making treaties. Marshall argued that the nationhood of the Indians was not destroyed by treaties acknowledging the protection of the United States, for the settled doctrine of the law of nations is that a weaker power does not surrender its independent seats' right to self-government, by associating with a stronger and taking its protection. The Cherokee Nation, therefore, was a distinct community, occupying its own territory, with boundaries accurately described, in which the laws of Georgia can have no force, and which the citizens of Georgia have no right to enter but with the assent of the Cherokees themselves or in conformity with treaties and with the acts of Congress. All intercourse with the Indian nations was vested, not in the state, but in the federal government. 26. The Jackson administration paid no heed to Marshall's decision, and went ahead with its removal plans, but the long arguments about treaty rights and Indian sovereignty had not been in vain. They provided a reservoir of views and opinions that greatly bolstered the status of treaties and the federal handling of Indian affairs. And the dire evils predicted by Evarts and other anti-Jackson supporters of the Cherokees did not materialize. Removal was accomplished, not by unrestrained executive action, but through the traditional forms of treaties, and those treaties preserved the ideas of Indian sovereignty and inviolable land titles, even while the Indians were being forced to abandon their homelands in the southern states and seek a new destiny west of the Mississippi. The debates in Congress and the Supreme Court decisions had enough moral if not legal force to make impossible in the 1830s the abrogation of old treaties or the abandonment of the process of treaty making. Appeals to good faith and national honor had not fallen on deaf ears. Removal treaties. The first of the southern tribes to sign a removal treaty was the Choctaw Nation, under a set of peculiar circumstances, which began while the debates and controversies over the Cherokees were being played out in Washington. 27. Mississippi, encouraged by Jackson's State of the Union address and following the lead of Georgia, on January 19, 1830, enacted legislation that extended the laws of the state over the persons and property of Indians within its limits and rejected any special rights or privileges that the Indians claimed. 28 Seeing the writing on the wall, the Choctaws began to act. Under the leadership of Greenwood Leffler, a mixed blood who in the crisis had been elected to the unprecedented position of chief of the whole nation, the Choctaws drew up a removal treaty on their own, with very favorable recompense for exchanging their Mississippi lands for those to the west, and in early May 1830 sent the treaty to Jackson for presentation to the Senate. Jackson, taken aback by the independent action of the Choctaws in drawing up their own treaty but pleased with the evidence that the tribe was reconciled to removal, sent the treaty to the Senate on May 6, 1830, together with a protest from certain of the Choctaws against the treaty. These measures, Jackson told the Senate, are the voluntary acts of the Indians themselves. The government was not represented in the councils which adopted them, nor had it any previous intimation that such steps were in contemplation. The Indians convened on their own accord, settled and executed the propositions contained in the treaty presented to me, and agreed to be bound by them if within 3 months they should receive the approbation of the President and the Senate. 29. Jackson did not want to accept the precise terms of this Choctaw Treaty, and he sent the Senate some suggested amendments for their consideration. The President, however, not being tenacious on the subject, indicated a willingness to come to an agreement with the Senate. He thereupon reverted to the long-abandoned practice of seeking Senate advice before acting, rather than simply presenting an accomplished treaty to the Senate for approval, amendment, or rejection. He proposed a series of questions to the Senate, as Washington had done with the Creek Treaty of 1790. Would the Senate accept the terms proposed by the Choctaws? Would it agree to modify the treaty according to Jackson's suggested amendments, or did it have further modifications to propose? Jackson justified his action as follows. I am fully aware that in thus resorting to the early practice of the government, by asking the previous advice of the Senate in the of this portion of my duties, I am departing from a long, and for many years an unbroken usage in similar cases. But being satisfied that this resort is consistent with the provisions of the Constitution, that it is strongly recommended in this instance by considerations of expediency, and that the reasons which have led to the observance of a different practice, though very cogent in negotiations with foreign nations, do not apply with equal force to those made with Indian tribes, I flatter myself that it will not meet the disapprobation of the Senate. He noted, too, that the Choctaws had asked that their propositions be submitted to the Senate and that the Senate's opinion would aid future negotiations if any should be required. To be possessed of the views of the Senate on this important and delicate branch of our future negotiations, he said, would enable the President to act much more effectively in the exercise of his particular functions. There is also the best reason to believe that measures in this respect emanating from the United Council of the treaty-making power would be more satisfactory to the American people and to the Indians. Jackson did not want cost factors to override other, more important, Considerations. The great desideratum, he insisted, is the removal of the Indians, and the settlement of the perplexing question involved in their present location. 30. The Senate referred the treaty and accompanying documents to its Committee on Indian Affairs, which submitted a resolution on May 27 that the Senate not approve the treaty. It noted the protest against the treaty by one party of Choctaws and recommended that the President withhold his sanction to it until the sense of the nation could be fairly taken, even if the terms proposed in the instrument were such as the United States would deem equitable and just. But the latter condition, it insisted, did not obtain. The committee called the treaty terms of the Choctaws so unreasonable that the United States ought by no means to accede to them, even if the nation was unanimous in proposing them. 31. The committee neatly sidestepped Jackson's request for prior advice on how further negotiations should proceed. It would be a waste of time, the report said, to go much into detail in specifying objections, although it did list articles that it thought should not be approved. The committee members had looked at the President's suggested amendments and found it very difficult to satisfy themselves as to the precise stipulations which ought to be contained in any treaty to be concluded. Because of very serious discontents in the Choctaw Nation, the committee thought that if the Senate should, in advance of any negotiation, attempt to fix in detail the terms and stipulations to be included in a treaty, such course might have the effect of defeating entirely an agreement with the Choctaws which might be highly advantageous to them and to the United States. The only suggestion it offered was that if any alterations were needed, they should consist in reducing payment offered for the lands of the Choctaws. On May 29 the Senate supported the resolution of the committee to reject the treaty, and it discharged the committee from further consideration of the subject. 32 So much for prior advice on treaty making in Jackson's time. Jackson then proceeded on his own. He invited the Choctaw leaders to meet him at Franklin, Tennessee, where he was spending his summer vacation, but the Indians refused and proposed instead a September meeting. Thereupon Jackson sent Secretary of War John Eaton and his old friend John Coffee to treat with the Choctaws in their own country, at Dancing Rabbit Creek, where 5,000 to 6,000 Indians gathered in the middle of September. Having sent the missionaries away from the treaty grounds lest they influence the Indians, Eaton and Coffee warned the Indians that if they did not move west, they would have to submit to state laws and thus lose their tribal existence. By providing generous land allotments and other benefits to tribal leaders, the commissioners were able to sign a treaty with the Choctaws on September 27.33. The Choctaws ceded all their lands east of the Mississippi in exchange for a specified tract in the west. The new land, contrary to past practice regarding Indian land tenure, was granted to the Choctaw Nation in fee simple. To inure to them while they shall exist as a nation and live on it. The national existence of the Choctaws, no longer possible in Mississippi, was strongly guaranteed by the United States in the 4th article of the treaty. The government and people of the United States are hereby obliged to secure to the said Choctaw Nation of red people the jurisdiction and government of all the persons and property that may be within their limits west, so that no territory or state shall ever have a right to pass laws for the government of the Choctaw Nation of red people and their descendants, and that no part of the land granted to them shall ever be embraced in any territory or state, but the U.S. shall forever secure said Choctaw Nation from, and against, all laws except such as from time to time may be enacted in their own national councils, not inconsistent with the Constitution, treaties, and laws of the United States, and except such as may, and which have been enacted by Congress, to the extent that Congress under the Constitution are required to exercise a legislation over Indian affairs. 34. The United States, moreover, agreed to protect the Choctaws from domestic strife and from foreign enemies on the same principle that the citizens of the United States are protected. Annuities from older treaties would continue, and the treaty authorized an extra $20,000 for 20 years. In addition, the United States offered houses for chiefs, schools, mechanics, miscellaneous goods, and education for 40 Choctaw youths for a period of 20 years. The United States would provide, at its own expense, for the removal and would furnish subsistence for 12 months in the new country. The treaty showed the ambivalence of the removal policy, whereas it made every effort to clear Mississippi of tribal Indians and included all sorts of inducements to encourage emigration, it at the same time. Roll 2, frames 30,617. The proceedings are summarized in Dossier, Removal of the Choctaw Indians, 11,628. Older accounts are Henry S. Halbert, The Story of the Treaty of Dancing Rabbit, Publications of the Mississippi Historical Society 6, 373,402, George Strother Gaines, Dancing Rabbit Creek Treaty, Historical and Patriotic Series of Alabama State Department of Archives and History 10, 131. 34 Kapler, 2:311. Page 172. Allotted lands to individual Indians within the ceded territory east of the Mississippi. The agent, William Ward, however, did not register all the latter claims as the treaty directed and thus seriously upset the intended operation of the system. All in all, the disposition of the Choctaw lands and the settlement of claims arising from their sale led to nearly interminable conflicts between the Indians, bona fide settlers, and land speculators that delayed removal and caused unsettled land titles for years following the treaty. 35. When Jackson submitted the treaty to the Senate on December 9, Senator George Poindexter of Mississippi tried to sidetrack it, first asking for more information from the President and then, after the information had been received, offering a resolution that Indian tribes within the United States were not independent foreign states and that any compact or agreement with them for the relinquishment of the title of occupancy was not a treaty within the spirit and meaning of the Constitution. But the resolution was tabled, and Poindexter later withdrew it. Upset by the admission in the preamble to the treaty that the President could not protect the Choctaws within Mississippi, the Senate rejected that part of the document, but the rest was approved by a vote of 33 to 12 on February 21, 1831.36. The Creeks were the next tribe to sign a treaty. Alabama considered the removal of the Indians necessary for the development of the state, and in January 1829 the legislature extended state laws over the Creek territory as added pressure for removal. In these circumstances, even before the passage of the Removal Act, Jackson urged the Creeks to move west of the Mississippi. Creek delegates to Washington voiced their complaints to the President and to Congress, seeking to remain in Alabama under federal protection, but to little avail. Meanwhile the conditions of the Creeks got worse. 37. Creek leaders, thereupon, drew up a plan for ceding their land in Alabama, but instead of removal to the west, they proposed a system of 35. The best discussion of the problems resulting from the allotments is Mary E. Young, Redskins, Ruffles Hertz, and Rednecks, Indian Allotments in Alabama and Mississippi, 1830-1860, 4772. There are many documents in the congressional serial set about the land problems, see, for example, Senate Document Number 266, 23-1, Serial 240. 36 Senate Ex. PROC, 4:126, 128, 141, 155, 16,062. The documents that Jackson submitted with the treaty are in Senate, Sen 21 BC 6. Kapler, 2:31011, prints the preamble to the treaty but indicates in a footnote that it was not ratified. 37 C. Michael D. Green, The Politics of Indian Removal, Creek Government and Society in Crisis, 14,173. Page 173. Reservations for the Indians within the ceded territory with fee simple title. Although this would mean allotment in severalty to heads of families, the Creeks hoped to locate the reserves in blocks, so that the towns would be kept intact and local customs could continue. A new delegation took these proposals to Washington in March 1832.38. Secretary of War Lewis Cass rejected the initial proposition, for he disliked the size and number of the reservations, but he reached a compromise with the delegation and signed a treaty with Chief Opatliahalo and 7 other chiefs on March 24.39. The treaty was not specifically a removal treaty. Although the Creeks ceded to the United States all their lands east of the Mississippi, they were to receive allotments within the cession and could sell these allotments to other persons or remain on the lands themselves and after 5 years receive a fee simple title. The United States solemnly guaranteed to the Indians the Creek territory west of the Mississippi, and recognized their right to govern themselves free from interference by any state or territory so far as may be compatible with the general jurisdiction which Congress may think proper to exercise over them. The Senate ratified the treaty with remarkable speed. 2 days after the signing, Jackson submitted the treaty to the Senate, whose Committee on Indian Affairs reported it without amendment on March 29. Senator Theodore Frelinghuysen, perhaps influenced by the memorials to Congress from anti-removal forces praying that treaties under the Removal Act not be ratified, tried to delay the procedures by a resolution to recommit the treaty to committee until it could be ascertained that the Creeks who had signed the treaty had been duly authorized, but his motion lost 33-7. And on April 2 the Senate approved the treaty unanimously. 40. The treaty on its face, indeed, seemed like a reasonable document, for it supported Creeks who chose to emigrate and provided for those who preferred to stay, but its actual operation was disastrous for the Creeks. Despite its promises to evict intruders, the federal government in fact was unwilling or unable to do so, and the Creek lands were quickly overrun. Moreover, the Indians, unused to handling financial matters, were victimized by speculators, who moved in to gain title to. 38. A summary of the proposal is given Ibid. 170. 39. Kapler, 2:34143. Creek memorials prior to the treaty that complained of the acts of Alabama and demanded protection are printed in Senate Document No. 53, 21-1, Serial 193, and House Document No. 102, 22-1, Serial 218. 40. Senate Ex. PROC, 4:23234. Page 174. The allotments enforce the Indians off the land. The frauds were spectacular and widespread, making a mockery of the treaty intentions, and the government seemed impotent to stem the speculators' chicanery. 41. The Chickasaws faced a similar fate, suffering the same disabilities in relations with their white neighbors as the other southern tribes, and the tribal leaders ultimately decided that there was no alternative to emigration and sought to make the move as palatable as possible. 42. The negotiations began at Franklin, Tennessee, in the summer of 1830, with John Eaton and John Coffee. President Jackson appeared, too, and addressed the council. Since the meeting was outside the tribal country, it was attended by only a score of Indian delegates, yet the protocol of feasting the Indians and regaling them with presents was followed. 43. A treaty was signed on August 31, 1830, by which the Chickasaws ceded their eastern lands in return for lands of equal extent beyond the Mississippi. But this treaty was contingent upon finding suitable lands in the west that were acceptable to the Chickasaws, for the treaty specified, if, after proper examination, a country suitable to their wants cannot be found, then, it is stipulated and agreed, that this treaty, and all its provisions, shall be considered null and void. Although a delegation of Chickasaws went west to seek an acceptable location, they could agree on none, and the treaty thus became inoperative. Jackson did not submit it to the Senate. 44. The condition of the Chickasaws in Mississippi worsened, and new negotiations for a treaty of removal were undertaken in 1832 in the Chickasaw country at Pontotoc Creek, where the Indians signed a treaty with John Coffee on October 20 that was similar to the Franklin Treaty. Chickasaw lands were ceded to the government, they would be surveyed immediately and placed on sale, to be sold for what the market would bring. Meanwhile, each adult Indian received a temporary homestead. 41. T. Hartley Crawford to Joel R. Poinsett, May 11, 1838, House Document No. 452, 25-2, Serial 331. A detailed history of the Creek frauds is given in Young, Redskins, Ruffles Hurts, and Rednecks, 73,113. See also Grant Foreman, Indian Removal, the Emigration of the Five Civilized Tribes of Indians, 12,939. On the military removal of the Creeks after the Creek War of 1836, see American State Papers, Military Affairs, 7:95155, and Foreman, Indian Removal, 15,290. 42 see Earl M. Gibson, The Chickasaws, 12,262. 43 A statement of expenses showed board for 21 Indians for 15 days at $1.25 per day, and listed the presents furnished. House Document Number 181, 22-1, Serial 219, pages 23. 44 Kapler, 2:103540. Page 175. The money from the sale of these temporary reservations and of the surplus lands would be placed in a general fund of the Chickasaw Nation, and from it would come the costs of survey and removal. 45. The problem of finding western lands for the emigrating Chickasaws was not solved until 1837. On January 17 of that year, at Dokesville in the Choctaw Nation, the Chickasaws and Choctaws signed a convention and agreement, by which the Chickasaws bought the central and western portion of the Choctaw Grant for $530,000 and received certain privileges within the Choctaw Nation. The parties to this convention, it should be noted, were the two tribes themselves, not the United States and the Indians, but the negotiations were held under the auspices of the federal government, and the agreement itself in its title stipulated that it was subject to the approval of the President and Senate of the United States. 46. Jackson sent the document as a convention to the Senate in February 1837, saying that it had his approbation and requesting favorable action. The Senate merely approved the convention or agreement made and entered into between the Choctaw and Chickasaw nations or tribes, without the usual constitutional formula of advice and consent to its ratification. 47. Another treaty of 1832 was that signed with the Seminole Indians at Payne's Landing in northeastern Florida on May 9, 1832, the result of increasing white agitation for the removal of the Indians. The Indians were destitute, and the promise of food and clothing in the treaty eased the negotiations. The Seminoles, however, would not agree to emigrate. 45 Ibid, 35,662. Supplementary articles were signed on October 22, which Kapler treats as a separate treaty. The Senate, to whom Jackson submitted the treaty on December 12, after requesting and receiving from the President and the Secretary of War information about the Franklin Treaty and amending the supplementary articles by eliminating a payment to Robert P. Curran, ratified the treaty, 23-4, on February 28. Senate Ex. PROC, 4:285, 29,091, 29,395, 31,721. In 1834, amendments were made to the Pontotoc Treaty, see Kapler, 2:41825. 46 see certified copy of the treaty in Documents, Roll 3, Frames 520 ff, and as printed in treaties between the United States of America, and the several Indian tribes, from 1778 to 1837, 68,799. The phrase is omitted in Kapler, 2:48688. 47 Senate Ex. PROC, 4:616. The President ratified the agreement on March 24, 1837. The Chickasaw District was more specifically defined in a convention and agreement between the two tribes on November 4, 1854, and in Articles of Agreement and Convention between the United States and the two tribes on June 22, 1855. The region west of the 98th meridian was leased to the United States as a home for other Indians. Kapler, 2:65253, 70,614. Page 176. until they had had an opportunity to examine the western land. The treaty, accordingly, provided that the government would send a party of the Indians to the west, where they could judge for themselves the quality of the land to be set aside for them. The members of the delegation arrived at Fort Gibson in November 1832 and were shown the region that was to be theirs in the Creek country, and they signed an agreement stating that they approved the land. This Treaty of Fort Gibson, March 28, 1833, was negotiated and signed by Special Commissioners Montfort Stokes, Henry L. Ellsworth, and John F. Schermer. Hornwo had been sent west by the Secretary of War to investigate the western lands and to make sure that the lands assigned to the incoming Indians were suitable. 48. The Seminoles later refused to acknowledge the treaties, and the parties soon arrived at an impasse. The government pointed to the treaties and insisted that they be fulfilled. The Indians denied that they had made the agreements specified and refused to move. The result was war, as the Seminoles retreated into the Everglades to escape removal. The Florida War. Second Seminole War began in 1835, and it dragged out unconscionably, as one commander after another failed to subdue the Indians. When General Thomas S. Jessup suggested in 1838 that a line be drawn through central Florida and the Indians be allowed to stay south of the line, Secretary of War Joel R. Poinsett refused to budge from the hard-line position of the government. The acts of the executive and the laws of Congress evince a determination to carry out, and it is to be regarded as the settled policy of the country. In pursuance of this policy, the Treaty of Payne's Landing was made with the Seminoles, and the character of the officer employed on the part of the government is a guarantee of the perfectly fair manner in which that negotiation was conducted and concluded. The treaty has been ratified, and is the 48. The two treaties are in Kepler, 2:34445 and 39,495. They were not submitted to the Senate until December 24, 1833, where they were reported by the Committee on Indian Affairs without amendment on April 7, 1834, and unanimously approved the next day. Senate Ex. Proc. 4:338, 38,687. John K. Mahone, Two Seminole Treaties, Payne's Landing, 1832, and F.T. Gibson, 1833, Florida Historical Quarterly 41, 121, is a careful analysis of the treaties and the charges of fraud. Because he found the evidence fragmentary and often contradictory, Mahone arrives at no judgment. But he concedes that the Seminoles did not regard the treaties as just and that their refusal to abide by them led to war. Page 177. Law of the land, and the constitutional duty of the President requires that he should cause it to be executed. 49. The war raged on until 1842, at which time the federal government declared the war won. By then, all but a remnant of the tribe had been killed or forcibly removed to Indian Territory. The Cherokee Indians were the final southern tribe to be removed. As they had been the focus of the controversy over the removal bill, so they furnished the most controversial episode in the history of actual emigration to the West. Many Cherokees, it is true, had migrated voluntarily before the crisis of the 1830s. These Indians, known as the Old Settlers or Cherokees West, had developed their own government and a prosperous agricultural economy on the lands set aside for them by the Treaty of 1828. In 1836 there were more than 6,000 in this group. But the bulk of the tribe adamantly refused to consider removal and refused to accept the enticements and the warnings of the Jackson administration. Instead, they repeatedly petitioned the federal government to protect them where they lived. Cherokee delegations encamped in Washington and sought to come to some kind of adjustment with federal officials. 50 In early 1834, a few selected chiefs entered into negotiations with Secretary of War Eaton and, over the protests of Chief John Ross and his followers, signed a removal treaty in Washington on June 19, 1834. Jackson with some misgivings submitted the treaty to the Senate. He told that body, "The practice of the government has not been very strict on the subject of the authority of the persons negotiating treaties on the part of the Indians. Sometimes it has been done by persons representing the tribe and sometimes by the individuals composing it. I am not aware that a case similar in its features to the present has ever before required the action of the government. He supported his action by alluding to provisions in the document that called for approval by the majority of 49 points set to Jessup, March 1, 1838, in John T. Sprague, The Origin, Progress, and Conclusion of the Florida War, 2012. For a similar statement, see point set to Jessup, July 25, 1837, House Document Number 78, 25-2, Serial 323, pages 3233. 50. A clear and detailed account of these maneuverings is provided in Charles C. Royce, The Cherokee Nation of Indians, a narrative of their official relations with the colonial and federal governments, 5th Annual Report of the Bureau of Ethnology, 1883-1884, 253,304. This report was reprinted as Charles C. Royce, The Cherokee Nation of Indians, with different pagination. Page 178. The tribe. The Senate, however, would have nothing to do with this treaty and unceremoniously tabled it on June 30.51. Meanwhile, rival groups solidified within the Cherokee Nation. Opposed to John Ross and his majority following was a treaty party, led by Major Ridge, his educated and politically active son John Ridge, and two nephews, the brothers Elias Boudinot and Stand Watie. These men and their followers had come to realize that removal was inevitable and that it was futile any longer to oppose the demands of the state and federal authorities. The bitter opposition between these parties split the Cherokees into factions that persisted for decades. 52. This factionalism was used by the United States in negotiating with the tribe. When a Ridge delegation in Washington let it be known that it was ready to treat with the United States for cession of the eastern lands and removal to the west, John F. Schermerhorn was appointed in February 1835 to deal with them, and the two parties arrived at a general understanding. The Ross delegation then submitted its own proposal for removal, which demanded a payment of $20 million for the cession of the Cherokee lands. On March 3, however, the Senate set the sum at the much lower figure of $5 million. Since Ross declined to accept this figure, a treaty between the Ridge Party and Schermerhorn was signed on March 14, with the stipulation that it would be binding only when approved by the Cherokee Nation in Council. 53. Despite Schermerhorn's endeavors and Jackson's encouragement, the Council, held at Red Clay in October, rejected the Ridge Treaty. At the Council, however, the Cherokees received notice to meet with United States commissioners on December 21, at New Echota, Georgia, to negotiate a new treaty. The notice told the Indians that those who did 51 Senate Ex. PROC 4:42425 44,546. 52 A reasonable and sympathetic account of the Ridge Party and its arguments and decisions is Thurman Wilkins, Cherokee Tragedy, The Story of the Ridge Family and the Decimation of a People. A memorial of November 28, 1834, is a good statement of the Ridge Party's argument that removal was inevitable for preservation of the nation, in House Document Number 91, 23-2, Serial 273, pages 17. The best work on Ross is Gary E. Moulton, John Ross, Cherokee Chief. See also the Papers of Chief John Ross, ed. Gary E. Moulton, 2 volumes, which presents exhaustively the position of the Ross Party. Theta Purdue, The Conflict Within, Cherokees and Removal, in William L. Anderson, ed., Cherokee Removal, Before and After, 5574, argues that the Ridges represented a small middle class in the Cherokee Nation that hoped to promote its own interests against the ruling elite by the removal treaty. 53 Royce, Cherokee Nation of Indians, 28,485. The Senate action is in Senate Ex. PROC, 4:47879, 482. Page 179. Not attend would be considered to approve any document signed by the negotiators. 54. Because Ross and his supporters boycotted the meeting, only some 300 to 500 Cherokees, led by the Ridges, met with Schermerhorn at New Echota, where they signed a treaty on December 29.55. In an unusual preamble, the United States sought to justify its reliance on only a portion of the tribe by reciting the history of negotiations with the Cherokees and by noting the earlier warning that those who did not attend the council would be considered to have given their assent to whatever might be done at the council. On this shaky foundation, the United States procured a removal treaty with the Cherokees. The Cherokee National Council vehemently condemned the action, and Ross, in a protest sent to the Senate, declared that the instrument entered into at New Echota, purporting to be a treaty, is deceptive to the world, and a fraud upon the Cherokee people. 56. The treaty ceded all Cherokee lands east of the Mississippi and for $5 million released the Indians' claims upon the United States. It confirmed the 7 million acres of land granted the Cherokees in the Treaty of 1828 plus the outlet to the west and provided additional lands. There were articles excluding the western lands from state or territorial jurisdiction and granting protection against unauthorized intruders and against domestic and foreign enemies, similar to those in the other removal treaties. Provision was made also for the emigration, for 1 year's subsistence, and for lands for Indians who desired to stay in the East. The treaty specified that the removal was to be accomplished within 2 years after ratification of the treaty. President Jackson objected to the provision for preemption rights and reservations for those Cherokees who wished to remain in the states where they resided, his desire being that the whole Cherokee people should remove together and establish themselves in the country provided for them west of the Mississippi River. Whereupon supplementary articles were concluded on March 1, 1836, which declared null and void. 54 Royce, Cherokee Nation of Indians, 28,586. 55 Kapler, 2:43948. William Carroll was appointed commissioner to serve with Schermerhorn, but ill health prevented his attendance. His signature, nevertheless, appears on the treaty, with the notation, "I have examined the foregoing treaty, and although not present when it was made, I approve its provisions generally, and therefore sign it." 56 Memorial and Protest of the Cherokee Nation, March 8, 1836, and other documents in House Document Number 286, 24-1, Serial 292, Memorial of December 15, 1837, House Document Number 99, 25-2, Serial 325. See also the discussion of Ross's activities in Moulton, John Ross, 7379. Page 180. The preemption rights and reservations and authorized an additional sum of $600,000 over and above the $5 million allowed for the cession of eastern lands. 57. The Senate was well aware of the protests against the treaty, and at one point in the debate Henry Clay proposed a resolution that the instrument of writing purporting to be a treaty concluded at New Echota, not made and concluded by authority on the part of the Cherokee tribe competent to bind it, and that therefore the Senate could not approve it. The resolution advised the President to open a new negotiation. This motion lost by a vote of 29-15. Then, with some minor amendments, the Senate voted 31-15 to approve the treaty, a single vote beyond the two-thirds required for Senate ratification. 58. The treaty party emigrated with little trouble, state officials treated them considerately, and they were, in general, economically well off. They established their farms and plantations among the western Cherokees. The remainder, having rejected the treaty as a valid instrument, refused to move, and Ross used every opportunity to attempt to reverse the treaty's provisions. He encouraged his followers to stand firm, and few enrolled for emigration. Numerous petitions poured into Congress from religious and philanthropic supporters of the Cherokees, protesting the execution of the 1835 treaty. 59. A strenuous denial of the validity of the treaty was submitted to Congress in early April 1838. It bore the signatures of 15,665 Cherokees and appealed to Congress once more for protection against the throngs of Georgians invading their lands as the deadline for removal approached. 60 Then, as the crisis continued, Ross sought finally to replace the new Akota Treaty with one of his own design, but government officials deemed his proposals unacceptable. 61. As the deadline for removal, May 23, 1838, approached and the Indians were still on their old lands, the government ordered General Winfield Scott to the Cherokee country with a view to the fulfillment. 57 Kapler, 2:44849. 58 Senate Ex. PROC, 4:54546. 59 For memorials against the treaty, see House Document NOS 374, 384, 385, and 404, 25-2, Serial 330, Senate Document NOS 388, 389, 390, 402, 416, and 417, 25-2, Serial 318. 60 Memorial of February 22, 1838, House Document Number 316, 25-2, Serial 329. Ross and the Treaty Party also carried on a pamphlet war, see Prucha, Great Father, 238n, 239n. 61 Joel R. Poinsett to John Ross and others, May 18, 1838, House Document Number 376, 25-2, Serial 330, Report of Senate Committee on Indian Affairs, June 5, 1838, Senate Document Number 466, 25-2, Serial 318. Page 181. Of the treaty. Scott, on May 10, issued an address to the Cherokee chiefs. The President of the United States, he told them bluntly, has sent me, with a powerful army, to cause you, in obedience to the Treaty of 1835, to join that part of your people who are already established in prosperity on the other side of the Mississippi. 62 The resulting emigration, finally carried out under the direction of John Ross himself, became the well-known and tragic Trail of Tears. 63. The conflict among the Cherokees over the removal treaty continued beyond the Mississippi. It was severely exacerbated by the vengeance taken by the Ross Party against the Treaty Party leaders for having ceded the eastern lands. On June 22, 1839, Major Ridge, John Ridge, and Elias Boudinot were brutally murdered. Standwoody, also marked for death, escaped. Although it was clear that this was a planned political assassination, John Ross denied any complicity or approval of the deed, but he could not completely shake the accusations made against his party. The federal government remained critical of him and continually called for punishment of the murderers. Ross's insistence that he was chief of all the Cherokees, moreover, irritated the old settlers, and turmoil continued in the Cherokee country. All three parties, Rosses, the Treaty Party, and the old settlers, appealed to the federal government. Exasperated, President Polk in 1846 urged the division of the Cherokees into separate tribes, and the House Committee on Indian Affairs supported his proposal. 64. Such action led Ross, who above all wanted a unified nation, to persuade Polk to approve a new treaty that would keep the Cherokees intact. The President thereupon appointed commissioners to negotiate. 62 documents on Scott's operations are in House Document Number 453, 25-2, Serial 331. Scott's part in the removal is treated in Charles Winslow Elliott, Winfield Scott, The Soldier and the Man, 34,555. Examples of reports of harsh treatment of the Cherokees appear in Niles National Register 54, 385, and in James Mooney, Myths of the Cherokee, 19th Annual Report of the Bureau of American Ethnology, 1897-1898, pt 1, 127. 63 descriptions of the emigration are given in Foreman, Indian Removal, 279,312. Moulton, John Ross, 95,106, discusses the removal under Ross and the subsequent controversy over removal expenses. For a brief discussion of the number of deaths on the Cherokee Trail of Tears, see FN 58, in Prucha, Great Father, 1:241. There is a recent discussion, with somewhat different conclusions, in Russell Thornton, The Cherokees, A Population History, 7377. 64 James K. Polk to Congress, April 13, 1846, House Document Number 185, 29-1, Serial 485, pages 12. This document also contains a long report of the Commissioner of Indian Affairs on the Cherokee conflict, memorials from the three factions, and several other pertinent documents submitted to Congress by the President in support of his message. Further documents are in Senate Document Number 301, 29-1, Serial 474. Page 182. With the three Cherokee delegations in Washington in order to heal all dissension. With able advisers and a firm intent to settle past differences, the three factions worked out an agreement. This Treaty of 1846, debated and amended by the Senate and finally ratified by a majority of one vote, was approved in its modified form by the Indian delegates on August 14. It provided for a unified Cherokee nation and declared a general amnesty and an end to party distinctions. The treaty was a compromise measure, for Ross now agreed to the legitimacy of the 1835 treaty and the Old Settlers admitted that the Ross party had rights to the lands in the West. 65. The Southern Indians had been forced into treaties they did not want, treaties whose validity they denied but which were adamantly enforced by the federal government. The hardships of removal were extreme. Yet these Indian nations were not destroyed. The arguments of men like Jeremiah Evarts and his supporters in Congress and the decisions of John Marshall in the Cherokee cases provided a theoretical basis for the continuing political autonomy of the tribes and their rights to land. The removal was accomplished by means of formal treaties, which in their recognition of the Indians' nationhood and the fee simple ownership of land formed a foundation for continuing political existence that even tribal factionalism did not crush. With regard to the Southern Indians, the treaty system had a new lease on life. 65 Kapler, 2:56165, Senate X. PROC, 7:14952. Page 183. Chapter 8. The removal period in the North. While the five Southern tribes were signing formal treaties for their removal to the West, the multiplicity of small tribes north of the Ohio underwent a different sort of treaty-making. 1 Instead of dealing with a few large tribes, which had well-established traditional homelands and organized tribal governments that could up to a point negotiate for terms that would protect their interests, in the North the federal government continued to face numerous tribes and overlapping land claims that resulted from a long history of migration from place to place. Although formal treaties under constitutional provisions seemed a bit pretentious for dealing with some of these small remnants, they continued to be the vehicle used to accomplish what United States policy and interests demanded. The story of these treaties is essentially the story of the final dispossession of the Indians in the region. 1 See Francis Paul Prucha, The Great Father, The United States Government and the American Indians, 2 volumes, Chapter 9, Removal of the Northern Indians, 1:24369, which I have drawn on here. Grant Foreman, The Last Trek of the Indians, 17,158, deals with the removal of the northern tribes, but the book as a whole is principally concerned with the actual emigrations. Useful articles on many of the individual tribes appear in Handbook of North American Indians, Volume 15, Northeast, ed. Bruce G. Trigger. Page 184. Treaties in the Old Northwest. Between 1829 and 1851, 86 ratified treaties were signed with 26 traditional tribes in New York, the Old Northwest, and the immediate Trans-Mississippi areas. These tribes sometimes acted individually, sometimes in conjunction with other tribes. A good many of the tribes or bands signed more than one treaty. Potawatomi Indians alone were involved in 19.2. The government's treatment of these tribes was hardly a new departure, for it continued policies and actions that had been going on for 3 decades. Removal, in the sense of an exchange of lands occupied east of the Mississippi for lands west of the river, was only one element. Many of the treaties provided for cession of portions of a tribe's lands to the United States and the concentration of the displaced Indians on remaining lands, with the privilege of hunting on the ceded lands until they had been surveyed and sold to white settlers. 3. Most of the Indians involved had a long history of shifting locales. The Delawares and Shawnees, who perhaps are extreme examples, moved frequently, step by step, toward the west from their original eastern locations. 4. None of the Indians north of the Ohio occupied precisely the same lands in 1830 that their ancestors had held when French traders first came in contact with them in the 17th century. The removal of these tribes by treaty in the Jacksonian era was part of 2. The chronological list of treaties in Appendix B gives information on these treaties, indicating the groupings of the tribes in some of the treaties and the division of tribes into separate bands in others. The areas ceded are shown on the plates in Royce, Cessians. 3. James A. Clifton classifies the treaties with the Indians in the Old Northwest, 1830-1839, as follows: 17 provided for a reduction of the land base without removal, 3 provided for permissive removal, 8 provided for obligatory removal. His low total of 28 results from omitting treaties that merely confirmed or supplemented earlier ones and from combining a number of treaties made with separate bands of Potawatomis, which were in fact a single action of ceding reservations established earlier. Escape, evasion, and eviction, adaptive responses of the Indians of the Old Northwest to the Jackson removal policy of the 1830s, an unpublished paper furnished me by the author. 4. The end paper maps in C. A. Wesslager, The Delaware Indians, A History, graphically depict the Delaware migrations. An elaborate map of Shawnee locations and movements is in Charles Callender, Shawnee, in Trigger, Northeast, 623. Page 185. Their migration history, which continued even after their settlement west of the Mississippi. By 1830 most of Ohio, Indiana, and Illinois had already been freed of Indian title by treaties between the Indian groups and the United States government. What remained in these states were enclaves of natives, subsisting on agriculture and government annuities and surrounded by whites. The presence of British Canada also affected the Indians in the Old Northwest, for many of the tribes in the region had had close economic and political ties with the British. For them, in times of trouble, Canada was an open haven. A large number of Potawatomis, Ottawas, and Chippewas, as well as small numbers of other tribes, in fact, moved into Canada. 5. The treaties continued to provide reserves of land for individuals or for small groups within the ceded territories. Such reserves were a hedge against removal, but they were also a means of individual profit, because the Indians could dispose of them for a reasonable price and sometimes more. 6. The reservations, however, were an obstacle to the government's plan to clear the states of Indians altogether, yet so insistent were the Indians that it was necessary to allow the individual grants in order to obtain new cessions. In 1833 Lewis Cass, then Secretary of War, instructed the commissioners dealing with the Potawatomis at Chicago. Decline, the first instances, to grant any reservations either to the Indians or others, and endeavor to prevail upon them all to remove. Should you find this impracticable, and that granting some reservations will be unavoidable, that course may be taken in the usual manner, and upon the usual conditions. But I am very anxious that individual reservations should be circumscribed within the narrowest possible limits. The whites and half-breeds press upon the Indians, and induce them to ask for these gratuities, to which they have no just pretensions, and for which neither the United States nor the 5. On the Potawatomis, see James A. Clifton, The Prairie People, Continuity and Change in Potawatomi Indian Culture, 1665-1965, 3019, Clifton, a place of refuge for all time, migration of the American Potawatomi into Upper Canada, 1830 to 1850. For Ottawa movement to Canada, see Robert F. Bauman, Kansas, Canada, or Starvation, Michigan History 36, 28799. There is discussion of Indians moving to Canada in the reports of T. Hartley Crawford of January 15, 1839, House Document No. 107, 25-3, Serial 346, and April 7, 1840, House Document No. 178, 26-1, Serial 366. 6. See Paul W. Gates, Indian Allotments Preceding the Dawes Act, in John G. Clark, ed., The Frontier Challenge, Responses to the Trans-Mississippi West, 14758. Page 186. Indians receive any real consideration. The practice, though it has long prevailed, is a bad one, and should be avoided as far as possible. 7. In the Chicago Treaty, cash payments were provided to satisfy sundry individuals, in behalf of whom reservations were asked, which the commissioners refused to grant. 8. After passage of the Removal Act, President Jackson in 1831 appointed James B. Gardner of Ohio to treat with the Ohio Indians and explain to them the necessity of moving beyond the Mississippi. As caution is essential to the successful termination of such a business, Secretary of War Eaton told him, "Reserve and silence, as to the object of your visit, is suggested to you as matter for your discretion, to make it known to the chiefs in conversation only as you pass amongst them, and explain the wishes of the government, and its conviction that it is the only course which can secure to them happiness, and preserve them as a people." If the chiefs seemed properly disposed, Gardner was to call them together to work out a treaty. In July and August 1831 Gardner successfully negotiated removal treaties with the Shawnees and the Ottawas, who ceded all their lands in Ohio and accepted designated districts in the western Indian country beyond the state of Missouri. These lands were granted in fee simple, but the Indians could dispose of them only to the United States. The sums realized from ceded lands sold at public auction were to be used to build mills and to pay for improvements, with the residue invested for the Indians and a yearly interest of 5% paid as an annuity. 9. With the Wyandots Gardner had less success. Although pressed upon by white settlements, these Indians first demanded an investigation of the land proposed for their residence in the West. When an unfavorable report was returned, they refused to emigrate. The treaty that Gardner signed with them on January 19, 1832, authorized the cession of 16,000 acres for which the Indians would be paid $1.25 an acre as the land was sold, provided that the band may, as they think proper, remove to Canada, or to the River Huron in Michigan, where 7. Cast to Commissioners, April 8, 1833, Senate Document No. 512, 23-1, Serial 246, p. 652. 8. Kapler, 2:402, see Schedule A, 4046, for a list of payments to individuals in lieu of reservations. 9. Eaton to Gardner, March 29, 1831, OIALS, 7:17276, Kapler, 2:32539. Page 187. They own a reservation of land, or to any place they may obtain a right or privilege from other Indians to go. 10. Congress in 1832 authorized treaties to extinguish the title of the Kickapoos, Shawnees, and Delawares at Cape Girardeau in Missouri and of the Piankashaws, Wees, Peorias, and Kaskaskias in Illinois, as well as for dealing with other Shawnees and the Menominees. In October the Indians concerned assembled at Castor Hill, the home of Superintendent William Clark near St. Louis, where treaties were signed between October 24 and 29 by which the Indians gave up lands in Missouri and Illinois and accepted new lands west of the Missouri. The treaties with the Kickapoos and Shawnees provided large sums to pay off the Indians' debts. 11 The northern part of the Indian country west of the Mississippi was gradually taking shape as the home of the northern Indians. Potawatomi removal. The Potawatomi Indians were a good example of the piecemeal negotiations with Indians of the Old Northwest. The tribe, if one can so speak, was divided into bitter factions, each looking out for its own interests. Following the Black Hawk War of 1832, United States commissioners met with bands on the Tippecanoe River in Indiana, where the commissioners signed 3 separate treaties with different groups of Indians between October 20 and 27, 1832. In order to expedite the negotiations, the United States agreed to continue the practice of granting small reservations of land within the ceded districts for individuals and for village bands. Some 120 such reserves were stipulated in the 3 treaties. They satisfied the desire of the Indians to remain, but they seriously interfered with the government's intention of removing the Indians from the states. 12. 10 Kapler, 2:33941, Carl G. Klopfenstein, The Removal of the Wyandots from Ohio, Ohio Historical Quarterly 66, 11936. 11.4 Stat 564, 594, Kapler, 2:36567, 37,072, 37,677, 38,283. There is discussion of these treaties in Foreman, Last Trek of the Indians, 6065. 12 I have depended on the general accounts of Potawatomi removal that appear in Clifton, Prairie People, 179,245, 279,346, R. David Edmonds, The Potawatomis, Keepers of the Fire, 24,072, and Foreman, Last. Page 188. The Indians drove a hard bargain and, relative to other treaties, were well paid in goods and money, with sizable tribal annuities, special annuities for chiefs, payment for stolen horses, and money for traders' debts. Trade goods valued at $177,000 were distributed at the treaty grounds, and more were promised for the next year. A total of $1,374,279 was transferred in the 3 treaties. 13. As a result of the treaties, the Potawatomis were concentrated on the small reservations scattered through Michigan, Indiana, and Illinois. They now owned in common only a single large tract in northeastern Illinois and southeastern Wisconsin. Their condition was deteriorating, and it appeared inevitable that they would soon be pressured to remove altogether from the states and territories that had been their home. Some migrated voluntarily, joining Kickapoos who moved to Texas, settling in the Kickapoo Reservation in Kansas, or establishing themselves on Manitoulin Island. For the rest, plans were soon afoot for a treaty at Chicago in the fall of 1833. The negotiation at Chicago was a spectacular affair. 14 Large numbers of Indians appeared, and whites of all persuasions seeking personal fortunes were on hand to gain whatever they could. The forceful demands of the American commissioners, led by George B. Porter, governor of Michigan Territory, were met by the skillful tactics of the Indian negotiators, the mixed bloods Billy Caldwell and Alexander Robinson. The treaty promised 5 million acres in the West, including a triangle between the original western boundary of the state of Missouri and the Missouri River known as the Platte Purchase, for an equal amount of land given up. Debts to traders were covered, and there was a long list of payments totaling $100,000 to individuals in lieu of reservations and an even longer list of payments for a variety of claims amounting to $175,000. In addition, a Trek of the Indians, 100,125. The treaties of October 1832 are in Kapler, 2:35356, 36,770, 37,275. 13 Clifton, Prairie People, 23,435. 14. A general account of the treaty is Anselm J. Jerwing, The Chicago Treaty of 1833, Journal of the Illinois State Historical Society 57, 11742. An excellent portrayal of the many interests at work in the negotiations is in James A. Clifton, Chicago, September 14, 1833, The Last Great Indian Treaty in the Old Northwest, Chicago History 9, 8697. Documents pertaining to the treaty are printed in Milo M. Quaife, ed., The Chicago Treaty of 1833, Wisconsin Magazine of History 1, 287,303. Page 189. 20-year annuity was included. The Indians agreed to emigrate as soon as possible, the cost to be borne by the United States. 15. This Chicago Treaty was a notable example of the use of negotiations to satisfy a myriad of diverse individuals and groups, all of whom looked upon the treaty as a means of succeeding in their claims against the Indians or against the federal government. The long lists of persons in Schedule A and Schedule B attached to the treaty included these people. The modern ethno-historian James Clifton has sorted them out in an amazing litany. They included aging agents grown feeble in the Indian service looking for funds to soften their retirement yearsmen such as Thomas Forsyth. They included soon-to-be disemployed American-appointed chiefs such as Billy Caldwell, Alexander Robinson, Shabona, and Pokagon, all faced with premature retirement once the treaty was done and their services no longer needed, all seeking recompense for services rendered and a portion for severance pay. They included elderly old-time small merchants and Indian traders as well as vigorous representatives of the powerful American Fur Company, all demanding that the government act as paymaster for Potawatomi debts, whether minor or immense. They included old residents such as Antoine Wilmette and Mrs. Lina T. Helm, wanting their due for injuries or losses suffered during the Fort Dearborn Massacre, as well as more recent sufferers such as Rachel and Sylvia Hall, desiring compensation for privations experienced during the Black Hawk War. They also included the rising new traders, the Robert A. Forsyths and the William Ewings, desiring payment of recent debts. They included principals from the Choctaw Academy soliciting scholarships for future Potawatomi students, and missionaries seeking to finance their visions of an Indian Canaan. They included companies of frontier characters of obscure antecedents and marginal means who had long made their livings in the interstices between American and Potawatomi institutions. They included regiments of Joseph Napoleon Bourasses, Pierre Navars, and Louis Grignons, the very old line French Canadians, Métis voyageurs, the traditional hewers of wood, drawers of water, teamsters, boatmen, interpreters, market gardeners who for ages had served first French, later English, and 15. Kapler, 2:40215, Kapler describes the treaty as made with Chippewa, Ottawa, and Potawatomi Indians, but the principal group was Potawatomi. Page 190. Then American interests on this frontier. Many of these men would, now that the frontier was passing and their place in it evaporating, shortly become convert Potawatomi chiefs and rise as a new elite class in the West. They included, as well, a miscellaneous sundry of heirs, children, assigns, retainers, servants, employees and associates of all of the above. Indeed, the long lists of payees appended to the Chicago Treaty excluded very few who had anything at all to do with affairs in the Chicago region in the half-century before the 1833 Treaty. 16. Clifton is right in seeing in this much more than bribery, fraud, or corruption. Under the treaty protocols dramatized in speeches and debatings and beneath the apparent tawdry exchanges of the marketplace, he says, was an arrangement. All those who had worked to make Chicago an American place, rather than a Potawatomi or a French or an English district, were being rewarded. The relative scale of compensation may not have been fully equitable, but rather than fraud it may be better seen as well-earned commission, instead of bribe hard-won pay, in place of embezzlement valid perquisite, in lieu of greed authentic reparation or indemnity, and as alternative to dishonesty legitimate reward. 17. When President Jackson submitted the treaty and related documents to the Senate on January 10, 1834, he recommended ratification of the treaty, but he asked for a provision that the lists of payments in Schedule A and Schedule B be first investigated by a special commissioner sent to Chicago. Such payments would be subtracted from the gross sum specified in the treaty, and Jackson did not want that amount whittled down by spurious claims. Considering the relations in which the Indians stand to the United States, he said, it appears to me just to exercise their supervisory authority. It has been done in more than one instance, and as its object in this case is to ascertain whether any fraud exists, and if there does to correct it, I consider such a ratification within the proper scope of the treaty-making power. 18. The Senate was aware of the objections made to the claims, but it was not sympathetic to Jackson's suggestion that all the claims be investigated. The Committee on Indian Affairs, which made its report on the treaty on April 7, did not recognize any advantage in such a general inquiry, for it saw no way to determine the legitimacy of the 16 Clifton, Chicago, September 14, 1833, 9495. 17 Ibid, 95. 18 Senate X. PROC, 4:33940. Page 191. Claims, and, in any event, payments not made to the persons named would go to the Indians, who could then make the payments themselves. Besides, many of the payments were not contested. The report, however, did recommend cutting in half the payments indicated for Billy Caldwell and Alexander Robinson, and it prepared a short list of claims that it thought should be checked. It noted that provisions in Indian treaties for the payment of debts to individuals is a growing evil, and if provisions of this kind have not heretofore been the cause of injustice to the Indians, the committee believe the Senate may safely conclude, unless some check is given, the time is not distant when they will be. The committee also recommended a change in the western lands granted to the Indians, moving the Indians from the Platte Purchase to a region in Iowa Territory north of it, for the state of Missouri desired the Platte Purchase for itself and at the time of the Chicago Treaty was already making plans to acquire it. The Senate on May 22 agreed to the suggested amendments by a vote of 33 to 1.19. It took some pains, however, to get the Potawatomis to agree to the changes, and in the end a special committee of only 7 Indians signed the revision in the name of the tribe. The Senate on February 11, 1835, accepted the new document with the approved changes 38 to 3, but it took care to add a proviso to the effect that nothing else in the treaty as originally ratified would be affected. The Senate approved the nomination of T.A. Howard as commissioner to investigate the questionable claims. 20. The Indians insisted on occupying the Platte Purchase temporarily, and it was only after much irritation on both sides and the threat of military force that the emigrants moved into Iowa, where a Subajenki was established for them at Council Bluffs. 21. While the United bands represented at Chicago were seeking stability west of the Mississippi, the United States began to eliminate the pockets of Potawatomis that remained in the states on the reserve stipulated in the 1832 treaties. Most of the lands allotted to individual Indians soon passed into white hands. Then, in a series of many treaties in 1834 and 19 Ibid, 38,285, 4078. 20 Kapler, 2:41415, Senate X. PROC, 4:46970, 481. 21 The Platte Purchase issue is discussed in R. David Edmonds, Potawatomis in the Platte Country, an Indian Removal Incomplete, Missouri Historical Review 68, 37592. See also documents in Senate Document Number 206, 24-1, Serial 281, and Senate Document Number 348, 24-1, Serial 283. Page 192. 1836, made with individual chiefs and their bands. The enclaves held communally by bands were ceded to the United States for considerations of goods, money, payment of debts and annuities, and their inhabitants agreed to move off the land. 22. A number of the treaties vaguely specified removal to a country provided for them by the United States, west of the Mississippi River. Through the years, many of the Indians affected by these treaties migrated into Kansas, settling on a reserve along the Osage River. In the removal of Chief Menominey's band in 1838, military force was used against the resisting Indians, and the hardships endured in the emigration were long remembered. Other individuals and groups drifted northward in Michigan and Wisconsin, and about 2,500 moved into Canada. 23. The two large groups of Potawatomis in Iowa and on the Osage River Reservation signed a treaty in 1846 in an attempt on the part of the United States to pull together into one unit the disparate strands of the Potawatomi people with whom it had been dealing. The Indian signatories agreed to cede to the United States their reservations in Iowa and eastern Kansas for $850,000. In return, the United States sold them a new reservation along the Core River, land recently ceded by the Kansa Indians. 24. The single national existence never materialized, however, for the bands from Iowa did not coalesce with the more acculturated Indians who had moved to the Kaw from the Osage River. 25. 22. In some cases the Senate struck out articles making grants to individuals or providing for payment of debts. See Kapler, 2:42831, 450, 45,759, 46,263, 47,072, 48,889. Treaties between the United States of America and the Indian tribes, from 1778 to 1837, prints the articles that were struck out. They also appear in the ratification proceedings, see Senate Ex. Proc. Volume 4. 23. There is a brief account of the removal of Menominey's band in Edmonds, Potawatomis, 26,668. See also Irving McKee, ed., The Trail of Death, Letters of Benjamin Marie Petit. The Potawatomis were not simply shoved around by the paternal government of the United States, they investigated and took advantage of options open to them in their adaptive response to white pressures. A fair number of Potawatomis were shopping around in these years, James A. Clifton notes, inspecting, testing, and comparing the alternative possibilities of Iowa, Kansas, northern Wisconsin, or Canada before finally settling in somewhere. Their freedom of movement in this period was far greater than has generally been appreciated. Prairie People, 285. 24. Kapler, 2:55760. The treaty at first failed to gain a two-thirds majority in the Senate, but the following day, on a reconsideration, the Senate approved the treaty without amendments, 36-8. Senate Ex. Proc. 7:12427. 25. Clifton, Prairie People, 347,403. The history of the citizen band is given in page 193. Treaties with other tribes. The history of many of the tribes involved in removal from the Old Northwest fitted a general pattern, a succession of treaties of cession following the War of 1812, increasing pressure on the remaining lands by white settlers supported by the state and federal governments, new cessions with reserved lands for chiefs and other individuals or bands that refused to migrate beyond the Mississippi, degradation and deterioration of the tribes because of drunkenness and indolence, and finally, as conditions worsened and pressures increased, acquiescence in treaties that stipulated removal from the states to reservations laid out in the Indian country to the west. Such was the case of the Miamis, whose cessions of land after the War of 1812 gave only temporary quiet. The stimulus of the Removal Act, the canal-building fever that hit Indiana after the great success of the Erie Canal, and anti-Indian sentiment created by the Black Hawk War all contributed to new demands for Miami removal. Government attempts to get cessions in 1833 failed, but the Indians' resistance was weakened, and on October 23, 1834, a treaty was signed at the Forks of the Wabash. For remuneration in cash, annuities, and payments of traders' debts, the Miamis ceded some of the reserves delineated in previous treaties. 26. The execution of the treaty was greatly delayed. Some 3 years and 2 months elapsed between the signing of the treaty in 1834 and its final proclamation by the President in December 1837. President Jackson disapproved of the treaty because he objected to the manner stipulated for paying debts and because reservations were allowed for certain individuals. Attempts were then made to get modifications in the treaty to answer the President's objections, but the Miamis were unwilling to forego the promised reservations. Finally, in September 1837, Commissioner of Indian Affairs C.A. Harris recommended sending the treaty with some. Joseph Francis Murphy, Potawatomi Indians of the West, Origins of the Citizen Band. 26 Kapler, 2:42528. The removal of the Miamis is covered in Bert Anson, The Miami Indians, 177,233. Page 194. Amendments to the Senate, although he realized that the treaty would still provide for individual reservations. President Van Buren duly submitted the treaty on October 2, 1837, asking advice in regard to ratification with the amendments, with the proviso that if ratified the new document would be sent to the chiefs for their sanction or rejection. 27 The Senate rewrote the treaty in accordance with the instructions from the executive branch and on October 12, 1837, approved it 32-1. On resubmission to them, the Miami chiefs on November 10 agreed to the revised treaty, and Van Buren proclaimed it on December 22.28. The inhabitants of Indiana strongly criticized the treaty for failing to rid their state of Indians, and it was clear that new negotiations would soon be undertaken. After a partial success for the United States in 1838, in 1840 the chiefs finally agreed to accept emigration. The treaty, however, was negotiated irregularly. The agent and the subagent, sensing a willingness on the part of the chiefs to negotiate, drew up with them an informal treaty favorable to the Indians in late November 1840, at the time of the annuity payments, without express authorization from the Indian office to so act and without the necessary authorization and appropriation of funds by Congress. The document was sent to Commissioner of Indian Affairs T. Hartley Crawford, who saw the advantages to be gained from such a treaty and who urged the treaty on the Secretary of War and the President. It will be thus seen, he wrote the Secretary, that the negotiation of a treaty was not authorized, but if, in the opinion of the President and Senate, it shall be advisable to adopt and confirm it, I do not see any legal objections to such a course. Secretary Poinsett cautiously sent the treaty with Crawford's explanation to Van Buren, who equally cautiously submitted it to the Senate on January 4, 1841, with the remark, although the treaty was concluded without positive in 27 Jackson's objections and the attempts to get the Miamis to agree to modifications in the treaty are recounted in Commissioner of Indian Affairs C.A. Harris to Secretary of War Joel R. Poinsett, September 25, 1837, OIALS, 22:34951. See also Senator John Tipton's account in Circular, to the People of Indiana, CA. July 1836, in the John Tipton Papers, Comp. Glenn A. Blackburn and ed. Nellie Armstrong Robertson and Dorothy Riker, 3 volumes, Indiana Historical Collections, volumes 2426, 3:29799. Harris's, Poinsett's, and Van Buren's letters are in Senate, Sen 25 BC 2. 28. The original treaty and the revised treaty are both printed in 7 Stat 45866. For Senate action, see Senate X. PROC, 5:4247. The Indians' assent is printed with the treaty in Kapler, 2:428. Page 195. Struct ions and the usual official preliminaries, its terms appear to be so advantageous and the acquisition of these lands are deemed so desirable, by reason of their importance to the state of Indiana and the government as well as on account of the Indians themselves, who will be greatly benefited by their removal west, that I have thought it advisable to submit it to the action of the Senate. The Senate did not object, On February 24 it ratified the treaty by a vote of 23-5. The amendments entered by the Senate were confirmed by the chiefs on May 15.29. For the Sacs and Foxes, the loss of their lands in Iowa began with a treaty at the end of the Black Hawk War, signed at Fort Armstrong on September 21, 1833, by United States Commissioners General Winfield Scott and Governor John Reynolds, of Illinois. The preamble spoke fancifully of the Black Hawk War as an unprovoked war upon unsuspecting and defenseless citizens of the United States, sparing neither age nor sex, carried on by certain lawless and desperate leaders, a formidable band, constituting a large portion of the Sac and Fox Nation. Accordingly, the United States demanded of the Indians a considerable cession of land, a wide strip along the Mississippi running north and south almost the length of the future state of Iowa, partly as indemnity for the expense incurred, and partly to secure the future safety and tranquility of the invaded frontier. 30. The Sacs and Foxes ceded more land by treaties in 1836, 1837, and 1842 and received a tract of land suitable and convenient for Indian purposes. For a permanent and perpetual residence for them and their descendants at some unspecified place on the Missouri River or its tributaries. They received also an annual payment of 5% of a sum of $800,000 and blacksmiths and gunsmiths, but they refused to agree to payment in the form of funds set aside for agricultural and educational purposes, for they consistently rejected the schools and religion of white society. They were allowed 3 years to move from the western half of the cession, and they eventually gathered at the headwaters of the Osage River in Kansas. 31. 29 Kapler, 2:53134. The letters of Crawford to Poinsett, December 29, 1840, Poinsett to Van Buren, January 4, 1841, and Van Buren to the Senate, January 4, 1841, together with the action of the Senate are printed in Senate Ex. Proc. 5:32932, 34,344. The story of the treaty is told in Anson, Miami Indians, 2048. 30 Kapler, 2:34951. 31 Treaties of September 28, 1836, October 21, 1837, and October 11, 1842, Ibid, 47,478, 49,596, 54,649, William T. Hagan, The Sac and Fox Indians, 20,524, Donald J. Berthrong, John Beach and page 196. The Winnebago Indians were moved from place to place unconscionably. The peace provided by the adjustment of boundaries in the Treaty of Prairie du Chien in 1825 was broken by Winnebago attacks on white settlers, and American military force brought the surrender of the murderers. Then, in quick succession, the Winnebagos signed treaties in 1829 and 1832 that extinguished their title to lands south of the Wisconsin River. By the 1832 treaty, the United States, realizing that the Wisconsin lands remaining to the tribe would not support its members, granted to them the so-called neutral ground, a tract across the Mississippi lying between the lands of the Sacs and Foxes on the south and the Sioux on the north. Some Winnebagos moved to the new reservation, but they were insecure in the war zone between the hostile western tribes. 32. The United States government wanted the Winnebagos to move entirely beyond the Mississippi, which the tribe refused to do. In 1837, however, a delegation of Winnebagos was induced to travel to Washington, D.C. There, in an irregular treaty, the federal government pressured them into signing away the rest of their Wisconsin land. The treaty created a permanent division in the Winnebagos. One group of the Winnebagos decided it would be best to abide by the treaty and, in a series of subsequent treaties with the federal government, moved from one location to another until they ultimately ended in Nebraska, where a reservation was provided for them. The defiant remainder hid out in central Wisconsin, where they were periodically rounded up and moved to join the Winnebago faction in Nebraska, only to drift back to scattered enclaves in Wisconsin. 33. The Chippewa Indians in Michigan, Wisconsin, and Minnesota did not take part in the general emigration of the northern tribes to the western Indian country. Although they felt the pressures of white advance and negotiated treaties for the cession of their once large estate to the United States, they managed to preserve reservations within their old territories. The removal of the Sauk and Fox from Iowa, Iowa Journal of History 54, 31,334. 32 treaties of August 1, 1829, and September 15, 1832, Kapler, 2:3000303, 34,548, Louise Phelps Kellogg, The Removal of the Winnebago, Transactions of the Wisconsin Academy of Sciences, Arts, and Letters 21, 2329. 33. These treaties are listed in Appendix B as numbers 217, 240, 281, and 303. See also Nancy Estreich Lurie, Winnebago, in Trigger, Northeast, 697,700. Page 197. The western bands of Chippewas signed a treaty in 1837 at Fort Snelling with Henry Dodge, governor of Wisconsin Territory. In it they parted with a large tract of timberland in eastern Minnesota and north-central Wisconsin in return for annuities, settlement of traders' claims, and cash for influential mixed bloods. Meanwhile, miners invaded the copper lands of the Indians along the southern shore of Lake Superior, and in 1842, by a treaty signed at La Pointe, the Chippewas sold their hunting grounds as far east as Marquette, Michigan, for similar considerations. Not until 1850 did the President order the Indians to prepare for removal from the ceded lands, but even then the Indians refused to consider moving entirely from their homelands. The outcome was a new treaty in 1854 in which the Chippewas accepted a group of small permanent reservations scattered across northeastern Minnesota, northern Wisconsin, and the upper peninsula of Michigan. As was customary in treaties made in the 1850s, the President was given authority, at his discretion, to allot the reservation lands in Severaltety. 34. In all three treaties the Chippewas retained hunting and fishing rights. The 1837 treaty said, "The privilege of hunting, fishing, and gathering the wild rice, upon the lands, the rivers, and the lakes included in the territory ceded, is guaranteed to the Indians, during the pleasure of the President of the United States." The 1842 treaty read, "The Indians stipulate for the right of hunting on the ceded territory, with the other usual privileges of occupancy, until required to remove by the President of the United States." And the 1854 treaty said, more simply, "Such of as reside in the territory hereby ceded, shall have the right to hunt and fish therein, until otherwise ordered by the President." The eastern bands of Chippewas in the state of Michigan met a fate similar to that of the western bands. Following a treaty of 1819 by which they lost a huge wedge of land extending from Lake Huron into central Michigan, the Chippewas gave up the northwest quarter of the lower peninsula in 1836. But no wholesale removal was involved, for reserves were provided, and the Indians retained the right to use the land until it was settled by whites. 35. 34 treaties of July 29, 1837, October 4, 1842, and September 30, 1854, Kapler, 2:49193, 54,245, 64,852. Negotiations with the Western Chippewas are treated in Edmund Jefferson Danziger, Jr., The Chippewas of Lake Superior, 6,890, and Danziger, They Would Not Be Moved, The Chippewa Treaty of 1854, Minnesota History 43, 17,585. 35 treaties of September 24, 1819, and March 28, 1836, Kapler, 2:18587, 450. Page 198. The eastern bands of Sioux also succumbed to treaty-making pressures. In 1830, at Prairie du Chien, in an attempt to end the long-standing conflicts between the Sioux and the Sacs and Foxes, the government negotiated a treaty with the tribes by which each ceded a 20-mile wide strip of territory along the dividing line to create the neutral ground later given to the Winnebagos. The buffer strip was ineffective. Then, at Washington in 1837, the Sioux were induced to cede their holdings east of the Mississippi in return for $300,000 to be invested at 5%, cash payments to relatives and friends of the tribe, $90,000 to pay debts due traders, and annuities in goods and provisions for agricultural development. The Senate was slow to ratify the treaty, and the Indians suffered because of the delay in receiving the provisions promised by the treaty. The experienced agent at St. Peter's, Lawrence Taliaferro, described the condition of the Indians and condemned the failure to carry out the treaty quickly. The Sioux parties to the Treaty of September 29, 1837, on the 13th of January came into Fort Snelling in a starving condition from their hunts, there being no game to be found on the ceded territory sufficient for the consumption of their families. The Lake Calhoun and contiguous St. Peter's bands of Mdewakanton are represented as being in the most miserable condition of any. These people are very solicitous on the subject of the fate of their late treaty with the United States. They say we shall be rendered desperate, and we must see our children starve in our lodges unless we soon get relief from the government. If we desire to bring the northwestern tribes into closer bonds of friendship with us, we must as speedily as practicable give them an interest in the government, and the only way to secure this is by entering into liberal treaty stipulations faithfully executed, and rigidly fulfilled by the government. If we deem peace and tranquility on our borders of any moment to the welfare of the country, we should ratify at an early day the Sioux, Chippewa and other treaties recently entered into with the tribes. 56. Elizabeth Newmeyer, Michigan Indians Battle Against Removal, Michigan History 55, 27588. Page 199. How much the Indians profited, even when the treaty was implemented, is questionable, for the annuities became a crutch for their subsistence and delayed the day when they could support themselves, and dependence upon the annuities created troubles if payment was late. 36. The cession of their lands east of the Mississippi did not spare the Sioux from demands for their agricultural lands in Minnesota, especially after Minnesota Territory was established in 1849. The Indians were soon pressured into new cessions at treaties held in 1851 at Traverse des Sioux with the Sisseton and Wahpeton bands and at Mendota with the Mdewakanton and Wapekut bands. These treaties exhibited in stark form the many forces that focused on treaty negotiations in order to serve non-Indian interests. The dominating force in the treaties was the interest of powerful traders like Henry H. Sibley in recovering the debts owed them by the Indians. There was adroit maneuvering by the conflicting groups of traders, missionaries, government agents, and the governor of Minnesota Territory, Alexander Ramsey, who was United States Commissioner for the treaties. While the Indians were divided into interest groups as well, many favoring treaties and seeking to honor and maintain kinship networks that had developed between them and the whites, it was the overweening interests of the traders that shaped the negotiations and the resulting treaties. 37. The Sioux bands gave up most of their lands in Minnesota and eastern Dakota and came close to losing them altogether. At Traverse des Sioux, on July 23, the upper band ceded their lands for $1,665,000. 36 treaties of July 15, 1830, and September 29, 1837, Kapler, 2:30510, 49,394, Lawrence Taliaferro to Wisconsin Delegate G.W. Jones, February 21, 1838, in John Porter Bloom, ed., The Territorial Papers of the United States, Volume 27, Wisconsin, 93,132, Roy W. Meyer, History of the Santee Sioux, United States Indian Policy on Trial, 3961. Taliaferro in a postscript to his letter to Jones said, I say boldly no man is a true friend either to his country or to the Indians who objects to the ratification of the Sioux and other treaties of late formation. You may say this as from me if you choose. I fear some underhanded work by the interested fur traders. I know some will be busy. The traders of Prairie du Chien and St. Peter's seem by late advices from these places to know more about our Indian concerns in the Senate than other persons properly interested. 37 Meyer, Santisu, 78. Meyer's evaluation of the treaties exhibits a common Indian as victim syndrome, in which passive Indians are acted upon by white conspirators. A new ethno-history approach to the same events in Gary Clayton Anderson, Kinsmen of Another Kind, Dakota-White Relations in the Upper Mississippi Valley, 16501862, sees the Indians, too, as having diverse motivations in regard to the treaty. Page 200. Of which $275,000 was designated for the chiefs to enable them to settle their affairs and comply with their present just engagements and to aid in removal and subsistence for a year. But the financial provisions were heavy with the civilizing goals of the missionaries and the government agent, as funds were set aside for schools, mills, blacksmith shops, and farms. And the funds from investing the remaining sums were to be used not only for cash annuities but for a general agricultural improvement and civilization fund, for educational purposes, and for goods and provisions. 38 The Indians signed a trader's paper, not part of the regular treaty, by which they acknowledged their debts to the traders. Having obtained what they wanted at Traverse des Sioux, the commissioners moved down the Minnesota River to Mendota to treat with the lower bands. There on August 5 they signed a treaty similar to the one negotiated in July. 39. These Sioux treaties provided for reservations roughly 10 miles wide on each side of the Minnesota River, but the Senate eliminated the articles providing for the reservation of land within the ceded tract and stipulated the payment of 10 cents an acre for that land. The President was authorized to provide a reservation outside the ceded lands, once the Indians gave their consent to the amendment. 40. It proved difficult to get approval of the change, although the chiefs finally acquiesced. But the Indians were then, in actual fact, without a clear reservation. The President never got around to selecting the reservation called for in the Senate amendment, and the Indians continued to live on the lands originally reserved in the treaties. Finally, on June 19, 1858, in Washington, representatives of the Upper and Lower Sioux signed new treaties, which provided for allotment of land in the southern half of the reservations. Wide discretion was given to the Senate to determine the title of the Indians to the lands and to provide payment for the northern half of the reservations now given up, and to the Secretary of the Interior to manage all treaty funds according to his own discretion. Not until June 27, 1860, however, did the Senate finally confirm the Indian title to the southern part of the reservations and authorize payment of 30 cents per acre for the northern part. Most of this money, again, went to pay the just debts of the traders. 41. 38 Kapler, 2:58890. 39 Kapler, 2:59193. 40 Senate X. PROC, 8:36869, 382, 384, 398, 401, 4045. 41 Kapler, 2:78189. There is a detailed account of the treaties and subsequent. Page 201. For the Menominees, treaty negotiations were complicated by the tribe's relations with the emigrant New York Indians. By a treaty of 1831 the Menominees ceded specific lands along the Fox River to the New York Indians and other tracts along the eastern shore of Lake Winnebago to the Stockbridge and Brotherton Indians. They also gave up their claims to lands lying east of Green Bay, the Fox River, and Lake Winnebago. When the Menominees objected to this treaty, however, a new agreement was drawn up in 1832 that somewhat modified the provisions. This was but the beginning in the decline of the Menominee estate, for by still another treaty in 1836 the tribe gave up its land along the western shore of Green Bay and west of Lake Winnebago, as well as a strip of pinelands along the Wisconsin River. 42. When Wisconsin became a state in 1848, new attacks were made on the Menominee holdings. In October, Indian Commissioner William Medill forced a removal treaty upon the now weakened tribe. the Indians gave up their remaining lands in Wisconsin and were assigned a piece of land on the Crow Wing River in central Minnesota. But exploring parties reported unfavorably on the Crow Wing land, and President Millard Fillmore extended the right of the Menominees to remain on their old lands. With the support of white citizens, the Indians moved to new lands along the Wolf River in 1852. 2 years later the United States confirmed this reservation in place of the Minnesota Tract. The adamant refusal of the Menominees to move across the Mississippi had succeeded, although the new Menominee Reservation amounted to but a fraction of the aboriginal holdings. 43. Actions in William Watts Falwell, A History of Minnesota, Rev. ed., 4 volumes, 2:39340. The treaties are discussed more briefly in Anderson, Kinsmen of Another Kind, 22,931, and Meyer, Santee Sioux, 1035. The cession of 1851 and the reservations along the Minnesota River are shown in Royce, Sessions, Plates 11, 24, 33, Area NOS 289, 413, 414, 440. 42 Treaties of February 8, 1831, October 27, 1832, and September 3, 1836, Kapler, 2:31925, 37,782, 46,366, Patricia K. Aurita, The Menominee Indians, A History, 7,198. 43 Treaties of October 18, 1848, and May 12, 1854, Kapler, 2:57274, 62,627, Aurita, Menominee Indians, 99,126. Page 202. New York Indians. In the 1820s the Indians of New York State again entered into negotiations with the federal government, for pressures to remove them from the state had mounted. The Ogden Land Company, still holding preemption rights to the Indians' lands in New York, was eager to free the lands of Indian title, and a remarkable self-promoter named Eleazar Williams interested some of the Indians in emigrating. After making arrangements with local Indians in Wisconsin, Williams led a group of Indians west in 1822, and migration continued through the decade. The 1831 and 1832 Menominee treaties provided land for these New York Indians. 44. The removal impulse of the 1830s affected the Indians who had remained in New York, and in 1838 a treaty was signed at Buffalo Creek with several bands of these Indians. Stimulated by the Ogden Land Company's heirs and by civic and political leaders in Buffalo, who wanted to make room for the expansion of the city onto adjacent Seneca Reservation lands, a full-scale drive began to eliminate the Indians from the state and move them to lands west of Missouri. The move paralleled that against the 5 civilized tribes, although on a smaller scale, for the New York Indian remnants numbered only about 5,000. The New York Treaty negotiations, however, had a unique and complicated history, which showed once again the peculiarities and uncertainty of treaty making with the Indians. The story concentrates on the Senecas, the largest of the Indian groups involved, and on their 4 small reservations, Buffalo Creek, Allegheny, Cattaraugus, and Tonawanda. But the Oneida, Onondaga, Cayuga, Tuscarora, St. Regis, Stockbridge, Brotherton, and Muncie Indians were involved as well. 45. 44 Prucha, Great Father, 1:26466. The Stockbridge Indians' later dealings with the United States were particularly complicated. See Marion Johnson Machen, Stockbridge Muncie Cultural Adaptations, Assimilated Indians, Proceedings of the American Philosophical Society 112, 182,219. 45 A Census of the Indians appears in Schedule A of the treaty, Kapler, 2:508. A detailed history of the Treaty of Buffalo Creek, upon which I have relied, is Henry S. Manley, Buying Buffalo from the Indians, New York History 28, 31329. Because the treaty caused much controversy and there was repeated consideration of its terms by the President and by the Senate, voluminous documentation exists. A large. Page 203. An aspiring New York Democratic politician and former Congressman, Ransom H. Gillett, was appointed United States Commissioner, and in January 1838 he met the Indian chiefs and headmen at Buffalo Creek. There he signed with them on January 15 a long and complicated treaty. The preamble traced the earlier history of the movement of New York Indians to Wisconsin, noted the difficulties with that arrangement, and asserted that the Indians now agreed on the wisdom and necessity of removing at once to the Western Indian Territory. The treaty, thereupon, provided for the giving up of the lands in Wisconsin set aside for the New York Indians. In return, the United States promised to them a region west of Missouri as a permanent home. That land was to be held in fee simple by a patent from the President of the United States, with enough land to provide 320 acres for each Indian. A limit of 5 years was set on the removal to those new lands. Attached to the treaty was a deed of conveyance, by which the Seneca Indians sold their 4 New York reservations to John L. Ogden and Joseph Fellows for $202,000. The deed was witnessed by J. Trowbridge for the state of Massachusetts and by Gillett for the United States. 46. President Van Buren submitted the treaty to the Senate on April 23, 1838. From that point on the treaty had rough sailing. Strong charges were made that it had been negotiated in a fraudulent manner, and the public outcry quickly reached the Senate. 47 pamphlets appeared containing copies of contracts made between Ogden agents and certain Seneca chiefs, by which the Indians were promised sums of money for signing the treaty and promoting its passage. One such publication, issued by the Quakers, who took a special interest in the affair, ran to 256 pages. It turned out, too, that some of the chiefs had signed the treaty privately in Gillett's quarters, not in public council, of some 80. Number of documents are found in 2 files concerning Senate ratification in the National Archives, Sen. 25 BC 14 and Sen 26 BC 2. Scores of these documents and others were printed for the confidential use of the Senate at the time. These are now available through SIS Index to U.S. Senate Executive Documents and Reports, covering documents and reports not printed in the U.S. Serial Set, 18171969, 2 volumes, and the accompanying microfiche. In addition, much of the material appears in Sen. X. PROC, in-house, and Senate documents in the Congressional Serial Set, and in other places. See citations given below. 46 Kapler, 2:50216. 47 Senate X. PROC, 5:95, 98, 102. Page 204. Or 90 Seneca chiefs, only 31 initially affixed their signatures to the document. 48. The Senate, aware of these developments, amended the treaty chiefly by striking out provisions for payments and services and substituting a general appropriation of $400,000 to cover costs of removal and improvements, to support the emigrating Indians for the first year in their new homes, to encourage the Indians in education, and to supply mills, houses, and implements for agriculture and mechanic arts. But it ratified the treaty only conditionally. The Senate resolved, provided always, and be it further resolved, that the treaty shall have no force or effect whatever, as it relates to any of said tribes, nations, or bands of New York Indians, nor shall it be understood that the Senate have assented to any of the contracts connected with it, until the same, with the amendments herein proposed, is submitted and fully and fairly explained by a Commissioner of the United States to each of said tribes or bands, separately assembled in council, and they have given their free and voluntary assent thereto. With the amendments and this proviso, the Senate, on June 11, 1838, approved the treaty by a vote of 33 to 2.49. There then began a new round of councils with the tribes and bands, which occupied late August and the month of September. Gillett, who had been appointed to get additional Indian signatures, returned the treaty to Washington with new signatures, some of them privately obtained. 50. 48. The most comprehensive publication was the Quaker booklet, The Case of the Seneca Indians in the State of New York, illustrated by facts. Together with 2 other documents, it is reprinted in The Case of the Seneca Indians in the State of New York. Another significant pamphlet, by a Seneca Indian, was M. B. Pearce, Address on the Present Condition and Prospects of the Aboriginal Inhabitants of North America, with particular reference to the Seneca Nation. Memorials and petitions appear in Senate Document No. 33, 26-1, Serial 355, House Document No. 66, 26-2, Serial 383, Senate Document No. 210, 26-2, Serial 378. The difficulty in determining which men to count as chiefs for approving the treaty is shown in studies of the Seneca chief systems. See Thomas S. Abler, Fraud and Factionalism, the Seneca and the Buffalo Creek Treaty, and Population, Moieties, and Tribal Chiefs, Early 19th Century Political Organization of the Seneca Nation, 2 unpublished papers furnished me by the author. 49 Senate Ex. Proc. 5:13031. 50 C. Kapler, 2:51316. Reports on these developments are in T. Hartley Crawford to Joel R. Poinsett, January 15, 1839, and Poinsett to the President, January 19. Page 205. The President and the Senate next resorted to a set of neat maneuvers, each trying to place the responsibility on the other for deciding whether the conditions of the Senate for ratifying the treaty had been met. President Van Buren sent the treaty with the new signatures to the Senate, asking for advice in regard of the sufficiency of the assent of the Senecas to the amendments proposed. The Senate Committee on Indian Affairs studied the long documents accompanying the treaty and decided that the additional signatures on the treaty had not been acquired in open council, a practice it inveighed against. The committee in the end, however, offered no recommendation, but merely submitted the facts to the full Senate for resolution. 51. The Senate could not agree either to accept the treaty or to reject it. Instead, on March 2, 1839, it tossed the issue back to the President, declaring that whenever he should be satisfied that the Senecas had given proper assent to the amended treaty, he should proclaim the treaty and carry it into effect. Van Buren delayed. He sent Secretary of War Poinsett to meet once again with the Indians, only to discover new opposition to the treaty. The President then concluded, that improper means have been employed to obtain the assent of the Seneca chiefs. There is every reason to believe, and I have not been able to satisfy myself that I can, consistently with the resolution of the Senate of the 2d of March, 1839, cause the treaty to be carried into effect in respect to the Seneca tribe. On January 13, 1840, he asked the Senate again for its advice on ratification. 52. The Senate, however, was still unwilling to make a clear decision. Resolutions to approve the treaty and counter-resolutions to reject it were interspersed with long speeches for and against the document. Senator Ambrose H. Sevier of Arkansas explained why the treaty should be rejected, while Senator Wilson Lumpkin and Senator Silas Wright of New York detailed the advantages of the treaty and answered criticisms against it. Charges of bribery were brought up, and Wright and Senator John Norvell, of Michigan, sought to dispel the weight of the 1839 records of the Office of Indian Affairs, National Archives Record Group 75, Report Books, 1:7172, 7778. Henry A. S. Dearborn, a commissioner appointed by the governor of Massachusetts, attended these latter proceedings and reported them fully in his journals. See Journals of Henry A. S. Dearborn, a record of councils with the Seneca and Tuscarora Indians at Buffalo and Cattaraugus in the years 1838 and 1839, Publications of the Buffalo Historical Society, 7, 33225. 51 Senate Ex. Proc. 5:18283, 20811. 52 Ibid, 212, 21,819, 24,246, 26,566, 269. Page 206. Charges. The latter argued, in fact, that bribery had become an established part of treaty making. Sir, has not your whole system of Indian relations been marked by the same species of fraud, bribery, and corruption, if you choose to call them so? Have you not always had to make presents of money and goods to their chiefs, at every treaty, in every treaty, which you have ever made with them? What is it, but the most splendid bribes, that induced the Cherokees and other southern tribes to remove west of the Mississippi? Sir, you had to pay John Ross $1 million to induce him to remove his part of the nation. To be sure, the money was given to him on the pretext of defraying his expenses in their removal. But it was a bribe on the largest scale. Millions have been paid to get rid of the Indians in the southern states. And yet you talk of fraud, of bribery, and corruption, to a paltry amount, to induce the New York Indians to go where their nation may be preserved for ages. 53. Motion after motion was made in the Senate, largely on the question of whether the chief's signatures had been obtained in open council, but there was no consensus. Finally, in 3 significant motions on March 25, 1840, all resulting in tie votes, Vice President Richard M. Johnson cast the deciding vote. First, an amendment to a motion on the treaty itself asserting that the amended treaty had been approved properly by all the tribes, including the Senecas, was approved. Second, an amendment to require a 2/3 majority in the vote was rejected, and finally, the amended motion to approve the treaty was approved. In this narrow fashion, depending on the deciding vote of the Vice President, the Senate overturned its original rejection of the new treaty and authorized the President to proclaim the whole treaty. The Seneca section included point 54. There was some complaint later that the treaty was invalid because the final vote had not had a 2/3 majority, but the Senate had rejected motions to add that requirement to the resolution it was debating. That resolution was merely to affirm the assent of the tribes to the amended treaty, not, strictly speaking, to ratify the treaty, which had been done conditionally by a 2/3 majority in June 1838. In spite of the proclamation of the treaty by Van Buren on April 4. 53, the speeches, although given in executive session, are printed in Congressional Globe, 8, Appendix, 28,588, 28,995, 3,089, and 35,259. 54 Senate Ex. PROC, 5:27175. Page 207. The removal of the New York Indians to the Kansas lands specified in the treaty did not take place. Those lands remained vacant for many years and were eventually returned to the public domain, except for 32 allotments held in the northeast corner of the tract by the few New York Indians who had emigrated. 55 A new treaty with the Senecas on May 20, 1842, including a new indenture between the Senecas and Ogden and Fellows, returned the Allegheny and Cattaraugus reservations to the Indians, who thus were enabled to stay in New York State. 56. 55 Royce, Sessions, 771. Royce shows this allotted fragment on Plate 27, area number 249. 56 Kapler, 2:53742. Royce, Sessions, shows the New York reservations on Plate 47. The Tonawanda band split off from the rest of the Senecas and fought to retain its reservation. At length, by a treaty of November 5, 1857, the band was able to purchase parts of the reservation from Ogden and Fellows with money provided by the United States in return for the waiver of rights to its part of the Kansas tract. Kapler, 2:76771. Page 208. Chapter 9. Patterns in Treaty Making. By mid-century the treaty system was nearly 3/4 of a century old. It had been nudged in one direction after another and had been manipulated to serve the interests of the United States. Most of its complexities can be seen in the narrative account of treaty making, but general aspects, too, deserve attention. Although George Washington had fretted about just how the constitutional provisions would be carried out in regard to Indian treaties, many procedures soon became regularized. Where there were problems, pragmatic decisions held sway, with a good deal of discretion left in the hands of the treaty commissioners. Treaty commissioners. Negotiation of a treaty depended first of all on congressional authorization, and Congress acted under diverse influences. Presidents and their subordinates urged upon Congress the necessity of specific treaties, and senators, representatives, and territorial delegates were pressured by constituents who wanted land cessions and removal of the Indians from their midst. Advocates of Indian rights, too, knew how to bombard Congress, as they did at the time of the removal crisis. Then, when Congress decided to authorize a treaty and make appropriation. Page 209. Appropriations to pay the commissioners' expenses and to buy the necessary provisions and presents for the Indians, the action was embodied in particular pieces of legislation or buried obscurely in appropriation bills. 1. The executive branch of the government bore the burden of treaty making. Treaties, of course, were monitored by the Senate, through its authority to give or withhold advice and consent, but the onerous duties of negotiations were seldom shared by the senators. The presidents themselves did not direct the treaty councils, though some of them Washington, Jefferson, and Jackson exerted considerable personal influence. The responsibilities fell to cabinet members, first the secretaries of war and then the secretaries of the interior, and their subordinates in the Indian Department. Other persons, too, were chosen to negotiate treaties, men prominent in military or political affairs of the young nation, who had or could expect to receive the respect of the Indians. At first the task was considered important enough that the President appointed the commissioners by and with the consent of the Senate, but this practice gradually disappeared. Territorial governors, who were ex officio superintendents of Indian affairs, did much of the work. Men like Arthur St. Clair of the Northwest Territory, William Blount of the Southwest Territory, William Henry Harrison of Indiana, Ninian Edwards of Illinois, Lewis Cass of Michigan, William Clark of Missouri, and Isaac I. Stevens of Washington. As the Indian agency system developed, increasingly it was the Indian agents Benjamin Hawkins, Return J. Meigs, Silas Dinsmore, Benjamin O'Fallon, James Gadsden, and Henry R. Schoolcraft, among many others who negotiated for the United States with the Indians. If the treaties were signed at the seat of government, the Secretaries of War Henry Knox, Henry Dearborn, John C. Calhoun, James Barber, John Eaton, Lewis Cass, and Joel R. Poinsett played a direct part in the treaty making. But they were increasingly replaced by the Commissioners of Indian Affairs, Thomas L. McKenney, Carrie A. Harris, Luke Lee, George W. Mennypenny, Charles E. Mix, William P. Dole, Dennis N. Cooley, Louis Bogie, and Nathaniel G. Taylor. No Secretary of the Interior, strangely enough, was ever an official commissioner for an Indian treaty. The commissioners for some treaties in the early years were military. 1. For examples of congressional authorization, see 1 Stat 333, 53,940, 618, 2 Stat 82, 18,384, 4 Stat 185, 188, 302, 9 Stat 437, 556, 558, 572, 10 Stat 238, 12 Stat 792, 15 Stat 17. Page 210. Men such as Generals Anthony Wayne, James Wilkinson, and Andrew Jackson, and many less prominent officers, though usually high-ranking ones, served as commissioners. Thus Brigadier General Henry Atkinson negotiated the peace treaties along the upper Missouri River in 1825, and General Winfield Scott signed the treaty with the Sacs and Foxes in 1832 after the Black Hawk War. The commission headed by Governor Newton Edmonds of Dakota Territory that treated with the Northern Plains Indians at Fort Sully in 1865 included Major General S.R. Curtis and Brigadier General Henry H. Sibley. And the Indian Peace Commission, signing treaties in 1867 and 1868, comprised such important military men as Lieutenant General William T. Sherman and Brevet Major Generals William S. Harney, C.C. Augur, and Alfred H. Carey, as well as civilians. The commissioners, by and large, were men of experience and integrity and sometimes of deep sympathy for the Indians, although almost universally they were convinced that the drive to move the Indians from their aboriginal culture toward the patterns of white society was proper and necessary. On a few occasions, however, men got the job of commissioner as a political reward or to promote some scheme of personal interest. In a few instances local agents or superintendents drew up agreements with Indians under their charge without having previously received instructions to do so, yet the resultant documents were duly ratified by the Senate and the President as formal treaties. Since treaties became a means by which federal Indian policy was carried out, treaty making, naturally enough, became a regular part of the duties of the men already employed to manage Indian affairs. The commissioners of Indian affairs, superintendents, and agents. Congress, in fact, in February 1851 declared that hereafter all Indian treaties shall be negotiated by such officers and agents of the Indian Department as the President of the United States may designate for that purpose, and no officer or agent so employed shall receive any additional compensation for such service too. Indian negotiators. Who negotiated the treaties for the Indians? In many cases it was the whole tribe gathered at the council site. Lewis Cass and 29 Stat 586. Page 211. William Clark, who were directed in 1829 to draw up a set of regulations for dealing with the Indians, called attention to this aspect of the treaty-making business. We assemble the Indians in council, propose the subject to them, and discuss the various propositions made, modified, and acted on. The whole matter is fully considered and openly conducted in the presence of all the Indians of the tribes, who choose to attend, and the result is embodied in the form of a treaty. When they assemble to deliberate upon their public affairs, they are pure democracies, in which every one claims an equal right to speak and vote. The public deliberations, however, are usually conducted by the elderly men, but the young men or warriors exercise the real controlling influence. No measure can be safely adopted, without their concurrence. Experience has demonstrated the utility of permitting as many of the young men as are willing, to sign the treaty. They thus become committed, and no change of opinion, to which few people are more subject than Indians, will then lead them to upbraid others for an act in which they themselves thus openly participated. And this is the true reason why so many signatures are usually appended to our Indian treaties. He who signs first, incurs a heavy responsibility, and it requires no ordinary degree of resolution in the man, who thus, in the presence of his countrymen, leads the way in sanctioning a measure which many may regret after the presents are expended and the excitement of the moment has subsided. 3. Cass and Clark, however, were speaking of their own experience with the northern tribes and admitted that their remarks did not extend universally to the southern tribes, where frequently chiefs were delegated to act in the name of the tribe. Even among the northern tribes, on occasion a small group of authorized delegates would come to the capital to negotiate and sign a treaty. In some treaties signed by Indian delegates a stipulation was inserted that the treaty would take effect only if approved by the tribe in full council. Tribe, however, was an inadequate term, for it was in large part an Anglo-American concept increasingly imposed upon Indian groups for convenience in dealing with them. Not only was there confusion and uncertainty about the proper political unit with which to deal village, band, tribelet, or tribe, but the governmental structures within the units were imprecise. How much power or authority did a village chief? 3 reports submitted to the Senate by the Secretary of War, February 9, 1829, Senate Document No. 72, 20-2, Serial 181, pages 1719. Page 212. Have, for how long, and how was it passed on? How much power did a tribal chief have, and what was the difference between peace chiefs and war chiefs? Did certain clans within a tribe have special responsibilities or powers regarding land cessions or other aspects of treaty making? How fluid were the systems? 4. The federal government tried to deal with recognized Indian leaders, but often there were no clearly discernible head chiefs, as Cass and McKenney had discovered when they dealt with the Menominees at Butte de Morts in 1827, and treaty commissioners resorted to appointing chiefs. Federal officials responsible for Indian affairs often were not well enough informed to appreciate the systems of chiefs and leaders in the various Indian groups and did not always negotiate with the appropriate men. At times, when treaties were signed at Washington, rival delegations appeared, and the United States had to decide which one to do business with. There was no clear criterion except, perhaps, expediency for determining what Indian political unit would be used for carrying on the negotiations. The United States varied its decisions, sometimes treating with separate small divisions of a tribe, as in many treaties with Potawatomis and with Chippewas, and at other times seeking to find a single tribal chief to represent all the bands together. In a good many instances tribes were grouped together for a single treaty. Sometimes these were quite disparate or even hostile groups, brought together to deal with some common issue. At other times the negotiators might represent a dominant tribe with fragments of other Indians traditionally attached to it. Treaty commissioners did not always know ahead of time how many of the tribes and bands invited to a council would actually appear or when. So they dealt with those at hand or extended the time of signing to accommodate latecomers. Government officials, eager to carry out the elements of Indian policy. 4C. Raymond D. Fogelson, The Context of American Indian Political History, in the Struggle for Political Autonomy, the Second Newberry Library Conference on Themes in American Indian History, 821. There is an excellent discussion of tribe in Morton H. Fried, The Notion of Tribe. Fried asserts that the most massive and familiar phenomena of tribalism occur as a consequence of the impinging on simple cultures of much more complexly organized societies. He calls the kind of tribe we know a secondary socio-political phenomenon, brought about by the intercession of more complexly ordered societies, states in particular. Page 213. Embedded in treaties, on occasion selected chiefs who were in favor of the government's policies and dealt with them to the exclusion of less receptive tribal leaders. Chief Lawyer, considered the head chief of the Nez Perces, agreed to and signed a treaty in 1863, but chiefs of significant bands within the Nez Perces did not sign and claimed that the treaty provisions did not apply to them. Honest misunderstandings arose on the part of federal officials, who frequently were frustrated in dealing with groups whose acknowledged chiefs signed treaties but were then unable to enforce the provisions among their tribal members. Interpreters. Key figures at the treaty councils and always among the witnesses signing Indian treaties were the interpreters. A few of them were prominent men on the frontiers, but more often they were faceless individuals, neglected by historians. 5 Their importance, nevertheless, was tremendous, for if the treaties were to make much sense as contracts, the two parties needed to understand what each was saying. The importance was amplified by the fact that the English version of the treaties alone was the standard. Nor was it only a matter of accurate translation of speeches and documents. Deep cultural differences between the Indians and the whites often made the understanding of the meaning of the treaty items different on each side. The interpreters at the treaty councils, to a large extent, came from a pool of agency interpreters authorized by law. 6 And Indians often brought their interpreters to meetings, individuals of long acquaintance with the tribes and highly respected by the Indians they represented. Some interpreters were traders who knew Indian languages and 5 A historical article devoted to interpreters is Yasuide Kawashima, Forest Diplomats, The Role of Interpreters in Indian-White Relations on the Early American Frontier, American Indian Quarterly 13, 114, but it deals with the colonial period only. In that period many of the interpreters were important frontier diplomats, serving as cultural go-betweens, not simply as translators, a condition that did not obtain so fully in later times under the United States government. Another study of the colonial period is J. Frederick Fow's, Middlemen in Peace and War, Virginia's Earliest Indian Interpreters, 1608-1632, Virginia Magazine of History and Biography 95, 4164. 6. Authorization of interpreters in 4 Stat 737. Originally, in 1834, the salary was set at $300 a year. In 1851 it was raised to $400 and to $500 for the far western states. 9 Stat 587. Page 214. Customs. Others were whites who had taken up life among the Indians, sometimes originally as captives. A great many were mixed bloods, and a considerable number who witnessed treaties were illiterate and signed their names on the treaty documents with a mark. For only a few treaties was it possible to do without interpreters altogether because the Indian delegates themselves knew English. Problems of accurate translation occurred at nearly all the treaty councils, more so, of course, when the United States commissioners met tribes who had not had sustained contact with white society. Thus Thomas Fitzpatrick, a competent and respected agent, had difficulties when he dealt with Comanches, Kiowas, and Apaches at Fort Atkinson on the Arkansas River in 1853. He wrote, "At first, almost insurmountable difficulties presented themselves, in the distant and suspicious bearing of the chiefs, and the utter impossibility of obtaining any interpreters who understood their intricate languages. But little intercourse had ever existed between them and the white race, and that usually of the most unfriendly character. There were no trappers or traders amongst them who could facilitate an interview, no one who could speak a syllable of the English tongue, none present in whom mutual confidence could be reposed, and the sign language, that common to all the wild tribes of the West, while it might answer the purpose of barter, could not be relied upon in matters of so much importance and delicacy. Eventually, Mexican prisoners of the Indians established some communication through use of Spanish, and different persons interpreted the same speeches, to aid in accuracy. An Arapaho Indian who had lived with the Comanches gave some help, and even sign language was resorted to. In the end the agent was satisfied that a full understanding of what transpired was finally arrived at on both sides. 7. Interracial communication at the treaty councils of Governor Isaac I. Stevens with the Puget Sound tribes in 185,455 was conducted in Chinook jargon, a lingua franca along the Pacific Northwest coast, but hardly an effective tool for sensitive negotiations, for it had a vocabulary of only about 500 words, and a single word might be used to. 7. Fitzpatrick to A. Cumming, November 19, 1853, CIAAR, 1853, Serial 690, p. 360. See also the discussion in Leroy R. Hafen, Broken Hand, The Life of Thomas Fitzpatrick, Mountain Man, Guide and Indian Agent, 30,910. Page 215. Translate a number of different English words. 8 Such difficulties in communication were noted by Indian Commissioner Francis A. Walker in 1872, as he explained the government's forbearance in dealing with recalcitrant Indians. He spoke of the extreme untrustworthiness of many of the interpreters on whom the government is obliged to rely in bringing its intentions to the knowledge of the Indians. 9. Critics of federal Indian policy sometimes charge that the government negotiators, through the connivance of interpreters, deceived the Indians about the terms in the treaties signed by unsuspecting and trusting chiefs. But such accusations do less than justice to the American commissioners, who, for the most part, sought earnestly to convey the treaty's terms to the Indians. It is true that often enough the Indians were displeased with the treaty provisions, but the United States had overwhelming power compared to that of the tribes and could ultimately compel agreement to its terms. It did not need to resort to deceit as a major tool of Indian diplomacy. Nor do they do justice to the Indian leaders, who were astute enough to bring along interpreters on whom they felt they could rely and who argued strongly for their own position. 7 Though in many cases they lost the argument. On occasion the Indians, after the fact, complained that they had not understood the treaties they had signed, but it is hard to judge whether that was due to poor or deceitful interpreters or to a change in mind on the part of the Indians after they saw the effects of the treaties or after the presents and provisions that had drawn them to the treaty grounds had been dissipated. Point 10. Considering the handicaps under which they worked, the interpreters, by and large, did a respectable job, and, although the Indians may not have liked what the treaties stipulated, pains were taken to be sure. 8. See the brief article Chinook Jargon in Howard R. Lamar, ed., The Reader's Encyclopedia of the American West, 2089. 9. CIAAR, 1872, Serial 1560, p. 395. 10. See Complaints of the Delaware Chief John Kilbuck to George Morgan, January 20, 1779, in Louise Phelps Kellogg, Frontier Advance on the Upper Ohio, 1778-1779, 2034. The story of Osage Indians who complained in 1808 that they had not understood the treaty provisions is told in Meriwether Lewis to the President, December 15, 1808, Aspaya, 1:76667. It has been asserted that the Winnebago Indians who signed a treaty in Washington on November 1, 1837, had been intentionally deceived by the interpreter. Nancy Estrike Lurie, Winnebago, Handbook of North American Indians, Volume 15, Northeast, ed. Bruce G. Trigger, 699. But the citation Lurie gives does not substantiate this accusation. Page 216. They understood the provisions. In early councils the interpreters were sworn to translate accurately, and many of the interpreters who signed the treaties as witnesses had sworn interpreter entered after their names. Most councils had more than one interpreter, so that they could aid and, if need be, correct each other. When several tribes were present at a treaty council, of course, it was necessary to have interpreters who could handle the various languages. A good example of the latter case was the Treaty Council at Medicine Lodge Creek in southern Kansas in 1867, when the Indian Peace Commission met with Southern Plains tribes, a council about which we know a good deal because of the large number of newspaper reporters on hand. Point 11. The Indians there spoke 7 different languages, and while only 3 interpreters signed the treaties as witnesses, the reporters mention 5 in all. The most important of these was Philip McCusker, a frontiersman married to a Comanche woman. He had been an Army scout and had acted as interpreter for the Army and for the Interior Department. McCusker was so valuable because Comanche, the best known of the Plains Indian tongues, served as a middle stage in the translating. Once a speech had been rendered into Comanche, tribal interpreters could translate for their own tribes. Another interpreter was Mrs. Margaret Adams, whose father was a French-Canadian trader and whose mother was an Arapaho. She attracted much attention. An historian of the treaty says, when she appeared at the first Grand Councils at Medicine Lodge, wearing a red satin dress, she created a sensation particularly among the Indians. Brown's comment on Mrs. Adams was to the effect that she came to all the meetings drunk. 12. The Treaty of Fort Laramie of 1851, a complex council of many tribes, depended upon the ability of the interpreters. The participation of the Crows, one of the principal tribes present, was described by the reporter for the Missouri Republican. Mr. Meldrum, the Crow interpreter, has been many years among them, and is, in feeling and habits, almost identified with them. He is, withal, an intelligent man, understands their language perfectly, and is capable of comprehending the extent, effect. 11. The work of the reporters is described and analyzed in Douglas C. Jones, The Treaty of Medicine Lodge, the story of the Great Treaty Council as told by eyewitnesses. 12. Ibid, 108. Jones gives a detailed account of the business of interpreting at the council, see especially pages 1049. Page 217. And importance of the propositions submitted. In addition to Mr. Meldrum, the Crows have unbounded confidence in Mr. Culbertson, who had induced them to attend the treaty. He has long been at the head of the principal trading post on the headwaters of the Missouri, and the Indians regard him with great respect and consideration. These men were able to explain to the Crows, very fully and satisfactorily, all the various propositions. Point 13. Later, at the final meeting, the same reporter noted, when the council was opened, Col. Mitchell explained the purpose of the assemblage to be the signing of the treaty, as it had been prepared in conformity to previous agreement. He then read it to them, sentence by sentence, and caused it to be fully explained by the different interpreters. At the instance of some of the chiefs, portions of it were read several times, for their better understanding. Every effort was made, and successfully, to give them the full and just import of each Article 14. Indians could be insistent in getting interpreters who pleased them. The Nez Perces, for example, in the Treaty of 1863, wanted as interpreter Peshier B. Whitman, rather than other men at hand, for they considered him more thoroughly acquainted with their language. They stated, the Journal of the Treaty Proceedings said, that it was possible they might have some plain, some hard things to say, and the commissioners on the other hand might have the same to reply. Whatever might thus be spoken by either party they wished to be just as plainly or sharply interpreted. They argued, too, that Whitman, who no longer lived with the tribe, would be considered impartial by all the Indian bands involved. The commissioners agreed to send for Whitman, who eventually arrived. Point 15. When delegations of Indians went to Washington to negotiate treaties or merely to visit the Great Father, they were accompanied by interpreters, some of whom were tribal members and shared in the enter. 13 Missouri Republican, November 9, 1851, letter from the editor dated September 11, 1851, typed transcript supplied me by Raymond Damalley. Both of the interpreters were longtime traders. See the biographical sketches by Roy H. Madison and John E. Wickman in Leroy R. Haffen, ed., The Mountain Men and the Fur Trade of the Far West, 10 volumes, 1:25356, 9:27981. The volumes of the set offer considerable information about traders as interpreters. 14 Missouri Republican, November 30, 1851, letter from the editor dated September 17, 1851. 15 Journal of Treaty Proceedings, Documents, Roll 6, Frame 65758, Ch. Hale to William P. Dole, June 30, 1863, Ibid, Frame 760. Page 218. Tainment and presents that the delegates received. They, like the delegates, could succumb to the enticements of the urban environment, which may have aggravated their linguistic limitations. Point 16 But the government officials sought for honest communication with the Indians. Other witnesses. There were many persons attendant on the treaty negotiations and signatory as witnesses to the formal treaty documents. Chief among these were members of the United States Army. Many of the treaties were negotiated at or in the vicinity of military posts, as the popular names of the treaties abundantly indicate. For example, Fort Pitt, Fort Stanwix, Fort McIntosh, Fort Harmar, Fort Greenville, Fort Wayne, Fort Jackson, Fort Armstrong, Fort Gibson, Fort Leavenworth, Fort Bridger, Fort Sully, and Fort Laramie. Others were signed at settlements in which an army post was a dominant feature, namely, Detroit, Vincennes, Chicago, Green Bay, Sault Ste. Marie, and Rock Island. For some councils, a detachment of troops was considered a necessary part of the American entourage, for there was a recurring fear that the Indians called to council might be hostile and that trouble might erupt without warning at the treaty grounds. In other cases, where several tribes were gathered together, there was danger that old and persisting enmity between tribes would break out in armed clashes. Military officers, if not taking an active part in the negotiations, signed many treaty documents as witnesses. Although in some cases the army troops were considered an absolute necessity to protect the American treaty commissioners, in many others their presence served principally as a means to overawe the Indians and impress them with the power and grandeur of the United States. Parades and special military maneuvers and the firing of salutes were frequently a part of the council ceremonies. It should not be forgotten, however, that the Indians could play the same game. Western treaty councils were attended by immense numbers of Indians, among whom were many war chiefs and warriors, who presented a striking military presence of 16. See the passing discussion of interpreters in Herman J. Viola, Diplomats in Buckskins, A History of Indian Delegations in Washington City. Some of Viola's best stories, however, refer to the post-treaty period. Page 219. Their own. And the Indians, too, delighted in astonishing the assembled Americans with their feats of horsemanship. Besides the military officers and their troops, there was a great mixture of other whites at the treaty negotiations on the frontier, which were often elaborate and spectacular affairs drawing people who were concerned about the outcome of the negotiations and others who were merely curious. Distinguished travelers affixed their names to the treaties whose councils they attended, giving, one supposes, an added touch of authority and solemnity to the documents. State and territorial officials and legislators appear on the lists: governors, territorial secretaries, attorneys general, judges and lawyers, justices of the peace, mayors, militia officers, and territorial delegates, along with federal employees such as Indian agents, subagents, factors, registers of the land office, postmasters, army paymasters, surveyors, Indian farmers, and a phonographer. Resident or traveling clergymen and missionarymen like Benedict Flaggett, Catholic Bishop of Bardstown, Kentucky, who witnessed the treaty with the Potawatomis in 1818, Methodist missionary to the Wyandottes James Wheeler, Catholic missionary to the Menominees F. J. Bonjewell, Presbyterian missionary to the Sioux Stephen R. Riggs, and the Jesuit Pierre Jean de Smet, and the Episcopalian Samuel D. Hinman, who attested the signing of some of the Indians to the Treaty of Fort Laramie in 1868, and newspaper editors and reporters all made their appearance from time to time, as did an array of Indian traders. Traders and the treaties. It is easy to think of the treaties by which the Indian title to land was extinguished as compacts between two parties, the Indian tribe and the United States government, and such, legally, they were. But in fact there was sometimes an influential and occasionally dominating third party, traders. When the fur trade flourished, traders supplied the Indians with goods in return for furs, but as the hunting lands were circumscribed and the fur-bearing animals disappeared, the Indians paid the traders from their annuities, or the government bought large quantities of goods for the Indians directly from the traders. As cessions multiplied and annuities and other payments grew, the traders became more and more involved in the treaty process. Indians were, page 220, indebted to the traders for goods received on credit. The debts could be recovered only by provisions in the treaties for cash annuities, by which the Indians could pay the debts, or by direct allotment of funds in the treaties to cover specified obligations. Point 17. Beginning with the Osage Treaty of 1825, allowance of traders' claims became almost universal in treaties signed with the Indians in the Old Northwest. And as the pressures for removal increased and removal treaties seemed necessary at any price, the rewards for the Indians and for the traders were considerable, as Table 1 makes clear. In addition, because the treaty negotiations were usually eased by generous handouts to the attending Indians, and because the treaties often specified large payments in goods as well as in cash, the traders profited by furnishing these supplies, often at inflated prices. The traders, moreover, had a deep interest in the lands allotted individual Indians in the treaties, for such lands could quickly fall into their hands. So much influence did the traders have over the Indians that in many cases the government would have been unable to procure the treaties of cession it wanted without providing adequately for the traders' interests. The exorbitance of many traders' claims called for government investigation and adjudication, lest unscrupulous merchants grow inordinately rich at the expense of the Indians and the United States Treasury. The Senate refused, from time to time, to ratify treaties until the claims against the Indians were checked, and the War Department issued regulations for the payment of claims. Sometimes special commissioners or commissions were appointed to decide on claims and adjust the payments among diverse claimants, and they were given detailed instructions. Those investigating the claims under the Winnebago Treaty of 1837 were told. 17. I follow here my account in Francis Paul Prucha, The Great Father, the United States Government and the American Indians, 2 volumes, 1:26669. The best general account of the role of the traders is James L. Clayton, The Impact of Traders' Claims on the American Fur Trade, in David M. Ellis, ed., The Frontier in American Development, Essays in Honor of Paul Wallace Gates, 299,322. Other studies, which deal with more restricted areas or tribes, are Paul Wallace Gates, Introduction, in the John Tipton Papers, Comp. Glenn A. Blackburn and ed. Nellie Armstrong Robertson and Dorothy Riker, 3 volumes, Indiana Historical Collections, volumes 2426, 1:353, and Robert A. Trenard, A Trader's Role in the Potawatomi Removal from Indiana, The Case of George W. Ewing, Old Northwest 4, 324. Trenard has expanded his account of the traders in Indian Traders on the Middle Border, The House of Ewing, 182,754. Page 221. Table 1 for traders' debt claims provided for by treaty funds, 1825-1842. Year. Tribe. Amount. Year. Tribe. Amount. 1,825. Osage. 1,500. 1,833. Quapaw. 4,100. Kansas. 500. Potawatomi. 175,000. 1,826. Potawatomi. 9,573. 1,836. Ottawa. 300,000. Miami. 7,727. Menominee. 90,000. 1,828. Potawatomi. 10,000. 1,837. Chippewa. 70,000. 1,829. Chippewa. 3,000. Sioux. 90,000. Winnebago. 11,601. Sac and Fox. 100,000. 1,831. Ottawa. 20,000. Winnebago. 200,000. 1,832. Sac and Fox. 40,000. 1,838. Miami. 150,000. Potawatomi. 28,700. 1,840. Miami. 250,000. Potawatomi. 62,400. 1,842. Wyandotte. 23,800. Shawnee. 12,000. Chippewa. 75,000. Potawatomi. 20,700. Sac and Fox. 258,000. Total. 2,013,601. Source, compiled from Kapler, Volume 2, and printed in James L. Clayton, The Impact of Traders' Claims on the American Fur Trade, in David M. Ellis, ed., The Frontier in American Development, Essay in Honor of Paul Wallace Gates, 303. Copyright 1969, Cornell University, used by permission of the publisher, Cornell University Press. You will require the respective creditors to deposit with you transcripts of their claims, exhibiting names, dates, articles, prices, and the original consideration of each claim. If original books or entries cannot be produced, their loss or destruction must be proved. The sale of spirit-use liquors to Indians being prohibited by the laws of the United States, no item of charge on that account will, under any circumstances, be allowed. If be against an individual Indian, he should be called before you, and each item in the account be explained to him, and his assent or dissent to it required. The Indian office recognized the forces pulling in two directions and instructed the commissioners further. The moral duty of paying every just claim should be pressed upon the Indians, and, in receiving their statements, you will bear in mind the danger arising on the one hand from the disposition to evade an obligation, and on the other, from the exercise of improper influence by any of the claimants. 18. The Commiss. 18 C.A. Harris to Commissioners, July 26, 1838, House Document Number 229, 25-3, Serial. Page 222. Zionists found it impossible to carry out their duties with the exactitude wanted by the Commissioner of Indian Affairs, but they went about their business carefully and made judgments on the validity of the claims presented. In some cases claims were scaled down or disallowed altogether. The attitude of the traders toward removal was often ambivalent. These men shared the sentiment of other white settlers that the Indians should be moved to the west to clear the land for white exploitation, and often they had a direct interest in the ceded lands. Yet it was not easy to give up the large profits they made in supplying the Indians where they were. Even though most traders realized that removal was inevitable, they worked to delay the emigration as much as possible. Each new treaty could be another bonanza. In 1838 the Commissioner of Indian Affairs asserted that disturbances arising in the removal of the Indians were caused by the large indebtedness of the Indians to their traders, and to the undue influence of the latter over them. He said he was confident that their influence is not only prejudicial to the Indians, but has been frequently exercised to defeat negotiations with them, and to prevent the accomplishment of objects sanctioned by treaties, and others devised and calculated to promote their welfare and permanent improvement. 19. It was the government's unwavering objective to rid the regions east of the Mississippi of Indians, and since it was often necessary to get the traders' acquiescence if not active support, measures were taken to circumvent any obstructionism. Thus in the Potawatomi removal the government threatened to pay no more claims until the Indians had emigrated. Then, on March 3, 1843, the Senate, by a 2/3 majority, resolved that in future negotiations of treaties with the Indians no reservations of land should be made in favor of any person, nor the payment of any debts provided for, and it sent the resolution to the President. 20 But many old debts were still outstanding, and claims dragged on, much to the irritation of the overburdened Indian office. In later treaties the claims of the traders against the Indians still 349, pages 56, the undated report of two commissioners appears Ibid, 1421. For other accounts of investigation of claims, see Trenard, Traders' Roll, and Clayton, Traders' Claims. 19 Harris to Poinsett, February 12, 1838, Senate Document Number 198, 25-2, Serial 316, p2. 20 Senate X. PROC, 6:170, 184. Page 223. Had to be recognized if the desired cessions were to be obtained. Even though the government did not pay the traders directly, large sums were provided to enable the Indians to settle their affairs and comply with their present just engagements. 21. Presents and medals for the Indians. An important element in United States policy toward the Indians was the distribution of presents to Indian chiefs as a means of winning their favor and attaching them to the United States. It was a practice that went back to colonial times, and, although presents were given outside of treaty negotiations, such gifts were an established part of treaty making and clearly distinguished Indian treaties from treaties signed with European powers. 22 The Indian chiefs expected gifts as part of treaty protocol. An abrupt stop to the practice would have imperiled success at the treaty councils. While special gifts were distributed to chiefs, where they might do the most good as a thinly veiled form of bribery. Large sums were spent as well on provisions for the multitudes of Indians who thronged to the councils, in large part just to receive such presents. As Cass and Clark noted in their 1829 report to the Secretary of War, provisions must also be regularly issued to the Indians. They are capable of great abstinence and great repletion. They come to the treaty ground expecting to be fed and clothed, and it is essential to the success of the negotiation with them, that their wants should be supplied, and themselves kept in good humor. Nothing short of the daily issue of 1.5 pounds of fresh beef, and 1.5 pounds of flour or bread, for each person, will satisfy them, and this quantity will not, unless there is a considerable proportion of children. The men are generally accompanied by their families, nor will they attend without them. All come expecting to partake of the provisions which are to be issued, and of the goods to be distributed. 21 Sioux Treaties of 1851, Kapler, 2:589, 591, Lucille M. Kane, The Sioux Treaties and the Traders, Minnesota History 32, 6580. 22 There is a brief discussion of presents for Indians in Prucha, Great Father, 1:16871. An excellent study of the use of presents in colonial times is Wilbur R. Jacobs, Diplomacy and Indian Gifts, Anglo-French Rivalry Along the Ohio and Northwest Frontier, 1748-1763. Jacobs provides great detail not only on the use and significance of the presents but on the kinds of goods provided. Page 224. Without the operations of these powerful motives, few cessions of land would be obtained. 23. It is sometimes difficult to distinguish how much of the provisions expended at the council grounds were presents, strictly speaking, and how much were part of the consideration paid for land cessions. Many goods were distributed prior to the signing of a treaty, and this occurred even if the council failed to produce a formal cession agreement. The large silver medals presented by treaty commissioners at the councils were very special marks of recognition for the chiefs and warriors. The medals bore pictures of the Great Father, the President, and other symbols of peace and friendship or promotion of the government's civilizing plans. While the medals were presented in large numbers on the frontiers by Indian agents and other government officials in order to gain the friendship of tribal leaders and were an indication of Indian acceptance of loyalty to the United States, they were especially important instruments of diplomacy at treaty councils, where their presentation to chiefs frequently marked the culmination of the treaty signing. 24. Thus by the second of the secret articles of the Treaty of New York with the Creeks in 1790, the United States presented a great medal with proper ornaments to each of the 6 great medal chiefs named in the Article 3 from the Upper Creeks, 2 from the Lower Creeks, and 1 from the Seminoles. 25 Medals also entered into General Anthony Wayne's negotiations at Greenville in 1795. Their significance in marking a switch from the Indians' adherence to the United States rather than to the British can be seen in the speech of Newcorn, a Potawatomi chief, on his arrival at the council. "I hope, after our treaty," he told Wayne, "you will exchange our old medals, and supply us with General Washington's. My young men will no longer listen to the former, they wish for the latter. They have thrown off the British, and henceforth will view the Americans as their only true friends." 26. Wayne did not. 23 Report of February 9, 1829, 20. 24 A full history of the use of medals as an element of Indian policy is given in Francis Paul Prucha, Indian Peace Medals in American History. 25 The title Great Medal Chief came from the usage of John Stuart, the British Indian superintendent in the South, who so designated influential tribal leaders. See Prucha, Indian Peace Medals, 35. 26 Minutes of the Treaty of Greenville, June 17, 1795, Aspaya, 1:564. Page 225. Disappoint the chief. The treaty was signed on August 3, after long days of council meetings and passing of wampum belts, and on August 7 the general again addressed the Indians. "Listen, all you nations present. I have hitherto addressed you as brothers. I now adopt you all, in the name of the President and 15 great fires of America, as their children, and you are so accordingly. The medals which I shall have the honor to deliver you, you will consider as presented by the hands of your father, the 15 fires of America. These you will hand down to your children's children, in commemoration of this day in which the United States of America gives peace to you and all your nations, and receives you and them under the protecting wings of her eagle. 27. Lewis Cass and Thomas L. McKenney, in 2 treaties they negotiated in 1826 and 1827, used the medals as symbols of the United States. In a formal presentation to Chippewa chiefs and warriors at the Treaty of Fond du Lac in 1826, McKenney spoke at length to the Indians, "We stand here to put medals around their necks, and smaller medals we will put around the necks of your first warriors, and best young men. All these medals have on one side of them your great father's face, and on the other side is his pipe, his peace hatchet, and his hand." McKenney told the Indians that a medal was a gift from their great father himself. "It is a new heart," he said. "Your great father has told us to come up here, and put it in the breast of his great Chippewa children." 28. Similarly, at Butte des Morts in 1827 the 2 commissioners gave medals and other gifts to the Indians designated as principal chiefs of the Menominees. At the end of the council the medals were presented with this admonition: "We have hung medals around your necks and put new American hearts into you. You must now take firm hold of your American father's hand and keep fast hold. You must give your young men good advice. You must drive away all bad words from your ears. These medals open the path to our great council fires. If at any time you want to say anything to your great father, these medals are your passports." 29. 27 Ibid, 580. 28 Thomas L. McKenney, Sketches of a Tour to the Lakes, of the Character and Customs of the Chippewa Indians, and of Incidents Connected with the Treaty of Fond du Lac, 47,374. 29 Treaty Journal, Documents, Roll 2, Frame 30. Page 226. Farther west as well Indian medals flooded the Indian country. The commissioners at the treaties of Portage de Sioux in 1815, for example, presented medals to the chiefs, and Atkinson and O'Fallon took medals with them when they ascended the Missouri in 1825 and gave them out at their treaty councils. The medals continued to be major instruments in Indian policy as long as treaties were made and even later. Land cessions and payment for them. Treaties were the legal instruments by which the federal government acquired full title to the great public domain stretching west of the Appalachian Mountains. Whereas the British government by the Treaty of Paris in 1783 recognized United States jurisdiction and ultimate sovereignty over the lands as far as the Mississippi, and the new nation eventually acquired the Trans-Mississippi West as well, the Indian right of occupancy to much of that land was recognized by the President, Congress, and the courts. The Indian title had to be extinguished by formal treaties. But what precisely was the title that the United States agreed to pay for in the treaties? That depended, to begin with, on the European doctrine of preemption, which divided rights to territory into 2 classes. There was a fee simple right of absolute dominion over the land, a right claimed by the European discoverers of the area. There was, second, the right of occupancy, sometimes called right of the soil, which permitted occupants to enjoy the usufruct of the land as long as they occupied it. By preemption the white governments asserted their exclusive right to purchase or inherit the Indians' right of occupancy when the Indians decided to sell or when they no longer existed on the land. 30. For Henry Knox the practice was dictated by common principles of human decency and the honor and dignity of the nation. Thus he wrote to President Washington on June 15, 1789, "It is presumable, that a nation solicitous of establishing its character on the broad basis of justice, would not only hesitate at, but reject every proposition to benefit." 30 I draw here on the discussion in Prucha, Great Father, 1:5860. Page 227. Itself, by the injury of any neighboring community, however contemptible and weak it might be, either with respect to its manners or power. The Indians, being the prior occupants, possess the right of the soil. It cannot be taken from them unless by their free consent, or by the right of conquest in case of a just war. He wanted the Indian rights to be ascertained and declared by law, and he wrote, were it enacted that the Indians possess the right to all their territory which they have not fairly conveyed, and that they should not be divested thereof, but in consequence of open treaties, made under the authority of the United States, the foundation of peace and justice would be laid. 31. Knox was seconded by Secretary of State Thomas Jefferson, who, when questioned by the British minister in 1792 about American rights to Indian lands, replied, first, a right to preemption of their lands, that is to say, the sole and exclusive right of purchasing from them whenever they should be willing to sell. 2d. A right of regulating the commerce between them and the whites. We consider it as established by the usage of different nations into a kind of jus gentium for America, that a white nation settling down and declaring that such and such are their limits, makes an invasion of those limits by any other white nation an act of war, but gives no right of soil against the native possessors. 32. A year later, in replying to queries posed by Washington to his cabinet, Jefferson was equally clear, I considered our right of preemption of the Indian lands, not as amounting to any dominion, or jurisdiction, or paramountship whatever, but merely in the nature of a remainder after the extinguishment of a present right, which gave us no present right whatever, but of preventing other nations from taking possession, and so defeating our expectancy, that the Indians had the full, undivided and independent sovereignty as long as they choose to keep it, and that this might be forever. 33. Jefferson maintained these views as president. When he proposed a constitutional amendment to 31 Knox to Washington, June 15, 1789, and January 4, 1790, Aspia, 113, 61. 32 The Writings of Thomas Jefferson, ed. Andrew A. Lipscomb, 20 volumes, 17:32829. 33 Ibid, 1:34041. See also the statements in support of Indian rights in Jefferson to Knox, August 10, 1791, Ibid, 8:22627, and Jefferson to Knox, August 26, 1790, The Papers of Thomas Jefferson, ed. Julian P. Boyd, 24 volumes to date, 17:43031. Page 228. Ratify the Louisiana Purchase. He included a statement of respect for the Indians' right of occupancy in the soil. 34. The Supreme Court under John Marshall endorsed the doctrine of preemption. In Fletcher v. Peck, the court declared that the nature of the Indian title, which is certainly to be respected by all courts, until it be legitimately extinguished, is not such as to be absolutely repugnant to seisin in fee on the part of the state, and the court expanded this doctrine in Johnson and Graham's Lessee v. McIntosh. With citations of colonial precedents to back up his position, Marshall maintained that the United States, or the several states, had exclusive power to extinguish the Indian right of occupancy. The Indian's right, he declared, is no more incompatible with a seisin in fee, than a lease for years, and might as effectually bar an ejectment. He continued, it has never been contended that the Indian title amounted to nothing. Their right of possession has never been questioned. 35. But if the Indian right of occupancy did not amount to nothing, what precisely did it amount to in monetary terms? That was a crucial question in treaty negotiations, where payments for land cessions were determined. It would appear that the United States commissioners paid as little as they could get away with, and usually they were given discretion in setting amounts, depending upon what the Indians would accept. They certainly were not governed by any consideration of what the lands might ultimately be worth. In 1804, Secretary of War Henry Dearborn provided an explicit model for calculating the price to be offered to Choctaws for cessions asked of them, showing clearly the limited title to hunting lands accorded the Indians by the United States. Dearborn proposed estimating as nearly as possible the actual profit the Indians annually derived from hunting on a given tract and the probable profits for the next 50 years. For instance, he wrote in preliminary instructions to Silas Dinsmore, one of the commissioners, if the Choctaws derive an annual profit of $3,000 from hunting on the whole of the tract proposed to be ceded, and if they will probably continue to derive an equal advantage for 50 or 60 years to come, then it would be proper to allow them such a sum paid down as would bring an interest of $3,000 a year, or such an annuity as would be equal to $3,000. They would in such a case make an advance. 34 The Writings of Thomas Jefferson, ed. Paul Lester Ford, 10 volumes, 8:24143. 35 6 Cranch 14243, 8 Wheaton 592. Page 229. Tejas bargain, as the annuity would be perpetual, and they would have permission to hunt on the land until it should be taken up by individuals and settled. 36. North of the Ohio the same rationale prevailed, and prices for Indian land were kept very low. For example, in the spring of 1805 Dearborn appointed the Indian agent Charles Jahut a treaty commissioner to get cessions of land in the Western Reserve of Connecticut. Jahut was instructed by Dearborn to get one cession, for the benefit of land companies in the reserve, at a fair and just price in line with what the United States was paying at the time, namely, 1 to 2 cents an acre. Dearborn directed the agent to purchase a second tract at not more than 2 cents an acre. 37 As the negotiator of a treaty with the Miamis in September 1809, Governor William Henry Harrison of Indiana Territory rejoiced that the cession would contain upwards of 2.5 millions of acres and will cost less than 2 cents per acre. 38. This, of course, was a far cry from the price of $2 an acre set in the land law of 1800 for sale of the public domain in fee simple to white settlers. As time passed and the Indians became increasingly reluctant to part with more land, the United States had to increase its offers. This was especially true in the removal period of the late 1820s and the 1830s, when the importance of the cessions to the white population and the adamant position taken by some tribes to cede no more territory combined to hike the prices. The Chickasaws did better than most tribes, for the individual homesteads assigned to the Indians sold for a minimum of $1.25 an acre, and some of them brought more. The unallotted land, some 4 million acres out of the entire cession of 6,422,400 acres, was sold at public auction under a graduation principle and brought about $3.3 million to the Chickasaw General Fund. 39. Northern Indians, too, steadily asked higher prices for their land, as Cass and Clark noted in 1829. 36 Dearborn to Dinsmore, October 25, 1804. WDLS, Book B, 1920. 37 Dearborn to Jahut, April 2, 1805, Ibid, 6264. 38 Harrison to the Secretary of War, October 1, 1809, Logan Easery, ed., Messages and Letters of William Henry Harrison, 2 volumes, Indiana Historical Collections, Volume 7, 9, 1:358. 39 See the account in Earl M. Gibson, The Chickasaws, 16,066. Page 230. A visible increase is manifest in the value of the consideration given from time to time for cessions of land. By the earlier treaties, a few articles of goods or clothing, specially enumerated, were considered a full satisfaction for the most important purchases. But, by degrees, the system of annuities was introduced, and even the characteristic improvidence of the Indians was compelled to yield something of the present to the future. As the stock of goods in market increased, and that of land diminished, the usual effect was observed in the change of their relative value. Some of the tribes, and particularly the Miamis, now receive an amount in annuities, which bears so considerable a proportion to their numbers, as to enable them, with very little exertion, to procure a support. Probably not less than $150 annually, falls to the lot of each family of that tribe. but the difficulty of procuring cessians is every year increased. The Indians are more and more reluctant to cede, and more anxious to procure high prices for cessians when made. It is not difficult to foresee that the present system must come to a close by its own operation. 40. It is difficult to calculate the total amount paid by the United States for the Indian lands it purchased by treaty. Felix S. Cohen, a close and sympathetic student of Indian affairs, wrote in 1947 that any such calculation would have to take account of the conjectural value of a myriad of commodities, special services, and tax exemptions, which commonly took the place of cash, and he offered a conservative estimate that placed the total price of Indian lands sold to the United States at more than $800 million. Was this a fair price? Cohen replied, "The only fair answer to that question is that except in a very few cases where military duress was present, the price paid was one that satisfied the 40 report of February 9, 1829, 1718. Representative James M. Wayne, of Georgia, in the debates over Indian removal in 1830, stressed the increasing costs of land cessians and echoed Cass's and Clark's opinion that the heavy costs would bring down the whole system. At the end of a long speech on March 24, 1830, he listed as well the incidental expenses of treaty making. "Sir, I invite gentlemen in the opposition to look at our expenditure, year after year, for holding treaties with Indians for cessians of lands, under our present system, and they will be startled at the sums paid to commissioners, secretaries, interpreters, messengers, bakers, and butchers, for the erection of buildings, council houses, mess houses, kitchens, and cabins, for corn, beef, pork, and salt, not alone for the subsistence of the Indians and their families while the treaty is in progress, but for their support on their return home. And then come those hundreds of contingencies for horses for expresses and their riders, stationery, pipes, tobacco, paint, and ammunition, and medical expenses, with a swarm of et-ceteras, the cost of which is never known until a demand is made for payment, and the reserve of all these abuses is a heavy item of goods for distribution to the Indians." Register of Debates in Congress, 6:1131. Page 231. Indians. Whether the Indians should have been satisfied and what the land would be worth now if it had never been sold are questions that lead us to ethereal realms of speculation. 41. Without exact records or methods of determining what counted as payment, ethereal realms of speculation are tempting. One legal scholar recently estimated that the United States took 2 billion acres of land claimed by Indians, half of which was purchased by treaty or agreement for less than 75 cents an acre. The rest, he said, was unilaterally confiscated by the federal government without payment, or the title was simply extinguished without formal action. He asserted that in 1970 the lands thus purchased, confiscated, or otherwise acquired by the United States had a value of over $560 billion exclusive of improvements and structures. 42. A new study, moving beyond mere speculation, draws upon the deliberations of the Indian Claims Commission to assess what the United States paid for Indian lands. Using the Central and Northern Great Plains as a case study, the author concludes that the United States paid the Indians $29,977,015 for 290 million acres of land in that region, Oregon, an average compensation of about 10 cents an acre. 43. In the face of wide discrepancies in appraisals and accounting, the Indian Claims Commission decided over the years that the sums paid. 41. Felix S. Cohen, original Indian title, In the Legal Conscience, Selected Papers of Felix S. Cohen, ed. Lucy Kramer Cohen, 28183. The article was originally published in 1947. The $800 million figure has been picked up by others. See President Truman's remarks on signing the Indian Claims Commission Act, August 13, 1946, Public Papers of the Presidents of the United States, Harry S. Truman, 1946, 414, H. D. Rosenthal, Their Day in Court, A History of the Indian Claims Commission, 7. 42. Russell Lawrence Barsh, Indian Land Claims Policy in the United States, North Dakota Law Review 58, 78. Barsh offers no careful accounting of land values at the time of purchase and no figures dealing with the varied payments made for the land. Today's value of lands, of course, is not directly pertinent to a determination of what the lands were justly worth at the time of cession. 43. David J. Wishart, Compensation for Dispossession, Payments to the Indians for their lands on the Central and Northern Great Plains in the 19th Century, National Geographic Research 6, 94109. The article, replete with tables, maps, and charts, is a pioneer attempt to use the data gathered by the Indian Claims Commission for a sizable area, but the complications in accounting and the legal maneuvering in the cases raise questions about the historical accuracy of the Commission's findings. For a detailed account of the legal complications in the Sioux claims under the Fort Laramie Treaty of 1868 and the Many-Penny Commission Agreement of 1876, see Edward Lazarus, Black Hills, White Justice, The Sioux Nation vs. the United States, 1775 to the present. Page 232. The Indians, whether in cash annuities or provision of goods, supplies, and services, did not equal the fair market value of the land at date of cession. A large part of the $818 million awarded by the Indian Claims Commission on petitions from Indian groups for unpaid claims was awarded for grossly inadequate and unconscionable payment for the ceded lands. But Cohen was right in noting that at the treaty negotiations the Indians, after receiving the presents distributed at the council and promises for substantial annuities or other benefits, generally left the council grounds without complaint about the sums. Whatever the treaty commissions finally agreed to in the treaties was monitored carefully in many cases by the Senate, which at times refused to ratify treaties in which it thought there were extravagant costs. The Senate often amended treaties to cut down the size or duration of the payments. More damaging and unconscionable was the failure of the federal government at times to pay the full sums promised in the treaties and to make sure that the goods and services stipulated were of high quality. 44. The question of preemption rights and the nature of Indian title to the land, either in cases of aboriginal title or in title recognized by treaty in reservations set aside for continual Indian possession, was closely attended to. The federal government feared that the absolute title to the land it claimed would be transferred to Indian tribes or to individual Indians, who might then dispose of the lands contrary to the interests of the United States. But pragmatic decisions sometimes overrode such views, notably in the removal treaties signed in the 1830s with the 5 civilized tribes, to whom, in exchange for their land in the southeastern United States, the government conveyed other land west of the Mississippi in fee simple to them and their descendants, to inure to them while they shall exist as a nation and live on it. The revision of the Chickasaw Removal Treaty assigned allotments to individual Indians in fee simple. 45. 44. The records of the Indian Claims Commission indicate, although sometimes unclearly, that the sums agreed upon did not always find their way into the hands of the Indians, and the corruption in supplying goods to the Indians, especially in the 1850s and 1860s, was one of the forces that sparked an aggressive Indian reform movement after the Civil War. 45. Kapler, 2:311. Page 233. There were a great many varieties of land transfers in the treaties beyond the simple sale or cession of lands to the United States to be added to the public domain and made available to white settlers. There were the exchanges of land that were at the heart of the Indian removal policy of the 1830s, the giving up of eastern land by Indians in return for lands assigned to them west of the Mississippi. There were sales of lands by the Indians to private land companies that claimed preemptive rights in New York State and in the Western Reserve of Connecticut in Ohio, in which transactions the United States commissioners acted merely as witnesses in order to signify the legal approval of the federal government. Many treaties reserved areas of land within the cessions for individuals and for bands of Indians who would not agree to remove from their ancestral homes. Later treaties provided for individual allotments of land when the tribal holdings were ceded, in the government's attempt to force the Indians into white land holding patterns. After the Civil War, some treaties provided that the beneficiaries of the cessions would be railroad corporations, not the public domain, a practice that ran afoul of Congress. While on the surface the treaties were contracts between two parties bargaining in good faith, in many cases the dominant power of the United States made it possible for the federal government to force its will upon the dependent Indians, in regard to both lands transferred and payments for them. But the Indians had an interest in the land cessions, too. As the fur trade declined, land was the commodity by which Indians could buy the manufactured goods of white society that had become necessities for them and by which they could obtain food and clothing needed to avoid severe suffering or starvation. Land was used to cancel debts to traders, some of which ran to high figures, but the United States, effectively vindicating its claim to preemption rights, would not allow the tribes to pay the debts directly. All land transfers had to be done by formal treaty, and some treaties were simply commercial documents, not diplomatic ones. By treaty the United States acquired other land rights besides land cessions to provide for white settlement. Treaties provided land for trading posts and military posts, roads, railroad rights-of-way, telegraph lines, and inns and ferries, often with provisional stipulations that allowed the United States to determine the precise places at its pleasure. Thus the treaty that Indian agent Thomas Fitzpatrick made with the Comanches, Kiowas, and Apaches at Fort Atkinson in 1853 included. Page 234. The expansive clause, the aforesaid Indian tribes do also hereby fully recognize and acknowledge the right of the United States to lay off and mark out roads or highways, to make reservations of land necessary thereto, to locate depots, and to establish military and other posts within the territories inhabited by the said tribes. 46. The land cessions and payments for them were at the heart of the treaty system, and ramifications of those transactions still abide. 46 Ibid. 600. Page 235. Chapter 10. Treaties in the Expanding West. The removal treaties of the 1830s, federal officials had hoped, would for the most part end the Indian problem. By 1840, lands east of the Mississippi had been freed of Indian title, except for a few small spots, and most of the eastern tribes had been located behind what some historians have labeled the permanent Indian frontier. Then, suddenly, the ease and tranquility that the Indian office had foreseen was seriously disrupted. Dramatic events in the 1840s overturned the premises upon which American Indian policy had been based. The concept of a north-south line separating white settlement from Indian country was shattered, and before long the barrier itself was physically destroyed. In 3 short years Texas, the Oregon country, and the Mexican cession were added to American territory, and the relationship between the United States and the Indians was radically changed. 1. With the territorial additions the federal government accepted responsibility for new groups of Indians, and old policies were stretched to try to make them fit the new situations. Increasingly, makers of Indian policy relied on reservations, in many cases small parcels of land reserved out of the original holdings of the tribes or bands, which were intended as a temporary expedient to prevent clashes between resident. 1. For a general account of the development of Indian policy in these new regions, see Francis Paul Prucha, The Great Father, the United States Government and the American Indians, 2 volumes, 1:315409. I have used some sections from this work in the present chapter. Page 236. Indians and oncoming white settlers, and to provide secure areas in which the humanitarian programs for acculturating Indians to white society could be carried out. The government conceived of no way to deal with the new problems except by the traditional method of formal treaties. The decade of the 1850s rivaled the 1830s in the number of treaties concluded and would have outstripped the earlier decade if all the treaties negotiated had been ratified. At the end of 1856, Commissioner of Indian Affairs George W. Manypenny reported, since the 4th of March, 1853, 52 treaties with various Indian tribes have been entered into. 32 of these treaties have been ratified, and 20 are now before the Senate for its consideration and action. In no former equal period of our history have so many treaties been made, or such vast accessions of land been obtained. He provided a threefold classification of the treaties: first, treaties of peace and friendship; second, treaties of acquisition, with a view of colonizing the Indians on reservations; and third, treaties of acquisition, and providing for the permanent settlement of the individuals of the tribes, at once or in the future, on separate tracts of lands or homesteads, and for the gradual abolition of the tribal character too. Treaty making in the 1850s, however, ran into a good many snags. The Indian Office and the treaty commissioners appointed were not well acquainted with the newfound Indians and made mistakes in trying to determine tribal organization and the chiefs with whom the United States should deal. For Indians in the Southwest there was no consensus about the status of their land titles under Spanish rule and what land status they carried over under American rule. And, for a variety of reasons, the Senate delayed and in some cases refused outright to ratify certain treaties, reducing to naught the efforts of commissioners to set up arrangements that would regularize the Indians' relations with the United States and protect their land rights. Despite some successes, the treaty system seriously deteriorated during the decade. 2 CIAAR, 1856, Serial 875, p. 571. Page 237. Treaties with the Plains Indians. The heavy migration to Oregon and California passed directly through Indian territories, and the consequent destruction of buffalo and grazing lands forced the Indians to seek new hunting grounds and increased intertribal irritations. To meet the crisis, federal officials sought to free the middle section of the plains of its Indian inhabitants by moving them to two great colonies, one already well established in the south as the Indian Territory and a similar one to be laid out north of the lines of travel. Point 3. Meanwhile, the Indians were to be kept at peace by compensation for the damage done by the whites traveling to the Pacific. Commissioner of Indian Affairs William Medill planned a grand meeting with the Plains Indians, and he sent a proposal to the Secretary of the Interior in June 1849. Noting the damage done by westering emigrants to the Indians' means of subsistence, he wrote, "Under these circumstances, whatever may be the nature and extent of their title to the lands, I think it would be sound policy to make them some annual compensation for the right of way through the country, and, in consideration of the destruction of the buffalo therein." He recommended payment in goods, stock, agricultural implements, and sea, which would be more useful and far better for them than money, and he urged that the Indians be encouraged to resort to agricultural pursuits in order that they may be prepared to sustain themselves when the buffalo shall have so far disappeared as no longer to afford them a certain or adequate means of subsistence. The Indians, too, should be bound to remain in the districts claimed by each of their tribes. To accomplish all this a treaty of friendship with the tribes seemed necessary. In February 1851 Congress appropriated $100,000 for expenses of holding treaties with the wild tribes of the prairie, and for bringing delegates to the seat of government for building on Medill's plan, the new Commissioner of Indian Affairs. 3. See the statement of William Medill in CIAAR, 1848, Serial 537, p. 390. Similar statements appear in the Commissioner's reports for 1849, 1850, and 1851. 4. Medill to Thomas Ewing, June 15, 1849, Records of the Office of Indian Affairs, National Archives Record Group 75, Report Books, 6:19395, 9 Stat 572. Page 238. Orlando Brown, sent instructions to Thomas Fitzpatrick, agent of the Upper Platte Agency and longtime trader, guide, and friend of the Indians. Together with David D. Mitchell, Superintendent of Indian Affairs at St. Louis, Fitzpatrick was directed to assemble the Indians and negotiate a treaty with them. As a further step, to impress the Indians of the prairies with some just idea of our greatness and power, and to inspire them with a proper degree of respect for the government, Brown instructed him to bring a delegation of chiefs to Washington. 5. Out of all of this came the Treaty of Fort Laramie of 1851, drawn up at one of the most dramatic of all Indian councils. Fitzpatrick and Mitchell sent out runners to call the Indians to the council, and large delegations arrived: Sioux, Cheyennes, Arapahoes, Crows, Assiniboines, Gros Ventres, Mandans, and Arikaras, some 10,000 Indians in all, who finally encamped along the Platte at Horse Creek, 36 miles downriver from Fort Laramie, where there was space and forage for the large assembly. Because there had been a long history of bitter hostility between some of the tribes present, there was question whether the small United States military force of some 200 troops could maintain peace, but the Indians behaved in an orderly fashion throughout the council. The assembly of Americans was impressive, too. The Army officers included Colonel Samuel Cooper, Adjutant General of the Army, and the Secretary of the Council was A.B. Chambers, editor of the Missouri Republican, who was assisted by B. Gratz Brown. Father Pierre-Jean de Smet, the famous Jesuit missionary, was on hand. In the slowly paced and formal council proceedings, Superintendent Mitchell outlined the proposals of the United States. His remarks were translated by the interpreters for the various tribes, and after counseling among themselves, the Indians replied. Despite the resistance of the Sioux, who lived in bands, each with its own chief or chiefs, Mitchell insisted on appointing a single chief over all the Sioux. Finally, on September 17 the treaty was signed, and then on September 20, the long-awaited supply train with goods for the Indians arrived. With the distribution of goods the next day, the council dispersed. 6.5 Brown to Fitzpatrick, August 16, 1849, OIALS, 42:29496. 6. There is an excellent account of the drama of the event in Leroy R. Hafen, Broken Hand, The Life of Thomas Fitzpatrick, Mountain Man, Guide, and Indian Agent, Rev. ed. 281,301. A description of the council by A.B. Chambers is in the Missouri Republican, October 6, 17, 2224, 26, 29, and page 239. The treaty document was brief. The Indians agreed to cease hostilities among themselves and to make a lasting peace, and to that end the treaty spelled out in detail the boundaries of each of the tribes. The Indians recognized the right of the United States to establish roads and military posts in their territories, and they promised to make restitution for wrongs committed against whites lawfully passing through their lands. In return, the United States agreed to protect the Indians from white depredations and to pay annuities of $50,000 a year for 50 years, the annuities to be paid in provisions, merchandise, domestic animals, and agricultural implements, in such proportions as may be deemed best adapted to their condition by the President of the United States. 7. Superintendent Mitchell reported optimistically on the treaty, noting that the presents distributed at the council satisfied the Indians for all past destruction of buffalo, grass, and timber by the emigrating whites. He felt a need, however, to justify the large annuity. $50,000 for a limited period of years is a small amount to be distributed among at least 50,000 Indians, he wrote to the Commissioner of Indian Affairs, especially when we consider that we have taken, or are rapidly taking away from them all means of support, by what may be considered a partial occupancy of their soil. On the score of economy, to say nothing of justice or humanity, I believe that amount would be well expended. Mitchell saw no alternative to providing means for the Indians to turn to agriculture and grazing, and he thought that 50 years would be enough time to give the experiment a fair trial, and solve the great problem whether or not an Indian can be made a civilized man. 8. President Millard Fillmore submitted the treaty to the Senate on February 17, 1852, and the Senate Committee on Indian Affairs re. November 2, 9, 23, 30, 1851, typed transcript furnished by Raymond Damalley. There is a perceptive account of the ritual aspects of the council proceedings in Raymond J. Damalley, touching the Penn, Plains Indian Treaty Councils in Ethno-Historical Perspective, in Frederick C. Lubke, ed., Ethnicity on the Great Plains, 4146. See also the accounts of the Council, based largely on the Missouri Republican articles, in Leroy R. Haffen and Francis Marion Young, Fort Laramie and the Pageant of the West, 1834-1890, 17796, and Burton S. Hill, The Great Indian Treaty Council of 1851, Nebraska History 47, 85110. 7 Kapler, 2:59496. 8 Mitchell to Luke Lee, November 11, 1851, CIAAR, 1851, Serial 613, pages 28990. Page 240. Ported it without amendment on April 19. But when the Senate next considered the treaty on May 24, it amended the treaty and began the process that eventually seriously clouded the status of the document. It first unanimously struck out the provision of paying the annuity for 50 years and then attempted to set a different duration. It voted down motions to substitute 25 years or 20 years and finally agreed on the term of 10 years with the right to continue the same at the discretion of the President of the United States for a period not exceeding 5 years thereafter. So amended, the treaty was approved by a vote of 44 to 7.9. The Senate, clearly, was not convinced by Mitchell's arguments. No doubt it felt that $2.5 million over 50 years was too much for a treaty in which no land cessions were made, and the new policy of strictly limiting the duration of annuities ran counter to a term as long as 50 years. It was hoped the civilizing provisions would have taken effect sooner than that point. 10. Following the Treaty of Fort Laramie, Agent Fitzpatrick accompanied a delegation of chiefs to see Washington and the well-developed eastern sections of the nation. The Indians were feted at St. Louis and at other places along their route, and in January 1852 they had a formal meeting with President Fillmore in one of the parlors of the White House. 11. The next year, Fitzpatrick by himself negotiated a treaty at Fort Atkinson on the Arkansas River in Kansas with the Comanche, Kiowa, and Apache Indians living south of the Arkansas River. With considerable difficulty, he established communication with the Indians and at the end of July 1853 signed a treaty with them similar to that of Fort Laramie 2 years before. An annuity of $18,000 worth of goods for 10 years, subject to a 5-year extension, was provided. A final article stipulated that if the United States decided it would be wise to establish farms among the Indians for their benefit, the annuities could be changed into a fund for that purpose. The Indians were hesitant to allow routes and military posts within their country, and Fitzpatrick felt that the concessions finally made were extremely fortunate, for they could obviate the need for new treaty arrangements when transportation routes through the Indian lands needed to be developed. 12. 9 Senate Ex. PROC, 8:36869, 382, 38,890. 10 For a discussion of the problems in the ratification of the treaty, see pages 44,042 below. 11 See the account in Haffen, Broken Hand, 3027. 12 Kapler, 2:600602, Fitzpatrick to A. Cumming, November 19, 1853, CIAAR, 1853, Serial 690, pages 36,263. Page 241. The Many Penny Treaties. There still remained a need to politically organize the Central Plains and to provide lands for white settlers already pressing upon the eastern boundary of the Indian country beyond Missouri and Iowa. The Kansas-Nebraska Act of May 30, 1854, which set up 2 territorial governments, however, did not of itself free the lands in those new territories of their Indian title. That difficult task fell to Commissioner of Indian Affairs Many Penny, a man who believed that for the Indians' own sake the western territories should be organized and the Indians moved out of the way of white emigrants. Under a congressional authorization of March 3, 1853, which provided for negotiations with Indian tribes west of Missouri and Iowa, Many Penny moved ahead energetically to fit the border tribes into the new order of things. He visited them, held councils with them, and tried to get them to agree to cede their lands and move to the southern or northern colonies, but the Indians would have none of such absolute removal. All they would grant was cession of some of their lands if they were allowed to keep small reserves in the areas where they were then situated. In a series of 9 treaties made with the Indian chiefs in Washington between March 15 and July 5, 1854, Manypenny got what he could from the Otos and Missouris, Omahas, Delawares, Shawnees, Peorias, Piankashaws, Wees, and Miamis. These tribes held some 15 million acres, all of which were ceded except for 1,342,000 acres retained as reduced reservations. 13. The treaties were much alike, and the Oto and Missouri Treaty of March 5 is a good example. 14. It provided for the cession of the tribe's holdings west of the Missouri River and designated a reduced area within the old reservation to which the Indians agreed to remove within a year. A significant characteristic of this treaty, as of all these treaties. 13 CIAAR, 1853, Serial 690, p. 251, 10 STAT 238, CIAAR, 1854, Serial 746, pages 21314, Royce, Sessions, Plate 41, area numbers 31415, Plate 27, area numbers 31618, 32430. For data on these treaties, see Appendix B, NOS 25760, 26266. 14 Kapler, 2:60811. Page 242. Was the provision for allotting lands in the newly designated reserve in farm-sized plots to individual Indians. The President was given discretionary authority to survey the land, set it off in lots, and assign the lots in specified amounts to all Indians who were willing to avail of the privilege and would locate on the lots as a permanent home. There were to be regulations for bequeathing the land and restrictions on its lease or sale. If the Indians left the land to rove from place to place, their patents would be revoked and their annuities withheld until they returned and resumed the pursuits of industry. Any residue of land after all the Indians had received an allotment was to be sold for the benefit of the Indians. In return, the United States agreed to pay the Otos and Missouris annuities on a sliding scale from $5,000 to $20,000 over the next 38 years. The President would decide what proportion, if any, was to be paid in money and what proportion expended for education and other means of acculturation. Another $20,000 was granted to help the Indians to move, subsist for a year, and establish themselves on their farms. Moreover, the government would build a grist and sawmill and a blacksmith shop and for 10 years would employ a miller, a blacksmith, and a farmer. Annuities would be withheld from anyone who drank liquor or brought it into the Indian lands. Thus were these Indians, who had been subjected to the civilizing policies of the government for a number of decades, to be finally incorporated into white society. The continued Indian residence in Kansas and Nebraska, however, was not intended to impede the westward movement of the whites, for the Indians agreed to allow all the necessary roads and highways, and railroads, which may be constructed as the country improves to run through their lands, with just compensation to be paid in money. 15. The policy of allotments followed in these treaties did not work out well, for aggressive settlers and speculators desired the choice lands still in the hands of the Indians and paid little attention to Indian rights. The decade of sectional conflict in Bleeding Kansas further aggravated the situation of the hapless Indians, and the federal government failed to protect them. 16. 15 clauses in the various treaties pertain to the special conditions of each tribe. The treaties with the Delawares and the Shawnees were the most complex. Most of the treaties made land grants to missionary societies that maintained schools for the Indians. These treaties were approved by large majorities in the Senate. See Senate Ex. Proc. Volume 9. 16 See Manypenny's complaints about the mistreatment of the Indians in CIAAR, 1856, Serial 875, p. 572. A detailed and critical account of the conflicts over Indian lands. Page 243. The California Indians. For the numerous small bands of Indians in California, the treaty system failed altogether, showing both the difficult problems that faced the treaty commissioners and the inability of the federal government to substitute any effective alternative policy to provide protection for the Indians from the onrush of miners and agricultural settlers. 17 Federal officials were especially ignorant concerning the California Indians, and the 3 men sent to California in 1850 to negotiate treaties with the Indians shared their ignorance. As a group, the commissioners signed a treaty in March 19, 1851, with Indians whom they took to be leaders of 6 tribes in the San Joaquin Valley, and on April 29 they made another treaty with 16 more tribes. Later, in order to speed the work, the commissioners split up, each moving to a designated region to continue the treaty making. By January 7, 1852, the commissioners and the Indians had signed 18 treaties. 18. In Kansas after 1854 is in Paul Wallace Gates, 50 million acres, conflicts over Kansas land policy, 1854-1890. What happened to the Indian reserves in Kansas is described in H. Craig Minor and William E. Unruh, The End of Indian Kansas, A Study of Cultural Revolution, 1854-1871. For the complicated story of the indefinite land grants made to certain Wyandot Indians when they moved from Ohio, see Homer E. Sokolovsky, Wyandot Floats, Kansas Historical Quarterly 36, 241,304. The pertinent Wyandot treaties are in Kapler, 2:67781, 960, 963. 17 Indian policy in California has been well documented in 2 older works, William H. Ellison, The Federal Indian Policy in California, 1846-1860, Mississippi Valley Historical Review 9, 3767, and Alban W. Hoops, Indian Affairs and Their Administration, with special reference to the Far West, 1849-1860, 3568. The story is told again in George E. Anderson and Robert F. Heiser, Treaty Making by the Federal Government in California 1851-1852, in George E. Anderson, W. H. Ellison, and Robert F. Heiser, Treaty Making and Treaty Rejection by the Federal Government in California, 1850-1852, 136. 18 The Instructions of A. S. Lowry to Reddick McKee, George W. Barber, and O. M. Wozencraft, October 15, 1850, are in Senate Ex. Document Number 4, 33 Special Session, Serial 688, pages 89. The various reports of the 3 commissioners and journals of their activity appear in the same Senate document. See also Alban W. Hoops, ed., The Journal of George W. Barber, May 1 to October 4, 1851, Southwestern Historical Quarterly 40, 14,553, and 40, 24,761, and Chad L. Hoops, Reddick McKee and the Humboldt Bay Region, 1851-1852, California Historical Society Quarterly 49, 195,219. The treaties are printed in Kapler, 4:10811128. A. Page 244. In the treaties the Indians recognized the United States as sole sovereign over the land ceded by Mexico in 1848, placed themselves under the protection of the United States, and agreed to keep peace. They ceded their claims in return for definite reservations specified for them. Subsistence in the form of beef cattle was to be provided while they were moving and settling on the reservations, and the government promised to pay annuities in the form of clothing, agricultural implements, and livestock, and to provide farmers, blacksmiths, and school teachers for a period of years. The 18 treaties set aside 11,700 square miles of land, about 7.5% of the state. 19. The 3 commissioners did their work rapidly, and they acted without the detailed knowledge of the Indians that modern anthropologists can provide. Although 139 tribes or bands were represented in the 18 treaties, an enumeration in 1926 indicated that more than 175 tribes were not included in the treaties. 30 years later, a study conducted under Indian Claims Commission litigation reported that of the 139 signatory groups, 67 were identifiable as tribelets, 45 were merely village names, 14 were duplicates spelled differently without the commissioners realizing it, and 13 were either personal names or unidentifiable. 20. In the end, the irregularities did not matter, for the Senate, without considering any amendments, on July 8, 1852, unanimously rejected each of the 18 treaties. 21. There is some question whether, even at the beginning, a majority of the Senate had intended to authorize treaties of cession rather than mere treaties of peace and friendship, for there was considerable feeling in Congress that the California Indians had no land titles and therefore that no treaties were needed to extinguish them. Other aspects of the treaties, too, militate against their ratification. There was strong opposition from Californians, who saw large copy of the Senate printing of the treaties, when it lifted the injunction of secrecy on them on January 18, 1905, is in documents, Roll 8, frames 41,045. 19. The calculations on areas ceded are those of Ellison, Federal Indian Policy in California, 57, and have been generally accepted. The map of California in Royce, Sessions, Plate 7, purports to show the land ceded and the reservations established, but the map is based on faulty information and assumptions. Robert F. Heiser, Treaties, in Handbook of North American Indians, Volume 8, California, ed. Robert F. Heiser, 7034. 20. Heiser, Treaties, in Handbook, 8:703. 21. Senate Ex. PROC, 8:39094, 40,910, 41,720. The Senate resolutions are printed without comment in the rejected California treaties, Indian Historian 6, 2325, and in Kapler, 4:108185 note. Page 245. Regions to be snatched from their grasp and reserved for the Indians, whom they despised. Furthermore, the costs of the treaties had grown to nearly $1 million, far beyond the total of $50,000 that had been appropriated. The commissioners, working on the spot, had felt it necessary to contract for large numbers of cattle to feed the Indians, and they also provided for further subsistence and annuities in the treaties. The new Superintendent of Indian Affairs in California, Edward F. Bale, argued strongly for the treaties, and Commissioner of Indian Affairs Luke Lee agreed. But Lee was aware of peculiar circumstances with regard to the treaties. He wrote to Secretary of the Interior Alexander H. Stewart in transmitting the documents. In considering this important and perplexing question, it should not be forgotten that our Indian affairs in California, like everything else pertaining to that country, are in an extraordinary and anomalous condition. Those entrusted with their management have had to contend with manifold embarrassments and difficulties. That they have made mistakes or fallen into error is by no means a matter of surprise. It would be strange if they had not. Their conduct in some respects has been improper. I allude particularly to their making contracts for fulfilling treaties in advance of their ratification. In this they certainly acted without authority. Secretary Stewart wanted a special investigation made about the treaties, but he was afraid that delay would be dangerous and recommended to the President that they be submitted to the Senate for its decision. 22. The federal government attempted then to make some provision for 22. Beale's report to Lee, May 11, 1852, Lee's report to Stewart, May 14, 1852, and Stewart to the President, May 22, 1852, are in Senate, Sen 32 BC2, they are printed in a note in Kapler, 4:108589. The question of the non-ratification by the Senate is thoroughly treated in Harry Kelsey, The California Indian Treaty Myth, Southern California Quarterly 55, 22,538. Kelsey considers and rejects the idea that there was a conspiracy by the Senate to keep information about the treaties secret and argues for the importance of the question of Indian land titles in the rejection of the treaties. A strong statement about California opposition to the treaties is William H. Ellison, Rejection of California Indian Treaties, A Study in Local Influence on National Policy, Grizzly Bear 37, 45, 86, 37, 45, Supplement 7, 37, 67, reprinted in Anderson, Ellison, and Heiser, Treaty Making and Treaty Rejection, 5070. A good view of California's sentiment against the treaties is provided in majority and minority reports of the Special Committee to inquire into the treaties made by the United States Commissioners with the Indians of California, and Senate Committee debate on appropriation of funds for aid to Indians of California provided by the three treaty commissioners, printed Ibid, 3749, 71122. Page 246. The California bands outside the treaty system, and a number of small reservations were established, but the Indians had no clear title to the land, were beset by aggressive white land seekers, and lived on a kind of government dole on the few spots saved for them. Whatever the difficulties, the United States clearly decided to forego any more treaties with these rapidly disappearing Indians. In 1864, when a purported treaty of peace and friendship between the United States and the Indians of Hoopa Valley was sent to Washington by the Indian agent Austin Wiley, the Commissioner of Indian Affairs replied that the government did not contemplate any more formal treaties with the California tribes. If any agreements were made with the Indians, the papers should simply be signed by the chiefs to show their commitment and then forwarded to the Indian Office. 23. Treaties in the Oregon Country. In the Oregon Country, early attempts at treaties were hardly more successful than those in California. The territory of Oregon was not created until 1848, 2 years after United States title to the region south of the 49th parallel was recognized by Great Britain. The territorial governor was eager to remove the Indians from the areas of settlement, and the territorial delegate in Congress pushed through a law in 1850 that called for the appointment of commissioners to negotiate treaties with the Indians of Oregon for that purpose. The law also authorized a superintendent of Indian Affairs distinct from the governor, a position to which Anson Dart of Wisconsin was appointed. 24. On October 25, 1850, 3 commissioners, including the new territorial governor, were appointed to negotiate treaties with the Indian tribes in Oregon Territory. The goal of the government, they were told, was to free the land west of the Cascades entirely of Indian title and to move all the Indians to some spot to the east. Their instructions made it clear that the payments stipulated for the ceded lands were to be in objects beneficial to the Indians: agricultural assistants, blacksmiths and mechanics, farmers to teach cultivation, physicians, and ample. 23. William P. Dole to Wiley, October 3, 1864, CIAAR, 1864, Serial 1220, p. 282. 24-9 STAT 437, Lee to Dart, July 20, 1850, CIAAR, 1850, Serial 587, pages 14851. Page 247. Provision for the purposes of education and that no part should be paid in money. 25. The Indians, however, were adamant in refusing to accept removal from their homelands, and the commissioners were forced to outline an alternative. It will be impossible to remove the Indians of Willamette and Lower Columbia valleys, without a resort to force, nor do we think it very desirable to do so. As before stated, they are friendly and well disposed, they live almost entirely by fishing, and the wages they receive from the whites for their labor. They possess little or no skill as hunters or warriors. And to remove them from their fisheries and means of procuring labor from the whites would, in our opinion, ensure their annihilation in a short time, either from want or by the hands of their more warlike neighbors. General satisfaction we believe would be felt by the Indians and the citizens to allow them small reservations of a few sections and a portion of their fishing grounds. 26. This is what the commissioners provided in the 6 treaties they signed with the Indians in April and May 1851. Then, when Congress directed that all treaty making be carried on by regular officers of the Indian Department, not by special commissioners, Dart continued the negotiations by himself. During the summer and fall of 1851 he signed 13 treaties with Indian bands. 27. None of the 19 treaties signed by the commissioners and by Dart were ever ratified. When President Fillmore submitted the treaties to the Senate on July 31, 1852, he transmitted as well a letter from Secretary of the Interior Stewart, in which Stewart noted the objection of the Commissioner of Indian Affairs to the provisions that allowed reservations near the white settlers. But Stewart wrote, "I have carefully examined the correspondence of the commissioners, and the treaties, and 25 A.S. Lowry to J.P. Gaines, Alonzo H. Skinner, and Beverly S. Allen, October 25, 1850, Ibid, 14,547. 26 Commissioners to Luke Lee, February 8, 1851, quoted in Hoop's Indian Affairs and Their Administration, 7,879. The commissioners made the same point when they submitted the treaties containing provisions for reserved lands, contrary to the directions they had received. See Commissioners to Lee, April 19 and May 14, 1851, CIAAR, 1851, pages 46,772. 27 The treaty making is discussed in detail in C. F. Cohen, The First Stage of the Federal Indian Policy in the Pacific Northwest, 1849-1852, Oregon Historical Society Quarterly 22, 4665. In an appendix, pages 6589, Cohen reprints the report of Dart to Lee, November 7, 1851, transmitting the treaties. Also reprinted there are the few treaties that are extant. Some of these treaties appear in documents, Roll 8. Page 248. Have come to the conclusion that if some of their provisions are objectionable, they are greatly overbalanced by the positive benefits to be derived from others. By these treaties the Indian title to a very large and valuable territory is extinguished on terms beneficial to the Indians and advantageous to the United States. Moreover, he argued, the Indians would not sign a treaty that demanded their removal to another area. 28. The treaties were reported by the Senate Committee on Indian Affairs without amendment on August 31 and then were simply tabled, never to be considered again. 29 The failure to eliminate the Indians completely from west of the Cascades by providing residual reservations for the tribes, of course, played an important part, for in this sense the treaties failed to accomplish what the congressional directive had stipulated. Some of the treaties, too, were negotiated with mere remnants of once more populous tribes. The Willapa band of Chinooks, with whom Dart signed a treaty on August 9, 1851, for example, had only 2 male survivors and a few women and children. And the cost of the annuities may have been another point of objection. 30 But without treaties, there was no firm settlement of the Indian problems facing the government in Oregon. Meanwhile, increasing numbers of whites moved into the territory, seeking the rich lands. In the summer of 1853, Joel Palmer, an Oregon pioneer, replaced Dart as Superintendent of Indian Affairs, and he initiated a new series of treaties. He began with a treaty of cession with Rogue River Indians at Table Rock on September 10, 1853, which was ratified on April 12, 1854.31. With this success behind him, Palmer proceeded to negotiate a series of treaties between September 19, 1853, and December 21, 1855, with other tribes along the coast and with tribes in central Oregon that eliminated Indian title over much of the area between the Cascades and the coast, as well as a sizable section of the interior. 32. 28 Stewart to the President, July 30, 1852, Senate, Sen. 32 BC 4. 29 Senate X. PROC, 8:43032, 452. 30 Cohen, First Stage, 59, 65. 31 Kapler, 2:6035, Senate X. PROC, 9:236, 28,788. The Indians agreed to a Senate amendment on November 11, 1854. Palmer had not been instructed by the Indian Office to negotiate treaties, but the Commissioner of Indian Affairs, nevertheless, approved the treaty, and President Franklin Pierce submitted it to the Senate. See Charles E. Mix to R. McClelland, January 24, 1854, in Senate, Sen. 33 BC 4. 32 See Treaties NOS 25,556, 27,072, 275, 286, and 293 in Appendix B. The areas ceded are shown in Royce, Sessions, Plates 8 and 51, Area NOS 312, 313, 343, 344, 352, 369, 401. C. F. Cohen, The Adoption of the Reservation Policy in the Pacific Northwest, 1853-1855, Oregon Historical Society Quarterly 23, 227, deals with the treaty making in Oregon and Washington. See also Terence O'Donnell, An Arrow in the page 249. The Palmer treaties fitted well into the pattern established in the 1850s. There was little indication in them that two sovereign equals were negotiating. For lack of other acceptable and established procedures, the treaties were the vehicle chosen to accomplish what the United States government wanted as it reacted to cries from Western settlers and to the philosophical principles dominant in government circles. The Indians were to be moved out of the way of the whites, not, as in the case of the removal of the eastern tribes, to open spaces in the west, but to limited reserves within their old, more extensive territorial claims or to other specified locations within the territory. Most of the treaties were made with confederated tribes and bands, and often more or less arbitrary grouping for convenience. In all of them the chiefs and headmen of these bands acknowledged their dependence on the United States and promised to stay on friendly terms with the citizens, sometimes consenting to submit to, and observe all laws, rules, and regulations which may be prescribed by the United States for the government of said Indians. They agreed, moreover, to grant rights of way through their lands for roads and railroads. All claims of the Indians to lands were given up in return for small reservations within their old limits, but most of the Palmer treaties included a blanket agreement to move from these reserves to other locations selected by the government should the President at any time believe it demanded by the public good and promotive of the best interests of said Indians. All the treaties spoke specifically of civilization and had the usual provisions for annuity payments in goods conducive to that end, for land in severalty for those Indians willing to avail themselves of the privilege and who will locate thereon as a permanent home, and for blacksmith shops, hospitals, schools, and prohibition of liquor. Although government officials no doubt rejoiced in the framework of existence for the Indians envisaged in the treaties, the negotiations were in fact a nearly complete capitulation of the tribes to superior power. The treaties signed by Palmer with the Indians in 1853, 1854, and early 1855 were ratified and proclaimed in good time. When war broke out in 1855, ratification of the later treaties was delayed. President Pierce submitted them to the Senate on August 9, 1856, where they were referred to the Committee on Indian Affairs. On January 12, 1858. Earth, General Joel Palmer and the Indians of Oregon. Page 250. The new Congress reassigned them to the committee, and in early June the committee reported them without amendment, but not until March 8, 1859, did the Senate finally approve them. By a vote of 39 to 8.33 the delay caused incalculable problems in dealing with the Indians, who did not understand why the benefits promised them in the treaties were not forthcoming. Treaties negotiated by Governor Stevens. The treaties in newly created Washington Territory, which was broken off from Oregon Territory in 1853, were the work of Isaac Ingalls Stevens, the first territorial governor. 34 Stevens, a bright young West Point graduate with service in the Mexican War, was placed in charge of the party surveying the northern route for a Pacific Railroad, and when he arrived in Washington Territory he quickly wrote to the Commissioner of Indian Affairs of the urgent necessity to sign treaties with the Indians west of the Cascades. He was astute enough to realize, however, that it would be impossible to remove the Indians completely because of their attachment to their homelands and their reliance on fishing as a livelihood, so he intended to provide small reserves for them in their present locations. He was interested as well in the eastern tribes of his large territory, and on a trip to Washington, D.C., in 1854, he pushed the idea of treaties with both groups. Congress appropriated $45,000 for negotiating treaties with the Indians of Washington Territory and another $80,000 for a council with the Blackfeet, Grove N. 33 Senate Ex. PROC, 9:28789, 43,637, 44,243, 10:132, 13,536, 287, 43,839, 11:83, 8,788. 34 A scholarly biography of Stevens that pays close attention to his handling of Indian affairs is Kent D. Richards, Isaac I. Stevens, Young Man in a Hurry. Hazard Stevens, The Life of Isaac Ingalls Stevens, 2 volumes, is by his son and must be used with caution because of its favorable bias, but it contains detailed accounts of the Indian councils. There are accounts of Stevens's treaties in Clifford E. Trafzer, ed., Indians, Superintendents, and Councils, Northwestern Indian Policy, 1850-1855. The chapters, written by different individuals, are in general very critical of Stevens. Page 251. Trace, and other wild tribes of Indians immediately within or adjacent to the eastern boundary of Washington Territory. 35. In preparation for treating with the Puget Sound Indians, Stevens organized a commission, which met first on December 7, 1854. The application of a pattern common to the whole nation can be seen in the report of the meeting, for the commission read and discussed the recent treaties that Commissioner Manypenny had signed with the Otos and Missouris and with the Omahas. After considerable discussion of reservations, fishing stations, schools, and farms, George Gibbs, a talented Harvard graduate who was a member of the group, was delegated to prepare a program of a treaty in accordance with the views of the Commission. 36. When the Commission met again 3 days later, a draft of a treaty was ready. Thus prepared, Stevens and his assistants met on Christmas Day with a number of tribes at Medicine Creek at the mouth of the Nisqually River. This was not to be a negotiation but an imposition on the Indians of the treaty provisions Stevens brought with him, for he was highly paternalistic. He spoke to the assembled Indians in a flowery and patronizing manner that expressed his view of relations between the government and the tribes. This is a great day for you and for us. A day of peace and friendship between you and the whites for all time to come. You are about to be paid for your lands, and the Great Father has sent me today to treat with you concerning the payment. The Great Father lives far off. He has many children. Some of them came here when he knew but little of them or the Indians, and he has sent me to inquire into these things. We went through the country last year, learned your numbers and saw your wants. We felt much for you and went to the Great Father to tell him what we had seen. The Great Father felt for his children, he pitied them, and he has sent me here today to express those feelings, and to make a treaty for your benefit. 37. The prepared treaty was explained to the Indians point by point through an interpreter who used the Chinook jargon, which was then. 35 Stevens to George W. Manypenny, December 26 and December 29, 1853, Senate Ex. Document number 34, 33-1, serial 698, pages 67, 1314, Many Penny to Robert McClelland, February 6, 1854, Ibid, 14, 10 Stat 330. A valuable study on the treaties with the Puget Sound Indians is Barbara Lane, Background of Treaty Making in Western Washington, American Indian Journal 3, 211. 36 Documents, Roll 5, Frames 2056. 37 Ibid, Frames 20610. Page 252. Translated for the Indians in their own language. And without objections the Indians signed the treaty on December 26. The provisions were very much like those made by Palmer with the Oregon Indians, but in addition the following special stipulations were made to protect fishing and gathering rights: the right of taking fish, at all usual and accustomed grounds and stations, is further secured to said Indians in common with all citizens of the territory, and of erecting temporary houses for the purpose of curing, together with the privilege of hunting, gathering roots and berries, and pasturing their horses on open and unclaimed lands. Beyond the graduated annuity payments and payments of removal costs, the United States agreed to maintain for 20 years an agricultural and industrial school for the children of the signatory bands and for those of other tribes and bands, at a general agency to be set up for the Puget Sound region. One article of the treaty authorized the President to move the Indians to other reserves or to consolidate them with other friendly tribes into a single reserve and to provide for homesteading on individual lots within the reservation limits. 38. Stevens sent the treaty to the Commissioner of Indian Affairs at the end of the month, noting that he was highly gratified at the result, as in the first instance they desired more reserves and larger reserves. The reserves that were set up had been selected so as not to interfere with existing white claims or the progress of settlement, yet to enable the Indians to continue their traditional subsistence patterns. The provision for later consolidation, Stevens said, would obviate any objection to the number of reserves he had created. The treaty was ratified by unanimous vote of the Senate on March 3, 1855.39. Stevens then proceeded quickly to sign similar treaties with other bands in the Puget Sound area, at Point Elliott on January 22, 1855, at Point No Point on January 26, and at Knee Bay on January 31.40. The governor delivered his prepared message to the Indians, and the chiefs replied, sometimes with strong objections to giving up their lands. But what resistance there was quickly disappeared, and Stevens's paternalism was evident throughout. He told the Indians at Point No Point. 38 Kapler, 2:66164. 39 Stevens to Many Penny, December 30, 1854, Documents, Roll 5, Frames 193,200, Senate Ex. Proc. 9:415, 416, 436. 40 Kapler, 2:66977, 68,285. Extracts from the proceedings at Point No Point are printed in Charles M. Gates, ed., The Indian Treaty of Point No Point, Pacific Northwest Quarterly 46, 5258. Page 253. This paper is such as a man would give to his children, and I will tell you why. This paper gives you a home. Does not a father give his children a home? This paper gives you a school. Does not a father send his children to school? It gives you mechanics and a doctor to teach and cure you. Is not that fatherly? This paper secures your fish. Does not a father give food to his children? Besides fish you can hunt, gather roots and berries. Besides it says you shall not drink whiskey, and does not a father prevent his children from drinking the fire water? Besides all this, the paper says you shall be paid for your lands as has been explained to you. Point 41. These treaties, with that of Medicine Creek, cleared a wide area of land around Puget Sound. Point 42. But the treaties after Medicine Creek, unfortunately, got caught in the ratification delays that affected the later treaties of Palmer with the Oregon bands, and they were not approved by the Senate until March 1859.43. In the summer and fall of 1855 Stevens held three great councils with the Indians of the interior. The first was at Walla Walla in late May and early June, attended by Joel Palmer as well as Stevens and made up of delegations of Walla Walla, Cayuse, Umatilla, Yakima, and Nez Perce Indians. The Indians, aside from the generally friendly Nez Perces, were hostile, and concessions, including special cash annuities for the chiefs, had to be made to get signatures on the treaties. Two treaties were signed on June 9, one with the Walla Wallas, Cayuses, and Umatillas and a second with the Yakimas. Another on June 11 was signed with the Nez Perces. They contain the usual provisions for cessions, reservations, annuity payments, employment of mechanics, articles for agricultural development, and means for moral improvement and education. 44 But the treaties were not the successes that Stevens assumed, for the chiefs were offended by the terms that the whites proposed and could see their crushing effect. The Jesuit missionary Joseph Josette commented, "The chiefs agreed to a mock treaty in order to gain time and prepare for war." 45. 41 Documents, Roll 5, Frame 294. 42 The ceded land and the reservations are shown in Roy's Cessions, Plates 60 and 63, Area NOS 34,556. 43 Senate Ex. PROC, 11:8485. 44 Kapler, 2:694706. There is an excellent account of the council and its background in Alvin M. Josephy, Jr., The Nez Perce Indians and the Opening of the Northwest, 285,332, a shortened version is Josephy, A Most Satisfactory Council, American Heritage 16, 2631, 7076. 45 Quoted in Robert Ignatius Burns, The Jesuits and the Indian Wars of the Northwest. Page 254. While Palmer went down the Columbia to the Dalles for a treaty with the Indians of that area, Stevens in mid-July moved on to Hell Gate on the Clark Fork just beyond the northern end of the Bitterroot Valley in what is now western Montana for a council with the Flathead, Kootenai, and Pendeorile Indians. Here, too, there was much agitation among the Indians as they argued about a proper location for the reduced reservation the government expected them to accept. The deep Indian attachment to traditional homelands was not appreciated by the whites, who looked chiefly at the economic potentialities of a reservation for sustaining the Indians in a peaceful agricultural existence. The Indians signed the treaty on July 16, 1855, with the understanding that the president would survey the region and designate an acceptable spot. 46. The final Grand Council was held in October with the Blackfeet, Flatheads, and Nez Perces at the mouth of the Judith River in present-day Montana. It fulfilled a need, observed by Stevens when he crossed the continent with the Railroad Survey Expedition in 1853, for a treaty of peace between the often warring tribes of the Northern Rockies, and the $80,000 appropriated by Congress in 1854 had been for this purpose. Joel Palmer and Alfred Cumming, superintendent of the Central Superintendency, were named with Stevens as commissioners for the treaty. After some false starts occasioned by a delay in the arrival of goods to be distributed as presents, the council was opened on October 16 by Stevens and Cumming with 3,500 Indians in attendance. Joel Palmer did not come. The treaty, signed the next day, began with a formal statement of perpetual peace between the United States and the Indians, and the signatory tribes agreed to maintain peaceful relations. 79. Hazard Stevens drew the same conclusion, asserting that with one exception the chiefs all signed the treaties as a deliberate act of treachery, in order to lull the whites into fancied security, give time for Governor Stevens to depart to the distant Blackfoot country, where he would probably be wiped out by those truculent savages, and for the Nez Perces to return home, and also for completing their preparations for a widespread and simultaneous onslaught on all settlements. Isaac Ingalls Stevens, 2:61. 46 Kapler, 2:72225. Palmer's Treaty of June 25 appears Ibid, 71,419. A thorough critical account of the Hell Gate Council is in Burns, Jesuits and the Indian Wars, 96114. An incomplete version of the official minutes is in Albert J. Partle, ed., The Flathead Indian Treaty Council of 1855, Pacific Northwest Quarterly 29, 283,314. See also Burns, a Jesuit at the Hell Gate Treaty of 1855, Mid-America 34, 87,114. Page 255. Shins among themselves and with other tribes. Boundaries were specified for common hunting grounds for the Indians for a period of 99 years, and the lands belonging exclusively to the Blackfeet were described. The United States agreed to provide the Blackfeet with certain annuities and to instruct them in agricultural and mechanical pursuits, to educate their children, and in other aspects to promote their civilization and Christianization. This treaty was ratified by the Senate on April 15, 1856.47. The earlier treaties at Walla Walla and Hell Gate had to wait for ratification until March 1859, when they were handled with those signed with the Western Washington Tribes and Palmer's Oregon treaties. The delay in treaty ratification, which seriously complicated Indian relations, was due primarily to the wars that broke out in 1855, as increasing penetration of their country by whites stirred up both the Rogue River Indians in Oregon and the Yakimas and their allies in central Washington. This military action in Oregon and Washington decisively defeated the Indians, and the movement to the reservations and the change toward white ways of life that the treaties specified became the lot of the Indians in the Pacific Northwest, Texas, New Mexico, and Utah. In the other areas of the New West, Texas, New Mexico, and Utah, treaty making was problematic, for the regular operation of the set principles in United States Indian policy was interrupted by special circumstances. In Texas, state autonomy; in New Mexico, the long tradition of Indian raiding into Mexican settlements; and in Utah, the overriding presence of the Mormons were significant obstacles. With the annexation of Texas in 1845, the United States took on responsibility for Indian affairs, but Texas retained control of its public domain. The federal government had no lands from which to provide. 47 Many Penny to Cumming, Stevens, and Palmer, May 3, 1855, CIAAR, 1855, Serial 810, pages 53,031, Kapler, 2:73640, Senate X. PROC, 10:75. For accounts of the Council, see Burns, Jesuits, and the Indian Wars, 11723, John C. Ewers, The Blackfeet, Raiders on the Northwestern Plains, 21422, and Alfred J. Partle, ed., The Blackfoot Indian Peace Council, Frontier and Midland, a magazine of the West, 199,207. Page 256. Reservations for the Indians, and it was unable to extend over them the restrictions and protections of the trade and intercourse laws. The string of small military posts established in the new state did little to control the Indians. Then in September 1845, two peace commissioners, Pierce M. Butler and M. G. Lewis, were sent to conciliate the Indians. They called a council of the tribes in Texas for January 1846, but it was not until May that the Indians Comanches, Anadarkos, Caddos, Lipan Apaches, and others assembled at Council Springs on the Brazos River. By that time the war with Mexico had begun, and it was important for the United States to keep the rest of Indians peaceful. 48 On May 15 the tribes signed a treaty that included the traditional provisions. The Indians acknowledged themselves to be under the exclusive protection of the United States and agreed to keep peace with the Americans and with other Indians. The United States assumed sole right to regulate trade and intercourse with the signatory tribes. The Indians agreed to give up all captives. Punishment for crimes between Indians and whites was provided for. The United States promised to erect trading houses and agencies on the border of the tribes. A special provision prohibited liquor traffic, and there was, finally, the usual stipulation, at the discretion of the President, for blacksmiths, school teachers, and preachers of the gospel. 49. Robert S. Neighbors, the agent appointed for Texas, called a great council of the tribes at the end of September 1847 to explain the treaty and to allay their fears, but the continued advance of surveyors and settlers caused new raids and hostility along the frontier. Eventually the state of Texas provided lands for the Indians. The two reservations that were set up in 185,455, however, failed to provide a solution to the problems in Texas, and in 1859 the reservations were abandoned and the Indians moved north of the Red River into Indian Territory. All this was done without treaties. In New Mexico the Pueblo Indians were considered to be civilized Indians, living in organized communities and dependent upon agriculture for their subsistence. Aside from an uprising at Taos in January 48, details of the negotiations are given in Butler and Lewis to William Medill, August 8, 1848, Senate Report No. 171, 30-1, Serial 512, pages 2937. For the record kept by a Cherokee Indian who accompanied Butler and Lewis, see Grant Foreman, ed., The Journal of Elijah Hicks, Chronicles of Oklahoma 13, 6899. 49 Kapler, 2:55457, Grant Foreman, The Texas Comanche Treaty of 1846, Southwestern Historical Quarterly 51, 31332. Senate amendments and ratification are in Senate Ex. Proc. 7:19495. Page 257. 1847 that killed Charles Bent, the head of a provisional territorial government. The Indians were peaceful, and the United States never entered into treaty arrangements with them. Attention was turned instead to the Apaches and Navajos, whose warlike existence and continual raiding of Mexican settlements kept the area in turmoil. The military governor of New Mexico appointed in October 1848, Lieutenant Colonel John M. Washington, intended to follow the conventional Indian policy of the day. "The period has arrived," he wrote to the War Department in February 1849, "when they must restrain themselves within prescribed limits and cultivate the earth for an honest livelihood, or be destroyed." 50. Together with James S. Calhoun, who had been appointed Indian agent early in 1849, Washington coerced one group of Navajos into a treaty on September 9, 1849, in which the chiefs agreed to recognize United States jurisdiction and to submit to the trade and intercourse laws, to return captives and stolen property and remain at peace, and to allow the federal government to determine their boundaries. 51 Before the end of the year, Calhoun had negotiated a similar treaty with the Utes, in which these Indians promised to build up pueblos, or to settle in such other manner as will enable them most successfully to cultivate the soil, and pursue such other industrial pursuits as will best promote their happiness and prosperity, to cease their roving and rambling habits, and to support themselves by their own industry, aided and directed as it may be by the wisdom, justice, and humanity of the American people. 52. The treaties did not bring the peace they promised. Although Calhoun planned to end depredations by a display of military force and then to settle the various tribes on reservations separated from each other, hostilities continued. On July 1, 1852, a treaty was negotiated with the Mescalero Apaches. 50 Washington to Roger Jones, February 3, 1849, quoted in Robert A. Trenard, Jr., Alternative to Extinction, Federal Indian Policy and the Beginnings of the Reservation System, 184,651, 113. 51 Kapler, 2:58385. Documents regarding Washington's Navajo expedition are in House Ex. Document number 5, 31-1, Serial 569, pages 10,415. Calhoun's early reports to the Secretary of the Interior and the Commissioner of Indian Affairs are in House Ex. Document number 17, 31-1, Serial 573, pages 198,229. The standard work on Calhoun is Annie Heloise Abel, ed., the official correspondence of James S. Calhoun while Indian agent at Santa Fe and Superintendent of Indian Affairs in New Mexico. 52 Kapler, 2:58587. The two treaties were quickly ratified by heavy majorities in the Senate without amendment. Senate Ex. PROC, 8:22930. Page 258. By Colonel Edwin V. Sumner and Indian Agent John Greiner. The Commissioner of Indian Affairs and the Secretary of the Interior both admitted that the two men had never been duly authorized to negotiate a treaty on the part of the United States, but they recommended the treaty's approval as sound policy, and the President and the Senate agreed. The treaty provisions followed those of the earlier treaties with the Navajos and with the Utes. 53 However inappropriate such an idealistic treaty may have been in the circumstances, peace was maintained in New Mexico for 2 years. Then the old trouble of raids and attacks and army retaliation broke the peace. The next move came from Congress, which in the summer of 1854 appropriated $30,000 for the negotiation of treaties with the Apaches, Navajos, and Utes in New Mexico. The money provided the opportunity to apply the policy that was maturing in the mind of Indian Commissioner Menny Penny, who believed that the only solution was to extend to New Mexico the system of reservations that was being developed elsewhere. 54. Accordingly, David Meriwether, who had become governor of New Mexico Territory in 1853, negotiated 6 treaties in the summer of 1855 with the Mimbres Band of Gila Apaches, Mescalero Apaches, Navajos, Capote Band of Utes, Muishe Band of Utes, and Jicarilla Apaches. These treaties were much alike and embodied Menny-Penny's principles. In return for cession of all their claims to land, the bands were given defined reservations, and they agreed to settle on them and to cultivate the soil and raise flocks and herds for a subsistence. In turn, the United States promised gradually reduced annuities for a set period of years, but the payments were to be made at the direction of the President, who could determine what proportion, if any, would be paid in money and what proportion might be expended for moral improvement and civilization. Furthermore, the President, at his discretion, could survey the reservations and allot parcels of land to individual Indian families. Additional articles prohibited the making, selling, or using of spirit-use liquors on the reservations and provided that the trade and intercourse laws would remain in force over the Indian lands. 55. Here was a clear indication of the theoretical policy of the government. 53 Kapler, 2:59860. Letters of Luke Lee and A.H.H. Stewart in support of the treaty are in Senate, Sen 33 BC 1. 5410 STAT 330, CIAAR, 1854, Serial 746, p. 222. 55 Two of the treaties with the Capote Utes and the Muishe Utes are printed in Kapler, 5:68692. Page 259. To turn the Indians of the newly acquired territories into settled agriculturalists, no matter what the Indians' traditions and inclinations might be or what the capabilities of the land for farming. Meriwether reported that the Utes very reluctantly consented to commence the cultivation of the soil for a subsistence, but he had strong hopes that success with this relatively amicable band would have a powerful effect upon all the other bands of this savage tribe. Meriwether's chief goal in the treaties can be seen in his exultant report to Menny Penny when he forwarded them. Each treaty contains a stipulation requiring the Indians to cultivate the land assigned to them. Although the governor urged speedy approval of the treaties, the Senate unanimously rejected all of them on March 13, 1857. Yet the negotiations appear to have had some effect, for Menny Penny reported at the end of 1856 that depredations in New Mexico had been less serious than in any of the previous years. 56. In Utah, the continual conflict between federal agents and Mormon officials clouded Indian relations. 57 Both sides, however, saw the need for treaties. John Wilson, who temporarily served as Indian agent at Salt Lake City, proposed in 1849 that the Indian title to lands near the Great Salt Lake be extinguished by treaty, and his successor John H. Holman asserted that a treaty with the various tribes in Utah would have the effect of preventing depredations on their lands, quieting their excitement against the whites, and ultimately save the government from much trouble and expense. The Mormon leader Brigham Young was of the same mind. He wanted the government to promote schools and other measures to civilize the Indians, and he declared, if previous to any such arrangements being made for their benefit it becomes necessary to enter into treaty stipulations with them, then we should not delay that operation any longer, but go about it as speedily as possible. 58. The movement for a treaty in Utah was abortive. Young's estimates of goods. 56 Meriwether to Manypenny, August 14, 1855, Ibid, 689, Meriwether to Manypenny, September 1855, CIAAR, 1855, Serial 810, p. 507, CIAAR, 1856, Serial 875, p. 566, Senate X. PROC, 10:25455. 57 For useful discussion of this matter, see Dale L. Morgan, The Administration of Indian Affairs in Utah, 1851-1858, Pacific Historical Review 17, 383,409, and Hoops, Administration of Indian Affairs, 13,159. 58 Wilson to Thomas Ewing, September 4, 1849, House X. Document number 17, 31-1, Serial 573, p. 105, Holman to Luke Lee, September 21, 1851, CIAAR, 1851, Serial 613, p. 446, Young to Lee, November 30, 1851, Records of the Office of Indian Affairs, National Archives Record Group 75, Letters Received, Utah Superintendency, U/1-1852. Page 260. Needed for treating with the Indians were merely filed away because the similar arrangements suggested for the Indians in New Mexico had been turned down by the Senate. 59. The stretching of the treaty system to encompass the new American empire in the West was thus only partially effective. The policy of the government toward these Indians was embodied in the treaties signed, but the Senate frequently balked at ratifying the treaties, and in other cases simple administrative measures replaced formal treaties. Few, if any, officials at the seat of government seemed to worry about these discrepancies. 59 Morgan, Indian Affairs in Utah, 396. Page 261. Chapter 11. The Civil War Decade. The 1860s were the final decade of formal treaty making. The period was a significant one, for the Civil War disrupted the treaty relations between the United States and the tribes in the Indian Territory, and wars between Indians and whites on the plains and in the mountains during and after the Civil War ended with new attempts to return to a peaceful reservation status by means of treaty negotiations. Treaty making seemed to have a new lease on life, and there were few indications that it would soon end. 1. Southern tribes and the Civil War. The 5 civilized tribes, which had received strong guarantees of their national status in the removal treaties of the 1830s, exerted their sovereign powers at the beginning of the Civil War by overthrowing their loyalty to the Union and aligning themselves as by means of new treaties with the Confederate States of America. Some of these tribes, with slave-holding leaders, sympathized with the Confederacy, and the inability of Lincoln's government to provide protection. 1. For the general context of Indian policy in the period, see Francis Paul Prucha, The Great Father, The United States Government and the American Indians, 2 volumes, 1, 41,178. I have used some sections from that account here. Page 262. Against Confederate troops who invaded the territory made the switch of alliance seem desirable. The Choctaws and Chickasaws, the first and strongest adherents to the Southern cause, were bordered by the aggressive Confederate states of Arkansas and Texas, and the other tribes, too, despite large Unionist factions, with a sense of desperation joined the movement. Point 2. To foster the transition and negotiate the new treaties, the Confederate government sent the able Albert Pike to woo the Southern Indian leaders with persuasive arguments and enticing promises. Although unsuccessful at first with Chief John Ross of the Cherokees, who stoutly maintained a position of neutrality, Pike quickly won over the other tribes. The Creeks signed a treaty with him on July 10, 1861, the Choctaws and Chickasaws on July 12, and the Seminoles on August 1. All these treaties began with a preamble that indicated the Confederacy's offer to assume and accept the protectorate of the several nations and tribes of Indians occupying the country west of Arkansas and Missouri, and to recognize them as their wards, subject to all the rights, privileges, and immunities, titles and guarantees, with each of said nations and tribes under treaties made with them by the United States of America and the Indians' agreement thereto. Despite the treaty's reference to the Indians as wards, the documents marked a formal transfer of political allegiance and loyalty of the tribes from the Union to the Confederacy. The tribes, moreover, agreed to offensive and defensive military alliances with the South. 3. The treaties recognized the existing territorial limits of the tribes and guaranteed fee simple ownership of the lands within the boundaries. They contained the stipulation that the Indian lands were to be held in common and, Volume 1, the American Indian as slaveholder and secessionist, an omitted chapter in the diplomatic history of the Southern Confederacy, Volume 2, the American Indian as participant in the Civil War, and Volume 3, the American Indian under Reconstruction. A shorter general article is Annie Heloise Abel, The Indians in the Civil War, American Historical Review 15, 28196. 3. The treaties are printed in the War of the Rebellion, a compilation of the official records of the Union and Confederate armies, 70 volumes, Series 4, 1:42643, 44,566, 51,327, henceforth cited as official records. They are exhaustively analyzed in Abel, American Indian as Slaveholder, 15,780. See also Kenny A. Franks, An Analysis of the Confederate Treaties with the Five Civilized Tribes, Chronicles of Oklahoma 50, 45,873. Page 263. Tribes, added so long as grass shall grow and water run. The lands were never to be included in any state or territory, nor would a tribe, without its own consent, be organized as a territory or state. In many respects the treaties were the same as the earlier treaties with the United States, but the new treaties were more generous to the tribes, and the tone was one of conciliation rather than dictation, for Pike promised the Indians many things that they had been contending for with the United States. The treaties allowed the Indians more control of their trade, guaranteed property rights in slaves, and promised financial benefits. Of course, it was understandable that the rights of the Indians would be clearly recognized by the Confederacy, which desperately needed the Indian alliances. The treaties, as Pike negotiated them, contained a provision for Indian delegates in the Confederate Congress, and the Choctaw-Chickasaw Treaty provided for ultimate statehood. President Jefferson Davis objected to both these provisions as impolitic and unconstitutional, and the treaties were amended to leave the decision on delegates and admission of states to the House of Representatives and to Congress. 4. At length Ross's resistance was worn down, and on October 7 he, too, threw in his lot with the Confederacy, hoping to prevent the widening gap between Cherokee factions and no doubt enticed by the attractive terms offered by Pike, Cherokee Nation control over its lands, the right to incorporate other tribes into the nation, rights of self-government, control over the appointment of agents, a Cherokee court, a delegate in the House of Representatives, and provision for sale of the neutral lands that the Cherokees owned in Kansas. 5. Meanwhile Pike had signed treaties with the Wichita and Comanche Indians on August 12, which were primarily treaties of peace and of promoting civilization and which were intended to satisfy the citizens. 4 Davis Message of December 12, 1861, James D. Richardson, Comp. The Messages and Papers of Jefferson Davis and the Confederacy, including the diplomatic correspondence, 1861-1865, New ed., 2 volumes, 1:14951. The ratification action of the Confederate Congress is printed with each treaty in official records. 5 Official Records, Series 4, 1:66987. A summary of the treaty is in Morris L. Wardell, A Political History of the Cherokee Nation, 183810907, 13941. A Declaration of the People of the Cherokee Nation of the causes which have impelled them to unite their fortunes with those of the Confederate States of America, October 28, 1861, is in Official Records, Series 1, 13:5035. Page 264. Of Texas, who were ravaged by Indian raids. They contained little to distinguish them from treaties made by the United States with the Western tribes, except, of course, that the Indians placed themselves under the laws and protection of the Confederacy. They were full of paternalistic rhetoric and asked the tribes to settle upon their reserves, become industrious, and prepare to support themselves, and live in peace and quietness. 6. Pike negotiated treaties, as well, with the small Indian groups in the northeastern section of the Indian territory, Osage, Shawnees, Senecas, and Quapaws. By these treaties, signed on October 2 and 4, 1861, the tribes submitted to the Confederacy and agreed to join in the war against the Union. 7. The Confederacy used strong arguments in dealing with the Indians, not the least of which was that the expansionist forces of the United States threatened the Indians' autonomy if not their very existence. But the South, too, was interested in the Indian lands. In transmitting the treaties to President Davis, Pike extolled the beauty and fertility of the country. The concessions made the Indians are really far more for our benefit than for theirs, he wrote, and that it is we, 1,000 times more than they, who are interested to have this country, the finest, in my opinion, on the continent, opened to settlement and formed into a state. In the end, of course, the fine promises made to the Indians by Pike came to nothing because under the pressures of the war the Confederacy was unable to live up to its treaties and to furnish the tribes adequate protection from the ultimate invasion of Union forces. 9 The last years of the war were disastrous for the Indian Territory. Guerrilla warfare caused widespread destruction, and political disorganization resulted in corruption and exploitation. Refugee Indians with Union sentiments who had fled into Kansas were in an especially serious plight. When the Civil War ended, the Indians, who had disowned their treaty obligations with the United States, concluded formal alliances. 6 Official Records, Series 4, 1:54254. See also Earl M. Gibson, Confederates on the Plains, The Pike Mission to Wichita Agency, Great Plains Journal 4, 716. 7 Official Records, Series 4, 1:63666. 8 Pike, Report of the Commissioner of the Confederate States to the Indian Nations west of Arkansas, quoted in Gibson, Confederates on the Plains, 1516. 9 Kenny A. Franks, The Implementation of the Confederate Treaties with the 5 Civilized Tribes, Chronicles of Oklahoma 51, 2133, and the Confederate States and the 5 Civilized Tribes, A Breakdown in Relations, Journal of the West 12, 43954. Page 265. With the South, and furnished many men who fought tenaciously for the Confederate cause, faced a United States intent on dealing strongly with such wayward tribes. There was considerable sentiment for direct action by Congress to consolidate the Indian tribes and establish a regular territorial government for the Indian Territory. Such a move would have bypassed the treaty system, shattered the unique Indian proprietorship of the lands provided by the removal treaties of the 1830s, and opened the riches of the area to all comers. Lincoln's Commissioner of Indian Affairs, William P. Dole, to his credit, fought to prevent a territorial government that would destroy the treaty guarantees made by the federal government. He saw no advantages in changing the government of the Indian Territory and noted that such action would be at variance with our long-established Indian policy. Although he admitted that there was question about the force of treaty obligations toward Indians who had joined the Confederacy, Dole insisted that the obligations were intact toward Indians who had remained loyal and that to violate them would mean a gross breach of national faith. 10. Dole was not alone. When Senator James Harlan drew up a bill to establish a regular territory with set boundaries and a government similar to that of other federal territories, an amendment offered by Senator James R. Doolittle provided that the bill would go into effect by means of treaties with the tribes. And Senator Lafayette S. Foster of Connecticut spoke strongly against the bill, arguing in terms reminiscent of the debate against removal in 1830 that the measure would be a stain upon the national honor, a breach of the national faith. The bill passed the Senate on March 2, 1865, just before the adjournment of the 38th Congress, but it was never debated or voted upon in the House. 11. Harlan's bill, nevertheless, became the basis for negotiations with the Southern Indians, who were called to meet with federal commissioners at Fort Smith in September 1865. The conference was under the direction of the new Commissioner of Indian Affairs, Dennis N. Cooley, a friend and associate of Harlan, who was now Secretary of the Interior. He was assisted by Elijah Sells, head of the Southern Superintendency, Thomas Wister, a well-known Quaker from Pennsylvania, General W. S. Harney, and Colonel Ely S. Parker, a Seneca Indian, and General Grants. 10. Dole to Caleb Smith, March 17, 1862, quoted in Able, American Indian under Reconstruction, 23536N. 11. Able, American Indian under Reconstruction, 24466, quotes extensively from the Senate debates of February 23, 24, and March 2, 1866, and discusses the matter fully, 21967. Page 266. Aide-de-camp, who later became Commissioner of Indian Affairs. The goal of the commission was well summarized in a telegraph from Harlan to Cooley en route to Fort Smith: the President is willing to grant them peace, but wants land for other Indians, and a civil government for the whole territory. Cooley also carried to Fort Smith a copy of the Harlan Bill and a long letter of instructions from Secretary Harlan. 12. When the conference opened on September 8, only the loyal factions of the tribes were on hand, but Cooley proceeded anyway to address the gathering as though he were talking to Confederate Indians, telling them they had forfeited their annuities and rights to land in the Indian Territory, but that the President was willing to make new treaties with them. The delegates were startled by what they heard, for none of them had come with authority from their tribes to make treaties, but the next day Cooley continued in his course and outlined for the Indians the stipulations that were to be included in the treaties. The tribes must declare peace among themselves and with the United States and assist the United States in compelling the Indians of the Plains to maintain peaceful relations. They must abolish slavery forever and incorporate former slaves into their tribes or otherwise provide for them, and a portion of the lands of the tribes must be set apart for friendly tribes from Kansas and elsewhere. It was the policy of the government, Cooley told the Indians, to consolidate all the tribes in the Indian Territory into a single government. Finally, no white persons, except officers, agents, and employees of the government or of companies building internal improvements, would be allowed to reside in the Indian Territory unless formally incorporated into a tribe. 13. The Indian delegates, aside from their insistence that they were not authorized to negotiate new treaties with the United States, were strongly opposed to some of the points Cooley proposed. They were hesitant about incorporating the freed slaves into their nations, and they were especially hostile to the scheme of a territorial government that had been the heart of the Harlan Bill. The best that Cooley's commission could accomplish at Fort Smith was an agreement of amity between the tribes and the United States, dated September 13, 1865. In it the Indians. 12. Harlan to Cooley, August 24, 1865, quoted in Gary L. Roberts, Dennis Nelson Cooley, 186566, in Robert M. Kvasnicka and Herman J. Viola, eds, The Commissioners of Indian Affairs, 18241937, 103, Harlan to Commissioners, August 16, 1865, quoted in full in Able, American Indian under Reconstruction, 21926. 13 CIAAR, 1865, Serial 1248, pages 48283. Page 267. Acknowledged once more that they were under the exclusive jurisdiction of the United States, and they cancelled and repudiated the treaties they had made with the Confederacy. In turn, the United States promised peace and friendship and renewed protection of the tribes. 14. Formal treaties were signed the next year in Washington by Cooley, Sells, and Parker with the Seminoles, Choctaws, and Chickasaws, Creeks, and Cherokees. The treaties had common provisions and built upon the points laid out by Cooley at Fort Smith, but considerable modifications were made to meet the protestations of the Indians. The tribes gave up sections of their land to make homes for other Indians, emancipated their slaves, prohibited slavery, and provided for the men and women who had been freed. The treaties stipulated a general council of all the tribes in the Indian Territory, and rights of way for railroads were authorized. The Seminoles gave up their entire territory and accepted a new region to the east. The Choctaws and Chickasaws sold to the United States their lands west of the 98th meridian. The Creek land was cut in two. But the Cherokees, although they sold the parcels of land they owned in Kansas and gave the United States an option on their outlet to the west that lay beyond the 96th meridian, lost none of their lands. They agreed to admit other Indians to their territories west of the 98th meridian, however. The Choctaw-Chickasaw Treaty and that of the Cherokees included provisions for survey of their lands and allotment of them in severalty whenever approved by the tribal councils. 15. The treaties were signed with reunited tribes, although the divisions were by no means all healed. Among the Choctaws and Chickasaws there was little trouble, for there had been no fundamental split into loyal and secessionist parties. The Creeks and Seminoles patched up their divisions and sent national delegations to Washington to negotiate with the government. But among the Cherokees hostile factions. 14. The agreement is printed in the minutes of the council, Ibid, 51415. It is printed among unratified treaties in Kapler, 2:105052. 15 Kapler, 2:91015, 91,837, 94,250. There is detailed coverage in Able, American Indian under Reconstruction, 30,163. See also the following articles on the separate treaties: Harry Henslick, The Seminole Treaty of 1866, Chronicles of Oklahoma 48, 28,094, Gale Ballman, The Creek Treaty of 1866, Ibid, 18,496, Marion Ray McCullough, The Choctaw-Chickasaw Reconstruction Treaty of 1866, Journal of the West 12, 46,270, Paul F. Lambert, The Cherokee Reconstruction Treaty of 1866, Ibid, 47,189. Page 268. Sist, and both groups were on hand in Washington. The Northern Cherokees, acting through the National Council, sent a delegation led by John Ross, who was in ill health and close to the end of his life. A Southern delegation, led by Elias C. Boudinot and William P. Adair, sought its own ends. Cooley dealt with both delegations, but he was favorably inclined toward the Southern group, for it was sympathetic with his proposals for a territorial government and his encouragement of railroad development in the Indian Territory. He was not averse, however, to considering a division of the Cherokee Nation into northern and southern parts. Cooley sent a treaty made with the Southern delegates to the President in May, justifying his action at great length in an anti-Ross pamphlet he published at the same time entitled The Cherokee Question. But President Andrew Johnson refused to forward the treaty to the Senate. The Commissioner of Indian Affairs was then forced to come to terms with the Northern delegation, with whom he finally signed a treaty that was ratified by the Senate on July 27. The treaty represented compromises on both sides. The Southern faction was offered a degree of autonomy in the Canadian district, lying between the Arkansas and Canadian rivers, but the unity of the nation was preserved. John Ross died on August 1, 1866, 10 days before the proclamation of the treaty, and new leadership was found for the distracted nation. 16. Indians in the North and West. While action with the tribes in the Indian Territory held center stage in the federal government's Indian affairs during the Civil 16 extended accounts of the treaty negotiations and the relations of the factions appear in Wardell, Cherokee Nation, 194,207, and in Able, American Indian under Reconstruction, 34,563. Cooley's pamphlet is The Cherokee Question, Report of the Commissioner of Indian Affairs to the President of the United States, June 15, 1866, being supplementary to the report of the commissioners appointed by the President to treat with the Indians south of Kansas, and which assembled at Fort Smith, Ark, in September, 1865. The pamphlet is reprinted, with introduction and notes to refute its anti-Ross position, in Joseph B. Thoburn, ed., The Cherokee Question, Chronicles of Oklahoma 2, 141,242. The heated nature of the conflict between the two Cherokee parties can be seen in the small pamphlet war they conducted in the summer of 1866. The pamphlets are conveniently listed in Lester Hargrett, the Gilcrease Hargrett Catalogue of Imprints, 5556. Ross's last days are treated in Gary E. Moulton, John Ross, Cherokee Chief, 18,496. Page 269. War. The war also brought military engagements with Indians that had little to do directly with the sectional conflict. Whites continued to move into Indian lands, almost unmindful of the Great War being waged, and many regular troops were withdrawn from the frontier, to be replaced by less able and poorly disciplined volunteers. The violent outbreak of Santee Sioux in Minnesota in 1862 resulted in a mass execution of Indians deemed guilty and the removal of the Sioux from the state. Even the Winnebagos in Minnesota, who had played no part in the uprising, were forced out first to Dakota and then to Nebraska without the benefit of negotiations or treaties. In an unprecedented move, under pressure from the white citizens of Minnesota, Congress canceled certain provisions of earlier treaties with the Sioux. On February 16, 1863, Congress declared that all treaties with the Sisseton, Wahpeton, Mdewakanton, and Wapekut bands of Sioux were abrogated and annulled, so far as said treaties or any of them purport to impose any future obligation on the United States, and all lands and rights of occupancy within the state of Minnesota, and all annuities and claims heretofore accorded to said Indians, or any of them, to be forfeited to the United States. The money thus saved was to be used to compensate whites for their losses. Individual Indians who had aided whites, however, would receive 80 acres from the public lands in several Tevi. 17. When the Indians in Minnesota rose up against the white settlers in 1862, there had been general consternation, for whites feared a widespread conspiracy among the Indians to attack all along the frontier while the nation was engaged in the Civil War. Although these fears proved groundless, the restlessness among the Sioux, Cheyennes, and Arapahoes worried the Indian Office and the War Department and unnerved territorial officials in the West. In February 1861, by a treaty signed at Fort Wise on the Upper Arkansas, peaceful chiefs, including Black Kettle and White Antelope of the Cheyennes and Little Raven of the Arapahoes, had agreed to give up the lands assigned them in the Treaty of Fort Laramie of 1851 and accept a reservation along the Arkansas. The land of the reservation would be allotted in several Tevi to individual members of the tribes in order to promote settled habits of industry and enterprise. The treaty provided annuities for 15 years, totaling $450,000, to be spent at the discretion of the Secretary of the Interior for agricultural development among the tribes, and land for the support of schools. The Indians who 1712 ASTAT 65254. Page 270. Signed the treaty agreed to induce the portions of the tribes not represented to join them in this great step towards civilization. 18 This treaty is another example of the government's sincere but unreasonable expectations of inducing the nomadic Plains Indians to settle down on individual lots as agriculturalists. The chiefs who agreed to the Fort Wise Treaty had no success in drawing others to a radical change of life. Meanwhile, the great westward migration of whites continued. Stage and freight lines moved across Kansas, and the burgeoning traffic cut sharply into the hunting grounds of the Indians, who reacted with sporadic raids on stations and settlements. It was enough to alarm Colorado Territory to the point of panic, and on November 29, 1864, Colonel John M. Chivington, military commander of the District of Colorado, with volunteer troops attacked a group of peaceful Cheyennes and Arapahoes at Sand Creek. The resulting massacre became a never-to-be-forgotten symbol of what was wrong with United States treatment of the Indians. 19. Sand Creek intensified Indian hostilities on the plains. Black Kettle and others who escaped were aided by Northern Cheyennes, Sioux, and Arapahoes and by the Comanches and Kiowas, and the Indians fought off the troops sent out to quiet them. The Army planned an extensive campaign, but humanitarian outcries over Sand Creek and the desire of the Indians themselves for peace led to treaty negotiations instead. A special United States Treaty Commission met with the Cheyennes and Arapahoes, Comanches, Kiowas, and Kiowa Apaches on the Little Arkansas River in October 1865, the month following the Fort Smith Council. The commission was guided by instructions drawn up by Secretary Harlan, which emphasized that the Indians, to obviate violent collisions with the advancing tide of white migration, must give up their wandering life and settle on reservations. The Western Indians were to be assigned tracts of land as remote as possible from the whites. Although Harlan admitted that a sudden transition from a savage and nomadic life to the more quiet and confining pursuits of civilization is not to be expected, the lands were to be suitable for the ultimate adoption of pastoral and agricultural life. He insisted that the govern. 18 Kapler, 2:80711. 19 The literature on Sand Creek is extensive. Useful accounts are Stan Hoig, The Sand Creek Massacre, and Michael A. Sievers, Sands of Sand Creek Historiography, Colorado Magazine 49, 11642. Page 271. Ment would have to furnish the assistance necessary for a transition to a new way of life and improvement of the Indians' moral and intellectual condition. The nation cannot adopt the policy of exterminating them, he said. Our self-respect, our Christian faith, and a common dependence on an all-wise Creator and Benefactor forbid it. Other nations will judge our character by our treatment of the feeble tribes to whom we sustain the relation of guardian. Morally and legally there is no distinction between destroying them and rendering it impossible for them to escape annihilation by withholding from them adequate means of support. 20. On October 14, 1865, the Commission signed a treaty with the Cheyennes and Arapahoes present, in which the Indians agreed to give up their lands in Colorado and accept a reservation which lay partly in Kansas and partly in the Indian Territory. 3 days later a similar agreement was concluded with the Kiowa Apaches, and on the following day one was signed with the Comanches and Kiowas, who were to get a reservation in the Indian Territory and in the Panhandle of Texas. The treaties included the stipulations Harlan had outlined in his instructions. Although the Indians were permitted to range over their old lands, they agreed not to disturb the roads, military posts, and towns of the whites, and the government agreed to pay annuities for 40 years, in such manner and for such purposes as, in the judgment of the Secretary of the Interior, will best subserve their wants and interests as a people. Although the treaties brought a temporary peace, they did not solve the problem because the reservations to be established never materialized. The control of Texas over its lands nullified the agreement with the Comanches and Kiowas, and Kansas refused to allow a reservation within its boundaries. 21. For the northern plains, Governor Newton Edmonds of Dakota Territory arranged a commission of civilians and military officers to negotiate with the Sioux in the hope of ending Indian raids. The commission met the peace chiefs of the various bands at Fort Sully in 20 Harlan to commissioners, August 16, 1865, in Able, American Indian under Reconstruction, 2245. These instructions were actually drawn up for Cooley and the commissioners who went to Fort Smith, in case they would have an opportunity to deal with the Southern Plains tribes, which they did not. 21 Kapler, 2:88795, Donald J. Berthrong, The Southern Cheyennes, 22,444, William H. Leckey, The Military Conquest of the Southern Plains, 2326. Council proceedings are in CIAAR, 1865, Serial 1248, pages 699,720. See also Senate Ex. PROC, 14:485, 755, 82,729. Page 272. October 1865 and between October 10 and 28 signed 9 treaties with the Minneconjo, Lower Brule, Two Kettle, Blackfeet, Sans Arc, Hunkpapa, and Oglala bands of Teton Sioux and with 2 bands of Yankton. 22 These were treaties of peace in which the Indians agreed to obligate and bind themselves individually and collectively, not only to cease all hostilities against the persons and property of United States citizens, but to use their influence, and, if requisite, physical force, to prevent other bands of the Dakota or Sioux, or other adjacent tribes, from making hostile demonstrations against the government or people of the United States. The Indians promised to discontinue attacks on other tribes, to promote peace in the whole region, and to submit controversies with other tribes to the arbitration of the President of the United States. They promised to stay clear of overland transportation routes, for which action each band was to receive sums varying from $6,000 to $10,000 or $30 per lodge annually. Provisions were made for those Indians who wanted to settle down on individual parcels of land for agricultural or similar pursuits. Although the treaties gave the Senate carte blanche to amend the stipulations without Indian approval, the Senate used the power sparingly. Only slightly amended, the 9 treaties were unanimously approved on March 5, 1866.23. Commissioner Dole's defense of the treaty system. The open hostility of many Indians during the Civil War brought to the fore the question of military control of Indian affairs. One challenge to civilian management, which was aimed directly at the treaty policy, came from General John Pope. Pope had been sent by Lincoln to put down the Sioux uprising in Minnesota in 1862, where he headed the newly created Department of the Northwest, and his encounter with the Indians there made him an instant Indian specialist. While engaged with hostile Indians, Pope's military commanders dealt with the Indians without much concern for the Indian office, but Pope wanted a general overhaul of 22 Kapler, 2:88387, 800, and 96,908. 23 Senate Ex. PROC, 14:58183. Correspondence from various official sources relating to the origins and activities of the Edmonds Commission is printed in South Dakota Historical Collections 9, 40,965. 16. Potawatomi Indian Council, 1837. 17. Treaty with the Potawatomis, September 23, 1836. Agent Abel Pepper held numerous councils in the mid-1830s with Potawatomi Indians, who ceded small reserves of land they still held in Indiana. And 1837. Council, depicted by the artist George Winter, who attended it, concerned removal to the west, not a treaty, but it was typical of the treaty councils. The first and second pages of the Treaty of September 23, 1836, show crossed out sections and interlinear changes, such as were found on a number of treaties. 18. Treaty of Traverse-des-Sioux, July 23, 1851. Frank B. Meyer, a young Baltimore artist, was present at the Traverse-des-Sioux Treaty Council and made sketches of the Indians and of the council grounds. Meyer hoped to use the drawings as sources for a large oil painting, which would be his masterpiece. In 1885 he produced an oil sketch of his proposed painting, which is reproduced here, but he got no further. A later artist, Frank D. Millet, used this oil painting as the basis for a more detailed and finished work that now hangs in the Minnesota State Capitol, but it does not have the historical authenticity of Meyer's sketch. Meyer's painting incorporates many common features of treaty councils held in the Indian country, an arbor or canopy to offer shade and give an air of formality to the proceedings, the American flag flying over the assembly, the face-off of United States commissioners and the Indian chiefs, the table with the secretary taking the signatures of the Indians, the gathering of white witnesses behind the commissioners, and the large number of Indians in attendance. 19. Robert Meldrum. Meldrum was an interpreter for the Crows at the large multi-tribal council held on the Platte below Fort Laramie in 1851. Of Scottish ancestry, he entered the upper Missouri fur trade and dealt especially with the Crows. He married into the tribe, knew their language well, and was accepted by the Indians as one of themselves. 20. Alexander Culbertson. When Culbertson, a native Pennsylvanian, acted as interpreter for the Assiniboines and Gros Ventres at the Fort Laramie Treaty of 1851, he had been for many years a trader on the upper Missouri and head of Fort Union for a decade. He had an Indian wife, and the Indians knew him well and respected him. This drawing is by Gustav Sohan. 21. Arrival of Nez Perce Indians at the Walla Walla Council, 1855. 22. Blackfeet Treaty Council, 1855. When Isaac I. Stevens negotiated treaties with the Indians in what are now Washington and Montana, he had the services of an enlisted man in the army, a German immigrant named Gustav Sohan, who had considerable artistic ability. Sohan's portraits of Indian chiefs and others and his rendering of the treaty councils that Stevens held with the Indians form a valuable pictorial record of treaty making. Here are two of Sohan's scenes. 23. Isaac I. Stevens. 24. Peo Mox Mox. 25. Chief Lawyer. Stevens was 35 years old, a graduate of West Point who had served in the Mexican War, when he was appointed the first governor of Washington Territory in 1853. One biographer called him a young man in a hurry, and he had strong paternalistic ideas about forcing the tribes into the white man's pattern. Two of the many Indian leaders he dealt with are shown here. In sketches by Gustav Sohan, Peo Mox Mox, of the Walla Wallas and Lawyer of the Nez Perces. 26. Presidential Signature and Seal, Treaty with the Nez Perces, June 11, 1855. Once the Senate had given its advice and consent to a treaty, the State Department prepared a ratification formula for the President to sign, which was attached to the treaty and included the seal of the United States. The forms used during President Buchanan's administration were elegantly prepared. Note that the President's signature on this treaty is attested by Lewis Cass, then Secretary of State. 27. Sack and Fox Delegation in Washington, D.C., February 1867. Of the 367 Indian treaties that were ratified, 69 were negotiated and signed in Washington, D.C. Tribal delegates, together with interpreters and agents, came to the capital to speak with the Great Father and to negotiate agreements with the government. On such occasions, they usually had pictures taken in their best attire. In this staged photograph, Commissioner of Indian Affairs Louis V. Bogie is reading a paper to the Sac and Fox delegation. Bogie signed the treaty as principal commissioner for the United States, but the Senate, in March 1867, refused to approve his appointment to the office of Commissioner of Indian Affairs. Page 273. Federal Indian Policy. In a letter to General Henry W. Halleck, General-in-Chief of the Army, in 1863, Pope strongly criticized existing policy and called for agreements with the hostile Indians that would be treaties of peace only, with no purchase of lands and no annuities of any kind. 24. Pope's most ambitious statement was the plan he drew up and forwarded to Secretary of War Edwin M. Stanton in February 1864. His plan was twofold. The reserve and annuity Indians along the frontier he proposed to move, with or without their consent, to some reservation within the settled portions of the country, take away their arms, stop the payment of their annuities, and spend any money due or appropriated for them in building villages and supplying them with food and clothing. So long as Indians retain their tribal organization and are treated in their corporate and not their individual capacity, he said, the change of habits and of ideas necessary to effect this result cannot be accomplished, nor can these results ever be obtained under any circumstances until the Indian is no longer an object of cupidity to the white man. For the wild Indians of the West with whom treaties had not yet been made, Pope proposed military control. All these Indians should be gathered at some point beyond the western limit of the great fertile region between the Mississippi River and the Rocky Mountains, where the army could be left to deal with them without treaties and without the use of Indian agents. Pope saw no reason to treat the Indians as sovereign nations with territorial rights. Treat them completely as wards of the government, he insisted, with the western tribes under complete military control and the partially civilized ones cared for far away from the disruptive forces they were encountering on the frontiers. 25. Indian Commissioner Dole refused to consider such a radical departure from accepted practice, and at first he simply ignored it. But when General Halleck arranged for the publication of Pope's plan in the Army and Navy Journal and sent his cousin Bishop Henry B. Whipple, the Episcopal missionary in Minnesota, to promote the plan with Dole and with President Lincoln, the commissioner felt obliged to reply. In so doing, he provided one of the clearest statements in support of the treaty system that ever came from the Indian office. He ridiculed the idea of easily removing Indians from their homelands without their 24. Pope to Halleck, September 23, 1863, Official Records, Series 1, Volume 22, pt 2, 56,970. 25. Pope to Stanton, February 6, 1864, Ibid, Volume 34, pt 2, 25,964. The document is printed also in CIAAR, 1864, Serial 1220, pages 56,873. Page 274. Consent, challenged Pope's assumption that there were free lands forever out of the way of white expansion, and forthrightly denied that military control would remove fraud and corruption in the Indian service. Dole favored retention of the present reservation policy, which he said had been gradually improving by experience. 26. Dole's eloquent plea for continuing the treaty system was an outright rejection of Pope's contention that the military should be given arbitrary control of the Indians. Dole's position was that there should be a mutual understanding between the Indians and whites about the boundaries of the Indian territory, the laws that were to be applied to Indians, and the reciprocal duties and obligations resting upon each race, whether regarded as individuals or distinct communities. And he compared two methods by which that mutual understanding could be arrived at. First, by availing ourselves of our overwhelming numerical, physical, and intellectual superiority, we may set apart a country for the use of the Indians, prescribe the laws by which they shall be governed, and the rules to be observed in the intercourse of the two races, and compel a conformity on the part of the Indians, or, secondly, we may, as has been the almost universal practice of the government, after resorting to military force only so far as may be necessary in order to induce the Indians to consent to negotiate, bring about this understanding through the instrumentality of treaties to which they are parties, and as such have yielded their assent. 27. Dole recognized that the overwhelming power of the United States enabled the government to adopt either of these methods, and the use of that power in imposing treaty agreements upon tribes who were not really free to give or withhold assent may have blurred any practical difference between the two methods. Yet the distinction that Dole saw was based on significant theoretical principles. The military plan advanced by Pope, he argued, entirely ignored the independence of the Indians and reduced them to absolute subjection, whereas the treaty system did not altogether deprive them of their sense of nationality and independence as a people. Moreover, arbitrary military control would lead the Indian to regard the whites as merciless despots and tyrants, who have deprived them of their homes and liberties, whereas treaties, although they rested on a recognition that the Indians as belligerents could not cope with the United States, might lead the in. 26 Dole to J. P. Usher, April 6, 1864, Ibid, 57,375. 27 CIAAR, 1864, 150. Page 275. Dion's Toward Friendship and a Gradual Appreciation of the Advantages and Blessings of Civilization. Dole asserted that the military plan was put forward for economic rather than humanitarian reasons, and he disputed even the economic benefits of it. He concluded that the advantages of the second method seem so apparent that I can hardly realize that the former is seriously advocated. He remained firmly convinced that no better system could be found for the management of the Indians than the system then followed, the fixing of the rights, duties, and obligations of each race towards the other through the instrumentality of treaties. 28. In thus taking an adamant stand against turning the Indians over to the War Department, Dole maintained an essential principle of Indian policy at a time when it might have been easy to gain substantial public as well as official support for a transfer. More significantly, Dole refused to consider Pope's recommendation to end the treaty system, cancel annuity payments, and manage the Indians without in any way seeking their consent or legally establishing Indian rights and the government's responsibilities. 29. An array of treaties. A great many other treaties in the 1860s continued to carry out the government's varied Indian policies. They cannot all be discussed here in detail, a number of examples will suffice. That the treaty process could be manipulated to serve white political and economic interests is well illustrated by the series of treaties made with Indian tribes and bands in Kansas. There the pressure to develop railroads through Indian reservations and to dispose of Indian lands for the benefit of railroad corporations influenced the Indians as well as the white citizens. The Delawares made treaties in 1860, 1861, and 1866 in which they accepted allotments and sold the surplus lands, not to the government but to railroad interests, and then finally withdrew from Kansas altogether. 28 Ibid. 29 Pope's plan and Dole's rejection of it are discussed in Richard N. Ellis, General Pope and U.S. Indian Policy, 3151. I do not agree with Ellis's strong charge that Dole completely distorted Pope's proposals. Page 276. Settle in the Indian Territory to the south. Other deals were made with the Potawatomis in 1861, 1866, and 1867, with the Kickapoos in 1862, and with a group of small tribes in 1867. It was part of the continuing drive to free Kansas of Indian lands, but it was not simply a white scheme to defraud the Indians, for in the beginning at least the Indian leaders, too, saw advantages in railroad development that would bring economic benefits to the state, in which the tribes would share. The Potawatomis in 1861, for example, accepted the railroad so that the value of their retained lands would be increased and a means would be provided for getting their surplus products to market. 30. Meanwhile, the federal government dealt with bands of Chippewas in 7 treaties signed in 1863, 1864, 1866, and 1867, all but 2 of which were negotiated in Washington by the Commissioners of Indian Affairs and chiefs of the bands. The treaties concerned land cessions, establishment of reduced reservations, payment of annuities, and a variety of civilizing elements. 31 The Eastern Sioux, too, were affected, as the government established reservations for groups of Minnesota Sioux who had not taken part in the uprising in 1862, some of whom had in fact aided the whites. In a treaty of February 19, 1867, the government laid out the Sisseton Reservation and the Devil's Lake Reservation for these members of the Sisseton and Wahpeton bands. The Indians were received back into the good graces of the United States, and the treaty made provisions for an agricultural life. 32. Farther to the west, the government, pressured by the expanding white population in Colorado Territory, entered into formal treaty. 30 Kapler, 2:826. For data on the treaties, see Appendix B, NOS 307, 310, 350, 311, 346, 355, 314, 354. The Delaware treaties are discussed at length in C.A. Wesslager, The Delaware Indians, A History, Chapter 16. A critical account of the fleecing of the Indians by scheming whites is in Paul Wallace Gates, 50 Million Acres, Conflicts Over Kansas Land Policy, 1854-1890, Chapter 7. A more balanced account, which understands the advantages that the Indians originally saw in the railroad deals, is in H. Craig Minor and William E. Unruh, The End of Indian Kansas, A Study of Cultural Revolution, 1854-1871, Chapter 2. A particularly sordid case of treaty used to defraud the Indians is told in extraordinary detail in William E. Unruh and H. Craig Minor, Tribal Dispossession and the Ottawa Indian University Fraud. 31 See Appendix B, NOS 315, 320, 323, 324, 326, 347, and 356 for data on these treaties. 32 Kapler, 2:95659. See Roy W. Meyer, History of the Santee Sioux, United States Indian Policy on Trial, 198,201. Page 277. Relations with the Ute Indians, following the pattern well set in earlier years with other tribes. The Tabagwatch Band of Utes, in a treaty of October 7, 1863, acknowledged the supremacy of the United States and claimed its protection, while ceding their land claims and accepting a specified reservation. The Indians allowed roads through their lands and permitted United States citizens to mine minerals within the reservation. The government provided annuities for 10 years in goods and provisions. And, in case the chiefs shall announce to the agent a willingness and determination on their part, and on the part of their people, to begin and follow agricultural or pastoral pursuits by farming or raising stock, and growing wool, sheep, and cattle would be added and the annuity goods changed to a character suited to such change of life. Though ratified by the Senate on March 25, 1864, and ultimately proclaimed by Lincoln in December, the treaty was not implemented. 33 Then on June 8, 1865, the Colorado Utes, together with bands in Utah, ceded all their claims except to the Uinta Reservation in Utah, but the agreement was not ratified. Finally, on March 2, 1868, in Washington, a new treaty extended the Treaty of 1863 to other bands and created new reservation boundaries. The treaty made provision for 2 agencies, for individual allotments to those who wanted them, and for schools and other incentives toward farming and the adoption of white culture. 34. In 1863 negotiations were made with various groups of Shoshones. The resulting treaties provided for military posts and settlements, for lines of communication through the lands claimed by the Indians, and, in return for destruction of game caused by the inroads, small annuities for 20 years. Some of the treaties authorized the president to set aside reservations within the Indians' traditional lands whenever he should deem it expedient for them to abandon the roaming life, which they now lead, and become herdsmen or agriculturalists. Mindful of the undetermined status of Indian land claims in the region acquired from Mexico in 1848, the commissioners included a cautionary clause to the effect that the Indians' rights to land were only those that they had had under the laws of Mexico. 35. The Nez Perce Indians furnished a striking example of Indians. 33 Kapler, 2:85659, Senate X. PROC, 13:46163. 34 Royce, Sessions, 849, Kapler, 2:99096. 35 See Appendix B, NOS 31719 and 322, for data on these treaties. There is a table of treaties and agreements, 1846196 made with Indians in the Great Basin in Handbook of North American Indians, Volume 11, Great Basin, ed. Warren L. D. Azevedo, 52627. Page 278. Overrun by the mining frontier, which continued its advance during the Civil War years. In June 1863 Calvin H. Hale, Superintendent of Indian Affairs for Washington Territory, and 2 Indian agents signed a treaty with these Indians, supplementary to and amending the Stevens Treaty of 1855. In the new treaty the signatory Indians ceded lands reserved in the earlier treaty and accepted a reduced reservation. They were encouraged to take individual allotments in the new reservation, and the government promised an array of agricultural implements, mills, schools, churches, and other tools of civilization. When the Senate ratified the treaty on June 26, 1866, it made some amendments, which were appropriately sent to the Indians for their approval. 36. The Indians, hoping to recover their old lands if the 1863 treaty were not approved, refused to agree to the amendments. Finally, in April 1867, the Indian Office sought to have the Senate recede from its amendments so that the treaty could go into effect, and the Senate agreed, ratifying the treaty in its original form on April 17.37.